Hello everybody, very good evening. Hope you all are doing really well. I am CS Supreet Agrawal, your faculty for ACCA AA, AAA and law subjects. My dear friends, I am quite excited today because today we are going to discuss about one of the most important chapters of your corporate and business law syllabus. My dear friends, this particular lecture is going to be very important for you because this is your first introduction to the work of law. My dear friends, whenever we discuss about law as a subject, a lot of students ask me that how is this going to help us in a further journey, as in is this subject related to some other subject as well? Is this subject going to help us when we will be qualifying as an ACCA? So let me tell you that here we are going to discuss about the global syllabus of your law subject, right? And when we talk about the global syllabus, we are going to discuss a lot of things which are applicable across the globe, and that is why this subject is going to be very important for you. We have already discussed about the exam pattern, the kind of questions that could be asked and the syllabus in the orientation video. So I hope you have seen it. Just in case if you have not seen it, what I am doing is I will be sharing the link of that video with you as well. Okay. But now, my dear friends, what is very important for us to understand over here is that whenever we discuss about law as a subject, we have to go step by step. In total, there are 19 chapters in your law syllabus, and when we talk about these 19 chapters, each chapter is going to bring some new information to you that you will be really amazed to know. But what we have to understand is, along with understanding everything, here we might be required to learn a lot of new things as well, because the exam pattern is 70% MCQs, and that makes it a kind of paper where you can just pass. If you want to just pass, you can do it even via just MCQs, and that is the beauty of this subject. That is, if you want to score really good marks and if you understand everything, then it is going to be very easy for you to score really good marks in this particular subject. And if you want to just pass, even if you understand everything, you can still pass. So that becomes very important for this particular subject. Now my dear friends, let me introduce you to chapter number 1 of this particular subject. Chapter number 1 is essential elements of legal systems. When I talk about this particular chapter, what we are going to cover here, let me introduce you to that. So number one thing that we are going to discuss is we are going to discuss about different types of systems that are followed. It could be economic systems, it could be political systems, it could be legal systems. Then what we are going to discuss here is that since we are understanding the law syllabus, so it is going to be very important for us to understand about different kinds of legal systems. For example, there could be criminal law, there could be civil law, there could be Sharia law, there could be a lot of laws and regulations that we will be learning throughout the syllabus. But this chapter is going to just introduce us to different kinds of laws. Okay, are we going to cover some of the criminal laws as well? No, my dear friends. Here we will be discussing about majorly corporate and business laws only, right? So criminal laws is not part of our subject, but we still have to understand what is criminal law. So I hope you have got good understanding about what the subject is all about. Now let's discuss everything one by one. Okay, what is more important here is that we have to read every line, and it is highly recommended that after attending this lecture, you give a good read to the ACCA study hub also, so that you just quickly revise everything, you just quickly cover all the pointers. Because my dear friends, I will be providing you the summary notes, but what happens is, since there are a lot of MCQs, I personally feel that a good reading always helps you. So these summary notes are prepared keeping in mind the expected questions from this particular chapter as well, and when we will be going for the MCQ solving, you will realize that these notes are really going to help you. So my dear friends, I am going to give you these kind of notes for all chapters. Okay, for all chapters I am going to give you these kind of notes along with the board notes as well. So whatever writing we will be doing, I will be sharing it with you as well. Okay, and then after completion of each chapter, we will be going for the question solving session of that particular chapter as well. Okay, so my dear friends, let's start with chapter number 1 here. When I talk about chapter number 1, the name of chapter number 1 is essential elements of legal systems. Essential elements of legal systems. Okay, so what kind of systems are there? So there is economic systems, there are political systems, and there are legal systems. What are economical systems? What are economical systems? So see, when I talk about economic systems, what it means is that how the system of finance, how the system of production, distribution works in the society. When I talk about political systems, so who has the power to govern the society, as in who has the power to create the laws and regulations to be followed by the countrymen. Then legal systems, this is the course of law, course of justice that is being followed. Okay, so economic systems determine the way in which the society operates financially, that is production cycle, that could be the production cycle, that could be the distribution cycle, all of that. So there are certain countries where production and distribution is being handled generally by the government only, but there could be another countries where there is some decentralization that has been done, right? Some privatization that has been done. Political system determine the way in which the society is governed, determine the way in which the society is governed, that is whether it is a dictatorship, whether it is a republic, whether it is a democracy, what kind of political systems are there. Then legal systems determine the way in which public and private behavior and relationships are regulated within a society. Regulated as in regulated by law, regulated by law, as in that is flow of justice, how justice is delivered. Okay, that is very, very important. I hope this is clear. I hope this is clear. Just in case if you have any doubts, what you can do is you can quickly write to me in the application, or if you are just in case if you are watching this lecture on YouTube, you can write in the comment section as well. I would be happy to answer. Okay, now let's talk about each one of them one by one. So let's talk about the economic systems. Like we discussed, it is the system of production and distribution of materials, right? So the production, distribution and consumption of goods and services in an economy. Production, distribution and consumption. Do you need to remember these words, mug these words up? No. But what you need to understand is when we talk about the economic system, so it is going to talk about the economic affairs. What are economic affairs? It might be related to GDP, that is gross domestic product. It might be related to some of the other aspects which are related to your economics, right? So the production, distribution and consumption of goods and services in an economy. You know, a lot of students make this mistake that whenever there's an MCQ on this, what they do is they just write goods. Okay, if there's a option which includes services, sometimes they forget it. Especially if they are writing the whole answer which is in the descriptive mode, they do not write services. So please make sure that you write services over here. Okay, okay, I hope that is clear. Services you have to write. Now the principles and techniques by which problems of economics are addressed. Now the ways, can you write ways also? Yes. So even if you forget principles and techniques, what you can write is ways. Okay, now the principles governing relationships between institutions, individuals and property. It could be property in the form of assets. That is how the ownership structure is defined. There are certain countries where the ownership of all the properties, all the assets goes to the government, right? But there are certain countries where you can have your ownership as well. Now let's talk about certain types over here. So there could be one economy which is planned or directed economy. Planned or directed economy. Here the production, the distribution, the consumption of goods and services would be in the regulation of government. So the government controls and regulates production, distribution, prices and so on. Are there certain countries like that? Yes, my dear friends, there are certain countries like that. Now a market economy is one based on market forces, the price of goods and services being determined in a free price system set by supply and demand. That is, here the prices are set, the prices, the commodities, the distribution network, everything is set by demand and supply. That is where there would be higher demand, there might be higher prices. Whenever there is lower demand, there might be lower prices as well. Vice versa, there are a lot of economic laws related to it. Our point is to study about the law aspect of it, right? Now most countries today have a mixed economy. This is very important. Most countries today have a mixed economy. So whenever there's a question on which kind of economy is more prevalent these days, you should answer that the mixed economy is more prevalent these days. Okay, I hope this is clear. Okay, in which two extreme examples merge. Now political systems, this was all about economic systems, but sir, only this much? So once we complete these three, this much of content for two more types of systems, we will be done? No, my dear friends. What we have to understand is that our system, our particular syllabus is focused more on the legal aspect of it. So there would be quick discussion on economic systems and political systems. But what we have to understand is that a major discussion would be around the legal systems. So we can finish off the discussion of economic systems in few minutes. We can finish off the discussion of political systems in few minutes. But when we go to the legal system discussion, there we have to invest a major time. Okay, so this lecture would also be majorly invested towards the discussion of legal systems. Okay, now sir, are we going to complete this chapter today? Yes, we are going to complete this chapter today. So sir, we will be completing this chapter, which is one of the 19 chapters of our syllabus today only. Yes, my dear friends, you will be completing it today only. Okay, and what we will try is whenever we come on the lecture, we will generally try to finish off one chapter in each lecture. Okay, there are definitely some chapters where it would take more than one lecture, but generally one lecture for one chapter. Okay, that is the policy that we will be following. Okay, now political system. When I talk about the political system, so the term political systems describes systems of politics and government based on who holds authority within a society, okay, how they acquire it, the influence of government on the economy and the people, and the role of religion in the state. That is, who holds authority, as in whether it is government who holds authority, that is government, or GOVT means government or certain individuals who has the power, okay, within the society. There are certain countries where you will see that the distribution of power is in one end, right? How they acquire it, as in whether it is democracy or what, okay. The influence of government on the economy and the people, influence of government on the economy, as in how powerful is the government, how powerful and how much authority does it have, and the role of religion in the state, that is whether the power is given via religion or whether the power is given via democracy. Okay, examples could be monarchy, republic, democracy, anarchy, right? Now these are the words that we have already discussed in our schools also, generally in the civics also. So just in case if you face any trouble, please feel free to let me know. I would be happy to explain it to you again. Now, separation of powers within constitutional systems. That is how the powers are distributed in our constitution, in the international constitution generally. So my dear friends, there are certain people who create the law, okay, who generally drafts the law. Then there are certain people who has the responsibility to actually make that law implemented at the ground level. And then there is third pillar, which is judiciary generally, which takes care of that if there is any non-compliances, then how they are dealt with, whether appropriate punishments are being given or not, appropriate sentences are being announced or not, right? So let's discuss about it. So the executive branch, this is one, okay, the executive branch of government comprises the head of a state. In India we call them governor also, chief ministers also, and the government organs and institutions. It is responsible for daily administration of the state bureaucracy. Daily administration as in day-to-day implementation, okay, daily administration as in day-to-day implementation, okay. Now, and the implementing of new law formulated by the legislature. Now what is legislature? Sir? Let me tell you what is legislature. This one. So they are the people who create the law. Just like parliament in India. Example, parliament or congress is the branch of government which carries out the function of deciding and passing new laws, and of repealing as in discontinuing, modifying as in altering or changing old ones. That is, they take the responsibility to create newer laws which are required, or to replace or delete the ones which are no longer required. Now, once formulated, new law usually has to be signed off and officially brought into effect by the executive. That is, they can create the law, legislature could create the law, but it is approved by executive only. So generally executive level, example, president. In India, president signs off the new law and they are part of the executive, okay, not legislature. Legislature as in the MPs, right? Now, the judiciary describes the court system. Judiciary, the third pillar, right? Judiciary, the third one, judiciary. The judiciary describes the court system through which legal decisions are made. And enforced. What is the meaning of this word, sir? Enforced. Made, we understand. What is enforced? So see, what happens is, say as the head of my organization, I could create the laws, right? But there would be certain procedures, certain people, certain departments that would actually enforce it, apply it at the ground level. They will communicate that what is required as per the newer laws and how do we apply it, and they will ensure that whether it is applied correctly or not. That is called as enforcing, okay? Enforcing. Implementing, okay? same word as implementing. Okay, now, and also describes the judges and other personnel who keep the system running. Ideally, the judiciary is completely independent of the other two branches of government. Why does it so, sir? See, if judiciary is dependent on the executive level or the legislature level, then there would not be any independence. People would try to interpret the laws to the best judgment, to the best interest of the legislature and executive only. But that is not true. That should not happen. What should happen? That judiciary should work independently and should take the decisions independently only in the national interest, in the interest of the people, in the interest of the nation. So that is why it is very, very important sentence. You should not forget it ever. Okay, this is one of the most important sentences. I hope you have understood till now. Any questions? I hope not. Yes. Now let's come to the third part, and my dear friends, this is going to be the most important for you for your examination as well. Okay, now law. What is law? Please remember this definition. Sir, is it asked in the examination? Generally not, but it could be asked. Okay, law. And as a student of law, you should remember the definition of law at least, right? Law, a set of rules of conduct recognized and applied by a state to members of the community and enforced by the courts. See, number one thing you have to remember is set of rules, right, of conduct recognized and applied by a state to members of the community. Third one, enforced by the courts. That is very, very important. Set of rules recognized and applied by the state. Recognized and applied by the state. That is legislature and executive. To the members of community and enforced by the courts. That is judiciary. I hope this is clear. Yes, I hope this is clear. Now let's move forward. When we discuss about the major legal systems, what we need to understand here is that there are different types of legal systems that are followed. Some could be civil laws, other could be common law, and third one could be religious law. My dear friends, please remember this is legal systems. Okay, you might feel that certain information is repeated, but please go with the flow right now. Okay, then you can ask any of your questions. Now, when I talk about the major legal systems, let's talk about the civil law first. What is civil law, sir? Civil law is related to the breach of contracts, torts. Okay, so it is also called as Roman law, continental European law, or continental law. Do you need to remember this? Yes. Do you need to mug this up? No. You do not necessarily need to write it in the descriptive answers, but what if there is a MCQ question that what else could be called for civil law? So you have to remember it. So the term civil law also refers to non-criminal branch of law. How you can define it? Non-criminal branch of law. How do I say that, sir? See, non-criminal law branch means what? For example, if somebody slaps somebody else, that is a criminal activity, right? It is not at all allowed as per the criminal laws, penal provisions, right? However, if I breach the contract, is it a criminal activity? No. So what happens is, whenever I talk about the civil laws, what should come into your mind is it is a non-criminal, not allowed action. Non-criminal, it is a non-compliance, it is not following the law, but it is non-criminal in nature. That is, if it is a criminal activity, it will come under the criminal law. But if it is related to non-criminal activity, then it is related to the civil law. That should be your approach whenever you explain anything related to civil law or criminal law. I hope this is clear. Let's move forward. Now, non-criminal branch of law within a legal system by which individuals can seek remedies for legal problems arising between them. That is, it could be contracts, it could be family laws, it could be the tort laws. That is, what we have to understand is civil law deals with non-criminal branch and remedies could be provided. Sir, are we going to discuss about the remedies also? Yes. Okay, but not today. Now, common law. Sir, when it is part of this chapter, then why are we not covering it today? It is not part of this chapter, it is part of the further coming chapters. Okay, now common law. What is common law? It is also referred to as English law, English or American law, or judge-made law. Judge-made law, sir. Can judges make law? So no, judges cannot make law, but what judges can do is Judges can set precedents. Precedents, no, precedents. Precedents, precedents. Okay, what is this precedence of? So for example, if there's some breach of contract between us, okay, and there's an existing case law regarding that if any breach of contract happens in such a case, this has to be compensated. Now whenever there would be any other case regarding that, no argument would be driven by law, it would be driven by that particular judgment, that earlier also this case has happened, similar case has happened, and the judge either of the similar level or of the higher level have passed this ruling, so you have to abide by it. That is called as common law. That is the judgments, the case laws, that is certain precedents, certain practices are set by the case laws or the judgments of the previous judges, and that is called as the precedents or the common law. So in common law, states judicial decisions are the cornerstones of the law. Judicial decisions as in decisions taken by judges. Judicial decisions as in decisions taken by judges. Okay, now the judiciary play an important role in identifying, interpreting and applying the law. Now religious laws, certain laws are religious based also. So in some states are recognized state religion operates or plays a part in the legal systems of the country. The most dominant of these in worldwide terms is Islamic law or Sharia law, right? Now let's talk about the branches of law. When I talk about the branches of law, what we have to discuss here is criminal law. So civil law again, yes, we have to discuss in a little more detail here. Civil law, then double liability. Okay, now but sir, there's a detailed discussion of civil law again. I told you, there could be certain repetitions of it. But sir, how will we identify that? How we write answer in the examination? My dear friends, whatever we are discussing about civil law, you can write anything in any of the answers related to civil law. Don't worry about it. Now let's discuss about it. Law is commonly recognized as having two branches: criminal law and civil law. Criminal law and civil law. Criminal law is the branch of the law through which a state regulates social order by imposing or prohibiting certain forms of behavior. State regulates social order, social well-being also, by imposing or prohibiting. Social order as in what? Social well-being. Imposing or prohibiting. Imposing or prohibiting. Imposing as in what? Imposing as in what? Imposing as in applying. Prohibiting as in restricting certain forms of behavior and imposing penalties on the persons who break the law. Now this penalty could be in the form of some jail time also, right, and sometimes fines also. In most states, the criminal law is contained in statutes or court. Statutes as in legal provisions or courts defining what conduct will be punished and what penalties are to be imposed. Now penalties could be in the form of imprisonment for specified or maximum periods of time, say imprisonment for 2 years, 3 years, 5 years, 10 years. Financial penalties could also be there, and there could be mix of both as well. Now why this line is red, sir? So see, beyond reasonable doubt is the standard of proof in criminal cases. The burden of proof is on the prosecution. What is prosecution, sir? Whenever there is a court case, there is somebody who fights, who argues from the point of view of state, right? Person arguing from the side of state. Okay, now when I talk about beyond reasonable doubt, what is the meaning of it? What is the meaning of this burden of proof and beyond reasonable doubt? See, who will be considered as an offender under the criminal laws, that is decided upon who can be proved as guilty beyond reasonable doubt. So for example, if somebody claims that this person crashed the car to me, I got injured, and then this person ran away. So it is a hit and run case, right? Now, if this person could prove, I'm just giving you an example, if this person could prove that neither me nor my car was available over there, neither me nor my car was present over there when this accident happened. Now this is a reasonable doubt. This is not sure. Maybe they are not able to prove, but somebody is their alibi, somebody is their witness who is claiming that this person, this car was not even there. They were with me, right? So now, in this case, there is a reasonable doubt. So what needs to be proved to give guilty sentence under criminal laws? Beyond reasonable doubt. Proof beyond reasonable doubt. I hope that is clear. Yes. Now civil law. Now civil law. Civil law. Civil law. Civil law is what? Civil law is the branch of the law which allows individual people or organization to seek remedies against one another through the courts for problems recognized by the law. It could be family law, it could be contract law. The laws of contract and tort are examples of civil law. What are torts other than breach of contract? Civil but other than breach of contract. Civil but other than breach of contract. I hope this is clear. Now, the principal remedy in civil law is money compensation payable by the guilty party to the injured party. Principal remedy is money compensation. What is the difference? In criminal cases there could be prosecution, but in civil cases there is no prosecution. That is no imprisonment. In civil cases. I hope this is clear. Now, on the balance of probabilities is the standard of proof in civil cases. That is based on the probability that could be there. If it could be proved that there is a probability that this person could have committed this offence under the civil law, then they might be required to make certain payment to the person who is getting damaged. The burden of proof is on the claimant. Claimant as in the person who is claiming the compensation. The person who is claiming the compensation. Okay, to show that the defendant was more likely liable than not liable. That is, there are greater chances. That the person is liable. That is, there are, what they have to prove, the claimant has to prove that there are greater chances that the person is liable than not. That is, the proof in the favor that they are liable is more than the proof that they are not liable. Okay, I hope this is clear. Now, double liability. What is double liability? See, we have understood so many things so far, right? Now let's discuss about what is double liability. What is double liability? What is double liability? So some forms of behavior may raise both criminal and civil liability. Example, fraud. Fraud is a crime, right? Fraud is a criminal activity, whereas it is also a matter of private law. For example, if somebody has defrauded me in my firm, it is one criminal activity that they have done, that they have committed fraud in the course of their employment, but I could also file a case for the purpose of distrust that they have shown, for the purpose of disobedience, negligence that they have shown. That is also civil liability. So there could be certain activities like fraud that could bring up criminal as well as civil charges. Okay, so that is very, very important. The state will seek to punish the offender under the criminal law, and the victim of a fraud may seek to bring civil proceedings against a fraudster for compensation. In most legal systems, the civil and criminal aspects of the case will be considered in separate proceedings in separate courts. Okay. Now, civil law. Again, civil law, sir? Yes, but in a little more detail. Civil code is there. Civil code is there. A codification of private law related to contracts, property, and obligation. That is, there are certain laws which have been created specifically for this. One example in India is the Indian Contract Act. Internationally also there are Contracts Acts. Internationally also there are Sales of Goods Acts. So that is part of this part. Now, role of judiciary in civil law system. Role of judiciary. What is the role of judiciary here? Do they have to interpret the laws, create the laws, pass the case laws? So, civil law judges are legally qualified professionals. They apply and enforce the law. And decide criminal and non-criminal cases. The use of jury is unusual in civil systems. What is jury? Multiple judges. In simple language, I could say multiple people other than judges. So earlier what used to happen was that whenever there used to be a trial, there used to be one judge, there used to be 10-12 people who used to sit as jury. So the case is presented to the jury also decides and helps the judge in making the right judgment. This is not required in case of civil laws. Okay, so use of jury is unusual. Okay. Now, civil judges generally do not interpret or reinterpret the law. Do not generally interpret or reinterpret the law. That is what they do. They just apply on the facts basis. Their function is to apply the law in line with what is says and with the social purpose for which it was created. That is, what they have to do, they have to apply the law in letter as well as in spirits. In letter as in what is written, whether that is applicable 100% or not, and in spirits, that is whether the outcome is as per the legal expectation or not. That is, with what intention, with the intention that the law was created, whether that outcome is being achieved or not. Okay, so that is whether law is followed in letter and in spirit or not. Okay, I hope this is clear. Now, whenever a new situation arises, they consider the historic intention behind the relevant law and apply the law so as to cover the new situation in line with the historic principle. That is, if new situation arises, what they do, they just go back, recheck that with what intention the law was created, and they just try to achieve that intention, achieve that particular outcome. Now, common law. In a common law system, one has not only to look at the legislation made by the parliament, but also in the cases for the judicial statement that actually constitute that common law. That is, we have discussed common law means judgment. So here you do not just need to look at the law, you also have to look at how the state has dealt it, how the senior judges have dealt it, or the judges of the similar level have dealt it in the past. If similar case has happened, how they have dealt it, and you have to pronounce the judgment, you have to announce the judgment based on that. Common law is judge made. Statute law is produced by parliament. This is very important. As parliament is sovereign, it can alter common law by enacting legislation to that end. That is parliament or legislature could alter what? Could alter common law. That is, if some judge have made certain judgments, but if legislature feels that this is not appropriate, what they can do, they can alter it via passing the newer laws. Now, case law, this is the judicial interpretation, explanation and application of law by reference to individual cases. That is done by judiciary, done by judges. The interpretation, explanation, application done by the judges. I hope this is clear. I hope this is clear. I hope this is clear. Yes. I hope this is clear. Now, the legal principle on which the decision rests sets a precedent. Precedent as in what has happened before. The legal principle sets a precedent. Precedent as in what has happened before. Set practice, right? Which must be followed by judges of equal or lower rank dealing with similar situations in the future. That is, if a high court judge has passed certain judgment and it is recognized as a common law, then every high court judge or every district court or sessions court judge has to abide by that particular ruling. Can a Supreme Court judge overrule this? Yes, they can. However, common law states are not regulated exclusively by judge-made law. Case law is supplemented by international treaties also. That is, case law is not a direct form of legislation. It could not happen that only the case laws are referred to take the decision. There are international treaties, there are international transactions, there are international relations also that needs to be kept in mind, international laws that needs to be kept in mind. Okay. Now, the judiciary has an important role in interpreting and applying these laws. Role of judiciary in common law system. Role of judiciary in common law system. So, the duty of a judge in common law system is not to make the law, but to identify, interpret and apply fundamental principles of common law. Not to make the law, but to identify, interpret and apply fundamental principles of common law and to interpret the statute. That is, they have to look for the fundamental issue that the law was trying to address. How is the intention of addressing it? What should be the best course of action that is taken care of here. The general rule is that precedent set by higher courts bind judges in lower courts. Now, points to note. A precedent will, it's not precedent, okay? A precedent will not be binding in a later case if it was wrong, that is, with a lack of proper attention to relevant laws of access. That is, it will not be applicable in case of inconsistent facts. Okay, then a precedent will not apply when the facts of a case are materially different so that it can be distinguished from those before the court. So, different facts. Here, negligence or ignorance is also covered. Then the precedent or ratio of an earlier decision by a lower court may be subsequently overruled in another case decided at a higher level. That is, higher court could overrule. That is, higher court. It's not could, it's higher court could overrule judgments of lower courts. Okay, that is also very important. The earlier judgment is not changed, but the precedent is set aside and will not be followed in future. That is, the judgments that has already been made, that is not changed, but for future it is changed. A higher court may also reverse, overturn a decision of lower court on appeal. The earlier decision is nullified. Okay, that is, sometimes if you are not happy with the decision of the lower court, you can apply to the higher court and then they can nullify the decision given by the lower court. Now let's talk about Sharia law. Okay, Sharia law is an Islamic law. So Sharia law is the law of Islamic religion. Sharia addresses all aspects of life, personal, business and public. In business life, Sharia law prohibits as in does not allow. Sharia law does not allow following. Does not allow following. Okay, number one is riba. Riba as in the making of money from money, that is charging interest, usury. The action or practice of lending money at unreasonably high interest rates, and business activities which exploit or contradict the principles of Islam, that is not at allowed, that is prohibited under the Sharia law. Now there is no trial by jury in Sharia law, no trial by jury is not allowed here. However, the judge is assisted by an advisory council. Advisory council is there of scholars and eminent people who help the judge make the right decision. Okay, and to bring all information to the judge. Now to the attention of the judge. Now they will suggest verdicts which can inform the judge's own reasoning. The members of the advisory council must be capable of independent juristic reasoning and should be of good character. That is very important. Now conflict of laws. Conflict of laws. Whenever we talk about conflict of laws, there could be majorly three conflicts. The key issues are whose courts have jurisdiction, that is whether it is under the jurisdiction of high court, civil court or what. Generally what happens is, say civil laws up to a certain level is given to the civil judges, but civil courts, but a money related transaction up to a certain or above, beyond a certain limit is given to the high courts. Question of facts are generally given to district courts. Question of law is generally given to the apex court, which in India it is Supreme Court, right? Whose laws are to be used, whether international or national, how and where the judgment could be enforced, whether the judgment could be enforced in this country, which country, where the judgment is, where is the jurisdiction. Now let's talk about the international law. Do you need to remember this? Yes, please. Can this be asked in the examination? Yes. Now, international law. When I talk about international law, it by default it means that it is applicable or it might be applicable to multiple nations, right? Multiple nations. So private international law describes different countries' internal mechanism for dealing with international contracts and recognizing foreign judgments, whereas public international law governs the relationship between states and international organizations. So see, describes different countries' internal mechanisms, okay, whereas governs the relationship between states and international organizations. Say treaties are part of the public international law, including international conventions and treaties. This syllabus is concerned with aspects of public international law in the way in which they affect international trade agreements. That is, here we are going to have very little discussion of the private international laws. We are going to discuss more about the public international laws and in the way it affects the business as well. That is something that we are going to discuss. Now we can come to the last heading of the chapter, which is public international law. We can come to the last heading of the chapter, which is public international law. Okay. So a number of international bodies contribute to the formulation and application of international law and cross-border trade regulation. That is, there are number of regulations, number of bodies, number of associations, number of committees that helps in creating this particular law. International trade bodies includes European Union. So do we need to remember it? Please. See, it might not directly be asked in the examination, but you are studying law, so it is very important for you. The Eurasian Economic Community, the Organization of Petroleum Exporting Countries, OPEC, Mercosur, the Southern Common Market of South American countries. Please remember it. Okay. Now, the international regulatory and harmonization bodies which have particular impact on the ACCA Law global syllabus are, this definitely needs to be remembered again. The United Nations, but do you need to remember word by word? No. You should just know that there is something called as UN, there's something called as ICC, there's something called as WTO. Union Nations Commission on International Trade Law, there's International Chamber of Commerce, International Code of Arbitration, World Trade Organization, Organization for Economic Cooperation and Development, International Institute for the Unification of Private Law. Okay. Now, some important pointers. What do we mean by this? Some important pointers. See, there are these many institutions. Every such body, every such institution plays very important roles. But do we need to remember everything? No. What we have to understand and remember is this. So I have taken out certain points from each one of them. WTO, which is World Trade Organization, has the highest explanation, largest explanation, because it is usually asked in the examination as well. So the United Nations. What you need to remember about the United Nations is, although you should give a good read to the study up also, but what you should remember about the United Nations is, the United Nations operates worldwide, best known for peacekeeping and humanitarian assistance. So whenever there is a conflict between two countries, generally on humanitarian grounds, UN gets involved, UN gets it resolved. The UN and its specialized agencies, funds and programs work on a broad range of fundamental issues, including economic and social development. When I talk about the UN Commission on International Trade Law, okay, it issues convention and model laws on aspects of international trade law. Convention and model laws, as in convention as in the agreement that should be made between two trading countries. Model laws as in the structure, the proper format of the laws that could be followed by different countries in a ready-made format. International Chamber of Commerce. So say the country specific Chamber of Commerce is also there. Similarly, International Chamber of Commerce is there, right? So it helps in promote inclusive, sustainable, greener trade, provide rules and standards for international business, and to help companies and states settle international disputes. All of this is done by International Chamber of Commerce. Okay. Now, World Trade Organization. This is important and this is important. These two are sometimes asked in the examination. Now, World Trade Organization. The WTO's main objective is to help trade flow smoothly. Okay. Objective is to help trade flow smoothly. That is, there should be smooth flow of trade, freely, fairly and predictably. It also endeavors to ensure that individuals, companies and governments know what the trade rules are around the world, giving them the confidence that there will be no sudden changes of policy. Them as in the countries. Now, the WTO seeks to achieve these purposes by doing what? Do we need to remember this? Please. WTO's objectives are asked in the MCQs a lot of times. Administering trade agreements, that is, they help in understanding and negotiating the trade agreements terms as well, acting as a forum for trade negotiations, settling trade disputes, reviewing national trade policies, cooperating with other international organizations, and assisting developing countries in trade policy issues through technical assistance and training programs. I'll just give you one example. Okay, if there's a discussion going on between, say, India and US regarding import and export of certain regulations, certain items, okay, and there are certain issues that the India is facing regarding agreeing on this trade agreement with, say, US. Who will help? WTO will help. ICC would help. Okay. Now, however, their areas are quite divided. That is, International Chamber of Commerce sets out the practices, whereas WTO sets out the rules and regulations. Okay, that is the major difference. Now, Organization for Economic Cooperation and Development, OECD. This is also discussed in AA and AAA syllabus as well. So, the aim of the OECD is to help its member countries to achieve sustainable economic growth and employment, and to raise the standard of living in member countries while maintaining financial stability. That is, what is their purpose? Their purpose is to increase the lifestyle or the quality of life in the member countries. Now, the last heading for today, which is International Institute for Unification of Private Law. So, its purpose is to study needs and methods for modernizing, harmonizing and coordinating commercial law as between states and group of states. That is, their main purpose is to do what? Their main purpose is to bring harmonization between different laws and regulations and to bring harmony in the country. Now, my dear friends, this is something that we have covered. This is chapter number 1, essential elements of legal systems, that we have covered. We discussed about the economic systems, political systems, legal systems. We discussed about economic systems in detail, then political systems in detail, then we came for the legal systems. Under this, we discussed about criminal law, civil law, common law, right, and double liability also. Then we discussed about some more aspects of it. Then we discussed about Sharia law. Then we discussed about conflicts of law. Then we discussed about international law. Then we discussed about public international law. And then we closed this discussion. Now, when we will be meeting for the next time, we will be covering chapter number 2. That is an extension of this particular chapter, and you are really going to enjoy it. Now, what I'll suggest is, Please read it carefully once more. Just in case if you have any doubts, please feel free to ask me. You can ask me on the app, you can ask me on the WhatsApp also. Now when we discuss about what you should what you should do further, what you should do is you should go through the ACCA study hub also. Just in case if you have any reference material that you want to refer, you can go through that also. You can ask any doubts to me, be it from the any reference material, but I would strongly suggest just stick to this book and you will cover everything. Okay, don't worry about it. Even if you feel like reading something more, please go through the ACCA study hub. Okay, you can solve the questions also, but we will also be solving certain special questions taken from each chapter. That is how we are going to cover. So all the very best. See you in the next lecture. Thank you. Hello everybody, hope you all are doing really well. I am CS Subrita Agrawal, your faculty for ACCA AA, AAA and law subjects. My dear friends, in the last class we have completed chapter number 1, and chapter number 1 gave us a great understanding about how the legal system works, what kind of laws are there, what kind of codes are there, right? However, today's session is again going to be very interesting for you. And why do I say that? What happens is, whenever there is a fight between two people, they generally either resolve it themselves, or if the fight is between kids, sometimes say parents gets involved. If the fight is between say two partners, they might mediate among themselves, they might negotiate among themselves. But what happens is, whenever these disputes happens in a corporate or a formal setting, then there are fixed rules and regulations on how to resolve it, and there are a lot of choices that makes all the difference. That is, there are different ways of resolving these disputes. Some ways are very commonly known to everybody, like litigation. However, there are certain ways which are very new for everybody, and this chapter is going to be very interesting, because in this chapter we are exactly going to cover those alternate ways. That is why the name of the chapter is chapter number 2, which is dispute resolution mechanisms. So here we will learn something about the litigation, and we will focus more on the alternative ways of resolving these matters. First of all, let's first understand one thing. Is this chapter really required in your ACCA syllabus or in any professional course for that matter? So please try to understand one thing, that disputes is an inevitable part. Whenever there is a formal business that is going on, whenever there is any transaction going on, or in simple terms, whenever there are multiple people involved, there might be certain disputes. In fact, there will be certain disputes. What is more important is, how do you resolve those disputes? I'm not giving you any relationship counseling over here, my dear friends, but it is very important for us as chartered accountants, as certified accountants, to know about how to resolve these disputes, because business should be a going concern. No dispute should be capable enough to disturb the flow of the business, right? So that is why it is very important for all of us to understand why these dispute resolution mechanisms are created and what are these dispute resolution mechanisms. So my dear friends, first of all, let's try to understand one thing, that this chapter is going to be very specific. That is, it is going to talk about certain specific terms, certain specific pointers that you need to remember also, and that is why it would be very required from our end to read it once. And I would strongly suggest again to go through the ACCA study hub also. Okay, so now my dear friends, the first heading of this chapter is international commercial arbitration institutions. There are certain institutions which are created on an international level. So what is this word arbitration? This is something that we are going to learn for the first time, right? Yes, my dear friends, this is the term that you are going to learn for the first time. Okay, this is one part of alternate dispute resolution, and we are going to throw a lot of light on this particular topic in this chapter. But please try to understand one thing, that whenever we say I will see you in court, that is part of the litigation. But what happens is, let me give you one example over here to understand why this alternate dispute resolution, that is arbitration, might be required. And as we move forward in the chapter, we will also learn about what are other ways of resolving these disputes in an alternative manner. But let me give you an example over here. Say there are two brothers, okay, X and Y. So why do you talk about X? This is X, alphabetic X, okay. So X and Y. Now what happens is that these two brothers are billionaires of the country, okay, billionaires of the country, billionaire 1, billionaire 2, okay. Now they have a family business, okay, and they had one father, okay, they had one father Z, who was multi-billionaire, okay. Now this father died, okay, and now there's a dispute that is going on regarding how the business would be divided among these two brothers. Okay, Mr. X is saying that I will get business A, B, C. Mr. Y is saying I will get business A, B and D. Okay, now C and D is pretty clear that okay, X is okay with getting C business, whereas Y is okay with getting D business. But what about these A and B? Now to settle this, assuming that there is no will that is provided, there is no inheritance certificate that is provided, now how will they resolve this dispute? They can go for litigation, right, or they can go for ADR. What is ADR, sir? Alternate dispute resolutions. Okay, now one of this ADR is arbitration. One of this ADR is arbitration. So what is the benefit? See, we will learn about all of that in a little more detail just in this chapter only, but let me give you a brief about it. Okay, in case of litigation, it would be publicly known, generally it would be publicly known that this case has been filed. Okay, the documents would be available publicly. There could be some reputational loss that could be done to the firm or to the company, to the family, right? However, if we just talk about arbitration, okay, if we give them the choice on what facts they want to disclose publicly, what they don't want to disclose, the hearing would be sealed, the documents would not be made public, right? So it will save a lot of time for them as well, because they don't have to rely on the court to make the decision, and the decision would also be binding on them, and they will save a lot on reputational risk also, because these both are billionaires. Every second of reputation loss might cost millions and billions also to them, right? So this is very, very important. This is one part of arbitration. Okay, now sir, are there others also? Yes, there are others also. As we progress through the chapter, we will learn about it. Okay, so I hope the agenda is clear of the chapter, right? Now let's go further. I hope this arbitration word is also clear. Now let's go further. So there are a number of major international institutions and rule making bodies that provide alternative dispute resolution. We know about it. ADR mechanisms outside the formal code structure. This is outside the formal code structure, that also we have discussed, because there here two people or the people involved in the transaction could decide on how to resolve the issues, right? For the resolution of disputes involving international commercial agreements. Okay, facilitating bodies include International Chamber of Commerce, ICC. Sir, do we need to remember these full words? Yes, you have to remember. You should know that ICC stands for International Chamber of Commerce. Okay, you should also understand that LCIA stands for London Court of International Arbitration. You should also know that Singapore International Arbitration Center is there, which is SIAC, and let me tell you that this is one of the most famous, most popular arbitration centers in the world. Okay, now the essence of alternative dispute resolution process is that they do not operate under the fixed terms of reference and compositions of courts of law. Now this is a wonderful line to explain the process of arbitration. Let me explain every word here. The essence, that is the importance, the significance, okay, of alternate dispute resolution, we will call it ADR. Process is that they do not operate under the fixed terms, do not operate under the fixed terms, that is parties involved could decide the terms, right, and compositions of courts of law. Composition as in, that is parties involved could decide who will be the arbitrator. I hope this is clear. I hope this is clear. Yes, I hope this is clear. Okay, now the ICC. What is ICC, sir? We understood something here, right, my friends? So this is ICC. That is why it is very, very important, right? What is ICC? International Chamber of Commerce. So the ICC, International Court of Arbitration, is there. Let's learn about it. Okay, do you need to mug up these lines? Definitely not. Do you need to understand it and be able to write the crux? Yes. What you should remember over here, that they are free, the parties involved in an arbitration process are free to decide the terms as well as the composition of the arbitration process, right? Now the ICC provides various business dispute resolution mechanisms. It provides services to. So, how you have created these notes? So, my dear friends, I'll tell you the best source of creating these notes has been the ACC Study Hub. I have read the ACC Study Hub fully. I have taken out certain important pointers from there which are relevant for you for the examination, as well as I have gone through other reference materials like BPP, Kaplan, and I have taken out certain important pointers from there as well. Then what I did is I also gone through the questions. I realized and I identified that there are certain pointers which are repeatedly asked in the examination. So, I have approached that points also here. I have not created a separate heading for exam important pointers, but what I have done is I have included it in the paragraph. Somewhere at some places what I have done is I have changed the language so that it is more from the point of view of examination. Okay. Now, and I have deleted the duplication parts. Now, it provides services to individuals, businesses and governments. That is, this International Court of Arbitration is not just for the business, it is for the individuals, businesses and governments. Okay, that is ICA. ICA provides services to individuals, businesses and governments. Should we note it down? Yes. There could be an MCQ on that. Therefore, ICA is not just for businesses. I hope this is clear. Yes. Now, to help resolve difficulties in international commercial and business disputes to support trade and investment. Now, its purpose is to ensure proper application of the ICC rules as well as assist parties and arbitrators in overcoming procedural obstacles. Okay, so it generally helps in operations as well as proper conducting. The ICA is not a code in the ordinary sense. This is very, very important. Not a code in the ordinary sense. That is, if tomorrow there is an MCQ that is ICA or can ICA be called as a court as well, so you need not write it, then yes, it could be called a court in some sense. No, it is not at all a court. Okay, everybody is very clear that it is not at all a court. Its responsibilities is nowhere related to the court. It is just an alternative dispute resolution. For example, if I am your teacher, you are my student, if any dispute happens in this relationship, how we will be resolving it, we can only decide. That is one part of the arbitration. Okay. Now, it oversees the process of arbitration of disputes following established arbitration codes. Okay. Now the responsibilities. Okay. So, ICA is responsible for overseeing all aspects of the arbitration process. ICA is responsible for overseeing all aspects of the arbitration process. That is, if anything goes wrong in the arbitration process, even if the parties have decided their terms, who will be considered as responsible? Who will be considered as responsible? The ICA would be considered as responsible. Hope that is clear? Yes. Now, including what? Confirming, appointing and replacing arbitrators. But sir, you just told us that the parties involved in the arbitration process are free to choose their arbitrators. Yes, but they have to have certain boundaries, no? And if that boundary is crossed, who will be considered as responsible? The ICA would be considered as responsible. Okay. Now, as well as deciding on any challenges made against them. Monitoring the arbitral process. We are going to discuss about an arbitral process in this chapter. So, monitoring of that process, whether that process is being followed appropriately or not. Just in case if it is not followed appropriately, then what corrective measures needs to be taken, that also needs to be decided by ICA. Okay, to make certain that it is performed properly and with the required speed and efficiency necessary. Now, scrutinizing and approving all arbitral awards. So, what is this arbitral award? What is this arbitral award? So, this arbitral award is similar to the verdict of the court. Verdict of the court, right? What happens is, let me tell you what happens is, if you apply for any proceeding in a court of law, the final verdict, the final decision that you receive is called as verdict, right? But in case of arbitration, whenever you apply for arbitration and you get the decision, it is called as arbitral award. You know, my dear friends, the beauty of this chapter today is that I have just signed an agreement with some party, okay, and there has been one arbitration clause, and we have agreed that if anything goes wrong in this relationship, then how we are going to resolve it? We are going to resolve it through arbitration at a certain specific location and jurisdiction as well. So, this is one chapter that I have just now exercised few hours back, okay, and now I am teaching you this chapter. So, this is very, very important. Now, setting, managing and if necessary adjusting fees and advances. See, what happens is, although arbitration procedures, terms, conditions, everything is decided by the parties, but there should be certain restrictions on that, that this would be the minimum fees, this would be the procedure, fees would be payable on this regard or on this part or on this day. That is what is under the jurisdiction of ICA. Now, overseeing emergency proceedings before the start of the arbitration. Sometimes there are emergency proceedings. What could be called as emergency proceedings? So there are no clear guidances regarding it, but if I have to explain emergency proceedings, that could be called as some proceedings where every day of delay could result into huge losses, either for the parties or in the national interest or in the public interest. Okay, those could be called as emergency proceedings. Now, so what are these maroon or red lines that you have noted down? We have seen it in chapter number 1 also. These are some of the important pointers that you should remember word by word. For example, litigation. If somebody asks you what is litigation, you might not be able to explain it via your own words. So that is why you should remember it. The process of bringing a lawsuit or claim in a court of law is called as litigation. Litigation. So what is this? This is alternate dispute resolution. Exactly opposite or two types of the dispute resolution. Yes. So the primary part is the litigation and alternative dispute resolution is one another part. So when are we going to discuss about litigation? Just after this. Okay. So don't worry. Now, alternate dispute resolution, some more pointers about it. A number of alternatives to litigations which are recognized domestically and internationally. Area mechanism includes negotiation, conciliation and arbitration. So what are these three terms? This is one of the most important paragraph for you. Why? Because this is term number 1, which is of area, number 2 conciliation, number 3 arbitration. If I have to create a chart, you know how I will create it? I will create it through dispute resolution mechanism. Okay, at one place I will say litigation, at another end I will say ADR, alternate dispute resolution. Under this I will call it as negotiation, conciliation and arbitration. The only catch here is this conciliation is also called as mediation. Why? We will just now understand. Okay, so this is a kind of chart that you should create. Okay, now alternate dispute resolution. A number of alternatives to litigations. Okay, one is ADR includes negotiation, conciliation and arbitration. This conciliation is also called as what? Also called as mediation. So why you have not written it here in the notes? Because I have written it here. Okay, so don't worry about it. Okay, now negotiation and facilitator. What happens is facilitation. What happens is, see, if I tell you that there has been a dispute between say two people, X and Y. Okay, now they want to sort it out. Assuming it is not a business dispute, it is a personal dispute. How they can resolve it? They can resolve it through counselors. If these people are couple, they can go to couple counseling. If these people are business partners, what they can do is they can go for the business counselors, and counseling could help, right? Similarly, in case of formal settings, there could be a professional negotiator. See, businessman A, businessman B are fighting. There could be a negotiator, and there are firms like that, and those firms are sometimes run by chartered accountants as well as ACCAs as well. So chartered accountants and ACCAs working as a negotiator. Yes, see, we are the people who understand the business from the point of view of costing, from the point of view of finance, from the point of view of taxation, from the point of view of law, right? From the point of view of accounting, from the point of view of audit. So just now we realized how many subjects do we study, right? Yes. So we understand so many things. That is why we as professionals are very much capable of entering into negotiation. We can help two businessmen enter into negotiation and negotiate and finalize the terms which are in the interest of both of them. So that is also a very good area. Are there firms like that? Yes. Now, in negotiation, facilitation, one or both parties will usually have recourse as in reference, to a trained negotiator, okay, or facilitator, to present their interest in discussions leading to a resolution which the parties themselves reach. Okay, so here there is negotiator who help them identify the facts, identify the issues, and they both only agree on the thing. Okay, so the decision is not given by the negotiator. What is more important here is that is decision is not given by the negotiator. I hope this is clear. Now, in mediation or conciliation, so there is one party who will help them identify the issues, resolve it among themselves. An impartial third party, impartial, okay. A mediator facilitates dealing between the parties, moving them towards their own resolution, but without imposing a resolution on them. That is, that party helps them identify the issues, make the decision, but they do not impose. That is, they might make a decision, but it is not binding, okay. That is what help in taking decision but not binding. Now comes the third one, which is arbitration, and which is the soul of this particular chapter. Now here, what would be the catch? The decision would be binding, okay. Now, in arbitration, the parties refer their disputes to an arbitrator or arbitrators. That is, there could be one, there could be more, whose function is to evaluate the case and impose their own resolution. Impose, that is decision is binding. Hope this is clear. Decision is what? Decision is binding. I hope this is clear. Okay, perfect. No issues? Yes. Any issues? Do let me know. Yeah. Let me go through the chats. Yes. Any issues? Okay. No. Excellent. Okay. Now this page is dedicated to litigation. Then after this, all the pages are dedicated towards arbitration and its related process. So this is a short chapter, yes, but a very important one. Okay. Yeah. No questions? Thank you. Either you are understanding everything or you are understanding nothing, right? No, I am sure you are understanding everything. Okay. Now litigation. What is litigation, sir? What is litigation? See, litigation is very, very simple. Litigation is when a matter is referred to a court of law. We have already understood it, right? So common features of all legal systems are that each national court system will have a formal set of procedures to be followed, with decision being based on the appropriate national laws and issued by judges. This is one more definition of the litigation. A hierarchy of appeal courts is there. Hierarchy of appeal courts in India. Example, in India, district or sessions court, then there is high court, and then there is honorable Supreme Court, right? This is very, very important. Okay. Now, so that a party who is unhappy with judicial decision may follow a formal process to have the decision modified, reversed or cancelled in a higher court. Have you seen any movies where the lawyers say that, sir, we do not agree with the decision and we are going to appeal in the higher court? Sometimes if Supreme Court has given certain decision, you cannot go to a higher court because it is the highest apex body, right? But if some decision is given by, say, the Honorable High Court, then what you can do is you can apply to Honorable Supreme Court to get that decision either reviewed or modified or amended. However, if the decision is given by Sessions Court or District Court, then what you can do is you can go to the Honorable High Court or Honorable Supreme Court as the matter is relevant. Now, advantages and disadvantages. So, do we need to remember it word by word? Definitely not. Do we need to remember the definition of litigation? For sure. But do you need to remember the advantages and disadvantages word by word? No. You should be able to write at least 2-3 pointers for each, but you should not be able to remember it word by word. Okay, don't worry. Now, availability of appeals. Advantages is availability of appeals, that is you can apply anytime. Now, finality. The final decision is in a case is binding on the parties. That is one advantage, that if the decision is given by court, then it is binding. Sir, but arbitration decision is also binding, right? But what happens is arbitration is not always the alternate dispute resolution. There could be mediation, there could be negotiation where the decisions are not binding. The use of legal rules, principles and precedents in the judicial system may give parties a degree of predictability. That is, they might be able to understand that what would happen in certain cases. For example, if there is a case of say a partner embezzling from his own firm. Okay, now there would be precedents that is available. Precedents as in what? The past. We have discussed about the common law, right? The precedents. So there would be precedents that would be available, that in such a case this might be the outcome. So predictability might be there, but in case of arbitration, in case of alternate dispute resolutions, that predictability might not be available. It is possible for the parties to estimate the likely outcome of the case and possibly agree a settlement. Now let's talk about the disadvantages part. Okay, disadvantages is it's formal, judicial, impersonal nature. Impersonal in nature. What, sir? But how is this a disadvantage? How is this a disadvantage? This should be the advantage, right? But see, let's again remember those two brothers who were fighting among themselves. Now they want the decision to be as soon as possible so that they can run their businesses, grow it further. Now, since it is a formal procedure, it might be taking some time. In case of arbitration, they might decide their timings of meeting based on the availability of both the parties, but in case of courts, they have to be bound by the decisions of the court, by the decisions, by the timelines of the court. So it might be a disadvantage. Now, the complex nature of many laws making it necessary for parties to be professionally represented. That is, they might be required to hire an advocate. Required to appoint outside representation, example advocates, right? Now, the international difference between laws, remedies, procedures and objectives in different countries. It might happen that some law in India is different, whereas in some countries it might be different. What is considered as money laundering in India might not be considered as money laundering in maybe in Singapore. What is a crime in Singapore might not be a crime in Switzerland. So that could happen, and whenever there are international boundaries that are involved, the decision making might be very, very different and very, very complicated. Now, the recruitment for expert lawyers to prepare and present the case, again we have discussed it. It's adversarial nature as in the decision might not be in the favor of the parties. It's procedural slowness. Sometimes the procedures are slow, which is further extended if appeals are brought. The expensive, which is further extended if appeals are brought, as in when appeal is made to the higher court, the decision time making time would again be increased. The expensive nature of court proceedings. Sometimes it might be very, very expensive, right? Public nature of court cases. Most hearings are open to the public, so this might be very, very difficult, and these might be the advantages. So do we need to remember it? No. Now let's come to the crux or the most important point of this chapter. We have understood everything we have understood so far just to reach to this point of the chapter. So sir, have we wasted last 30 minutes? No. What we have done is we have understood everything. We have followed the right road. It's like we were hiking and we have crossed through all the right roads, and now we have reached a point where we are going to enjoy the view as well, because now we are sure that what is arbitration, how arbitration is required. At the same time, we are also sure about what is litigation, what is alternate dispute resolution, what is negotiation, what is mediation, right? So all of that we are aware about, but now we have to focus on the most important part of the chapter, which is arbitration. Okay, so arbitration, the process of resolving disputes outside the courts, okay, whereby the parties by agreement refer their problem to non-judicial adjudicators and agree to be bound by the arbitral decision. Do we need to remember this definition? Yes. Sir, every time you were saying no, so we were expecting that you will say no only. My dear friends, it's a shock to you, but it is very, very required. See, I generally ask you to remember two things. One, that is frequently asked in the examination directly, and second thing, which if asked, you will not be able to frame your definition appropriately and will end up losing marks. And that is why I strictly want you to remember this definition. Once you remember this definition, and if it is asked in the examination, I am sure you will not be able to write in your own language, the appropriate language. That is why it is important that you remember it also. Understand every word of it, but then you have to remember it also. Okay, now the process of resolving disputes outside the courts, that we have understood, whereby the parties by agreement. So by agreement, yes, we will understand when we move forward, we will understand that if arbitration is not agreed in agreement, then arbitration cannot be referred to. Strictly via agreement only. That is why strictly via agreement. When we move further, we will also discuss about there are two types in which it could be included in an agreement. We will discuss about it when we move forward. Now, refer their problem to non-judicial adjudicators. What is this non-judicial? Or not other than court appointed judges. Okay, non-judicial, and agree to be bound by the arbitral decision. Agree to be bound, that is arbitral awards are binding. Arbitral awards are binding. So, sir, whatever decision is given by the arbitrations or arbitrators, that is binding. Nobody could change it, right? It could be challenged, but under certain circumstances only. There are very few circumstances under which it could be challenged. Are we going to learn about it? Yes, the last page is dedicated towards that only. Okay. Now, common features. Common features. What are common features? So, a set of general procedures to be followed by reference to the courts of facilitating body, national laws, and or international principles. Decisions are made by the arbitrators in accordance with these principles. That is, international laws are followed. You don't need to remember it. International laws are followed to give the arbitration decisions. It is not solely based on the professional judgment only. Now, flexibility within the general principles for the parties themselves to determine who the arbitrators will be and how the process is undertaken. Flexibility is given. We have already discussed about it between the parties. How many arbitrators could be there? We will learn about it when we move forward. But you try to guess. No, there are two parties who has the dispute. Now, this party would appoint their arbitrator, this party would appoint their arbitrator, these two would again be fighting. It would have been better if these two would have been fighting other than these two newly appointed people. So, generally there are either one or there are three people. Okay. Now, limited appeal mechanism usually only in relation to procedural irregularity rather than points of law. That is, if you have or if you do not agree with the arbitral awards, then there is very limited scope of applying for appeals. Okay, that is, the awards are or the arbitral awards are binding. So, limited appeal mechanism usually only in relation to procedural irregularity. Like we have told you, that there are very few areas on which you can go to the courts for the purpose of appeals that you do not agree with the arbitral awards. So, let us write it over here. That is, if parties do not agree to the arbitral awards, they can refer to appeal only in few cases. Example, irregularity. In procedures. I hope this is clear. Now, let's talk about the advantages and disadvantages. So, do we need to remember it? No, don't remember it, but what you have to understand is you have to be able to write at least 3 to 4 pointers for each of disadvantages and advantages. That's it. Okay. Now, avoidance of the complexity and adversarial nature of litigation. That is, the procedure here is set by the parties only, so it is generally not very complex. Availability of consistent international processes, that is, arbitration process is driven by ICC, International Chamber of Commerce. Then it is driven by International Court of Arbitration, International Council of Arbitrations also. So that is why international laws are present always to refer to the matters. Cooperative, relatively informal nature of process, that is, it is particularly specific to the parties that are involved. Imagine a situation that these two billionaires are running listed companies, they have board meetings and the court have appointed them or have summoned them for the purpose of hearing. Now, they might not be able to attend the board meetings just for the purpose of going for the court, but in case of arbitration, they can decide their timings also, they can decide the terms and conditions also among themselves. Parties' involvement in selecting the rules of law and procedure and in appointing the arbitrators. Rules of law as in by following which laws the decision would be given and how the arbitrators would be appointed. Rules of law, that is, parties can choose which rules and laws would be referred, and appointing the arbitrators, that is, parties can decide who would be the arbitrator. Who would be the arbitrator? Okay. Now, speedier and more affordable than litigation. So, speedier. What is this word? That is, it is more. Its speed is more. Okay. Now, convenience. Dates can be agreed between parties rather than determined by a court, like we have discussed. Privacy proceedings are not open to public. Okay. So, that is very, very important. Flexibility is there and the details are also not made open to public. So, is this important? Yes, because that might save you from the repetition risk. Now, disadvantages. Limited rights of appeal are there. Cannot go for the higher appeal. The decisions are binding. That is, arbitral awards are binding in nature, right? Then need to turn to the courts for enforcement. Sometimes what happens is you might go to the court because even if the arbitration award is given, the other party might not be able to follow it, so you might be required to go to the court. Subjective nature of decision, because the person might not be considering just one law, they might be considering international laws as well. Now, arbitral process. So, what is this arbitral process? What is this arbitral process? What happens is that all of these proceedings that we have discussed, they do not happen on a generic basis. There are specific procedures that is followed to run this particular arbitration process. Okay. Now, from here we have to read and interpret every line, because the process is very, very simple, but this is a process. Okay. So, you have to understand each word over here. So, we will quickly read and we will try to understand everything and we will try to make notes of it. So, the model law is in, if no specific law is created, these laws would be applicable. I have given certain important pointers from these model laws that is applicable if nothing is agreed. So, the model law is designed to assist jurisdictions in reforming and modernizing their laws on arbitral procedure. That is, if no law is created or absent for a particular case, what would be done? That is given by model laws. For example, if it is not agreed that the arbitration award could be challenged in a court of law also, then there would be certain clause that would be interpreted that if nothing is agreed, then they have to challenge it, say within 15 days only if it is written. Okay, that is important. Now, it covers all stages of the arbitral process, from the arbitration agreement, the composition and jurisdiction of the arbitral tribunal, and the extent of court intervention through to the recognition and enforcement of the arbitral award. That is, it is applicable to all stages. Okay, covers all stages. That is important. Now, arbitration agreement. This is very, very important. Literally the 5-star topic of this particular chapter, arbitration agreement. You cannot afford to miss this. Okay, you have to remember it. Now, an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. Okay, but what is important is this one, how the agreement needs to be created. Okay, the agreement could be agreed or could be made as part of the main agreement, or there could be a different agreement for that. For example, if I have collaborated with some institution to provide my training services to them, now in this particular case, either the arbitration clause could be mentioned in the main agreement of my teaching services agreement, or there could be a separate agreement that could be referred. That is, in this main agreement it could be referred that there would be a separate arbitration agreement that would be signed, and there we will decide on all the terms and clauses. That could be done. So, the agreement may be part of a wider contract, in my case teaching agreement. Example, it may be a clause in a trading contract between the parties, an arbitration clause or clause compro. What is this? Compromisor. Yes, it is not in our language. Clause compromisor stands for a specific clause of compromise, how the disputes would be compromised. Now, a separate submission agreement could be there, or compromise made after the dispute has arisen, under which the parties agree to go to the arbitration. That is, there could be a different agreement also. What is that agreement called? Submission agreement. Very, very important. Please remember it. There could be an MCQ on this one. 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 Okay. Generally, arbitration clause and submission agreement is tested in the examination. Made after the dispute has arisen, under which the parties go to the arbitration. That is, there could be a separate agreement also. That agreement would be called as submission agreement. Now let's try to understand each one of these lines, because these are part of the model laws. Okay, if nothing is agreed, then this would be covered or this would be applicable. Okay, yes. Now, a party cannot be made to take part in arbitration proceedings if they have not made an arbitration agreement. That is, no agreement, no arbitration. Very, very important. Okay. Now, an agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally, by conduct or by other means. That is, writing if its content is recorded in any form. That is, if it could be said that this agreement was recorded. It could be oral agreement, it could be written agreement, it could be recorded in some recorders. If it could be proved that it is recorded in some sense, then it is considered as the agreement was made, otherwise not. Then an electronic communication meets the in writing requirement if the information contained is accessible for subsequent reference. Imagine that you have sent a Snapchat message, okay, and this message is going to be trashed or is not going to be visible after 24 hours, okay. Now, will this be called as agreed in writing? No. It should be available for the reference later, okay. That is very, very important. It should be available for reference later on, like email, okay. You can refer it after 1 year also. So that is why it is very, very important, okay. Arbitral tribunal, okay. What is this? The committee that is created for the purpose of arbitration, for the purpose of listening to the queries, to the problems, to the dispute, and then finalizing the arbitral award is called as arbitral tribunal, okay, arbitration tribunal. A sole arbitrator or a panel of arbitrators, there could be one, there could be more. The parties are free to determine the number of arbitrators, otherwise the number will be 3, one by each party, one by each party plus one by both selected. That is, let me explain. X and Y are there, they will select 1, this will select 2, these 2 will select the third one, okay. Now, the parties are free to agree on a procedure of appointing the arbitrators. The parties are free to agree on a procedure of appointing the arbitrators. Failing agreement, failing agreement as in, if you fail to do an agreement, okay, do not try to understand it like the agreement has failed. No, if you fail to do an agreement, each party chooses one arbitrator and the 2 arbitrators appoint the third. If this process fails within 30 days, either party can ask a court to intervene and appoint, okay. So what happens is, either you appoint the arbitrator, you can decide, sir, can this happen that one party will appoint all the 3 arbitrators? Yes, if they agree. If they don't, each party will appoint one and those 2 will appoint one more, that is 3. The decision would be definitely taken by majority only, okay. And if there is only one arbitrator, then that's fine, okay. Now, if they do not appoint within 30 days, then the court may be appointing, either party can apply to the court. A party can challenge an arbitrator's appointment on grounds of, that is, they might say that this person is not capable or this person is not the right arbitrator because, number 1, impartiality or independence being doubtful. That is, they are saying that, you know, this person is the uncle of this person, that is, Mr. X is appointed their uncle only for the purpose of arbitrator. Now, this person is not independent. This person is bound to take decision in the favor of Mr. X because they are relatives. That could be one. Not possessing the qualification agreed to by the parties. That is, if they have agreed that both of them should be the ACCs, the certified accountants, both of them should be the certified accountants. Now, this person could say that this person is not an ACCA, okay. This person is not an ACCA, is not an active ACCA member, or this person has not qualified the ACCA examination. How can this person be appointed as arbitrator? So they can challenge it. Third one, the parties are free to agree on a procedure. The parties are free to agree on a procedure for challenging an arbitrator. That is, they can agree that how they will be challenging. Even from that there could be an agreement. Yes, that is why if those things are agreed, then there is a separate arbitration clause is there. Okay, arbitration agreement is there. Now, failing such agreement, the party making the objection must do so in writing to the tribunal within 15 days. So, do we need to remember this? Yes, these are model articles. Okay, that is, if there is no agreement, this would apply. The parties are free to agree. If not, then 15 days. Okay, from the tribunal's appointment or from the discovery of the defect. Now, the tribunal makes its own decision as to whether it has jurisdiction to hear the case. The tribunal makes its own decision as to whether it has jurisdiction to hear the case. Who makes the decision? The tribunal. That is, tribunal decides the jurisdiction, not parties. That is, parties cannot force the arbitration tribunal to take up the case. Arbitration tribunal will decide whether it has the jurisdiction or not, although either party can challenge the validity of the tribunal. Now, unless the parties agree otherwise, the arbitral tribunal can grant interim measures and preliminary orders before the proceedings have ended to preserve or release disputed assets if asked by one or both parties. Now, this is very, very important. First of all, what is the meaning of this line? Unless the parties agree otherwise. That is, unless it is agreed not to do so. That is, unless it is agreed not to do so, it could be done that the arbitration tribunal could decide to release certain asset. For example, Mr. X and Mr. Y had the dispute. Say this dispute is about a factory, okay, that who will run the operations of that particular factory. Now, what is happening in that particular factory is, every day the factory is not run, there is a loss of crores that is happening. Okay, the arbitration proceeding is about to go on for say 5 months. So, people or both the parties could agree that let's release this asset, let's apply to the arbitrator to release this asset for now. I will take up the operations for now. Whenever the award comes, then we will decide who has the ownership over it, who will be running it. Okay, so that could also be done. That a tribunal could release certain asset on the application. Can they release by their suo motu analysis? No, they have to wait for the application. Okay, now this is very, very important. So, please remember this one. After this, now statement of claim and defense. What is this statement of claim and defense? Statement of claim and defense, as the name suggests, is what? That the party will be submitting one statement of claim. That, for example, Mr. X could say that I claim this factory, the factory that we are talking about, I claim this factory. Mr. Y would be submitting I claim the defense, or I do the defense, that is, it should be given to me. Okay, and this person does not having right to claim the ownership or the operational head of this particular factory. So, within a period of time agreed by the parties or decided on by the arbitral tribunal, the claimant has to stay. Claimant as in the person who is claiming. Claimant, that is, person who is claiming, okay, has to state the facts supporting their claim, okay, the points at issue and the relief or remedy sought. In this particular case, the facts supporting their claim as in why they are the right one to claim the factory ownership. The points at issue, why the other person is feeling that they are not the sole owner. The relief or remedy sought, that is what they want. Do they want the compensation? Do they want the ownership back, or what? Okay. In response, the respondent, that is the person defending, that is the person defending, okay, should state their defense in respect of these particulars unless otherwise agreed by the parties. Now, we know the meaning, unless otherwise agreed, that is, unless it is agreed that it cannot be do so, it could be done. Either party may amend or supplement that their claim or defense during the course of the arbitral proceedings only. All statements, documents or other information supplied to the arbitral tribunal by one party must be communicated to the other party as well. Okay. Now, that is, they should be made aware, that is, parties should be informed about submissions made by the other parties. Hope this is clear. Yes. Now, if the respondent fails to communicate their statement of defense, the arbitral tribunal will continue the proceedings but not treating such failure in itself as an admission of the claimant allegations. That is, if Mr. X has done the claim, okay, has made the claim, Mr. Y fails to defend, then it is not presumed that X's claim has been accepted by Y. No, it is not there. The proceedings will go on. That is, if Mr. X makes a claim and Mr. Y fails to defend, this is not assumed as acceptance of claim by Mr. Y. Okay, and the proceedings will go on. Now, arbitral award. So, what is this? Verdict. Arbitral award is what? The verdict. Okay, hope this is clear. Arbitral award is what? The verdict. I know you must be tired a little, but see, only this much is pending. Just one more page. Okay, 1.5 page to be honest. Okay, just this much. Okay, maximum I feel 15 minutes, 10 to 15 minutes. Let's wait. Okay, and then we will be covering everything. Now, if more than one arbitrator, decision making is by a majority. Okay, that is, if there are 3 arbitrators, 2. If there is only 1, then 1 only. If the parties can come to a settlement, the tribunal will terminate the case. That is, it could happen that 2 parties come to an agreement during the proceeding only, then the case would be terminated. If the proceedings continue to the, so what are these? These are model laws. Okay, these are model laws. That is, if nothing is agreed, then this would be applicable. If the proceedings continue to the making of an award, the decision must be made in writing and signed by the arbitrators. It must give the reasons upon which it is based and the state and state the date and place. So it should be in writing. That is, arbitral awards must be in writing with reasons, date and time. The process is terminated by the final award, how the proceedings comes to an end. That is, how proceedings can come to an end. It's just like how the contracts may be discharged or contracts may be fulfilled. The final award or an order of the arbitral tribunal when the claimant withdraws the claim, that is, either the final award is made, then the proceedings comes to an end, or when the arbitral tribunal decides or gives the order that claimant withdraws the claim, claimant has withdrawn the claim, the parties agree on terminating the proceedings, or the continuation of the proceedings has become unnecessary or impossible. That is, maybe one party has died and their testimony was very, very important for the case. So this is important. Sir, do we need to remember this? Please remember this. I'll write it this way, or let me write it here. Let me write it here. Please remember this. Sir, we are glad you are a teacher, not a painter. Otherwise, this painting would have been thrown out of the window. I know. Yes. Okay. Okay. Now, last few paragraphs. Let's quickly read it. Unless the parties have agreed otherwise. Now, this term is very, very habitual to us, very, very comfortable with us. They each have 30 days following the award to ask the tribunal to. Within 30 days, what they have to do? Correct any computation, clerical or typographical errors, give an interpretation of a specific point, or make an additional award in respect of matters included in the claim but omitted from the award. That is, if they want to correct anything, if they want to interpret anything, or if they want to make an additional award, they have only 30 days time, unless it is agreed that there is 6 months time. Sometimes in a very bigger agreement, or where many factors are considered, there might be more time also that might be given. If the request is justified, the tribunal has 30 days from the request to comply, 60 days for request for additional awards. The tribunal can extend the period if necessary. This is also important, that if the request that is made is justified, 30 days time is given to the tribunal, but 60 days time is given in case of additional awards, because again you will have to go through all the cases. The arbitral tribunal has to go through all the cases. This is also important. So can this be asked in the MCQs? Yes, this is part of the model articles, so this could definitely be asked. Now setting aside, what is setting aside? Setting aside as in, can this happen that after getting the arbitral award, some party could apply to the court as well? So let's see, the parties have limited right to have recourse to the court. Recourse as in reference to the courts against an arbitral award. They cannot go, right? The rights only apply when there has been a serious procedural irregularity. That is, you can apply, we have discussed in the starting, you can apply if there is a serious procedural irregularity. That is, you cannot apply for the purpose of changing the arbitral award. You can only apply that the procedure has not been followed appropriately, then only you can challenge the arbitral award. Now a party, what could be examples? A party to the arbitration agreement was under some incapacity, or the arbitration agreement is not valid under this law to which the parties are subjected it. Okay, that is incapacity of the party, or arbitration agreement is not valid. Then the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. Okay, so not given proper notice or unable to present his case. Okay, do you need to write the exact words? No, you can write it in your own language. The award deals with a dispute or makes decision beyond the scope. That is, the decisions are beyond the scope. Okay, now decision or the matter that has been considered is beyond the scope. Then the composition of the tribunal is not in accordance with the agreement. Composition is not in accordance with the agreement. That could be one. Okay, do you need to remember this? Please do it. But sir, earlier you were saying you do not need to remember anything. My dear friends, the chapter is of say 7 pages. I am asking you to remember 3-4 pointers. I think that is justified, right? Now, an application for setting aside must be made within the 3 months following the party's receipt of the award. This is written where? This is written in the model articles. The court can suspend the setting aside proceedings to give the arbitral tribunal an opportunity to resume the arbitral proceedings, or to take such other action as in the arbitral tribunal's opinion will eliminate the grounds for setting aside. Okay. Now that is, court could ask the arbitral tribunal to resume the arbitral proceedings if it feels that the arbitral award needs to be reviewed or revised. I hope you have understood this particular chapter, and with this we complete this particular chapter. What all things we have understood in this chapter? Let's have a quick revision. So we started with chapter number 2, dispute resolution mechanisms. First of all, we discussed about international commercial arbitration institutions. Then we went for the discussion of International Court of Arbitration. Then we discussed about the responsibilities of ICA. Then we discussed about brief definition of litigation and alternative dispute resolutions. Then we discussed about negotiation, mediation and conciliation also, and arbitration also. Then we discussed about the advantages and disadvantages of litigation. Then we discussed about the advantages, disadvantages, common features of arbitration. Then we discuss about the arbitral process, arbitration agreement being one of the most important points of this particular chapter. Then we discussed about the arbitral tribunal. Then we discussed about the arbitral awards, and finally we move towards the last discussion, which is setting aside, that is referral to the court. Now all of the things that we have understood in this chapter is majorly driven by model laws, because the parties are free to decide the terms among themselves. They are free to decide the days, the period among themselves, the procedures among themselves. But just in case if they fail to agree, then what procedure would be applicable via international laws? That is something that is covered in this chapter that we have understood about it. Now I would strongly suggest you to go through the ACCA study hub and solve the questions also, although we will also be solving a lot of questions. But I hope you like this session. And now if you want to attend lecture number 3, please do let me know that what is your level of understanding of chapter number 1 and chapter number 2, and then we will be discussing about how do you need to proceed further for chapter number 3. I hope you have understood everything. All the very best. See you in the next lecture. Thank you so much. Hello everybody, hope you all are doing really well. I am CS Agrawal, your faculty for ACCA AA, AAA and law subjects. My dear friends, I welcome you all to this session, which is for chapter number 3 of your law syllabus. And let me tell you that this chapter is going to be your favorite chapter after you study this. Why do I say that? Because as of now, we have only understood about the facts, we have only understood about the international laws. But in this chapter we have to understand with a lot of examples, because this chapter is not just based on facts, but this chapter is also based on the real life understanding of certain things. So to make you understand everything very clearly, I'll have to take a lot of examples, and I'm sure that you are going to love it. See my dear friends, in case of law, every chapter has a different way of understanding it. Once you understand it from the right point of view, once you understand it from the point of view of getting it for the exam purpose as well as for the real life, you will really love all the chapters. But this one is again going to be your favorite only, that I'm sure about. Now let me explain what is the content of this particular chapter. When I talk about chapter number 3, chapter number 3 is CISG, contract formation and obligation. So what is this CISG? You will get to know, don't worry about it, okay? But contract formation and obligation. So what is a contract? What is a contract? My dear friends, I launched my classes for ACCA Law. You enroll for it. Do we have a contract? We'll have to figure out today, right? If I tell you that I launch a test series and you enroll for it, do we have a contract? Again, we'll have to discuss about it. If Mr. A offers Mr. B something and Mr. B says yes, do they have a contract? If Mr. A offers something to Mr. B and Mr. B says no, do they have a contract? If Mr. A offers certain thing to Mr. B, Mr. B says yes, but then Mr. B, after certain things that I don't want to enter into this contract, and now Mr. B wants to say no, how he can say no? That is also taught in this chapter. How Mr. A should communicate his offer to Mr. B, that is also very important. So here we are going to learn about offer, we are going to learn about acceptance, we are going to learn about agreement, we are going to learn about contract, and there is going to be a new term which is going to enter your life, which is enforceability. We are also going to learn about the enforceability, okay? So all of this content is going to make this chapter very interesting for all of you. Now what is going to be the best way of understanding it? So see, we can see that this chapter is divided into 7 pages, but what I have done is I have created this chapter in the form of bullet points. That is, instead of giving the headings then explaining via paragraphs, what I have done is I have given the headings and I have explained everything, literally everything, via bullet points. So what we will have to do is we will have to figure out one bullet point at a time. We will take one bullet point, we will understand it, we will read it, we will frame certain example for it, we will make a board note of it, and that's how we are going to progress. We do not need to rush for this chapter. What we need to do is we need to understand everything completely, and once we understand everything completely, you will definitely enjoy this chapter. Okay, let's discuss about it. Now chapter number 3, CISG. We are going to learn what is the CISG. Contract formation and obligations. What is this words of formation? Formation as in how the contract is created. Obligations, what is the obligation of both of the parties of the contract, assuming there are two parties. Okay. Now nature of a contract. So see, this chapter is divided into 4 parts. Nature of a contract, I have given this heading. Then formation of a contract, how the contract is formed. Then we are going to discuss about obligation of the seller, and then we are going to discuss about naturally obligation of the buyer. And once we complete this, we are going to complete the entire chapter. So these are the 4 pointers that we need to study really well. Okay. Now what is a contract? What is a contract? So let me explain with the help of an example here. My dear friends, I am explaining in very general terms. Okay. Mr. A, let me write it this way. Okay, Mr. A gave one offer to, it's not right to write Mrs., we can write Miss. Okay, Mr. A gave one offer to Miss B. Mr. A gave one offer to Miss B. Okay, Mr. A gave offer to Miss B. Miss B, after listening to this offer, Miss B said that what I want to do is I want to say yes to this particular person. Miss B wants to say yes. Is this a contract? Is this a contract? So in legal terms, this is called as agreement. and not contract. This is agreement. This is agreement and not contract. Let me explain again. If Mr. A gives some offer to Miss B and Miss B says yes, this becomes an agreement but not a contract. So how will this become a contract? So agreement plus enforceability, that is legal enforceability, will make this a contract. I hope this is clear. I hope this is clear. Yes. Now let's discuss about what is written over here for the contract. A legally binding agreement between two or more people. Legally binding. So what is the keyword over here? The keyword is this one, legally binding. It should be legally binding. Agreement. Agreement as in what? Offer plus acceptance, that is agreement. That is offer given is offer, acceptance given is acceptance, but when offer and acceptance are clubbed together, they become an agreement, and these two parties have agreed to something. Okay, then agreement plus enforceability becomes the contract. Now an agreement enforceable by law. Why do I say that? Agreement plus enforceability is contract, right? Agreement plus enforceability. Do not worry about the consideration part here if you have understood anything. Okay, now, and if you do not know what is consideration, let go of it. Now there is no unified international contract law. My dear friends, I have covered all of the MCQ pointers also here, so you don't need to worry about it. Just try to understand everything one line at a time. Once you understand everything one line at a time, you will be sorted. There is no unified international contract law. This means that a lot of countries have created their separate contract laws. For example, in India also we can see that there is the Indian Contract Act 1872, right? Now this Indian Contract Act and the international contract law might differ. So a lot of countries do not have any international contract law, they just operate via their nationwide law. For example, in India there is the Indian Contract Act, okay, but there is something called as contracts for the international sale of goods, that is called as CISG. And now there are certain countries who have framed this group and have created CISG, which is contracts for the international sale of goods, and they have agreed that what will happen if these countries, these member countries trade with each other. Okay, that is called as CISG. And whatever we are going to study after this, everything is going to be driven by CISG only. You have to remember this. Yes, contracts for the international sale of goods. Okay, if you have studied some part in India, the Sales of Goods Act is somewhat related to the CISG. Okay, now let's discuss about it in detail. The United Nations, which is UN, we have already discussed. Convention on Contracts for the International Sale of Goods was developed by UNCITRAL. Did we discuss about this in lecture number 1? Yes. And signed in Vienna in 1980. Do you need to remember this? No. It offers a uniform international sales law. It offers a uniform international sales law, not contract law, sales law. Okay, because when we talk about contracts, it might include sales, it might include other contracts as well. Most major trading countries around the world have signed CISG with notable exceptions. That is these countries are not members. These are not members. These have not signed. Okay. What are these countries? These are India, Nigeria, South Africa and UK. UK has also not signed. Yes, they have their independent contract law. Now, CISG applies to sale of goods contract between parties who are in different states. States as in jurisdictions. States as in not the real states, jurisdictions. Jurisdictions. Where the states are contracting states, that is they are contracting with each other, or where the contract is governed by the law of a contracting state, that is either they are transacting with each other, or even if these are not involved, but this law is still applicable based on their contract. That is, in contract it is written that everything would be driven by this law. Okay. Now very important thing here, what are goods? What are goods? Very important. What are goods? Very important for you. Okay. Goods generally mean tangible, movable items. Tangible, that could be touched. Tangible, that could be touched, or it could also be defined as has physical presence. For example, this pen has physical presence, so it is tangible. My feelings, not tangible, right? Movable, could be moved from one place to another. could be moved from one place to another, like my laptop, like my iPad. These are movable, so these are generally called as goods. CISG does not apply to sales of, does not apply, okay, needs to be mentioned. One of my students did what? He wrote the perfect answer, all the points perfectly, he just did not mention does not, he mentioned it includes, and the whole answer got converted and he got 0 marks. So please do not do that. Okay, now not apply to goods bought for personal, family or household use. For personal buying, this does not apply. Okay, unless at the time of contract was made, the seller neither knew nor ought to have known that the goods were bought for personal use. That is, unless it is no. Okay, so what we can write? If not known, then applies. Is it correct? Then CISG applicable. If not known to seller, then CISG applicable. Is it correct? Tell me, is it correct? If not known, then CISG applicable. Yes. Okay. Now, goods bought by auction. In this case also it is not applicable. Why? Because there are separate laws for the purpose of auction. Goods bought by authority of law, that is sold by court. Again, there are special laws for it. Stocks, shares, investment security, negotiable instruments or money, because these are driven either by the country specific laws which are related to stocks and securities, or they are, for example, in US there is SEC, for in India there is SEBI, or they are driven by negotiable instruments act. That is why not. Ships, vessel, hovercraft or aircraft, again special laws, aviation rules are there, and electricity, because it is generally in the control of government in every jurisdiction. Okay, do you need to remember this list? Yes, unfortunately yes. Even if you do not remember word by word, you will have to remember this. Now, CISG does not apply to the seller's liability for death or personal injury caused by the goods. CISG does not apply to the seller's liability for death or personal injury caused by the goods. That is, if Mr. A has sold certain thing to Mr. B, and that, say car, okay, and that car had failed brakes, and now there is liability on Mr. A. So will CISG rules govern it? No, CISG just deals with the sale transaction, not with the transaction of obligation or liabilities. I hope that is clear. So, example, Mr. A sold car to Mr. B with failed brakes. Sale transaction, CISG is applicable, but liability for damage is not covered by CISG. Hope this is clear. Hope this is clear. Yes. Now, formation of a contract. So with this we have completed the first part, which is nature of a contract. Now let's come to the second part, which is formation of a contract. Okay, let's come to the second part, which is formation of a contract. Now, offer. How will you define offer? Because this is again divided into offer. Then second part is of acceptance, and once we complete acceptance, we can directly go for the obligations of the seller. Okay, and once we complete this part, we will be completing roughly 60% of the chapter, because this is one of the most important parts. Okay, now not a complicated one, just important. If an offer is unequivocally, what is this unequivocally? Without conditions. Unequivocally as in what? Without conditions, without conditions, without conditions. Okay, without conditions. If I have said yes, if you have given me certain offer and I have said yes unequivocally, as in I have given ultimate yes, absolute yes. Okay, accepted while it is still in force, that is while it is still valid, because it gets lapse also sometimes. The parties have made an agreement. So offer, that is offer plus acceptance equals to agreement. I hope this is clear. Yes. Now offer plus acceptance is agreement. So why you have written in board notes also? Because this is important. No. Now agreement plus enforceability is contract. Now what is this? We have discussed agreement, then enforceability. We have discussed it here, right? Agreement plus enforceability is called as contract. So why have you repeated it? It's important, my dear friends. Now CISG, okay, We know the full form now. CIG provides that a communication from one of the parties to the other reach the recipient when, that is when communication gets completed, that is when communication of offer and acceptance gets completed. We are going to repeat certain points in the acceptance part again. Okay. Now, when it is made orally, that is I have spoken to you orally, then the communication is done, or it is delivered by any other means personally, example to a place of business or mailing address. Sometimes what might happen is, if I have to deliver this pen as a token of my acceptance, I have done it personally by going to your shop or your office. If there is not a place of business or mailing address, it is delivered at their habitual residence. It could be a residence also. For example, if I don't know where I should deliver this, there is no fixed place of business by the offerer, then I would be handing it over to your residence or your usual place of residence. Now, an offer can be accepted by the offeree. Who is the offeree, sir? So see, there are two parties. Let me write it over here. There are two parties. Okay. One offerer, another offeree. Okay. Offerer makes offer. Whoever makes offer, that is called as offerer. Accepts or not accepts, to whom the offer is made. To whom offer is made. Okay. This is who accepts or rejects the offer. Okay, I hope this is clear. Now, an offer can be accepted by the offeree unless it has expired because of time, because of certain conditions, or it has been withdrawn, revoked, or rejected before the offeree accepts. Very important line. That is acceptance must be given when the offer is in force, that is valid. If it has expired or if it has been withdrawn, that is offer has said now I don't want to make an offer. Say I have given an offer that, say there is Mr. A whom I want to hire to teach, say, accountancy. Okay. And if I have given him an offer and I have said that you have 2 days to reply and 2 days have elapsed, the offer is elapsed, right? Or after 1 day I realized that I don't want an accountancy teacher, I have already hired it. So that way I could withdraw the offer also. An invitation or proposal, that is why I said just read one line, try to understand the examples, and that's how we move forward for this chapter. Okay. Now, an invitation or proposal, whatever queries you have, please write it either in the comment box or do let me know on WhatsApp, on the app, anywhere. Okay. Now, an invitation or proposal to someone to make an offer. What is this? Is not an offer, and the response to it will therefore be regarded as an acceptance. It will not be regarded as an acceptance. What is this? I have given an advertisement that whosoever wants to teach mathematics, they should apply to my institute. Okay. Whosoever wants to teach mathematics, they should apply to my institute. In this particular case, whosoever comes, can they accept? Is this an offer? No. What I have done is I have asked people to give me an offer. Correct? I have asked people to give me an offer. I have not made an offer. I have asked people to give me an offer. I will be the one who will be accepting it. Correct? So this is called as invitation to offer, not offer. Okay. So just like tender. Example, tender, where what happens, I release a tender that anybody who can supply me, say, the desk for the students, they should apply, then I will evaluate and accept. Okay. So what I have done is I have given an invitation to offer. Now, CISG regards as in accepts. Okay. Offers which are not made to specific persons as being mere invitation. That is, if you have not made an offer to a specific person and you have given it in general, say anybody who prepares the or who manufactures the dress could apply, anyone who teaches accountancy or mathematics could apply. So this is generally regarded as an invitation and not an offer. Okay. So example, if a seller advertises goods for sale in a newspaper or a catalog or on the internet or television, like I have told you about the accountancy faculty or the mathematics faculty. Okay. Now, An offer which is not sufficiently definite, that is, which might be vague, which might be called as incomplete, would also be treated as merely as an invitation, that is, you don't want to reveal all the details, so this is not an offer because the other person cannot accept it unequivocally, right? So, not sufficiently definite means what? Vague or incomplete. Hope this is clear. So, is it important for us to remember everything line by line? No, but it is very important for you to understand when it would be considered as a valid offer, when it will not be considered as a valid offer. That is very important for you. Okay. Now, the offer will cease to be in force, that is valid, if it is withdrawn or revoked by the offerer or if it is rejected by the offeree. So, here we understand up to here, but what is this? Or if it gets rejected by the offeree, that is, even if offeree, that is the person to whom the offer is given, rejects, the offer comes to an end. Okay, sir. Can this happen that Mr. A has given one offer to Mr. B? So, you are not deciding whether it is Mr. B or Miss B. See, I will have to change it again and again, okay, based on the scenarios and the examples. So, if Mr. A has given an offer to Mr. B, okay, Mr. B rejected it, and after 2 days, the offer was still valid, and after 2 days, Mr. B realized, I want to say yes, okay, it could happen, change of heart could happen, right? In this particular case, will that offer be still considered as valid? No, because it has already been rejected by the offeree earlier, right? Now, withdrawal, revocation and rejection take effect when notification reaches the other party, that is, see sir, in case of law, we have to understand a lot of things between the lines, okay. So, withdrawal, revocation and rejection take effect when notification reaches the other party, that is, unless notification reaches the offer and acceptance are valid. Okay, this is good. Now, but sir, do we have to understand in this detail? Yes, that is very much required. Now, the offerer may not be able to revoke if the offerer, the person A, Mr. A, will not be able to revoke if it is irrevocable. If the offer indicates that it is irrevocable, that is, if it is written that once issued it cannot be cancelled, sometimes it could happen, then it is called as irrevocable. Or for some other reason, it was reasonable for the offeree to rely on the offer as being irrevocable and the offeree has acted in reliance on the offer. That is, if offeree believed that the offer is irrevocable, then also, or there are sufficient reasons for the offeree to believe that the offer is irrevocable. What could be those reasons? First of all, it will be decided on the context, but there could be a similar case like that when all the offers given by the offerer is irrevocable. Now, rejection arises if the offeree refuses the offer, that is, when it would be called as rejection, when the offeree, you have to be very particular about who is the offerer, who is the offeree, refuses the offer. This we have already understood. The offer is terminated when the rejection reaches the offerer even if the offer was irrevocable, that is, even if the offer was irrevocable. See, what is being communicated here? Rejection by the offeree, that is, offerer cannot revoke an irrevocable, but offeree can reject, that is, offerer cannot withdraw an irrevocable offer, but offeree can reject. See, this is the rule of world, no? This is the rule of life. Whosoever is giving the offer, they have lesser choices than who is getting the offer. Always the case, right? Now, a reply to an offer which purports to be an acceptance but contains additions, limitations or other modification, that is, you are accepting it, but you are accepting with certain conditions. Say, I have given the offer to Mr. A to teach accountancy and I have told them that you have to take the class from say 9 to 11. They have said that yes, I will be teaching with you, no worries on that, but I will be available from 11 AM to 12 PM. That is, they have changed the timings and it is a material change, right, in case of classes. So, a reply to an offer which purports to be an acceptance but contains additions, limitations or other modification. In this case, it is addition or modification which significantly change the terms of the offer is treated as a rejection of the offer and a new offer, which is counter offer. So, what is counter offer? What is counter offer? when offeree modifies a significant term in the original offer, that is called as counter offer. That is, Mr. A has given some offer to Mr. B. Mr. B has said that if you change this, then I will accept. So this is not called as acceptance, this is called as counter offer. That is, a new offer has been given to Mr. A now, and now the offerer and offeree roles have been shifted or converted. On the offeree's terms to the original offer, the original offerer becomes the counter offeree and has the option of accepting or rejecting it. In this case, now I have the option of either accepting 12 p.m. or 11 a.m. to 12 p.m. as the timing, or I have the option to reject it also. I hope this is clear. With this, we have completed offer. Now we can go for the acceptance part. So this is looking more than the offer, but a lot of points of this is repeated. We have already understood from the point of view of the offerer. Now what we have to do is we have to understand from the point of view of offeree. Okay. So the offeree can accept by words or conduct which indicate that the offeree assents to the offer. Offeree can accept by words or conduct. That is not mandatory to express acceptance. See, if you have given offer to somebody, okay, and they have done certain act which could only be done when they would have accepted it, then it would be called as an acceptance by conduct. Okay. Now, silence or inactivity does not in itself amount to acceptance. That is, you gave an offer and the person stayed silent. Will it be considered as acceptance? No, it is not considered as acceptance. Silence is not equal to acceptance. Okay. However, there is one rule that is not written over here. When silence amounts to speech in certain cases, then it is called as acceptance. Okay. But what you have to remember, silence is not acceptance. Okay. Unless there are special factors. Now, acceptance is effective as soon as the indication of assent reaches the offerer. Once the communication is complete, the acceptance is effective. That is, communication reaches the offerer, acceptance is effective. I hope this is clear. Now, it is not effective. It is not effective if it does not reach the offerer within the time the offerer has fixed, if no time is fixed within a reasonable time. That is, if offerer has said that you have to accept by say 2 days, and if the communication did not reach within 2 days, then it is not effective. An oral offer must be accepted immediately unless the circumstances indicate otherwise. That is, unless the circumstances speaks for something or demands for something else. An oral offer, that is, I have given you a verbal offer, this should be accepted or rejected then and there. Okay, very special line. I know you might be feeling that this is not right, this is not fair, you should be given the time, but that depends. Unless it is clearly mentioned this time, there is no time. Okay. Now, if there is an established trade usage or an established practice of accepting certain things, for example, in some traditions there might be, I have personally seen it, people offer, there is something called as pan, there is something called as snacks. Okay. What they do is they offer the snack, if the other person accepts it, then it is automatically said that they have accepted the offer. So that way also the offer could be accepted. If there is an established trade usage or an established practice between the parties, or if the terms of the offer provide so that the offeree may indicate assent by performing an act, by example by dispatching or for paying of the price without notice to the offerer, the acceptance is effective at the moment the act is performed. As in this case, as the snacks are taken, as the pan is taken, it is effective, provided that the act is performed while the offer is still in force, that is, when the offer was still applicable. So that is, acceptance could be given by trade customs as well. Wherever we say could, may, it is not mandatory, but it is allowed. If the offeree accepts but on terms which contain addition, this we have already discussed, limitations, it will be considered as counter offer. This we have already discussed in the offer stage also. Additional terms which do not materially alter, then it is a valid acceptance. This is important. If there are additional terms with which the offer is not changed materially, then it is called as a normal acceptance. For example, they did not change the timing. They just said that I will be needing, say, I'll be bringing my own notes, and it was clearly mentioned in my offer that you can use any notes. Okay, you can bring you can use our notes, and they have said that I'll be bringing my own notes. This is not a change. This is not a significant change. Okay, now the offer may impose a time limit for acceptance. We have discussed. If the offeree accepts outside the time, acceptance is ineffective. That is not valid. That is not valid. This also we have discussed. I hope this is clear. Next 2 to 3 chapters are going to be on the similar line. Okay, we have to read the words, we have to interpret it, we have to identify our judgment. Do we need to mug up everything? No. Do we have to remember these words? Ineffective? Yes. Acceptance? Yes. Offer? Yes. Acceptance? Yes. Agreement? Yes. Contract? Yes. Now, the period for acceptance of a time limit set by the offeror is measured as follows. See, if nothing is mentioned, then this timeline is important. So, please remember. This one you need to remember, because there could be MCQs on that. What would be the timeline in case of, say, letter, in case of telegram, in case of telephone, telex or other means. So, letter, from the date shown on the letter, or if no such date is shown, from the date shown on the envelope. If set in telegram, from the time telegram is handed in for dispatch. If fixed by telephone, from the moment that the offer reaches the offeree, from then the time starts. Okay, time limit starts. Okay, I hope this is clear. Now, here you should not understand that in case of, say, letter, the acceptance, say, acceptance should be given within 7 days. So, if letter was dispatched or letter was created on 1st January, okay, it got reached on 4th January. So, timeline, if 7 days is 7th January and not 11th January. That you need to remember. Hope this is clear. Now, no exception is made for official holidays and non-business days. But if the last day is a non-business day, the period is extended by 1 day to allow the acceptance to arrive. That is, if the last day is, say, on this, say, 7th of January, if it is Sunday, then it would automatically be shifted to 8th January. Now, no exception is made for official days. We have covered this. If the acceptance is delayed in transmission and so arrives out of time, even though it was properly sent. So, say, if they have sent properly, it got delayed because of the carrier, maybe because of any factor which is outside the control, they followed the due process, they dispatched it on a timely basis, then it is considered as a valid acceptance. So, read it. If the acceptance is delayed in transmission and so arrives out of time, even though it was properly sent and should have arrived in time, it is regarded as valid unless the offerer promptly notifies the offeree that the offer has lapsed orally or by dispatching a note. Okay. Now, the offeree may change their mind. The offeree may change their mind and decide not to proceed with the agreement also. Sometimes, yes, offeree, Mr. B, offeree, Mr. B, Mr. B, okay, may change their mind and decide not to proceed with the agreement. CISG allows the offeree to withdraw acceptance on condition that the offerer is informed and the withdrawal reaches the offerer before or at the same time as acceptance would have become effective. That is, after acceptance. So, this is important. Can there be withdrawal of acceptance? Yes. So, let me write it clearly here. That is, withdrawal of acceptance allowed, big yes. How? But only on or before acceptance becomes effective. That is, before acceptance becomes effective, it is considered as valid. Okay, you can withdraw your acceptance also. I hope this is clear. Now, key points. What are these key points, sir? These were certain additional points that I want to highlight so that you do not miss out on it. Okay, CIG contracts do not have to be made in writing or be evidenced in writing and are not subject to any other requirement as to form. They may be proved by any means including witnesses. That is, CIG contracts do not need to be made in writing or be evidenced, just needs to be proved. It could be any form of proof. However, if a contracting, can this be audio recording also? Yes. Okay. Can this be through witnesses? Yes. However, if a contracting states domestic law requires that there should be written guidance, there should be written formalities and or evidence, it may make a declaration that the provisions of CIG which do not agree with the written formalities do not apply where any party has a place of business in that state. That is, unless it contradicts with the national laws, CIG does not need written evidences, written agreements. So let me write it over there. Unless contradicts with national laws, CISG does not necessarily requires written agreements, only in the way it could be proved. Only in the way which could be proved. That is enough. Which could be proved. I hope this is clear. Okay. Now with this we have completed the second heading also. What was this second heading? This second heading was formation of a contract. Nature of a contract, formation of a contract. Now obligation of the seller, and then we have to discuss about obligation of the buyer. Once we complete these two, we are going to get done with this entire chapter. Okay. Anything to ask over here? Let me read the chats. Yes. Anything to ask? Anything to ask over here? Yes. Please do let me know. Let me read the chats as well. Okay, perfect. Now obligations of the seller. So the seller must deliver the goods at the right place at the right time. But sir, how we will decide what is right place or what is right time? Right place, right time. Right place means the delivery of the goods must be at the place specified in the contract, or if no place is specified, reasonable place, usual place, to the first carrier, that is the transporter. Carrier as in the transporter. Why first is written? Because there could be multiple transporters could be involved, from place A to B, then B to C, then C to D, then the ultimate user. Then by making them available to the buyer at a particular place where goods were stored or manufactured, if the parties knew of it at the time they made the contract, that is, say at the time Mr. A sold goods to Mr. B, Mr. A clearly mentioned that the goods are lying in my warehouse at, say, location A. Okay, you have to collect it from there. Then if they have delivered at that particular location, it is considered that the delivery has been done. Okay, let me write an example. Mr. A sold goods to Mr. B lying at warehouse A in the knowledge of Mr. B. In the knowledge of Mr. B, then A is the right place. Warehouse A is the right place. Now, by making them available to the buyer at the place where the seller had their place of business at the time the contract was made. That is, if nothing is described, if it was not in the knowledge of B also that the goods are placed in warehouse and they have to collect it from there, then at the time of contract, wherever the seller usually sells. For example, I bought an AC few days back. Okay, now even if the AC is in the warehouse, they specifically told me that you can collect it from this shop. So I went there, I collected from that shop only. Okay, now the right time, on the date or during the period fixed in the contract, or if no time or period is specified, within a reasonable time after the contract was made. That is, on the date, period fixed in the contract, or if no time is specified, within a reasonable time. In the above part also you could have written reasonable place if you do not remember exactly, but it would be always better if you can mention more specifically. Okay. Now the contract may require the seller to hand over documents relating to the goods which will entitle the buyer to claim the goods. For example, in case of international transport, there is a bill of lading, there is shipping bill that is there, right, in case of import and exports. So all the relevant documents should also be sent. The contract may require the seller to hand over the documents also. May, why? Because sometimes it is said that we will not be able to provide you the documents unless the goods are delivered. Now, if the seller is arranging for carriage of the goods, that is, it is on CIF basis, that is, they are arranging for the carriage, they are paying for the transportation, the seller must also make such contracts as are necessary for carriage. That is, unless it is mentioned, that is, unless mentioned, buyer arranges carriage. Hope this is clear. Now, the terms of the contract may require the seller to deal with insuring the goods while they are being carried. If not, the seller must, if the buyer asks, give the buyer all available information necessary to enable the buyer to effect such insurance. That is, unless agreed buyer, unless agreed in contract, buyer insures the goods, however, seller needs to provide, all information required to insure the goods. See, this is very, very important, right? Okay. Now, the seller must deliver goods which are of the quantity, quality, description in the packaged in the manner as set out in the contract. If it is different, then it would be on the buyer's choice whether they want to accept it or not. If buyer does not want to accept, they can reject it. Say, if buyer bought 10, they sold 100, buyer could accept, buyer could reject. If buyer wanted X quality, they have sent Y quality, buyer could accept, buyer could reject. If buyer wanted, say, shoes which is in the right foot, which is of the right foot only, that is, it is not matching the description because they have said they have sent both pairs, okay, both foot, but they only wanted, say, one foot only. So it is not matching, again they can accept or reject. So unless the parties have agreed otherwise, what this means? That is, unless they have agreed something else, otherwise as in unless something else is agreed, unless something else is agreed, in order to comply with the context, the goods must be fit for the purposes for which the goods of the same description would ordinarily be used. For example, if I have bought mobile phone, it should be capable of making calls, it should be capable of handling all the functions of a smartphone if I am buying a smartphone. Be fit for any particular purpose expressly or impliedly made known to the seller at the time. For example, if I want a phone which has long battery life, specifically minimum 10 hours, then it should be of the quality which has minimum 10 hours of battery life. Possesses the qualities of goods which the seller has held out to the buyer as a sample or model. For example, if they have shared me a sample phone with saying that this phone has a good camera, I have tested it, I realized that okay, this is a really good camera, I want to buy it, but when they deliver the final phone, the camera quality is not matching, that would not do unless otherwise agreed. Say they have shown me 12 megapixels and they have said that the phone that you will be buying, that will have 10 megapixels, then it's fine, otherwise it should match. Be contained or packaged in the usual manner for such goods, or where there is no such manner, in a manner adequate. For example, they cannot give me a phone whose box is already opened. Now, this should be remembered, not because it is always asked in the examination, but this is common sense. You should not make any mistakes over here because this is very, very specific, this is very, very basic. Now, the seller is not liable for any lack of conformity, that is, if the goods are not matching the sample or description which the buyer knew or could have been unaware of at the time of the contract was made, that is, seller is not liable. Seller is not liable for anything which the buyer knew or could have known. Now, okay, if the seller, that is, let me write here, that is, if buyer aware, non-conformity works. Non-conformity works. That is, in our case, if the buyer was aware that what they are seeing is 12 megapixels, but what they will be getting is 10 megapixels, then it works, otherwise not. Now, if the seller has delivered goods before the date for the delivery, the seller remains free until that date to remedy any lack of conformity in the goods delivered, provided that the exercise of the right does not cause the buyer unreasonable inconvenience or unreasonable expenses. This does not prevent the buyer claiming damages. What does this mean? Very important line. See, let me explain. Due date of delivery, of course, is say 4th January. Okay. Actual date is 31st December. That is, they have delivered 4 days earlier. Now, as a courtesy, buyer has kept the goods in the warehouse, but say buyer has booked the quality checking team to check these products on say 4th of January only, when they were supposed to be delivered. Now, when on the 4th of January any non-conformity is there, then the seller is saying that, see, we delivered the goods to you on 31st, you had 2 days to test, okay, we agreed on 2 days. Now you are saying after 4 days that the goods are not of the appropriate quality. Still the damages claim would be appropriate because the due date was anyways 4th of January. So buyer is not obligated to test the goods within 2 days of delivery. They are obligated to test the goods within 2 days of the due date of delivery, not the actual date. I hope this is clear. Now the goods must be free from potential claims from other people. This is called as unencumbered, also known as unencumbered access. That is, if they have sold this phone to me, nobody should have access to call it their phone. That is, nobody should be able to call it their phone. Okay. Now the seller must deliver goods which are free from any right or claim of a third party unless the buyer agreed to take the goods subject to that right or claim. That is, they knew that somebody else also has right over these goods and they are still buying. So will there be buyers like that? Yes, there could be buyers. Or the claim relates to intellectual property and the seller was not and could not have been aware of the possibility of a claim that the contract was made when at the time the contract was made. Say somebody has sold company A's brand name to company B, and there was a claim later on. Now company A might not be aware, or company A was not aware. If it is proven that company A was not aware that this will have some trademark issues, then also the sale will be considered as valid only. Okay, it just based on the claim of a trademark related, copyright related, or intellectual property right related, the sale will not be invalid. Sale will be valid because it was not known to the seller also. Okay. Now obligations of the buyer. These were the obligations of the seller. Now let's come to the obligations of the buyer, and this is going to be very interesting discussion. We have already covered major parts of it in the obligation of the seller only. Now obligation of the buyer. So the buyer must make all necessary steps to pay in accordance with the contract. The buyer must take all necessary steps to pay in accordance with the contract. That is, whatever is their payment terms, buyer should abide by it. If a contract does not set a price or a method for assessing it, the parties will be regarded as having agreed that the price is the one which is the usual. That is, no price agreed, then usual market price. Okay. Now the buyer should make the payment at the place specified in the contract, or if none is specified, at the seller's place of business, or if the payment is to be made against the handing over of the goods, then when the goods are handed over, then the buyer should make the payment. I hope this is again clear. Where you will make the payment, when you will make the payment, based on the contract, or if not mentioned anywhere in the contract, then as per the usual terms or usual place of business. If not even that, if it is mentioned that on the delivery, then after the delivery is done. Now if the seller changes the agreed place of business after the making of the contract, the seller must bear any consequent increases in the expense incidental to payment. Say they were sitting at city X while we did the contract, and we wrote that we will be making the payment at city X. Now they are sitting at city Y, okay, and we have to travel over there, we have to make the payment over there, we have to incur additional cost. Who will bear it? The seller will bear it. Okay, the acceptor of the payment will bear it. Okay. Now the payment should be made. The payment should be made at the time specified in the contract, or when the seller puts the goods or documents for claiming the goods at the buyer's disposal. That is, when seller hands over the goods to buyer, if nothing is agreed, then the payment is due and to be made. If it is agreed after 30 days, then after 30 days. Now if the contract involves carriage of the goods, that is transportation, carriage as in transportation, that is transportation. If the contract involves transportation of the goods, the seller may dispatch the goods on terms whereby the goods or documents controlling their disposition will not be handed over to the buyer except against payment of the price. That is, there could be a cash on delivery arrangement as well, that unless the price is paid, it would not be handed over. Now this needs to be agreed. This needs to be agreed in advance. Okay. Okay. This usually happens in our orders also, right? Now The buyer is not bound to pay the price until they have had an opportunity to examine the goods. What if the goods are delivered before the timing? Then also they will not be bound to make the payment unless the due date is there and they have examined the goods. Unless the procedure for delivery or payment agreed upon by the parties are inconsistent with having such an opportunity. So the buyer is not bound to pay unless otherwise agreed. Let me write it this. Unless otherwise agreed. Okay. Now the buyer must do everything which could reasonably be expected of the buyer in order to enable the seller to make delivery and take over the goods. For example, if it was agreed that the buyer's place is usually open from Monday to Friday from say 11 a.m. to 5 p.m. and if the goods have been delivered then only during a working day, then it could be presumed that buyer has made a mistake if the goods if the shop was not available or if the shop was closed. Okay. So buyer needs to do everything that buyer should be doing as per the normal agreement terms. If the seller delivers early, the buyer is not obliged to accept the goods. The buyer can take delivery or refuse to take it as well. Again, very important, we have already discussed that same example, 31st December delivered on 31st December except for 4th of January instead of 4th of January, then buyer is not obligated to accept the goods. They can reject also, they can accept also. Even if they accept, they are not obligated to check the quality unless the due date is there. Okay. Now, if the seller delivers excess goods not included in the contract, the buyer is not obligated to accept the excess goods. That same example 1 and 100, that is instead of 10 they have delivered 100. Are you obligated to accept all 100? No, you can accept, you can reject also. Now the buyer must examine the goods or cause them to be examined as soon as possible after taking delivery. If the contract involves carriage of the goods, examination may be deferred until after the goods have arrived at their destination. That is, even if the sale has completed when Mr. A handed over the goods to the carriage and buyer was allowed to make the examination, it could be deferred. It could be deferred until the goods have actually been received by Mr. B, the buyer. Notify the seller about any lack of conformity within the reasonable time only. Unless the goods are covered by a guarantee, the very latest the buyer can give notices 2 years after taking delivery. Do you need to remember this? Yes. Okay, 2 years time is there. Now notify the seller about any right or claim of a third party within a reasonable time after the buyer has become aware of. That is, if any third party comes and claims over these goods and put a claim over these goods, buyer has to make the seller aware as soon as they can, as soon as they got to know about it. With this, we have completed the entire chapter. So have we completed all 4? Yes. We have completed nature of a contract, we have completed formation of a contract, we have completed obligations of the seller, and we have completed obligations of the buyer. I hope you have understood this, and this was a really informative and interactive session for you. I hope you really liked this chapter, because now when we go to the next chapters, the way of understanding it is going to be similar, but what is more interesting is that this chapter will form the basics of everything that we discussed about contracts or that we have discussed about CISG. Now there would be more details, more diving deep into these topics, and you will naturally love these topics because these are core of the law subjects. So whatever queries you have, please feel free to reach out to me. Please feel free to subscribe to my YouTube, Telegram as well as Instagram. I am available by the name of ACCA with CS Suprita Agrawal at all 3 places. YouTube is ACCA with CS Suprita Agrawal, all small cap. Telegram channel name is ACCA with CS Suprita Agrawal, and our website is www.bbvirtualsglobal.com, bbvirtualsglobal.com, and you can refer it as well for more information. You can also come to my Telegram channel, which is again ACCA with CS Suprita Agrawal, and Instagram again ACCA with CS Suprita Agrawal. Thank you so much. See you over there. Thank you. Hello my dear friends, hope you are doing really well. This is CS Suprita Agrawal, your faculty for ACCA AA, AAA and law subjects. My dear friends, today we are going to complete chapter number 4 from your law syllabus, and please let me tell you this beforehand only that this chapter is going to be very important. Why it is important? Because this talks about one of the fundamental concepts which is very important for you whenever you discuss about any of the contracts, and especially the contracts related to sale and purchase of goods. What is that term that creates confusion in the mind of a lot of students? So that is risk. When the risk is transferred, because see, it is very easy to say that when the ownership is transferred, but what is more important to understand is when the risk is transferred. Say, if I tell you that there was a cargo which was moving from say location A to location B, okay, it was moving through a vessel. Now somewhere here during the journey it got destroyed, okay. Now this A had exporter Mr. A, this had importer Mr. B. Who would be considered as responsible? Responsibility would be of. So responsible party would be dependent on the contract. Now today we are going to discuss about a lot of terms which would be commonly called as what? Incoterms. As in import export terms, the risk of transfer terms and the transfer of risk terms, and all of these things which helps us decide how a contract of sale and made is done. Of course, a lot of these contents that we are going to discuss today could be supersede, could be changed, could be agreed differently via a separate agreement in the jurisdiction of the national laws. However, if no law is created or if no specific or against law is created, then what we have to follow? We have to follow these terms. Sir, what is this? This is again created by CISG only, okay. You remember CISG from the, I hope you remember CISG from the previous chapter, chapter number 3. Now what this chapter covers exactly, let's discuss about that. This is chapter number 4. What this chapter covers exactly, let's discuss about that. So this chapter covers the question of which party should bear the burden of risk for damage to goods before they are delivered. Now what happens is, in this case, if it would have been delivered to Mr. B and the ownership and risk have been transferred, then definitely it is in the risk area of Mr. B. Whereas if it is not delivered and if it is in the jurisdiction of Mr. A, it is decided that Mr. A would be considered as responsible. But when that exact event is going to happen, that it is going to be transferred, that is very, very important over here. Say if it is agreed, that once it crosses say India, okay, it enters India. So this is territorial water. Once it enters India, it would be the responsibility of buyer. So here Mr. B would be considered as responsible. If it is here, if it is destroyed here, then it would be the responsibility of seller. But what is more important is how these contracts needs to be made and how it needs to be justified. It needs to be agreed between different parties, and in case there are no separate agreements towards it, then how it would be dealt. That is what is going to be understood under this chapter. Now the question, second question, the question of which party shall be responsible for arranging their transport carriage from seller to buyer. That is, whether there are certain contracts or there might be certain jurisdiction where it might be agreed that if a buyer has produced or bought certain goods, then seller would deliver it to the buyer's premises. There might be certain jurisdictions which might agree that by default, if the buyer has obtained certain product, bought certain product, then they'll have to arrange for the transport from the seller's place to the buyer's place. For example, let me give you an example. Okay, I bought an AC few days back. Okay, I bought an AC few days back. Now what happened was, in my jurisdiction, what happened was, there was an agreed term between the seller and the buyer based on various local laws that if somebody makes a purchase, they will be entitled to get that product delivered on the seller's accountability to the buyer's place. So for example, I have an AC right here. Okay, now this AC was bought by me. I was the buyer, somebody was the seller, but the concern here is that that seller had the responsibility of delivering, not installing, delivering this AC to my place. Okay, based on the companies of the AC that I have bought, that was the terms. Now there could be some other AC company which might agree with the buyers that once you buy our company's products, what you have to do is you have to arrange for the travel part, you have to arrange for the delivery part. That could also be there, and there could be a separate agreement between buyer and seller. That is what is covered over here. Now let's discuss about both of them one by one. Here we are going to discuss about risk of loss, then we are going to discuss about carriage of goods, and once we do that, we are going to complete this chapter. Okay, here we are also going to learn about various Inco terms, various export import terms also. Now let's discuss about risk of loss. I have created these notes again in the manner that once we read everything, once we understand everything with the help of an example, you will be able to comfortably understand everything, and you will be able to launch the question bank also. You will be able to solve the question bank also. Now identifying the point at which risk is to pass helps the parties to make their insurance and other arrangements. What does this mean? See, if example, okay, if let me give you an example right here. Example, Mr. A has transferred certain product to Mr. B. Okay, after this point it is the responsibility of Mr. B. Before this point it is the responsibility of Mr. A. So Mr. B could take insurance for this route or this duration. But what happens is, you might get a question here that, sir, what is the harm? You can take the insurance for the overall travel part, for the overall delivery route, or both of them could take the insurance. But sir, here we are not talking about thousands of rupees, hundreds of rupees. We are talking about millions, sometimes billions, sometimes trillion of rupees also. So that is why this is very important, that how much of insurance would be taken, who would bear that insurance cost, and how much of insurance, on what kind of insurance needs to be taken, okay, and from which jurisdiction it needs to be taken. Now, CISG provides for the passing of risk, connecting it with the time at which the buyer takes actual or notional possession of the goods. However, the parties may make their own different arrangements in the contract. That is, what is the meaning of this overall paragraph? That is, unless otherwise stated, the risk is transferred when the buyer takes actual or notional possession of the goods. That is unless otherwise agreed, the risk is transferred when buyer takes actual or notional possession of the goods. Sir, actual possession, we understand that the buyer took the actual possession of the AC. What is notional possession, sir? What is notional possession? So sometimes there are certain transactions where actual delivery is not done, but constructive or symbolic delivery is done. What is this constructive or symbolic delivery? So example, warehouse keys have been given, or it has been agreed that the goods are there in the warehouse and now they are your responsibility. Your guy has inspected them also. So what is this? Constructive or symbolic delivery. Could be examples. For example, constructive means what? Without delivery, without physical transfer. Say the goods have been kept at a warehouse and I have given you all the documents, giving you all the rights towards those goods. Now that is also delivery. Now you are responsible because now you are the owner. But this is not an actual delivery, this is a notional delivery, notional possession. Symbolic delivery, when token is transferred. Token is transferred. Say I have one car, and when the guy from the showroom was transferring me this car, they did not bring the whole car to me. They just gave me the key. That is a symbolic delivery. That is a symbol of delivery is there. That is, they have delivered a key. Okay. Now, when risk passes, so let's just read it. If the contract involves carriage of the goods, the risk passes to the buyer when the goods are handed over to the first carrier for transmission to the buyer in accordance with the contract of sale. That is, what has happened is, if Mr. A has agreed to transfer to Mr. B via Mr. C, who is the transporter, so it would be assumed as delivered when it is transferred to Mr. C. Okay. So if the contract involves carriage of the goods, the risk passes to the buyer when the goods are handed over to the first carrier. If there are multiple carriers, then first carrier, in accordance with the contract of sale. Example, the contract may specify that they are to be given to the carrier at a particular place. So once you have delivered to that carrier, that transporter, then it would be assumed that the delivery is done. First carrier as in transporter. Now let's discuss about if the goods are sold in transit. Okay, what is this sold in transit? What is this? So they were moving from one place to another place, and during that time only it has been sold. So let's write it over here. Goods are getting transported, not transferred, transported from one place to another and it got sold in the way. Okay. So if the goods are sold in transit, risk passes to the buyer at the time the contract is made. When it is made, not when it reaches the buyer, when it is made. So not when it reaches the buyer. Not when it reaches the buyer. Hope that is clear. However, this does not apply if the seller is on notice at the time of the contract that the goods have been damaged already. That is, if the seller was aware that at the time the contract is made during the sale in transit, then the actual possession or the actual ownership will not be transferred, because this is bad faith, right? Because this is bad faith. Because this is bad faith. That's why not valid. That's why not valid. Now, okay, in cases not involving carriage, that is, no transportation is there. For example, I bought one paper holder. Okay, this paper holder I bought. Now, do you think there's any transportation that is required for this, that they will transfer it to my place? No, there's no requirement of delivery or transportation, so that is why I took it. So in cases not involving carriage, the risk passes when the buyer takes over the goods or from the time when the goods are placed at the buyer's disposal. That is, it is given within the full control of the buyer. For example, they have given this into my hand. Now, if it gets slipped from my hand and it gets destroyed, then also it is my responsibility. So when the buyer takes over the goods or from the time when they are put in the buyer's disposal at the seller's place of business. For example, I was holding it into the seller's shop only and I destroyed it. At any other place specified in the contract, I was checking it out in the warehouse and I disturbed it, I destroyed it. When delivery is due and the buyer has been notified that they are there. So they told me that, sir, this is not a fresh piece. What you can do is you can come tomorrow at 10 a.m. I would keep it outside for you. You can just come and collect from my shop. They kept it and it got destroyed, then also I would be responsible. Now, the goods are considered not to be placed at the buyer's disposal until they are clearly identified to the contract. For example, there were 10 of these paper holders that were brought for me. However, I only wanted one. If it was clearly distinguished that this one is going to go to Mr. Supreet Agrawal and it got destroyed, then it is considered as something that is considered as what? That is considered as what? That is considered as placed at the buyer's disposal. Otherwise, it will not be considered as placed at the buyer's disposal, because if there were 10 of them and it was not clearly identified which one belongs to me, then it does not belong to me. It said no, that if something is not for you, if something is not clearly for you, then it is definitely not for you, right? So that is how we need to understand it. So the goods are considered to be placed at the buyer's disposal until they are clearly identified to the contract, that is, they have been set aside and marked or otherwise identified as being related to the contracts. Now, carriage of goods. What is this? Carriage of goods. So here we discussed about the risk part, right? Risk of loss. But here we are going to discuss about the carriage part also. Here we are going to discuss about the carriage part also. Now, when I say carriage, there are certain terminologies that you need to understand. Then you have to understand about the CISG provisions. Then you have to discuss about the INCO terms, and under those INCO terms also you have to discuss about for any mode of transport, and then you have to discuss about for main carriage by water, that is ocean, or any of the water bodies inland. Okay, now this is very, very important. Carriage of goods. There are certain terminologies that are very, very important. Do you need to remember this? Yes. I would say let's make this. Please remember this. Okay, this is very, very important. Now, carriage or shipping. Carriage or shipping. The process of transporting people or goods by land, sea or air. The process of transporting people or goods by land, sea or air, that is by any means of transport, that is by any means of transport, it is valid. That is, it would be called as carriage even if it is via any mode, any medium, any means of transport. Okay, now carrier. What is carrier? The transporter. So a business that transports people or goods, usually according to defined and published routes, schedules and price rates, and usually under recognized regulation. That is a business that transport people or goods commercially. Okay, commercially. That is, it's not like I was going from one place to another, you gave me certain products that needs to be delivered over there and I did it. No, if I'm doing it as a business, then I would be called as a carrier. Now, shipper. Who is shipper? It's not shipper, it's shipper. Shipper. A person who prepares goods for shipping, including arranging or coordinating the transport of goods. You know, once I was going from one city to another and I wanted my bike, a motorcycle, to be delivered from one place to another. Now, there was the railway department who would be considered as the transporter in that arrangement, but when it came to me, I realized that there used to be a separate packaging that is really important for this. There is a separate packaging that is really important to transport my bike from one place to another. Now, in this particular scenario, when I was thinking about transporting my bike, there was a particular person who helped me prepare the product for the purpose of transferring. That is called as shipper. Okay. Consignee. Who is consignee? The person to whom the goods are to be delivered and usually named in the carriage documents. That is the importer. That is the importer. Then freight. What is freight? The fee charged for transport. Now, there might be certain important things that might be written for freight against it also, but what you need to remember is the fee, the price, the rent. Okay. Now, CISG provisions, that is, if nothing is agreed, then these provisions would be applicable, whatever we are going to discuss after this till the end of the chapter. So, if the contract requires the seller to arrange for carriage of the goods, the seller must make such contracts as are necessary for carriage to the place fixed by means of transportation appropriate in the circumstances and according to the usual terms. That is if carriage to be done by seller needs to enter into relevant contracts. What do I mean by this? See, it is very important for us to understand that if I as a seller have done what? Have entered into an arrangement where I have to deliver the products from one place to another, then what is more important to understand here is that we have to enter into relevant contracts also to make that delivery happen. That is, if I have said that I will be delivering a product from say India to UK, then I have to enter into a contract with some transporter to actually transfer those products from India to UK. Now, if the contract involves carriage of the goods, the seller may dispatch the goods on terms whereby the carrier will only hand over the goods to the buyer against payment. That is, what they could agree is, they could also agree that the carrier will only transfer the goods to the buyer when they receive certain payments. So, for example, in case of your say some quick commerce delivery parcel, if you have selected the cash on delivery option, the carrier, the transporter, say any of the company, the transporter company, they are not liable to hand you over the products until the payment is made. So, they can also agree on the cash on delivery method. Now, let's discuss about certain Incoterms. Do you need to remember these? Yes. Do you need to remember all of this in the same words? No. You need to just remember what needs to be done in a particular scenario. That is very, very important. Now, Incoterms. Okay, Incoterms. ICC rules for the use of domestic and international trade terms. ICC rules for the use of domestic and international trade terms. Sir, but these should be international only, right? See, what happens is, generally these are international only. These are created for international transactions only. But a lot of these terms are usually used for the domestic terms also nowadays. Okay. Now, our standard trade definitions used in the international sales contracts and increasingly often also in the domestic transactions. Now, the Incoterms are devised and published by the International Chamber of Commerce. Do you need to remember this? Yes. Please remember this. The Incoterms are devised and published by the International Chamber of Commerce. Now, the Incoterms typically specify when the seller is deemed to deliver to the buyer and the seller's responsibilities for the arrangements, cost and risk of carriage. What is this? Let's read it again. The Incoterms typically specify when the seller is deemed to deliver to the buyer and the seller's responsibilities for the arrangements, cost and risk of carriage. That is, although this does not need much explanation because you will anyways understand it once we move forward with the syllabus in this same chapter. But let me explain you this. Whenever we discuss about Incoterms, they decide when the risk would be transferred, who would bear the cost, when would actually possession would be transferred. That is very, very important to understand. So, possession, risk, cost. Now, when we are going to understand about a lot of Incoterms where we will distinguish among different terms also. Now, when goods are sold several times over during transit, that is, it was moving from say UK to India, person A who actually sold it, then somebody in the transit bought it, then somebody in the transit only again sold it, then again sold it, then again sold it. There are multiple transactions like that. So, when goods are sold several times over during transit through a series of sale contracts, a purchaser or seller in the middle of the series does not actually ship the goods because the goods are already in the ship. Now, will they be able to export it? No. What is generally agreed is that the goods are already in the ship Now we will not unload it. What we will be doing is we are giving you all the rights and responsibilities regarding those goods. So anybody who has sold in the middle, they do not need to reship the goods. That is very important for us to understand, as they are already on board when they acquire title over them. On board as in on ship. On board as in what? On ship. On board as in on ship. Consequently, under the rules, only the first seller will be responsible for shipping the goods. That is important. But why I am telling you this? This is very common sense, right? But what happens is, whenever there is a question in the MCQ format, you guys might miss it. That is why it is important to understand. Now, each term is known as by some acronym. Acronym, the shorter versions, right? For example, FOB, free on board. CIF, cost, insurance and freight. These are there. But they are divided into 4 groups: E group, F group, C group, D group. So we need to remember this. I would strongly suggest, if you can just understand which group is for which terms of delivery, that is important. Used where the seller does not want to. Seller does not want to arrange transport. E group is used there. F group, seller can arrange some transport within their own country. C group, seller can arrange and pay for most of the freight charges up to the foreign country also. D group, where the seller can pay for most of the delivery charges to the destination country. What is this? What is this? So say, this is when no transport is there. Okay. Now, this is same country. Here, foreign country but not destination country. For example, if the goods were coming from UK via from UK to Dubai to India, and the UK transporter have agreed that I will pay up to Dubai, I will not pay up to India. So now here what happens is, they will be considered as what? Under C group. Then D group is what? When they are paying up to destination country, up to destination country. That is important. Up to destination country. That is very, very important. Okay. Now, the Incoterm that comprise these 4 groups can be divided into 2 categories. That is, these 4 groups come into these 2 categories. Term suitable for any mode of transport, term suitable for sea and inland waterway transport. That is, by any means of transport, only when marine transport is involved. Marine transport, that is transport via water. Now, there are certain terms. Once we complete this, our chapter would be completed. Okay, these terms are that important. Any questions so far? Any questions so far? Do let me know. Any questions so far? I can read your chats. Any questions so far? Yes. Any questions so far? Okay. Now let's discuss on these Incoterms. So EXW, that is X works. That is the symbol. This is the name. This is symbol or acronym. This is the name. Okay. So X works. Here what happens is, if goods are sold X works, the seller makes the goods available at the seller's own premises or another named place, say warehouse. This rules places minimum responsibility of the seller. That is, goods sold from Mr. A to Mr. B, and Mr. B will deliver the goods at Mr. A's place only. That is about this paper weight. What happens is, whenever I buy this, the terms are very simple, that we have presented it right here. You can take it from here. This is what X works. Okay. A lot of times it happens that I'll deliver or I'll produce and load it into your truck in my factory, but I'll not move beyond. Now, free carrier. What is free carrier? As the name suggests, free transportation. So the buyer specifies the name of the agent or carrier and stipulates a place at which the seller is to deliver the goods to the carrier or agent. The seller clears the goods for export and hands them over at the place. That is, seller gives the product to, seller delivers to the transporter. That is the that is the responsibility of seller. Here, seller delivers at seller's premises, right? Very important. Now, CPT. What is CPT? Carriage paid to. Carriage paid to. So the seller pays the carriage to the named point of destination, but risk passes to the buyer when the goods are handed over to the first carrier. Because we have discussed wherever there is a carrier, the goods are transferred to the buyer once the first carrier is delivered the goods. So the seller pays the carriage up to a named place. Now CIP, carriage and insurance paid. That is carriage as well as insurance, the freight as well as insurance would be paid. So the seller pays the carriage and insurance to the named destination point, but risk passes to the buyer when the goods are handed to the first carrier. That is also very, very important. Named destination could be anything based on the contract. Now DAP, delivered at place. What is this delivered at place? So the risk remains with the seller until delivery of goods to the buyer by putting them at the buyer's disposal at a specified place in the contract. What is this? The risk remains with the seller until delivery of the goods to the buyer by putting them at the buyer's disposal at a place specified in the contract. That is delivery to a specific place mentioned by buyer in the contract. Okay. Now DPU, delivered at place unloaded. What is this? Do you need to remember all of this? Yes, you have to remember. That is the crux of this chapter. Delivered at place unloaded. So the seller delivers when the goods once unloaded are placed at the disposal of the buyer at a named place of destination. What is this? The seller delivers when the goods once unloaded are placed at the disposal of the buyer at a named place of destination. Here unloaded. Okay. To and the seller bears all risk involved in bringing the goods to and unloading them at the named place of destination. That is unloading. Delivery plus unloading. See, delivered at place, unloaded. Now delivered, duty paid. As the name suggests, these are very important, right? But these are very simple also. As the name suggests, what? Delivered, duty paid as in what? Delivered, duty paid as in what? Delivered, duty paid as in what? As in the custom duty would also be paid. So the seller is responsible for the transport of the goods, duty paid to the named destination. For example, if they have been exported to India and if there is any custom duty that is applicable over there, they will be paying that also. The seller bears all the transport costs to that point and all fees, duties and taxes, and all the risk until the goods are unloaded. That is unloaded is very important here. Now, INCO terms for main carriage by water. That is, this is very important when only the transportation is done by water. So these terms are generally used for those transactions where water transport is involved. The above terms that we have already discussed can be used for any mode of transport. Sir, can there be a case that these terms are used for any other mode of transport also? Yes, there could be a case. Okay, that totally depends on the contract, but these are the terms which CISG has given when no other contract has been agreed. So this is CFR, cost and freight. That is, the seller will bear what? The cost and freight up to a specified location. So the seller is responsible for the cost to bring the goods to the buyer's nominated destination port and clears the goods for export. Okay. However, the insurable risk is transferred to the buyer once the goods have been loaded. That is, once the goods are loaded, then insurance cost needs to be taken by the buyer, otherwise all costs are taken care of by the seller. CIF, what is this? Cost, insurance and freight. Here insurance is also taken by the seller. So the seller is responsible for the cost to bring the goods to the port of destination, and the seller must also take out and pay for the basic insurance to cover the buyer's risk of loss during the carriage. That is, during the transit, if anything gets broken, then who is responsible? The seller is responsible. However, the seller delivers the goods cleared for export when loaded on board ship at the outbound port, and risk passes at that point only. That is, risk is passed when the seller delivers the goods cleared for export when loaded on board ship at the outbound port, and risk passes at that point only. That is, after this only insurance is there. That is after loading risk is transferred. However, seller has paid for insurance. Seller has paid for what? Has paid for insurance. That is all that is important over here. Now, FAS, what is this? Free alongside ship. Free alongside ship. Okay. The seller must get the goods to the outbound port specified in the contract. The seller must also clear the goods for export if the contract signifies the buyer is responsible for the shipping cost and risk of loss. That is, buyer is responsible for shipping cost, that is before that seller is responsible, and risk of loss, that is insurance, would also be covered by buyer only. Free on board, here the seller will transfer up to what? Up to boarding stage. So the seller must clear the goods for export and have them loaded. Clear the goods for export and have them loaded on board the ship nominated by the buyer at the port named in the contract. Okay, so they have to deliver the goods to the specified ship also. Cost and risk passed from buyer to seller to buyer when the goods are loaded on board. Now, the most commonly used Inco terms are ex-works, delivered, duty paid, FOB, CIF and FAS, free alongside ship. What is this free alongside ship? The buyer is responsible for the shipping cost and risk of loss thereafter up to it is delivered to a specified place. With this, we have completed chapter number 4 also. I hope you must have liked it. Now, my dear friends, this is very important for us to understand that up to now we have understood a lot of pointers regarding CISG. Now, this CISG needs to be remembered by you when different agreement is not agreed. When there is a specific agreement, you have to go for that agreement. With this, we have completed chapter number 4. This was a short chapter but an important one. Now, let's meet you tomorrow and in the next class for the next chapter. Thank you so much. Hello everybody. Hope you are doing really well. This is Syllabus Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, I would like to invite you all to this session where we are going to discuss about chapter number 5 from your law syllabus. My dear friends, when we talk about chapter number 5 from our law syllabus, here we are going to discuss about majorly the breach part and what are the obligations, what are the rights of the buyers as well as the sellers. That is the overall discussion that we are going to do here. And this chapter might be very important as far as the individual MCQs are concerned, because here the CISG provisions would also be applicable and the other provisions would also be applicable. So my dear friends, I would like to start with the summary part here. Here the major criteria that we need to follow to complete this chapter is that we'll have to read each and every word that is given over here. So whatever I am throwing light upon, you please read it along with me, and for the remaining portion also I would strongly suggest that you read this complete chapter at least once. Now, under CISG, the principal obligations of the sellers are, under CISG, the principal obligation, the main obligation of the seller are to deliver the goods and to ensure that the goods conform with the contract, that is whatever description or sample you have given, the goods, the overall goods that are delivered should match that, right? Now, under the CISG, the principal obligations of the buyer is what? To accept the delivery when it is delivered. Of course, there are certain rules regarding it, that it should be delivered in the due time, to pay the seller at the place and time required under the contract, and to inspect the goods for conformity. If the buyer refuses to check it, to inspect it, then there might be an issue. Later on, if the goods do not match, then seller would not be obligated towards it, right? So this is very important. Now, when I talk about breach, what is the meaning of the breach word? That let's first understand that. Okay, say if I have a contract with one of, say, my employees, okay, or one of my, say, business partners. My contract to them says that I'll have to deliver, say, 50 set of books to them, okay, on, say, 20th of March. Now, if I do not deliver by 20th of March 50 set of books at their premises, be it the terms of the contract, now that would be considered as a breach. Now, here I would also have certain obligations, they'll also have certain rights, I'll also have certain rights based on the terms of the contract. But the thing that has happened is called as breach. That is whenever there is any non-compliance of any terms of the contract, that is called as a breach. Hope this is clear. Now, breach of contract occurs when one of the parties fail to honor agreed contractual obligation. That is how you need to define the breach. Breach of contract occurs when one of the parties, so what if both of them fail? Would it be considered as breach? Yes, that would also be considered as breach. So the right word here that you should include is at least one, not one. At least one of the parties failed to honor agreed contractual obligation, that is called as a breach. Now, what we have to decide is what is the scale of the breach. Is it a minor breach or is it a major breach? So for example, let's discuss this with the help of an example here. Okay, if I tell you that the contract require that there should be a white name slip on the box, on the package box, and the name plate or the name slip that has been inserted is, say, green colored. Okay, as per the terms of the buyer and seller, this is not a very major thing for the contract. Any color would do, but they would have preferred white, but any color would do. Okay. Now this is also breach, but this is a very small breach, a very relatively small breach, right? Trivial breach, relatively minor breach, but there are certain things which are very, very major. Say they ask for the accountancy book and I send them the business law book. Now here, this is a major breach, right? Now, fundamental breach or not, that we have to decide. So what is the definition of fundamental breach? A breach is fundamental if it results in such a detriment to the other party as substantially to deprive the innocent party of what they are entitled to expect under the contract. For example, they were expecting me to send the accountancy books, but I sent them the business law books. Now, this is a fundamental breach because what they were expecting under the contract, that has not been delivered. Okay, unless the party in breach did not foresee, and a reasonable person of the same kind in the same circumstances would not have foreseen such a result. That is, it would not be considered as a breach if a reasonable person in the similar scenario would have behaved like this. For example, if the contract said they need CA foundation books, okay, or they need ACCA books, ACCA knowledge level books. So I would be sending what? I would be sending FA, MA and BT only. But if they were expecting only BT and the contract says ACCA knowledge level books, then any prudent person would have assumed that they are asking for all three books. So here this would not be considered as a breach. Hope this is clear. Now, time of breach, very, very important. Time of breach, very, very important. See, there are two types of breach that could happen. One, at the time of performance of the contract, there's a breach. So say the contract when it was delivered, the package of 50 books when it was delivered, then it got identified that the books that are delivered are only of BT, are of all three subjects rather than just BT. Okay. Now this particular thing is also a breach, but this is a breach at the time of performance of the contract. What if after the agreement but before the delivery, it was identified that the person would be sending all three books, they have already delivered it, it cannot be stopped, and now all three books would be delivered. This is anticipatory breach. That is, before the actual performance, a breach has happened. So in the performance or non-performance of the contract at the time due under the contract, and by a party's words or actions before the due time, indicating that when the time comes, that party will not honor the contract. That is, before the actual time due under the contract, there is a breach, and that is called as anticipatory breach. That is, it could be anticipated that there could be a breach. Hope this is clear. Now, remedies for breach. My dear friends, this is one of the most important topics of this particular chapter. So please pay due attention to this particular topic. Okay, what could be certain remedies? Now, let me tell you, whenever we discuss about remedies, what could be the possible remedies? You might pay the compensation, that could be one remedy, right? You might pay the compensation, that could be one remedy. What could be other parts of the remedies? So there could be specific performance, that is, you say that I do not want any compensation, I want the books of BT. Okay, that could be one. Okay. Now, third thing could be what? You avoid the contract, you suspend the performance, you ask for the completion of the performance, you ask for price reduction. That is, now I'll be taking all three, but I will not be paying say 1000 rupees which is due, I would be paying say 900 rupees only. Okay. And damages, you might say that I have suffered losses, you have to compensate for that. So what would be their demand for performance? The buyer or seller may be entitled to demand that the other party completes agreed contractual obligation, that is specific performance only. Allowance of additional time, the buyer could say or the seller could say that if you allow us more time, or the buyer could say if we allow more time, will you be able to complete? So the buyer or seller may combine a demand for performance with an additional period of time. Okay. Now, completion of performance, if the buyer is in breach, the seller may be entitled to continue with the contract and insist on payment of the full contract. That is, if the buyer is in breach, say they did not accept the delivery, now this is a breach of the contract, but can a seller still say that okay, you take additional time to take the delivery, to accept the delivery, but you please accept the contract, okay, because it would be very expensive for us to call back the products. Now, suspension of performance, the buyer or seller may choose to suspend their own performance until the other party resumes. Say buyer has refused to make the payment, so seller might say that until and unless you make the payment, I will not be delivering the goods to you. That could be one thing. Price reduction, the buyer may be entitled to a reduction of the price payable, like we have discussed, 900 rupees. And damages, either party may be entitled to monetary compensation also for the other party's breach. Okay, what is damages? Damages is a monetary reward that is given to the other party who has incurred a loss. Generally, it is called as the aggrieved party. Now here, please read it. Okay, CISG provides. See, we have to discuss these 5 points, then we have to discuss these 5 points in detail. That is why if we understand it here, we'll just have to read the next 5 slides. Okay. So CISG provides that if the seller fails to perform any of the contractual obligations or commits an anticipatory breach, the buyer may require the seller to perform agreed contractual obligation. This is something that we have already discussed, right? The if the seller fails to perform, the buyer may, that is we are discussing about the seller's obligation and the buyer's right, so require the seller to perform agreed contractual obligation. This is something that we have already discussed, right? Second, reduce the price of non-conforming goods, that is whatsoever is not conforming with the contract, they'll have to reduce the price for it. For example, in this particular case, they were expecting only BT book, but we have sent all 3 subjects, right? So for the remaining 2 subjects, that is FA and MA, that they were not expecting, that is not confirming with the contract, they might be asked to reduce the price. Okay, can they ask to reduce the price for BT as well? No. Now, suspend their own performance of the contract. That is, buyer could do what? Suspend their own performance. They might say that we do not want these books, we will be refusing the delivery of it. Okay. Then declare the contract avoided. That is, they might say that we do not want to continue the contract. We say the contract is avoided from our end. Now, claim damages for the loss suffered as a result of the breach. So same, they were only having storage for the BT books. Now, since additional books have been delivered, they'll have to take more storage, more warehousing storage. Now, in this particular case, they might claim the damages also. Okay. Now, we'll have to read all of them together. Okay. But what I'll suggest is that you go through it yourself also, so that you understand it really, really well. Now, the buyer has the, see, this is just the extension of what we have already discussed. So I'm reading the key points here. You also read it from your end. Just in case you face any trouble, please feel free to reach out to me. Okay. Now, right to require performance. So the buyer has the right to demand that the seller performs all contractual obligations. Okay. Delivers substitute goods for any non-conforming goods and repairs any non-conforming goods if it is reasonable to do so. There could be additional time also. Okay. Now, the seller must inform the buyer that the seller intends to remedy the error. So if seller wants to remedify the error, that is correct the error, they must inform the buyer as well. That is, they are accepting that they could take back the delivery of the remaining 2 subjects. Early delivery and excess delivery, very important point. So if the seller delivers the goods before the date fixed, now it is an issue. But sir, what is why it is an issue? It is delivered before the due date also, right? It happens in case of our personal orders also. The online website sometimes say that the product would be delivered on say 20th of March, but they are delivered on 17th of March. So what is the issue? Difference, it's an issue. So if the seller delivers the goods before the date fixed, the buyer may take delivery or refuse to take delivery. So sir, just asking, if we receive any parcel before the due date, can we just ask them to refuse the delivery? Yes. What if they come back on the agreed date, and then you will have to accept the delivery. Okay. So do not run your mind on that part, that if the order is delivered early, you can reject it. No, you'll again have to accept it when it is delivered on the due date. Okay. Now, okay. Okay, what if the seller delivers more quantity? So it was say required 50 and they have delivered 75. Will the buyer have to accept? No, buyer has the choice whether they want to accept or not. Now, right to reduction in price for non-conformity. I'm talking about say 500 rupees in Indian currency. 500 was the price for single books. Okay, so for FA, MA, and BT. For BT book, you'll have to pay 500, but for FA and MA, the total is 1000. You might not be required to pay 1000, you might be required to pay 900. So if the goods do not conform with the contract, the buyer may reduce the price proportionately unless the seller corrects the defect in accordance with Article 37 or Article 48, or the buyer refuses to accept a performance by the seller under those articles. That is, the seller is not bound. If the seller corrects it, then they do not have to accept the reduced price. But if the seller is unable to correct it, then they will have to accept the reduced price also. But it would be mutually decided between the buyer and the seller. Hope this is clear. Now, right to suspend performance in cases of anticipatory breach. That is, if it is anticipated that there would be a breach, so you can suspend your performance. You can say that now I will not be performing my part of the obligation as well. So the right is available to both the buyer and the seller, because there could be anticipatory breach from both ends. But sir, how can there be a anticipatory breach from the end of buyer? That is not possible, right? Because they just have to accept the delivery. There could be. What if the payment was required of say 500 rupees? They have been declared bankrupt now. Okay, or they are facing financial troubles from which we can assume, or we can reasonably conclude that they might not be able to make the payment. Now, this is also an anticipatory breach, right? Because they will not be able to fulfill their obligations of the contract. So this right is available to both the buyer and the seller. The buyer or seller may suspend the performance of obligations if after the contract has been made, it becomes apparent that the other party will not be able to perform. Okay. Now, right to declare the contract avoided. Sir, so either party could declare the contract avoided. That is, they will not be performing their part of the obligation, right? Yes, they can do so. They can do so. So, avoidance of the contract releases both parties from their obligations under it, subject to any damages which may be due. So, they'll have to pay it off first. Now, there's one word, a party who has performed the contract either wholly or in part may claim restitution. Restitution as in what? Restitution. Restitution means restorage. Okay. So if they have gained certain benefits, they'll have to restore that benefits to the other party. So say they have received a payment of say 50,000 rupees as an advance, they'll have to give it back unless the terms of the contract restrict so from the other party or whatsoever. Restitution means what? A remedy for a breach of contract by which the parties are restored to their original positions before the contract was made or the breach occurred. That is, their going back to their original position. So, say if we have accepted an advance of 50,000 rupees, so we'll have to give it back to the particular person. Okay. Now, right to claim damages. Right to claim damages, my dear friends. We have already discussed all the relevant points from this particular topic, but what I'll suggest is you also should go through it from your end once so that you are able to understand everything. Okay. So the buyer's right to claim damages is independent of other remedies that may be available. It is not harmed by claiming the other remedies. That is, you can still claim damages even if you have claimed any other remedies. Say you have reduced the price of the contract. Okay, you have accepted the reduced money. Can you still claim the damages for any losses that you have incurred? Yes, you can still claim the damages. Nobody is stopping you. Okay, so that's the beauty of this particular particular obligation here. Okay, now we can come to the next topic. But before that, let's take a 2 minutes break and then we can come to the next topic, which is CIAG gives the seller right to. That is, up to now we have discussed about the buyer's right, but now we will be discussing about the seller's right. Let's take a 2 minutes break, then we will start with it. Okay, so now let's start with it again. So when I talk about CISG provisions, where we talk about the seller's right, the first thing is require the buyer to pay or to accept the goods. That is, the seller's rights includes that they might be asking the buyer, or they might ask as a right that buyer has to pay or to accept the goods as well. Now make, supply and claim payment for goods to the seller's specification. The buyer has failed to provide a specification under the contract. That is, until and unless it has been mentioned by the buyer in which way they will be making the payment, they'll have to make the payment as per the seller's specification. So say if the other party wanted to make the payment in cash, but the seller does not accept the payments in cash, and unless it is being written in the contract that they will be making the payment in cash, they'll have to make the payment as per the seller's specification. So seller has the right to decide that. Okay, now suspend their own performance of the contract in cases of anticipatory breach. That is, they can suspend their own contract, their own performance of the contract, just like the buyer could also do so. Declare the contract avoided, similar to the rights of the buyer. Claim damages for the loss suffered, similar to the buyer. Okay, so first two rights are different, other three rights are similar in both the cases. So we'll read these two rights that are different here. Right to require payment and or acceptance. That is, they might be asking, or they have the right to ask the buyer to either make the payment or to accept the goods, or both. So the seller may require the buyer to pay the price, take delivery, or perform the buyer's others obligation. The seller can allow the buyer extra time. They can allow the buyer an extra time. This is something that we have already discussed, right? If the goods have been lost or damaged after the risk of loss passed to the buyer must still pay for them. What does this line mean? This is very important. If the goods have been lost or damaged after being the major word here, the risk of loss passed to the buyer. Sir, how the risk of loss passes? We have already discussed it. Okay, now the buyer must still pay for them. Okay, now right to supply goods made to seller's own specification. So if the contract provides that the buyer will specify the form, measurement, or other features of the goods, and the buyer does not do so, or does not do so on the due date, then the seller may make the specification himself that how the contract would be performed, how the payment would be made. Now right to suspend, we have discussed already in buyer, same is mentioned over here. Then when we discuss about right to declare the contract avoided, similar to buyer. Then when we discuss about right to claim damages, similar to buyer. Let's just read it for your own satisfaction. The seller's right to claim damages is independent of other remedies available to them. Similar thing we have discussed in the buyer also. That is all only covered over here. With this, we have fundamentally covered the rights and obligations of the buyer as well as the seller. Okay, hope this is clear. What if, sir, we have discussed about the obligations, right? What if we are asked about the rights? So we will have to just write. So whatever are the obligations of the seller, those are the rights of the buyer. Whatever are the obligations of the buyer, those are the rights of the seller. That is how we can write it. Okay. Now there is one contract which is called as an installment contract. Installment contract. Sir, are you sure this is the name of the contract? Yes. I'm very sure that this is the name of the contract. The name of the contract is what? Installment contract, where the obligation is to be fulfilled in multiple parts. I was creating new form of notes, new type of notes, and that is why I asked the buyer that I will be delivering in two parts. Volume 1 would be delivered here, and volume 2 would be delivered, say, after 1 month. Okay, now this is some contract which could be called as an installment contract. There might be a contract that even if I supply in one go, they might be paying in parts. That might also be an installment contract. Okay, so an installment contract is one in which payment or deliveries to be made in a series of payment or delivery. We have discussed both. Payment, that is they will be paying in parts, or delivery, that is I will be delivering in parts, is to be made in a series of payments or deliverables, usually on specific dates. If there's a fundamental breach of one installment, please read these 3 points very carefully. Okay, if there's a fundamental breach of one installment, what is fundamental breach? We have already discussed. The injured party may declare the contract avoided for that particular installment. For that particular installment, okay, for that particular installment. If breach of one installment gives the injured party good grounds to believe that there will be fundamental breach of future installments also, then what they can do? Then they can declare the contract avoided for the future. Because if they have a reason that they will not be able, say they have missed out on one payment, and we have a reason to believe that they are not solvent anymore, they might not be able to make another payment. So we are also not obligated to deliver the another set of books. Now, if a delivery fails in a contract in which the installments are interdependent as in one installment depends on the another one, that is, unless volume 3 is delivered, volume 4 delivery would not make sense. So for this, the buyer can declare contract avoided for the present installment and for deliveries already made or future deliveries also. Now, now, measuring damages. What is this, sir? What is this? Measuring damages. We have said no, that damages could be done, right? Damages might be required to be paid. This is like a compensation, okay? So, assuming that you have a land and the government is trying to take this land from you and they have to pay you a compensation. So, how will you decide the damages? So, what is the likelihood that you could have generated, likelihood of income that you could have generated from this piece of land, right? So similarly here, there are multiple types of damages. One is the liquidated damage. Liquidated damages as in, this is a calculation based damage, that is, this could have been generated and now we want that as a compensation. So one way of quantifying the foreseeable loss is for the parties to make a provision in the contract for the amount of likely loss should one or the other breach the contract, or for the means of measuring the loss. That is, whenever there would be a breach of the contract, what would be the loss to the other party, that would be the basis of calculating the damages, right? So say if I have not delivered the 50 books to them, they'll have to buy from some other source, and when they have bought from other source, they got, say, they, instead of 500 rupees for that particular BT book, they had to pay 700 rupees from the another vendor. So they might claim that 700 rupees as a damage. But so 700 rupees, why? Because they were anyways about to take 500 from you, right, my dear friends? You will be required to pay 200 as a damage here. That is 700 they are paying to them, 500 they were anyways paying to you. So now the balance 200 they will be taking from your pocket because you have breached it. Okay, very important. Now let's discuss about the other parts. Okay, when I talk about, this was liquidated damages. When I talk about other measure of damages under CIAG, so there is one. If the injured party has actually made a substitute purchase or sale, like we have discussed in our case, in a reasonable manner and within a reasonable time after avoidance, the injured party can claim the difference between the contract price and price in a substitute transaction. So our price was 500, their price was 700, so that is why they might claim 200 rupees. Okay. Now, if the party claiming damages has not made a purchase or resale, the injured party can claim instead the difference between the price fixed by the contract and the current price also. What if they are not making the repurchase? Because of that, now they will not be able to take admission for the current year, and that is why they have lost. So they will be able to take the difference between the current price and the price of the contract. Mitigation of loss. Mitigation as in reduction of loss, elimination of loss. So provides that Article 77 provides that the injured party must take reasonable steps to mitigate the loss resulting from the breach. This includes taking measures to reduce the injured party's loss of profit also. What if they could have, because they were buying it from you at 500 rupees, they would have sold it at, say, 800 rupees. So you will have to take up for that loss of profit as well. You will have to see that loss of profit is also compensated to the injured party. Now, interest. If a party fails to pay the price or any other sum that is in arrears, that is outstanding, the other party is entitled to interest on it. That is very, very important. So what is the interest rate? Now, interest rate should be as per the rate prevailing in the market for that. Rate should be as per the rate prevailing in the market for that. Hope this is clear. Hope this is clear. Now, exemption from liability to pay damages. So, sir, some parties are exempted from paying damages. That is, they will not be asked to pay the damages. True. It is possible that the buyer or the seller is unable to perform as a result of unforeseen circumstances beyond either party's control. Say natural calamity has happened. Now, in that particular case, Article 79, neither party is liable in damages if it is proven that the failure to meet contractual obligation was due to an impediment beyond their control. Beyond their control. Say natural calamity has happened. They could not reasonably be expected to have taken the impediment into account at the time of making the contract. That is, they were not aware that this could have happened, and they. So what about the reasonable risk that could have happened and that has happened? That will not be covered. But any unusual task that has happened to have avoided or overcome or its consequences. Exemption under Article 70. So, sir, what could be one example where they are not liable? So, I'll give you one example. What if the transaction was to supply 50 kgs of tomatoes? Okay. Now the government has made a rule that now the transportation of tomatoes from one place to another place is restricted, is limited for a certain period of time during the period of the contract. Now this party, the seller, they were unable to transport the tomatoes from one place to another place. But are they breaching the contract? No, because there are legal rules that do not allow him to transfer the products from one place to another. So this is something where damages might not be paid because their intention is to perform the contract, but they are unable to do so because of the legal contract. Hope this is clear. Now, CIRG articles. So let's discuss about Article 85 to 88. Okay, both parties are under a duty to preserve the goods. That is preservation of goods. This is talking about preservation of goods. That is, what if I get the access to that particular goods before the due date? I should preserve the goods. Okay, I should maintain the products. Okay, say if they require a temperature of 10 degrees Celsius. Okay, so I should be keeping it at a temperature which is required for them, that is 10 degrees Celsius only. What if the seller is delaying? They'll have to take care. So both parties are under a duty to preserve the goods if they are in possession of them pending a dispute. So whosoever has the possession of the goods, they'll have to take care of the goods. Okay. It's not like that. Say you found a child and you are about to return to their original parents, but there's a time delay of say 3 days. So you will not allow, or you will not make that particular child eat anything for 3 days. No, you will have to take reasonable care of that particular child, right? Similarly, you will have to take care of the product as well. Hope this is clear. Now, seller's duty to preserve when buyer fails to take delivery. That is, if buyer fails to take delivery, seller's duty is to preserve. What if buyer fails to take delivery? That is why the goods got damaged. So, seller would be responsible. So, under Article 85, if the buyer fails to take delivery, the seller must take such steps as are reasonable. So, sir, for example, the tomatoes were required to be stored at say 10 degrees Celsius. Okay. Now, since buyer refused to take the delivery, or buyer was unable to take the delivery, seller has to book a cold storage and had to input additional cost. So they can claim it as a damage from the buyer. That is okay, but they'll have to preserve the goods. Okay, hope this is clear. The seller is entitled to retain the goods until reimbursed with reasonable expenses by the buyer. Now, buyer's duty to preserve rejected goods. Buyer's duty to preserve rejected goods. If the buyer has received the goods and intends to reject them, then also they'll have to take the reasonable steps to preserve them. If the goods have been placed at the buyer's disposal at their destination and the buyer exercises the right to reject them, the buyer must take possession of them on behalf of the seller and they should preserve it. Okay. This provision does not apply if the seller or an appointed agent is present at the destination. That is, if they are present, then they'll have to bear all the expenses. So can they claim damages from the buyer? Then yes. If buyer refuses to take the delivery, they are not required to preserve the products if the seller or the agent is present over there. Seller or agent would be responsible to preserve the goods. However, they can take the damages. So it is not written here that they can take the damages. That is driven by law. That is driven by case laws that I am telling you. So can we write it in our answers also? Generally, you are not asked to write the descriptive parts. Even if you are asked, you can write it. Don't worry. Okay. Now, let's talk about buyers and sellers' right to store or sell the goods. So, under Article 87, a party who has to preserve the goods may deposit them in a warehouse of a third person and the other party's reasonable expense. Other party's reasonable expense. Okay. Other party's reasonable expense. That is, whosoever is preserving, they can claim it from the other party. Under Article 88, a party who has to preserve the goods is allowed to sell them by any appropriate means if the other party is unreasonably delayed in. That is, say the buyer has refused to take the delivery or is unable to take the delivery, can seller resell it? Yes, but if they are taking possession of the goods or taking the goods back or paying the price at the cost of preservation or the cost of preservation, then they can sell it back also. The party selling the goods must first give the other party reasonable notice of the intention to sell. That is, before selling, the seller should send a notice to the buyer that if you do not accept the delivery, then we will be selling it off, and there should be a particular date that should be mentioned. Hope this is clear. Now, with this, we have particularly completed this chapter. I hope you have understood this chapter really well, and just in case if you face any trouble, please feel free to let me know. But I would strongly suggest for this particular chapter and the next chapter that you should read it very, very carefully once from your end, and if you face any trouble, please feel free to let me know. Thank you so much. Hello my dear friends, hope you all are doing really, really well. Today we are going to discuss about chapter number 6. The name of chapter number 6 is Transportation Documents and Means of Payment. And my dear friends, this chapter might not be directly relevant for your examination as far as remembering the concept is concerned, but you will definitely have to understand this chapter in a manner that you are able to differentiate between different items. So here we are going to discuss about what kind of documents are required while transporting the goods from one place to another, and also we are going to focus majorly under this chapter on means of payment. That is, what could be different means of payment. But sir, why means of payment is such an important thing? See, for example, if you go from here to a shop, say to buy a shirt, okay? Now you buy the shirt and you make the payment in India through say Google Pay, through say other UPI apps, through say net banking transaction checks, okay? But when it comes to import and export internationally, that might not be a very suitable mode of transfer of the payment. So there might be other avenues, other options that you might have to explore to make the payment internationally, and that is why this chapter will teach you about the means of payment. So what we are going to consider under this is, see, first thing is that you'll have to understand it, that this chapter is very important conceptually, okay, because whenever MCQs are asked from this chapter, they are not asked on the basis of exact wordings, keywords, but it is majorly asked on the basis of concepts. So even if you are able to reiterate the whole definition, but if you're not able to differentiate between two items, then this chapter will not be a very scoring chapter for you. So that is why please try to understand it from the point of view that you have to differentiate between different items that are being taught under this chapter, okay. So first thing is that we have to discuss about carriage of goods, and the first thing that is going to be important here is bills of lading, okay. See, for some items, this chapter is a little mix of different types of items. So for certain items, I will tell you that you will have to remember the exact keywords. For some items, I am going to tell you that remember the concept. So please note it down, okay. So for bills of lading, you will have to remember the definition and you will have to remember the concepts as a whole. Then we are going to come to the means of payment, and under that we are going to discuss about the non-cash mechanism. So why non-cash mechanism is required? Non-cash as in why a non-cash transaction is required when it comes to import and export or in terms of business, okay. So we are going to discuss that. Under that we are going to discuss about bills of exchange. We are going to discuss about international bills of exchange, so intra-nation bills of exchange and international bills of exchange. Then we are going to discuss about letters of credit, and you can see that there are so many discussion, there is so much of discussion that we need to do for the international bills of exchange, but there would be certain important pointers that would be equally applicable to an intranational bills of exchange and international bills of exchange, like this one. Then letters of credit, this is one thing that is kind of a form of payment when it comes to the international transactions. Under this we are going to discuss about the nature and form of letters of credit, procedure, special feature, types of credit, types of letters of credit. Then we are going to discuss about the letter of comfort here. Then we are going to discuss about each one of them in detail. Then electronic payment like credit transfers, and then the operations of it, the UNCITRAL, UNICITRAL, which is called as UNICITRAL model law on this, and then we are going to conclude our chapter, okay. So this is very, very important for you. Now coming to the first point, which is bills of lading. When I talk about bills of lading, so here, see, in this chapter you will see a lot of pointers would mention the history about it, okay. Now you should ideally read it once from the ACC study hub. Just in case if you face trouble, please let me know, but you do not need to remember the history part, okay. That is for your knowledge. But what might be tested here, that is very important. What might be tested here in case of bill of lading is the definition and why it is required, okay. So bill of lading is a document which transporter issues. So who issues it? A transporter or a carrier issues it, okay. So say I am the exporter, you are the buyer, and there's a transporter. So the transporter will issue. Who will issue? The transporter will issue. So for every document you have to write who issues it, to whom it is issued, why it is issued, okay. So number one, who issues it? The transporter or the carrier issues it, okay. So issued by carrier or a transporting company to a shipper. Shipper as in the seller. Shipper as in who is loading the goods. Who is loading the goods? To a shipper. Okay, that is to me they will be issuing this document to. And what they will be saying in this particular document is that they have received the goods. What they will be saying? They will be saying that they have received the goods and they will be loading it into the cargo. Confirming receipt of specified goods as cargo to be transported to a named place, whichever is there mentioned, for delivery to a named or identifiable consignee, that is the buyer, that is to you. So sir, my name would also be there as a seller, yes. Your name would also be there as a buyer, yes. Who issues it? The seller or transporter. The transporter issues it, okay. That is how you need to remember it, okay. Hope this is clear. Hope this is clear, okay. Now the history is mentioned over here, background and history. You do not need to remember it exactly, but you should ideally read it, okay. Now certain important pointers about it: negotiable and non-negotiable bills. That is, there are certain bill of lading which is negotiable. Say the product is being transferred from me to you, okay. During the product is being transferred, during the goods are being transferred, what I can do is the transporter issued the letter of credit to me. What could be done is it could be transferred to any other person as well, okay. That is, the buyer could transfer to any other person, so it can be helpful for the shipper. So that is called as negotiable, and the other one is called as non-negotiable. So it can be helpful for the shipper or consignee to be able to transfer a bill of lading. For example, if the shipper seller does not yet have a buyer when the goods are consigned, or that the buyer is not yet entitled to the goods, the shipper or seller will want to retain the rights to the goods until a buyer has been found and or the seller has been paid. Or if a buyer sells the goods on while they are in transit, that is our case. The buyer will want to transfer the right to the goods to their own customer. So what might happen is that if there is a sale that has happened during the transit, the buyer that is you might want to transfer the ownership of the documents to the new buyer, right? So that is how the bill of lading could also be negotiable, but it has to be agreed in advance that whether this bill of lading would be transferable or not. Now, a bill is transferable if it is made out to a named consignee or order. That is, it is written that it is made for a specific person, that is on behalf of you, you will be collecting, or order, that is whomsoever you will order, they can collect it. So you can transfer it. Made out to bearer. So whosoever will carry this bill of lading, they can collect the goods. So that is how you can transfer it. You can just transfer the document and they can collect it. States that it is negotiable. That is, it could be stated that it is negotiable. It could be transferred to any person. My dear friends, now this is very, very important for you. This is very, very important. Why or how a bill of lading could be transferable. Okay. Hope this is clear. Okay. Now, non-negotiable. This is very, very important. Whereas a negotiable bill of lading can serve as a document of title, allowing the holder to claim ownership of the goods, a non-negotiable bill of lading does not have this function. It does not transfer ownership or provide the right to possess the goods to anyone other than the consignee. That is, whosoever it is mentioned to, only they will have the right to collect this consignment. Okay. However, this have the following functions. Evidence of contract, that is, it provides a written evidence of the contract between the buyer and the seller. Proof of shipment, it provides the proof that the shipment was done by the seller towards the buyer. Delivery instructions, whether it is CIF or FOB, what is there. Customs clearance, that is, it helps in clearing through the customs, because custom officer might be demanding a document that shows the document that this particular seller has transported the goods from that place. And legal protection, sometimes there might be legal cases also, so it might prove as an evidence. Okay, so should we remember this? No, not required word by word, you can write in your own language. Now let's talk about the second part. Okay, let's talk about the second part here. Okay, yes. Now, non-cash mechanisms. First of all, before reading this, tell me, do you think that in case of international transactions, only cash method would be sufficient? No, I don't think so. Cash method would only be sufficient. Okay. What is more important to understand here is that this particular method might not be very, very specific, might not be very, very workable when it comes to international transactions. Because let me give you an example. Okay. So say I have this remote. Okay. I have this remote. I'm the seller of this remote, you are the buyer of this remote. I am say sitting in America, you are say sitting in India. Okay, now I might be saying that you need 1,000 such remotes, please make an advance payment 50%. Okay, please make an advance payment of 50%. You will be saying, I have not received any remote, how can I make 50% advance payment? What if you deny to supply it later on? Okay, first problem. Second problem, you say that you transfer these remotes to me, you send it to me, I will be collecting, I will be selling, and then I will be making a payment in a matter of say 60 days. Now I will be concerned that if I send you the consignment, you sell it, but what if you do not pay me? That could be an issue, right? That could be an issue, right? So now in this particular case, we both will not be able to trust each other, and if there is no solution to this problem, then there would be a very major problem economically across the world, because the seller and the buyer will not be able to trust each other and the global business will come down. So there has been a solution that has been identified for this particular problem, and that are known as non-cash mechanisms. So in the face-to-face transaction, the parties can pay one another in cash. In international commercial transactions, the parties are less likely to be dealing face-to-face, and the sum involved are likely to be larger than can conveniently or securely be settled in cash. A party's ability to pay may be dependent upon a chain of linked transaction coming to fruition. So that is why this is very, very important. Now you can read the background yourself, but let us come to the important point here, which is paper payment mechanism, particularly bill of exchange. So bill of exchange is something that we might have discussed a little bit in our FA and FR syllabus, right? Bill of exchange. So that bill of exchange is used. Now, generally, what is bill of exchange? Let me explain. Okay, bill of exchange has three parties: the drawer, the drawing, and the payee. Okay, so say you as a buyer, you draw a bill of exchange. You say in that particular document, you say that I promise to pay, okay, or I will be paying this much amount to the seller, that is me, okay, and you issue it to a third person. Okay, so just like in case of check, there's a banker to whom we issue it, right? Similarly, there could be a third person, okay, that we need to pay this person this much amount and I would be paying it. So payee would be me, the drawer would be you, and the drawee would be the person to whom it would be asked that they make the payment to me on your instruction. Okay, now this is called as bill of exchange. Second one, letters of credit. Letters of credit. What is this letter of credit? So this is generally issued by one person, one bank to another bank. Okay, letter of credit is issued by one bank to another bank. Why? Why? See, what I could do is, or what you could do is, as a buyer, you can deposit some money in your Indian bank, or you might get some overdraft facility or some arrangement between you and the bank. That bank might issue a letter of credit, okay, that would say that this person would be making the payment. If this person fails to make the payment, then I would be making the payment. That is called as letter of credit. And the letter of comfort we will be understanding later on. That is just a simple difference between letter of credit and letter of comfort. Now, hope you have understood this. And after that, there would be electronic payment mechanism by way of credit transfer between banks. Okay, just like NEFT in India. Now, let's talk about bill of exchange in a little more detail. When I talk about nature, form, and general principles, so we have to discuss bill of exchange. A written instruction issued by one person to another. One person to another we have discussed to pay a specified sum of money to a third person. You have issued to another person to pay a specified sum of money to this particular person. Now, there would be three parties: drawer, drawee, and payer, like we have discussed. Drawer, who is signing it; drawee, to whom the instruction is given; payee, to whom the payment would be made. Drawer, the person who gives the instruction; drawee, the person to whom the instruction is given; and payee, the person to whom payment is made. A bill of exchange may be payable on demand or payable at a specified future time. That is, there could be written in the bill of exchange that when it is made payable, okay, when it would be made payable, or there could be on demand. That is, whenever I would be demanding as a payee, they'll have to make the payment. Can that happen? Yes. Okay. Now let's talk about general principles, acceptance and transfer. So sir, this bill of exchange needs to be accepted. What if you issue it? But they do not accept it? So there needs to be an acceptance. There needs to be an acceptance by the drawee. What is this transfer? Can this be negotiated also? Yes, it could be negotiated. For example, this person could also negotiate it that yes, this person or this person could negotiate it that yes, this person has agreed to make the payment. I could also negotiate it that yes, this person has agreed to make the payment. Now, acceptance. Generally, the payee will want reassurance that the drawee will pay up when the time comes for them to do so. With documents other than checks, it is usual for the drawer or the payee to ask the drawee to countersign the bill of exchange. Why not in case of bank? Because it's an established institution, we already trusted. But what if you issue this bill of exchange to a particular person? Now I do not trust that person, so I might be asking that they would be signing it. Okay, now it is less usual for a bill of exchange which is payable on demand to go through an acceptance process. Transfer. A bill of exchange, like a bill of lading, is a negotiable instrument. Okay, unless the wording of the bill clearly prevents it, the payee can transfer the bill to another person. Payee, that is, I can transfer the bill to another person that yes, this payment would be made by this particular drawee. Now they have signed it. So what I'll be doing is I might be transferring it to another person that you go and collect the payment from this person on a specified date or on demand. Okay. Now, discounting. What is this discounting? So this is known as a factoring. Okay, let me explain in a little bit of detail. Okay, this might be asked as an MCQ. What is factoring? See, I have to collect say $1,000, okay, after say 90 days, but I want the money immediately. So I cannot go and ask them because we have already agreed that the payment would be made after 90 days, but I need the payment. I need to produce more goods. Okay. What I can do is I can go to a financial institution, a particular person, a particular bank, and what I can say is that there is a bill of exchange of say $1,000. You take this $1,000, you give say $950 to me. Okay. And on the due date, you go and collect $1,000 from them. What is the benefit to me? I get the cash immediately after deducting certain expense here. What is the benefit to them? No benefit, no loss. Okay. What is the benefit to this particular banker? They will be paying me 950 and they will be collecting 1,000. So $50 profit would be there. So that is how this transaction happens. So it is common for bills to be sold to banks or on the financial markets for cash. The payee takes a discount on the face value, like I have taken $50 discount. Okay. In exchange for ready payment, and the transferee makes a profit on the difference, the $50 transfer difference that they will be generating as a profit. Okay. Now let's talk about some international provisions here. So there's a particular Bills of Exchange Act, UK Bills of Exchange Act 1882, that talks about this particular Bills of Exchange. In India also, the Negotiable Instrument Act takes care of this Bills of Exchange transactions. Okay. Now the convention deals with international bills of exchange and international promissory notes. So what is promissory note? See, bills of exchange is between three people. Promissory note is between two people. Say, I promise to pay you this much amount on this particular date. That is called as promissory note. So, can you give us an example of promissory note? Yes, there is an example. If you see any of the bank notes, okay, generally the governor or the relevant person of the country, they sign it that I promise to pay the bearer of this particular instrument this much amount. Okay, so that is just a promissory note. The notes that we see, you can check it. Okay, now definition and specifications. So let's talk about international bills of exchange. The convention does not apply to checks. So why it is specifically written it does not apply to check? Because bill of exchange has one more category which is called as check, because you also issue a particular document as a drawer to the bank. They become the drawee to pay a particular person to whomsoever it is written, right? So that is why it is specifically written here that it is not applicable to banks. Now bills of exchange are written instrument. See, you have to read it in full once. Okay, I will be explaining all the core points here. So bill of exchange are written instrument other than a check. It is specifically written. Do you need to remember this? Yes. Which contains an unconditional order whereby the drawer directs the drawee to pay a definite sum of money to the payee. That is three parties we have already discussed. Drawer issues it, to whom it is issued, drawee to make the payment to the payee, or their order on demand, or their order, that is whomsoever I tell it to, on demand whenever I ask, or at a definite time also. I hope you have understood it. So do we need to remember this definition? Yes. Bill of exchange definition you need to remember. Okay. Now, a bill of exchange must be dated and signed by the drawer, just like a check. Okay. Please remember, you have to remember all the possibilities, all the features of a check only, but you have to write other than check. Okay. That is the beauty of this particular topic. Now, it is international. If it specifies at least two of the following places and indicates that any two are in different states. So the place where the bill is drawn. So if out of these 5 points, at least two are in different jurisdictions, then it would be called as an international bill of exchange. Okay. The place where the bill is drawn, say in Mumbai, India, the place indicated next to the signature of the drawer, if these two are different, it would be called international. Say the place it is drawn is India, but the sign has been done in Dubai. Okay. The place indicated next to the name of the drawee, so say in Mumbai they have issued it to say a Dubai bank, it's called international. The place indicated next to the name of the payee, say they have issued it in India only, but they have to make the payment to me in Dubai, international. The place of payment, where the actual payment needs to be done. So should we remember this? Yes. Should we remember this? Yes. This could be asked in the MCQ. When a bill of exchange becomes international. Now the place where the bill is drawn or the place of payment must be specified on the bill and must be in a contracting state, that is a valid state. Now amount of payment. So the bill must be payment for a definite sum of money. It could not be blank. A blank bill of exchange is not valid. So there should be a certain sum of money for which amount it is to be paid. Payment on demand or at a definite time. Payment on demand or at a definite time. So bill is payable on demand if it does not specify time for payment. Whenever it is presented, they have to make the payment. Okay. At a definite time, we have already discussed. Parties to an international bill of exchange are called as drawee, payee, drawee, acceptor, and endorsee. In certain cases, we have discussed all of these terms already. Who is endorser? Who is transferring it? Who is endorsee? To whom it is being transferred? So say you issue it to this person to make the payment to me. I endorse it to some other person. I would be called as endorser, and that person would be called as endorsee. Okay. Hope this is clear. Hope this is clear. Now, transfer of bill of exchange. Now, what we have understood in core is the same thing that would be repeated a lot of times here. You don't need to worry. You just need to read it. Whatever you find different, please let me know. Okay. But I'll just show you how it is similar. An international bill of exchange is transferable unless it has been drawn or endorsed on terms that is non-transferable or non-negotiable. That is, unless it is specifically written that it cannot be transferred, it could be transferable, or is payable to a named payee only or not to order. Okay. Now endorsement, we have already discussed about it. If an endorsement is forged as in there is a fraudulent signature to the document, say I have not endorsed it, but somebody has forged my signature and endorsed it. The person whose endorsement is forged, or anyone who signed the instrument before the forgery, has the right to recover compensation from the forger whosoever has signed. Say my brother has signed my signature without my permission and they have forged the document. So I could be demanding the compensation from the forger. The person to whom the forger transferred the document, I could be demanding the compensation from them, or anyone who has gained the benefit out of it. Okay. Now, drawee acceptance, presenting the bill for acceptance. So you have to, again, you have to present the bill for acceptance. The drawee would be accepting it. Okay. The convention provides that a bill must be presented for acceptance if the bill states that it must be presented for acceptance, or the bill fixes the time for payment by reference to the date of acceptance. That is, they might be saying that within 90 days of payment, the acceptance needs to be done. So acceptance needs to be taken. The bill is not payable on demand and is not payable at the drawee's resident or place of business. So if it is payable by demand, no acceptance is required. We have already discussed it, right? If it is payable on demand, no acceptance is required. But if it is payable other than on demand, say at a specified date, then the acceptance is very, very important. Or if it is not payable at the so whatever, whenever there's any unusual thing, that is, it is not paid at the usual place of business or residence, or it is not paid on demand, so we have to take the acceptance. Okay. Acceptance process: to accept the bill, the drawee will sign it on the front or back. Drawee, that is to whomsoever it is issued, they will be signing it. Okay, with or without the word accepted. Okay. Now, guaranteeing an international bill of exchange. What is this? This is the guarantor. They might also have a guarantor. I might be saying that what is the guarantee that this person would be making the payment? I am transferring you $1,000 worth of goods. What is the guarantee that this person would be paying? They might deny. They might be insolvent, right? So there might be a person who might be taking the guarantee on their behalf that if they are able to not pay, then we will be paying on their behalf. So it is getting so much complex. Yes, it is. International transactions sometimes are complex. Don't worry about it. Now, what is more important here is that the guarantee also needs to be mentioned on the bill of exchange by the word the guaranteed or able or good as able. So these are the terms that needs to be mentioned and then signed for the person to act as the guarantor of a particular document. So if somebody presents me a bill of exchange, okay, then it is written able, and they tell me that it's nothing, you just sign it. Should I sign it? No, because it means that you are taking the guarantee of that particular amount. Okay. Now, the guarantor may specify the persons for whom they have become guarantor. That is, on their document, they can mention that guaranteed on behalf of this particular person. Now, if the guarantor makes payment in whole or in part on the bill, the party for whom the guarantee was supplied is discharged in that amount from liability. That is, if the guarantor has made the payment on the behalf of this particular person, then we cannot demand the money from this particular person. They are discharged. Now, the guarantor may recover the amount paid with interest from the party for whom the guarantee has been given. They have the right to demand the payment from this particular person to whom, on behalf of whom they have given the guarantee. Hope this is clear. Hope this is clear. So this is very, very important, right? Yes, very, very specific keywords. That is why I was telling you. Now, within say 20 minutes, 15 to 20 minutes, we will be covering this chapter. You just have to follow along. Now you have developed the concept. You just have to follow along. Okay. Now there would be a new concept that we will be developing when we come for letter of credit. To be paid, the holder must present the bill to the drawee or acceptor again, this time for payment. The presentation must be at reasonable hour on a business day on the date specified on the bill. That is, to make the payment, the bill has to be presented to the particular person to who will be making the payment. It should be presented on a reasonable hour, that is the business hours, on a business day, not Sunday, and at a specified date and place. Okay. Now, the presentation must be at the place specified in the bill or in the usual place of business. What if there's no usual place of business, or the person could not be found near the usual place of business? Then their residence also. Okay, so the presentation must be, so should we remember this, please? This is something that is very, very important in a tested area here. So the presentation must be at the place specified in the bill, or if no place is specified, it must be presented at the address of the drawee or acceptor as shown in the bill, or if none, at the drawee or acceptor's habitual residence or place of business. Sorry. Okay, I'll just pause the video for a second and come back. Okay, now thanks for waiting. So let's discuss about dishonor of bill of exchange. What is dishonor? First of all, the meaning, the plain English meaning of dishonor is when the honor has not been done, right? The respect has not been given, right? In simple terms. Similarly, when we talk about dishonor of a bill of exchange, what it could be, it has been presented for acceptance, but it has not been accepted. It has been presented for payment, but the payment has not been done. So it has been dishonored. Okay. So a bill is dishonored if the drawee refuses to accept or fails to pay, like we have discussed. Non-acceptance if the drawee refuses to accept a bill which is not payable on demand, or circumstances beyond the holder's control mean that the bill cannot be accepted, or the drawee refuses to pay a bill which is payable on demand. The holder can claim payment immediately from the drawer, endorsers, guarantors. If payment is refused when due, the holder can proceed against the drawer, endorsers for non-payment. Okay. So is there any legal proceeding that could be done? Yes, That is why we say no, that check bouncing is a crime. At least in India, it's a crime. That is, if your check is being bounced, which is a part of bill of exchange, that would be considered as a crime. Okay. Now, procedure for seeking recourse, that is for the remedy part. Okay. Before the holder can proceed against the parties on a dishonored bill, there must be some written record made that the bill has been dishonored. That is, you might be presenting it in writing that you need to make the payment, and they must be refusing, or they must be delaying, they must not be responding in writing. Unless the bill states that a formal protest must be made, this can be via way of declaration on the bill signed and dated by the drawee. Otherwise, the bill must be formally protested. This means that the formal statement of dishonor must be drawn up at the place where the instrument has been dishonored. The statement must be signed and dated by a legally authorized person, say notary, to show that the presentment was done and the payment has been refused, or the acceptance was presented, the bill was presented for acceptance but it has been refused. Who is asking for the bill to be protested and what demand has been made? Now, rights of holder and other parties. Rights of holder, as in this case, my right. What would be my right to collect the payments? So the holder can do what? Can exercise rights. If the holder seeks recourse when the bill falls due, the holder can claim the full amount of the bill plus any interest provided if there is a delay. If the bill is overdue, that is past maturity, that is, say it was due on 10th January, what I could do on 15th January, can claim the interest also. If the bill is dishonored before maturity, that is before the due date, it has been dishonored, that is they have become insolvent or they have refused to pay, the holder has the right to claim immediate payment plus stipulated interest subject to a discount for the early payment. Say it was due for another month, it was not due for another month, and you are demanding the payment now because of the dishonor, say they have refused to accept. So you will be given you will have to give the discount also for this 1 month early payment. Okay. So what would be the rate of discount? That would be decided as per the national jurisdictions. With this, we have completed this very important topic, which is bills of exchange. Now let's come to another topic, which is letter of credit. Okay. Like I told you, we will be finishing off in another 10 to 15 minutes. Now, when I talk about letter of credit, let's try to understand the objective of this particular document first. Then we will be reading the theory context. Okay. You are dealing with me, I am selling the goods to you, you are the buyer, and till now we have discussed that there's a third person, but let's assume that this person is not there. Now we are dealing directly. Okay, I don't trust you, you don't trust me, you could be a fraudulent buyer, I could be a fraudulent seller, right? You will not be willing to make the payment early, I will not be willing to transfer the goods early. Who will take the guarantee? If a random person is able to take the guarantee, but I might not be very trustworthy, this person might not be very trustworthy to me, right? What could happen in this particular cases? If the third person is not trustworthy, I might lose all my trust and I might not be able to transfer you the goods. What if you don't trust this person? You will not be making the payment, right? Now the very important point is, who could be this person, the third trustworthy person? It could be a bank also, right? But why a particular bank will be sending a notification to me? Even if they send, how will I trust? I do not have any particular measures, resources to test if this document is authentic. It could be created through AI also, right? How will I trust? So letter of credit is given by one bank to another bank because they are able, or they are having the resources to verify the documents submitted by them to each other. So this letter of credit, as the name suggests, letter of credit is issued by one bank to another bank to say that you can enter into this transaction. We assure you that we will be making the payment if this person does not make payment. Okay. So letter of credit, a bank to bank commitment. This is very important to remember. Who issues it? A bank. To whom it is issued? Another bank. Okay. For commitment of payment in favor of an exporter or seller, the payee or beneficiary guaranteeing that payment will be made against certain documents on presentation are found to be in compliance. Say they can issue that we issue this letter of credit that we will be making the payment of $1,000 on this person's behalf, provided that the relevant documents are being presented. Say the invoice and the delivery order. They might say that the payment would be made, say, on the day of delivery, and we might be presenting the proof of delivery. If we are able to provide the proof of delivery, then we might collect the payment. Okay, this is very, very important. Like a bill of exchange, a letter of credit is a document by which a buyer can arrange for the bank to make payment to another person. Unlike a bill of exchange, a letter of credit is drawn up by the bank itself. It is not drawn up by a particular person. It is drawn up by the bank. That is the difference. So should we remember the difference? Yes. Please remember the difference. Okay. Referred to as the issuing bank at the request of the buyer. The letter will serve as the authorization to the seller's bank, that is my bank, okay, which would be called as advising bank. Should you remember this term? Yes. Issuing bank, advising bank. Who issues it? Issuing bank. To whom it is issued? the advising bank on its behalf to pay the seller a given sum of money on terms laid down in the letter of credit. Procedure. Let's read it point by point. A buyer and a seller agree a contract. The buyer applies to their bank for letter of credit. Sir, should we remember this word by word? No. You can remember it and you can write it in your own words. Don't worry about it. Okay. In favor of the seller to be paid through the seller's bank, the buyer's bank issues a letter telling the seller's bank what the issuing bank undertakes to pay and terms for payment. Like we have discussed, advises the payee of the credit and the terms. Okay. If the payee complies, advising bank will pay. That is very, very important. Confirms matters to the issuing bank and claim reimbursement. The advising bank may also forward the specified documents to the issuing bank. Again, very important. Now, special features. Letter of credit can be for any amount, okay, in any freely traded currency. That is, say this transaction could be done in dollars also through letter of credit, and subject to the presentation of compliant documents, that is we have converted, say in this case, document of delivery at site, which means as soon as compliant set of documents are presented, the payment would be done after a specified term, say 30 days, 60 days. Letter of credit are irrevocable unless they state otherwise and may be transferable by the payee. What is this? This line is very important. Is irrevocable. See, what might happen is I might be transferring the goods, then this bank might be saying that now we revoke the letter of credit. Say 30 days is the time period, and on 20th day they say we'll revoke it. That will not work unless it is clearly mentioned on the letter of credit that this letter of credit is revocable or can be revoked by the issuing bank. This is irrevocable because now the transaction is started and now they cannot back out. When I talk about this, maybe transferable, what this means, that I might say that I have to issue or I have to receive a payment of say $1,000 from this bank. I might be transferring it to another person saying that you go and collect on my behalf, or you go and collect yourself. I might be making the payment, I might be required to make the payment to this third person. I might be issuing this, or I might be transferring this document to them saying that you go and you collect on my behalf, or you go and you collect directly. Okay, that is why this is transferable. Should you remember this? Yes. Now, there are different types of letter of credit. Okay, standby. A standby letter of credit is an assurance from a bank. So should we remember this? Yes. These three is something that you should remember. Is able to pay a seller. The seller does not expect to have to draw on the letter of credit to get paid. Okay. What is this? Standby. A standby letter of credit is an assurance from a bank that a buyer is able to pay a seller. The seller does not expect to have a draw on the letter of credit to get paid. That is, they might not be required to present it. The buyer is sufficiently solvent to make the payment. Revolving. A revolving letter of credit can cover several transactions. That is not just for one transaction, for several transactions. It is usable for each transaction until all the shipments have been made or the full value has been paid. So say letter of credit could be issued. Say we provide the letter of credit up to an amount of say $1 million of transaction. So until that $1 million has been done, the letter of credit is worthwhile between a stated period in the document. Back to back. What is this back to back? So the document could be used by the seller again to generate the business. So back to back letters of credit allow the sellers to use the buyer's letter of credit as security to issue a second letter of credit from them as buyer to the original supplier or seller. That is, if the transaction is happening in such a way that I am buying, that you are buying from me and you are also selling to me. So this letter of credit could be used by you as well towards me. They may be used when an intermediary is involved, but a transferable letter of credit is unsuitable. Okay. That is, transferable letter of credit is not suitable for this transaction. So the same letter of credit could be issued by you as well. Now, practical consideration for parties using letter of credit. So the issuing bank will want to be sure of its arrangement with its customer before committing its funds to the beneficiary. They might be requiring, say, a deposit, a fixed deposit, a bank guarantee. The customer and the issuing bank should take care in specifying the terms for payment. That is, when it will be paid, say immediately after delivery, 30 days after delivery, or what. The advising bank, that is my bank, will want to make sure of the validity of the letter and of the beneficiary's documentation before acting under the letter of credit. That is, before trusting this letter of credit, we might be wanting some documentation, some verification. Recent case law shows that if an issuing bank default, it may have to compensate for all the consequential losses to the advising bank, to the exporter and the seller as well. Hope this is clear. Now let's talk about letter of comfort. Letter of comfort is very, very important here. What is this letter of comfort? Letter of comfort, first of all, is not a method of payment. So why it is given in a non-cash method of payment? Not a method of payment, it's a method of trust. Okay, I tell you, say there are two law teachers. Okay, there are two law teachers. One is a very new teacher, another one is a very experienced teacher. Okay, now if I hire a new teacher under my watch, under my behalf, and I ask you that you please study from them. Okay, I give you a letter of comfort that if they are not able to teach well, I would be teaching you. Okay. Now, earlier you might not be enrolling with them because you don't trust them. But in this particular case, you might be willing to enroll with them because I'm anyways taking like a guarantee, or I'm giving you a comfort that if they don't perform, I will be doing it. Okay. So that's very important. Letter of credit, a statement or letter by a third party. In this case, I am the third party because the transaction is between you and the new teacher, that it will stand behind the obligations of a party under a contract. That is, if they are not able to fulfill it, I will be fulfilling it. Okay. A letter of comfort, also called as a letter of support or comfort letter, is not a method of payment. It is a letter about a person or business to provide assurance to the recipient of the letter that the person or business is or will be able to meet its liabilities when fall due. If they are not able to if they are not able to complete it, I would be completing it. The letter may be sent by any or a number of persons. See, there's a mistake that is there. It is written off here, it's or. It is written off here, it's or. By any number of persons in the manner of a reference. A letter of comfort imposes no obligation or liability upon the writer unless it has the effect of guaranteeing or indemnifying the debts. That is, unless they mention. See, if I write letter of comfort, it just means that I am saying that they will be able to fulfill it. But if I write that I am guaranteeing that if they don't perform, I will be performing, that will create obligation. Make some other clear undertaking that I guarantee if they do not perform, I will be paying you a sum of say $1,000, is issued negligently or fraudulently, say forgery. So then there is obligation, otherwise there is no obligation. Now operation. Let's talk about the credit transfer here, and let me show you something. After this, we just have to discuss one more heading and we will be completing a chapter. Okay. Now what is more important here is the operation, the credit transfer. This is just like the NEFT or RTGS that we have heard of in India. A payment transaction by which a payment services provider transfer funds to a payer's account against a payer's order. So say I issue a letter to my bank that I have set $1,000, I have set $10,000 in my bank. Out of that, $1,000 needs to be transferred to this particular person, and they do it. That is like a NEFT document or a RTGS document that I fill, right? So similarly, it is called. In India, we call it ECS, right? Electronic Credit System. So that is what is the term, the credit transfer. Credit transfer, also known as bank transfer or sending payment by wire. You might have heard this term in a lot of international series, web series also. Wire transfer. Wire transfer as in the instruction to the bank to make a payment on their behalf to some other person. Okay. Or a particular secure and speedy way of sending payment using the sender's and recipient's bank account. Now, in simple terms, the credit transfer process is the person wishing to make the payment, the originator, instruct their own bank. The sending bank, sir, should we remember these terms? Yes, the sending bank, okay, on behalf of the beneficiary to the receiving bank. The sending bank sends a message using SWIFT, that is called a SWIFT transfer also, to the receiving bank, asking to make the payment in accordance with the sender's settlement instruction. Okay. Now, if the sending and receiving banks have reciprocal accounts, the credit will be funded through those accounts and made available by the receiving bank to the beneficiary. If the sending and receiving banks do not have reciprocal accounts, they will use a correspondent bank, reciprocal as in which should be transferred directly, to which the sending bank makes the order and from which the receiving bank draws it. Okay. Now, very important point here is that what are these terms? Once you understand these terms, you will be able to complete the whole chapter. What is the credit transfer? So the operations beginning with the first payment order for the purpose of putting funds at the disposal of a beneficiary via receiving bank, including payment orders issued by the originating banks. So should we remember these terms exactly? No. You should know the meaning of these terms. Okay. Now, payment order and unconditional instructions to a receiving bank to put a fixed or determinable amount of money at the disposal of a beneficiary against reimbursement by the sender. That is, after collecting the payment from the sender, you have to provide this amount to the beneficiary. So in my case, I would be called as the beneficiary if I have to receive the payment. Sender, the originator, and the sending bank. Intermediary bank, to whom the instruction would be given to make the payment to the receiver bank. Any receiving bank other than the originating banks and the beneficiary's bank. Authentication, a procedure. Say the instruction needs to be given to from ABC bank to say DEF bank to make the payment to say XYZ bank. Now this DEF bank would be called as the intermediary bank. Now authentication, that is the proof, the authorization, a procedure established by agreement to determine whether a payment order or an amendment or a revocation of a payment order was issued by the person indicated as the sender. So this is called as the authentication. The OTP that we receive, part of the authentication. Okay. Now execution period, the period for processing a payment order usually 1 or 2 days from receipt. So generally you will see that the NEFT is immediate, but RTGS is up to 2 days, right? So the payment period upon which the payment would be made after giving the order. Now this is something that we have already covered. Here there is some sender's obligation. So a present or former employee of the sender or someone to whom the sender bank has given or enabled access to the authentication procedure, that is, they should be present. Intermediary banks, so when they detects an irregularity, they should issue a notice and should confirm. If a transfer fails, the bank must repay the sender any funds received with interest. Okay, so if the transfer has been failed, so the sender should get the reimbursement of that particular. That is why you receive the message that if any amount is deducted, you will be receiving the credit of it within some period, and it is usually received with interest also. Beneficiaries bank obligations, completion of the credit transfer. So the obligation of the beneficiary bank are the same as those of an intermediary bank, because the obligation of both of them is to make the payment to the relevant beneficiary account. Now revocation of a payment order, can it be done so? Yes, it could be done so. The sender may make the payment order on terms that it is irrevocable also. If not, the sender is allowed to revoke the order and reclaim any funds transfer. So in my case, I can cancel the RTGS also, unless it is mentioned that it is irrevocable. For example, in case of DD, it is irrevocable, right? Once I create it, I have to honor it. But in case of check, it might be revocable. I can stop the check payment also. Now rights of assistance, refund, restitution and interest. So similarly, what we have discussed, that it could be revoked, it could be paid with interest, it could be demanded with interest. With this, we have completed this particular chapter. It has been an amazing chapter, and now this would be the official chapter. This would be officially the last chapter of this particular unit, where we discuss about the transfer provision, the buying and selling, the CIAG provisions. Now after this, we will be starting with a concept called agency, partnership, then we will be discussing about company accounts and so on. So I hope you have understood this concept really well. This chapter would be particularly important from the point of view of letter of credit, letter of comfort, the international payments, the bill of exchange. That is what would be important here. So if I have to name 3 topics: bill of exchange, letter of credit and letter of comfort. With this, we have completed this particular chapter. Now see you in the next chapter. Thank you so much. Hello everybody, hope you all are doing really well. I am C.A. Subrit Agrawal, your faculty for ACCA AA, AAA and law subjects. My dear friends, today we are going to discuss chapter number 7 from your law syllabus, which is agency. This chapter is not individually important for your examination, but if you look at the overall syllabus, then there would be a lot of discussions about this particular concept, which is agency. But sir, how is that possible that the individual concept is not important, but it is used in other chapters as well? So let me give you an example for now. Okay, so my dear friends, let's assume an example that I run a training institution. Okay, I run a training institution. So say there is Mr. A, there is Mr. B, and we run a firm. Okay, we run a firm of training institution. Okay, now what happens is Mr. A has committed certain discounts to one of the student, say C. Okay, do you think Mr. B is also obligated to follow this discount now? Even if later on Mr. A is not available at the time of the final admission, but Mr. B will still have to honor the discount that has been given by Mr. A. Do you think so? Yes. Why? Because this is a firm, and when we move to our next chapter, we will have a chapter on partnerships, where we learn about that both the partners are principals as well as agents of each other. Okay, now again let me give you another example. There is one person, Mr. B, who has hired Mr. A to do a job. Okay, based on the instruction of Mr. B. Mr. A has done that job. By following the instructions, they have not disobeyed any instruction, they have followed the instruction, they have done the job, and there is any liability that has been arised. Who is liable? Mr. B would be liable, right? Why? Because this is an employment contract and the person has worked under the employment obligations, employment instructions only, and therefore Mr. B, that is the person who has appointed the person, would be liable, even if the mistake or even if the liability is on account of Mr. A as well for the work done, right? So that is very important for us to understand that there is this concept agency that plays a very important role in the lives of any of the business transaction. So see, let's talk about chapter number 7, agency now. what we are going to do is, first thing that we are going to discuss about the basics of agency, then we are going to discuss about liabilities of a principal, who is the principal, who is an agent, then that we will discuss, then duties of agent to the principal and duties of principal to the agent, and that's how we will be completing this chapter. Sir, it is this short chapter? Yes, it's just a 3 to 4 pages chapter, you don't need to worry about it. Okay, now let's discuss about who is principal, who is agent. So my dear friends, it is not defined in law that what is a principal, who is a principal and who is an agent, but if we speak generally, then agent is someone who does a work for or on behalf of somebody else. And who is the principal? Principal is a senior authority, right? So someone for whom or on whose behalf the work is being done. The work is being done. That is important to understand. That is somebody who is actually doing the task on behalf of somebody else, that is called as an agent. But somebody on whose behalf the work is being conducted, that would be called as principal. So here both the person would be principal as well as agents of each other, but here Mr. B would be principal, Mr. A would be agent. Okay, I hope this is clear. Now let's discuss about each one of them in detail. Let's discuss about all the key pointers. So agency, the authority of one person, an agent, to make legally binding commitments with third parties for someone else. That is, agent has the power to do certain tasks on behalf of the other person, that is the principal. Now agency relationships can arise formally as well as less formally also. Formally as in what? Through power of attorney, right? Power of attorney could be signed. That is, if I am not living in India but I want to sell some property, I can transfer my power of attorney to someone who is living in India who can enter into the transaction on my behalf, right? So through signed sealed power of attorneys or written agency agreements or through employment arrangement. Why this is called informal? This is also formal, right? But it is called informal because here automatically agency is created in the case of partnerships, in the case of employment, like we have discussed. Now examples: company directors are agents of their companies. Do we understand it? Yes, because they are in the employment contract. Members of our partnerships are another's agents as well as principals. Did we discuss it? Yes. We will discuss it in little more detail when we enter into the next chapter, which is the partnerships. Okay. Now, if the agent acts improperly, without authority, the principal will usually be bound to honor the commitment with the third party, but will be able to claim compensation for the agent's breach of duty. What is the meaning of this? Let's understand this. Okay. Let's understand this. My dear friends, Mr. A hired Mr. B. Mr. B did certain tasks but did not follow instructions. Not followed. Okay. Will Mr. A be liable? Yes. Will Mr. B be liable? No. But Mr. A can claim compensation from Mr. B. That is important. Okay, I hope this is clear. Now, an agent can make contracts for the principal within the scope of whatever authority the principal has given the agent. That is, I also sell my books. Through my agents. Now, all those agents have the power to sell the books because I have given the power to sell the books. Can they sell the lectures also? Yes, because I have given them the power to sell the lectures. But can they provide discounts? No, because I have specifically told them that whatever price I have decided at my level, you have to sell at that particular level only, at that particular price only. You do not have any rights to provide discounts. There are some of my agents who are really old agents to whom I have provided the authority that you can provide discounts up to 10% of the fees that has been charged from the students. So that is, an agent can make contracts for the principal within the scope of whatever authority the principal has been given. The principal has given the agent. Now, an agent who is a minor, that is under 18 years generally, can be authorized by an adult principal to make commitments for the adult which would not be binding on the minor. That is, point to be noted here is, that is, minor can be appointed as an agent, but ultimate responsibility would be of principal. or let us rephrase it, but principal would be, but what? But principal would be liable for all acts of minor. Can minor be appointed as the agent? Yes. Can minor appoint an agent? No. Can minor appoint an agent? No. So let's write a point over here. Minor cannot appoint an agent. But why, sir? See, the logic is pretty clear. Try to understand one thing. If agent does some mistake, principal is liable. Here, if minor would appoint an agent does some mistake, then it comes to minor, and minor would say that I should not be liable according to the law. Therefore, minor cannot appoint the agent, but minor can be appointed as an agent. Now, an agent cannot be empowered to make contracts by a principal who cannot make contracts due to a legal disability. An agent cannot be empowered to make contracts by a principal who cannot make contracts due to a legal disability. That is, an agent cannot work on behalf of somebody who is legally incompetent. Say they are of unsound mind, they are minor, or they are insolvent. So, agent only only a person capable of entering contracts can appoint agents, right? Very, very important. Now, an agent is an extension of the principal. Agent is an extension of the principal as long as third parties know that they are dealing with an agent. Even if they do not know who the principal is, they will be bound to the principal by agency contracts made on the principal's behalf. That is, even if they do not know who the real principal is, but if some contract has been done by the agent on behalf of the principal, still the third parties would be liable towards the principal to do certain tasks. So, for example, Mr. A hired Mr. B as the agent, and Mr. B entered into a contract with Mr. C. Here, Mr. C would be liable to Mr. A to complete the agreed work, even if it is done through agent. Now, the agent usually has no liability to a third party. Why it is written usually? Usually. Why usually? Because agent is liable to third party, because agent is liable to third party when agent goes out of authority or works illegally, then agent would be responsible. Therefore, it is written usually agent is not responsible. However, an agent who enters into a contract with a third party on behalf of principal warrants the authority to do so. If this is not the case, the third party has the right to sue the agent for breach of warranty of authority. That is, warrants as in should have authority. Warrants as in should have authority. Warrants, that is, should have authority to enter into such contracts. You know, few days back, I'll give you one example. Few days back, what happened was, one of my team members was there who was given the authority to just counsel the students, not take the admission of the students until I say so. Okay. Now they have counseled, and the student really was interested in enrolling, so they enrolled also. Now, did they perform? Did they do anything which is beyond their powers? Yes. Now, I did not warrant them to do this task. Now, if any liability comes up, then then the student could directly sue this particular person who has acted beyond their authority to perform the task. Okay, this is the summary of this page number 1. My dear friends, you must have noticed by now that even if we just study one page, we make so many pointers, so many notes, that it helps you to understand in detail, and that is why I share the board notes with you all as well. So please go through the board notes as well. These are really important for you, and you need to understand that law is that one subject where interpretation is very important. So we cannot just read the lines and expect that we will remember everything. What we need to do is we need to understand everything in the manner that we are able to relate everything as well. Every new word, for example, warrants here, should be understood by you in complete sense. So whenever you face any difficulty, please feel free to let me know. Now, liabilities of a principal. Liabilities of a principal. Here we are talking about principal. Here we are talking about whom? The principal. That is very important. Okay, now there are two types of authority: actual authority and apparent authority. So what is this third one? This is agency by necessity. We will discuss about it just after this. Okay. Now, actual authority. When I talk about the actual authority, what is the meaning of actual authority? So the agent's authority may be express or implied. Express or implied as in, it could be written or oral, implied by actions. That is, sometimes if somebody is there whom I do not have a written agreement with, but they have been selling my books, they have been selling my lectures from years, and now students have a trusted name that if we buy from this person, they will be selling Supreet sir's lectures. Now in this particular case, that person would be considered as my agent, because for years I have allowed him to do that work that my agent should have been doing. So by act, now that person would be my agent. Will I be responsible for his acts? Yes. Now a principal may retroactively authorize an agent by ratification. Retroactively as in after the work is done. That is, if the task was done on say 1st of January and it came to the attention of principal on 10th of January. Now on 10th of January, this principal has two options. They could ratify, they could say that yes, this act is authorized, and the person, even if not initially authorized, now I authorize this particular act and now I am liable for this particular act from the day of the transaction only, or they can reject it also. So a principal may retroactively, that is when they come to know about it, they can authorize it. Now the principal is liable for all commitments incurred by the agent within the scope of the agent's actual authority, that we have discussed, that if agent has performed certain tasks within their actual authority, then the principal is bound by it. Actual express authority may be granted under an explicit agreement also, under a partnership agreement also, because partners are principals as well as agents of each other, and under an employment agreement also, by operation of law, when law has specifically made an agent. So sometimes what happens is, by court of law, by operation of law, the person is considered as an agent. So that is also covered. Now an agent's authority to sign deeds for the principal must be given by deed. This document is known as power of attorney. That is, an agent could only sign the documents on behalf of the other person, on behalf of the principal, only when they have been given the specific authority in writing. That is, if any document is signed without authority, principal is not bound by it. That is, if any document is signed by agent without power of attorney, principal is not bound. Principal is not bound by it. I hope this is clear. Now, an agent has implied authority, that is, even if they do not agree, by actions also, to do things which are necessary, conducive or incidental to performing expressly authorized acts. That is, even if it is not mentioned specifically, but if some task is important to do the actual assigned task, then also the agent is liable, or agent has the power to do it. For example, if I specifically told my agent that you have to go to a different city, okay, which is say 500 kilometers from now, you have to go there at the company's expense, you have to sell the books, and you have to come back. Now in this particular case, the initial task, the assigned task is to sell the books, right? Meet people, sell the books. But here the agent would be responsible, would be authorized to book the tickets, to have some food that is really organic, that is really good for a human being, okay, that is fit for a human being to consume. So that is very important here. Now this line is very important. Okay, this is important also, because some of my students have previously answered in the test that So this particular act was out of the purview, they were not authorized to do so, they should have asked the principal, but no, these are incidental acts, right? Now, the principal is bound by acts within the agent's implied authority that we have discussed, even if a particular transaction contravenes the agreement with the principal. An exception to this rule is if the other party was at the notice that the agent's authority was restricted. That is, even if agent has not followed the instructions and have certain tasks and have done certain tasks, principal would be bound by it until and unless the other party also knew about the restriction that the agent is not authorized. That is, if other party knew that agent is not authorized, then principal not liable. Then principal not liable. I hope this is clear. Yes. Now, apparent authority. When I talk about the apparent authority, this was all about the actual authority. So, do we need to remember this word by word? Definitely not. You do not need to remember this word by word. What you need to do is, you need to understand the overall concept of it and you can write it in your own words. Now, apparent authority. Apparent authority is also referred to as ostensible. This word would also be used in the active partner when we go to the partnerships. Ostensible authority or authority by holding out. This is the word that you might have studied in your 12th commerce syllabus also, right? Ostensible could be called as active, okay. By holding out could also be called as estoppel. These are the words that you might have already studied in your partnership syllabus of 12th commerce. Just in case if you have not studied it, don't worry, the next chapter is on partnerships only. It arises from the equitable principle that a person cannot deny something that has previously been held to be true. That is, if something has been agreed previously that this task would be done in a specific way, now the principal, even if there is some loss on account of the principal, they cannot deny accepting that task that has been done by the agent. So, a principal who allows someone to appear to be an agent will be liable to those who relied on the holding out of the perpetrated agent, said agent, okay, not sad, SAD, no, SAID, said agent, and estoppel will be raised to prevent the principal from denying the agency. That is, principal cannot deny that the person is his agent once the agency is created. That is, it could happen no, that whenever there is a liability, the principal might say that okay, this person is not my agent, but that could not happen. The principle of estoppel stops the principals from letting go of their liability. Now, agency by necessity, what is this? So, sometimes what happens is, for example, my books were kept at some warehouse, the warehouse kept the fire or took the fire. Now my agent is standing over there and they are thinking that, you know, I do not have the authority to keep the books outside of the warehouse because the agreement specifically says that I have to keep the books inside the warehouse, but the warehouse is on fire. Should I keep it out to keep it safe or not? So this would be covered under the case agency by necessity. So agency arises out of necessity if a person in possession of another's property, in this case books, and unable to take the owner's instruction, in this case they might have called me, I might not have picked up, is obliged to do something with the asset in order to protect the owner's interest. In this case they were just trying to protect my interest. The owner will be liable as principal for the bona fide acts of the agents of necessity. That is, what bona fide as in good faith, bona fide as in good faith, acts done with good faith, acts done with good faith. So if somebody has done some work with good faith, so you know what happened when they kept the book outside, some book got wet by rain, and now some book got destroyed, some book got damaged, and I am claiming that money from the agent, but agent was just trying to do a bona fide act to protect my interest. So now agent would not be liable, I would be liable to do this. This is also very, very important in my vision. Okay, this is very, very important for you to understand. I hope you have understood it. Just in case if you have not understood it, please feel free to ask your queries. I would be happy to answer it. Okay, now let's go for the last page, which is duties of the agent to the principal and duties of the principal to the agent. Let's just read it. These are very, very simple, just the basic duties. Okay, an agent must obey. So we just have to read it. An agent must obey the principal's lawful instructions. That is true. Failure to do so as instructed is a breach of duty. Clearly, there can be no obligation to honor unlawful instruction. That is, it is not forced that you should follow all instructions, be it unlawful also. But whatever lawful instructions are there, you have to follow it. An agent must exercise due care and skill when performing duties. That is, they do not just have to blindly follow the instructions. They have to apply common sense. They have to have some good understanding of what they are doing, and they should exercise due care and skill also. An agent must act in good faith for the benefit of the principal. That is, they must always act in good faith for the benefit of the principal, like we have discussed in the emergency task also. An agent must avoid conflicts of interest with those of the principal. That is, if there is some task where agent's interest and the principal's interest are conflicting, they should think about the principal's interest and they should prevail that. They should think about that. The agent must not compete against the principal and is not permitted to acquire any personal profit, not permitted to acquire any personal benefit. That is, they could not do so that whatever books they were selling on my behalf, they got an offer to sell on somebody else's behalf also, and what they did is they thought that okay, if I sell not on their behalf but on somebody else's behalf, I will get more money from the same product. No, they are not allowed to gain personal benefit out of it. They cannot do so that they have charged 1000 rupees but they have reported only 900 rupees. That would be called as personal profits, right? An agent who makes an unauthorized secret profit in some way is liable to account for principal. That is, return to principal. That is, return to principal. Okay. Now, an agent must render a true account to the principal where required to do so. True account as in full account. True account as in full account. The duties entrusted to an agent must be carried out personally unless it has been agreed that the duties would be performed by somebody else. Duties should be carried out personally. Someone else cannot do things that the principal chose the agent to do unless the principal gives permission or the contract or trade practice permits. For example, if I have given somebody the contract to paint this entire room, now this paint would not be conducted by one person to whom I have given the contract. They could hire their agents and get the work done. That is allowed. Now, an agent can however appoint a sub-agent. Sub-agent could be appointed where, this is important, where the task is what? Is one which any reasonably competent person can do equally well. That is, they have obtained the agreement but anybody else would be doing. Can it happen that I take your admission and somebody else teaches? No. Even if they are really good teachers, still you have taken my admission, I have to teach because personal skill is involved. Although involving a discretion is a merely ministerial act, is one in which no personal confidence is reposed in the agent. That is, no personal confidence is there. For example, I have said that this phone is sold, I want this phone, and you are getting it from my agent. Even if my agent sells it or I sell it, it's same. It's such that exigencies of business require it. That is, the nature of business requires it. Exigencies, nature of business requires it. Okay. Now, duties of the principal to the agent. Duties of the principal to the agent. Duties of the principal to the agent. So, the duties owed by a principal to the agent are as follows. Principal to the agent, timely remuneration and all, right. So, the duties owed by a principal to the agent are as follows. Of lien, that is a proprietary right to retain the principal goods until paid, or stoppage of goods in transit to the principal. This allows the delivery of goods to be interrupted pending payment. That is, the agent has the right to do what? To obtain lien or to stop transit of the products to get their payment. Just in case if the principal has not paid the person on time, then what they can do is they can exercise lien over it. In certain situations, an agent has a right to pay the agent the commission or other remuneration as agreed. Okay. If no sum has been fixed but payment was implied, a claim may be made on quantum merit basis. What is quantum merit basis? Quantum merit as in what is earned. What is earned? Quantum merit, what is earned or deserving amount. Now, to reimburse the agent for any expenses, losses or liabilities incurred by the agent in the proper performance of the duties. That is, if they have incurred, if the agent has incurred, in this case railway ticket prices, so they have to reimburse it to the agent. With this, we have completed this entire chapter. This was a really short chapter but an important one, so I hope you have completed it. Now, what you need to understand here is that once we have completed this chapter, we have to go for the next chapter, where agency might not be tested directly in the examination, but it will definitely help us to understand when we go for the partnerships chapter or the company related chapters. So this is an important chapter, not from the point of view of examination, but from the point of view of the further chapters. So I hope you have understood it. Please solve the questions. Just in case if you face any trouble, please feel free to let me know. Thank you so much. Hello everybody, hope you all are doing really well. I am CS Agrawal, your faculty for ACCA AA, AAA and law subjects. My dear friends, today we are going to cover a very important chapter because today's chapter is going to be asked in your examination for sure. There are very few chapters where I can say that this chapter would be asked in your examination for sure, and this is one such chapter. So this is chapter number 8 from your law syllabus, which is partnerships. Okay. Now in this particular chapter we have opened the ACCA study hub because this chapter is so critical that we cannot afford to miss even a single point that is relevant for you. Although I would be sharing the notes with you as well, but this chapter and there are very few other chapters as well for which I would like to refer to the ACCA study hub for the purpose of proper coverage of the chapter. So let's start with it. My dear friends, let's first discuss about what is partnership. What is partnership? What is ideal estate? I would suggest that ideally you should also open your ACCA study hub. You should read everything along with me. Okay. So now here, partnership, the relation between two or more persons. What is it? The relation between two or more persons. That is, there should always be two or more persons in business. That is, they should be conducting a business. Now what is business? Business could be manufacturing, trade, service also. Together with a view of profit. That is, if there is no profit view, then it is not a business and it is not a partnership. So if somebody asks you what is partnership, so partnership has three attributes. Two or more persons should be involved. They should be involved in conducting a business and they should be doing it with the purpose of profit, with a view of profit. Now partnership relation is recognized in all legal systems. It arises where more participants enter into a business venture with a view to sharing assets, profits and risk as well. Now this partnership is also an example of agency. When we covered the agency, we discussed that partnership is the best example for agency because here all the partners are principals as well as agents of each other. Okay. Now here ordinary partnerships are regulated by what? Are regulated by the provisions of Partnership Act 1890. Sir, should we remember this? Yes, you should remember this particular act, which is Partnership Act 1890. My dear friends, whatever points I am highlighting over here, ideally you should make a note of it and you should cover it. You should read the ACCA study hub after this lecture also, but you should carefully mark all the pointers that I am telling you right now. Okay. Now there is one more, Limited Partnership Act. Limited partnership, that we have already covered. What are limited partnerships? So limited partnership is also there, which is 1907. Okay. So this act, these two acts are the ones that you should remember. These two acts should be remembered by you. You should remember it along with the year also. Okay. Now the limited liability partnership, see what is the difference? This is Partnership Act, this is Limited Partnership Act, and this is Limited Liability Partnership Act, that is 2000. Okay. Limited Liability Partnership Act 2000. You should not be confused between these three. I have seen a lot of students getting confused between these three. Okay. Now let's move forward. This was all about this page. Now types of partner. When I talk about types of partners, so number one is a general or full partner. In India, we also call this partner active partner or ostensible partner. By the name it is suggested that active partner is the one who is actively involved into the business, right? So here also a general or a full partner is fully involved into running the business and sharing in profits. Now my dear friends, when I say sharing of profits, it includes sharing of losses as well. You don't need to worry about it. Okay. Now a sleeping or dormant partner, sir, is it the name of same partner? Yes, sleeping or dormant partner is the same partner. What would be this partner's attributes? This partner would not be getting involved into the day-to-day business. So invest in business and shares profits, but plays no part in running the business. That is, they enjoy profits as well as losses. They invest, but they do not take part in the regular business. A salaried partner. So salaried partner could also be there. Yes, salaried partner could also be there. A salaried partner is held out by the firm as a partner, but has limited involvement in partnership decision making and profit share. So sir, is it relevant for us? Yes. When you become an ACCA and maybe you become partner of a firm, do you think that after your manager level or director level, they will directly make you a sharing partner? No, because there might be some senior partners as well. So what they might be doing is, they might be making you a fixed salary partner first. That is, you will have some control, you will have some decision making, but you will not have complete power, complete equity into the firm. Then a fixed share partner. A fixed share, that is, there is a particular share. That was salaried partner. Then there's a fixed share partner also. Fixed share is a 10% share. Okay. So a fixed share partner is a salaried partner who also receives a designated share of profits it is common for a person to join an existing partnership as a salaried partner before being offered a full partnership. So this gets the sharing also. Okay, so sir, if I talk about my journey in say Big Fours, okay, can I become manager? Yes. After that, generally director, senior manager or director, then there might be fixed salary partner, okay, salaried partner, and then you can become the full-fledged partner, that is the sharing partner, the fixed share partner. Okay, these are the types of partners. Should you remember this word by word? I would say word by word. Okay, now ordinary partnership agreements. Let's discuss about ordinary partnership agreements. So a partnership agreement can take the form of quite informal, simple contract. Quite informal as in it need not be signed. No, it needs to be signed, but it could be informal also. There is no legal requirement for there to be a formal partnership agreement. That is, even without a formal partnership agreement, the partnership would still be considered as valid only. See, we have understood in certain contracts that certain contracts needs to be in written format only, certain contracts could be in express or as well as implied format also. So this one is not required to be written. Very important point, because if it is asked in the examination, a lot of students generally writes that partnership should be in writing, partnership agreement should be in writing, but that is not true. Now, what is more important here is that a partnership can exist for a single venture or continuing activities. What do we mean by it? So say if I have to conduct the batch of ACCA, okay, say ACCA law subject only. In this particular case, I could be doing a partnership with certain person, that I would be completing this batch and then the partnership is done. Okay, partnership would be finished. But there could be ongoing series also that I would be conducting for law, I would be conducting for AA, AAA, and for multiple attempts also, for multiple quarters also. Now that is a series of events, partnership for series of events. Okay. Now if the parties carry on the business in common with a view of profit, in which they intend to share the profits and losses, then also it would be called as partnership. Okay. Now the PA 1890, what is PA? Partnership Act. The Partnership Act 1890 treatment of partners applies to salaried or fixed share partners and to sleeping partners as well as full partners. That is, if there is any provision that has been created in Partnership Act 1890, then that applies to all types of partners. It is not important that it is only applying to full partners only or fixed share partners only. It applies to all partners, including sleeping dormant partners also. Okay, with this we have completed this particular page. See my dear friends, you can see that this is very important, right? Now this one. So sir, for other chapters shouldn't we study ACCA study? You should, but for these chapters what we should understand is that every particular page is important. I cannot afford to miss even a single point here, right? Because it is directly asked in the examination also. Now publicity. Okay, what is publicity? Publicity is if a sole trader or partnership trades under any name other than the combined names of partners, it must disclose the name of sole trader or each partner, and in relation to each partner named an address in Great Britain at which document can be served. What is the meaning of it? If a sole trader or partnership trades under any name other than the combined names of the partners, that is, if there is one partner, okay, there's a partnership firm ABC and they have created a partnership firm by the name of ABC and Company. Now if this individual people A, B or C or the partnership firm ABC and Company operates under any other trade name, that is, they are operating at some other trade name also, they are conducting some other business activity also, that should be disclosed. Okay, the name of the sole trader or each partner, that should be disclosed, and the relation to each person named and address in Great Britain at which documents can be served. That is, if there would be any documentation serving requirement, so they should have an address at Great Britain. Okay, now the information must be displayed in a prominent position so that it can be read easily in all places where the business is carried on. There you should mention that you are partners of this firm on business letters also, on written orders also, on invoices and receipts also, and on written demands for the payment of business debts also. Okay, now there is something called as this point that is mentioned, which is £1,000. Wow, what is this? It is a criminal offense not to disclose. Criminal offense not to disclose business details as required, punishable by a fine of up to £1,000. That is huge. Okay, that is huge. Okay. Now extent of, but sir, why? Because it is important to protect the interest of the partnership also, because if anybody from the partnership, either partnership firm or any of its partners are working independently also, that might create a risk of breach of confidentiality or illegitimate interest benefits to the relevant partner or the firm. Now, extent of liability of partners. We are talking about the capping on the liability of partners. So, members of a partnership act 1890 business relationship usually have full liability for its debts and obligations. That is, there is no limit on the liability. We have already discussed in chapter number 9. I understand that this is chapter number 8, but we have already discussed in chapter number 9. When you go to chapter number 9, you will see that there is a particular point that business assets, share of business assets of a particular partner can be used to pay off their personal debts, as well as their personal assets could be used to pay off their share of debts in the partnership firm. In fact, not the share, the overall liability also. So, partners are liable to contribute to losses first and foremost in proportion to their profit sharing ratio. Okay. So, first of all, losses would be covered, and then after that, if there would be any liabilities, then also profit sharing ratio. In the profit sharing ratio, they have to incur. If any partner cannot meet their share, the others are liable to make up for the shortfall, because everybody is jointly and severally liable, like we have discussed in chapter number 9, like we will discuss in chapter number 9. Okay. Now, authority under PA 1890. What is this authority? As in powers, the powers that are being given to the partners. Okay. So, every partner is an agent of the firm and their acts in the usual way of business bind the firm, that is all other partners also. So, for example, in this case A, B, C, they have created the company, they have created the partnership firm ABC and company. Now, if A does something in a regular course of business, okay, by using the usual authorities, by not going beyond their authority, then the firm and every partner would be responsible. So, if A has made some mistake because of which there is a liability, can B and C say that now A has to pay it? No. All the partners are equally responsible, the firm is equally responsible. Okay. Now, anyone who represents himself or knowingly allows himself to be represented as a partner in a particular firm is liable as a partner to anyone who has relied on that information to give credit to the firm. Say, this ABC company contracted with Mr. D that they will be disclosing Mr. D as the partner. However, Mr. D will not act as a partner, but they will just be disclosing in their documents that Mr. D is the partner. Based on that information, a bank or a financial institution or an individual has granted some loan to the partnership firm that Mr. D is the partner because of that. Okay. Now, that Mr. D could have some creditworthiness in the market. Now, can that financial institution, can that banker, can that particular person demand money from Mr. D in case of any default? Yes. Why? Because they assume that Mr. D is the partner. Mr. D knowingly allowed himself to be presented as the partner of the firm. So, now Mr. D would also be liable. Okay. But the point to be noted here is knowingly. What if it was falsified information? Then Mr. D is not liable. Only when Mr. D himself allows the firm to allows the firm to communicate that Mr. D is the partner, then only Mr. D would be liable. Otherwise, Mr. D would not be liable. I hope this is clear. Now, let's read the key point here. So, the effect of section 5 and section 14 is that firm is liable for the acts of all its partners and all purported partner as in who has been assumed as the partner, who have been knowingly held out as partners of the firm. Okay. Now, implied versus apparent authority. What is implied versus apparent? Apparent as an actual authority, implied as in what is assumed that this should be the authority, and by default this is a authority. Okay. So, implied authority may be assumed if the person is an actual partner. That is, if I am the partner of say ABC and company, I'll have some responsibilities. So, capacity to act arises automatically from the position of partner in a firm. Apparent authority arises if a person is not officially a partner, but is either held out by others to be a partner or makes some representation about holding that position, like partner by holding out we have just discussed about. So, implied authority, that is if you are an actual partner, there will be some implied authority. But if I talk about that somebody has knowingly allowed themselves to be represented as the partner, then they might have some apparent authority. Okay. Now, after this, powers available to all partners. Now, these are the powers that we are going to discuss. These are the partners that are available to all partners. So, sleeping partner also, they do not get involved into the business, so not to them. The outsider can assume, regardless of the nature of the business, the partner will have authority to sell goods or personal chattels of the firm. Personal chattels as in personal assets of the firm. Can sleeping partner do so? So, generally for the business assets they cannot do so because they are not actively part of the business. To purchase on account of the firm, that is to make the purchases. To receive payments of debts, that is anybody could pay off their debt to this relevant partner. To engage employees for the business, that is to hire employees. Yes. To employ a solicitor to defend the firm in the event that an action has been brought against the firm. So, all of these functions, should you remember this? Yes. Please remember this. This is very critical for you. Okay. Now, partners in trading firms. What are trading firms? Trading firms are the firms which generally buys the goods and sells them for a margin. So say if I buy this remote and sell it off, I would be called as trader. If I manufacture it, I would be called as manufacturer. Okay. If I just provide the repairing services, I am the service provider. Okay. So partners in trading firm have additional assumed powers to deal with bills of exchange also, to borrow money on the credit of the firm also, to secure a loan by pledging assets of the firm. That is, in Hindi we say girvi. So here what is more important is you can create security against the firm, you can give them as collateral and generate the money out of it. Now, no apparent authority. No partner, whether in a trading firm or not, has apparent authority for the following. That is, whatever may be the status, they do not have power to do this, to bind the firm by deed, unless the other partners have given express authority by deed. A partnership agreement made by deed does not suffice for this. That is, it is important that a partnership firm cannot be bind by deed unless the other partners have clearly given their assent. To give a guarantee so as to bind the firm even in relation to the firm's business. That is, they cannot give guarantee on behalf of the firm that if the other person is not able to pay, the firm will pay. To compromise a debt by taking something else instead of money. So say there was a debt of 10,000. Now the other person, 10,000 units, I'm saying bucks. Okay. Now the other person, the person from whom we need to collect the debt, they have proposed that instead of 10,000, you take 5,000 worth of inventory, 5,000 rupees would be paid in cash. A partner cannot go and agree on this unless it is agreed by other partners. Okay. Now, to bind the firm by submitting a dispute to arbitration. That is, they cannot withhold the right of going to court, and they cannot accept the right of going to arbitration only. To unilaterally open a bank account for the firm. That is, unless it is approved by other partners, they cannot open a bank account for the firm also. And that is why you will see in the procedure part also, in general life, you will see that the signature, the OTPs of every partner is required. Now, the firm is bound only if the partner has express authority to enter into these transactions. That is, if a partner has been given the express authority, say in my firm I have been given the express authority to enter or to sign the checks on the behalf of the firm, then I can execute it. I have been given the authority to open a bank account on behalf of the firm because I am the active partner, so that could be acceptable, otherwise not. Now, partnership debts and obligation. Partnership debts and obligations. So see here, the word is active partners. All the partners who are actively involved into the business are called as active partners. Then there is retiring partners, post-retirement benefits, and incoming partners. Okay. So let's discuss about the active partner first. Okay. So partners have joint liability for the firm's debts and obligation, like we have already discussed that there is joint and several liability. Okay, they are jointly and severally liable. Partners have joint and several liability for torts also. Torts as in other than breach of contract, example negligence. That is, there could be some liabilities on behalf or because of negligence also, right, committed by a partner in the course of the business. The Civil Liability Contribution Act 1978 allows a creditor to bring action against successive partners until satisfaction is reached. Successive partners as in who were not involved when that particular transaction was done, but now they are the partners of the firm, they will also be bound by it. If a partner has died, creditors can claim against the partner's assets for payment of debts incurred while still a partner. See, this is very important. If a partner had died, okay, creditors can claim against the partner's asset, that is their share of assets. You can claim against their share of assets if they borrowed it or if they had to pay it, okay, for the debts. Now, partners can look to one another to contribute to meeting liabilities that we have already discussed. If there is any shortfall, every partner will be responsible. So, let's take one example here, okay. A company gave a loan to a partnership firm. There were 4 partners, okay. They have given 10,000, so each would be liable for say 2,500 as per the agreement. Now, partner D died and they are unable, and now 2,500 recovery has to be done. Can their share of assets be used to make this recovery? Yes, because it was a debt that was taken when he was a partner, so therefore he would be liable. Now let's talk about retiring benefits. Okay, so retiring partner will continue to be liable for post-retirement debts unless released from liability by the relevant creditors. That is, a partner who has retired, see, a retiring partner will continue to be liable for pre-retirement debts. That is, whatever debts have been taken before their retirement, they will be liable to them even after their retirement, unless creditor has specifically signed that now we will not be collecting this debt from this particular person. But sir, what if the debt has been taken after their retirement? Then they will not be liable. Okay. Okay, now post retirement debts. Okay, so former partners will be liable for transaction incurred after leaving the firm in dealing with person who knew them to be partner. To avoid this liability, retiring partners should say, see, what happens is retiring partners, even if they retire, they might not, it might not be aware to other person that they have retired and they will not be responsible. So to save them from that liability, what they should do, ensure that individual notices are sent to all people who were customers or suppliers of the firm while they were a partner, that is they have retired, and advertise having left the firm in London Gazette. In London Gazette, they should do what? They should advertise that they have left the firm. Okay, that is the official Gazette of London or UK. Now, incoming partners. What is incoming partners? The partners who are joining the firm now, right? So, incoming partners will not automatically be liable for the existing debts of the firm. However, they can agree to assume them, for example, by a novation agreement, that they can say that yes, we are liable for any liability that comes because of the existing assets of this particular firm. Alternatively, they may be held out to be a partner prior to joining the firm. Okay, that is, if their name appears on the firm's stationery or business website, they may be held out to be a partner prior to joining the firm. That is, they might be disclosed as being partner before joining the firm also. Now, the third section concerns the relationship between partners. As of now, we have discussed about what? The liabilities towards third parties. Let's discuss about the liabilities and duties towards each other. Okay, this is also very, very important for your exam. Hope up to now this is clear. Just in case if you are facing any trouble, please feel free to let me know. Please feel free to reach out to me via Instagram, Telegram, YouTube. You can comment, you can write in the comment box, you can let me know in a WhatsApp message. Don't worry about it. Please feel free to reach out to me. Now, PA 1890. What is PA 1890? What is PA 1890? PA is Partnership Act 1890, sets out the following rights and duties of partners which apply unless the partnership agreement provides otherwise. Profits and losses to be shared equally. Profits and losses to be shared equally. Okay, so unless the agreement provides otherwise, that is unless something else has been agreed in writing, this would be prevailing. That is, profits and losses would be shared equally. No interest on fixed capital. No interest would be paid to partners. 5% interest per annum on advances by partners. That is, if any loan has been given by partners, 5% interest. No salaries payable to partners. No salaries would be payable to partners. The firm to indemnify partners for expenditure that has been incurred by them. That is general clause only. Records and accounts must be kept at the main place of business. Very acceptable. Every partner to be entitled to take part in management. Okay, that is also good. Unless it is written that somebody is a sleeping partner, everybody would be considered as a partner who has right to take part in the business. Any decision to change the nature of the firm's business to be unanimous. What does this mean? That if there is any ordinary business, it could be approved by majority. But if there is any business, if there is any point for that which might result in a change in nature of business. Say you are leaving the education industry and you are going into the printing industry, printing of books, for example. This is change in nature of business, right? So for that, unanimous consent, that is every partner should give their consent. Even if one partner is not giving their consent, even if all 9 are given but one partner is not giving the consent, then also it would not be considered as acceptable. So no new partners to be introduced without the consent of all existing partners. That is, all existing partner will have to agree before inviting any new partner. Now this is similar to that in case you have to invite any family member. Okay, you want to marry somebody, so you need the consent of every person that is there. That is why, and then only you can bring a new partner in your family, right? So similarly in the case of firm also, no expulsion as in removal of a partner by majority vote unless the partnership agreement specifically provides for this. That is, unless this power has been given to majority of the partners, that majority of the partners could expel a partner, they can not do so unless it has been previously agreed in the deed. Duty not to make secret profits. What is this? That is, you cannot do anything, you cannot generate any extra profits beyond what has been agreed in the partnership business. So duty not to make secret profits, to take benefits from the information that is there, that is the property of the partnership firm. Duty not to compete with the firm, that is, you cannot have a separate business which is in the similar business line or similar products and services are offered as the partnership firm. You cannot open any separate firm. Even if you do, you have to return all of that profit to the firm only. Okay, hope this is clear. Now let's talk about partnership agreement. So for example, most firms will not want equal share of profits. So what they should do is they should have a partnership agreement. Now what is this partnership agreement? A written agreement is desirable from a commercial and common sense point of view. Particularly if the partners want to vary out any of the statutory basic terms, say they need interest on their fixed capital. Now unless it is agreed in writing, it cannot be provided. Say they need interest of say 10% per annum. Now unless it is agreed, only 5% could be provided. So that is why partnership agreement is very important. It is not however a legal requirement to have a partnership agreement, that we have already discussed about. Now partnership property. What is partnership property? So anything which has been given or introduced as a capital into the firm, or anything which has been brought from the money of the firm, that would be called as partnership property. For example, if I bought this phone with the firm's money, I would be called, or this would be called as partnership property. Or if I have officially introduced this my personal phone as a capital into the firm, that would be called as partnership property. So partnership property is all property which any rights and interest in properties into the partnership are acquired on account of the firm. That is whatever has been brought out by the partners as a capital, or whatever has been brought from the money of the firm. Unless the contrary intention appears, that is unless the intention appears that something else or the opposite is wanted, property bought with the money belonging to the firm is deemed to have been brought on account of the firm. That is, if I use the firm money to buy this phone, it would be assumed that this is the partnership property and not my personal property. It must be held and applied by the partners exclusively for the purposes of the partnership and in accordance with the partnership agreement also. Land belonging to a partnership held in the name of one or more partners is held for the firm only. Now my dear friends, why this is important? Because generally land is registered on the name of some particular individuals only, not the firm. So in this particular case, even if it is registered in the name of some partner, still it would be considered as partnership property. Okay, hope this is clear. Now property of the partners. What is the property of the partners? So partnership property must be used exclusively for partnership purposes. Any increase in the value of the partnership property belongs to the partnership. Partnership property is used to pay debts before personal property. Partnership and personal property are treated differently in satisfying any claims made by partnership creditors also. That is, partnership property would be first used to pay off the debts of the partnership firm, and then the other partners could enjoy the benefits, or any other personal liabilities of the partners would be paid off after that. Now formalities. What is this formality? So a general partnership has no legal existence separate from the partners. Therefore, if a partner leaves the firm or a new partner joins, it is technically dissolved and a new one is started. See, when I talk about a general partnership which is created for the general purposes, if any one partner, that is partnership at will, if any one partner leaves, then it would be considered that the partnership has been dissolved and now a new firm needs to be created. In practice, the formalities are kept to minimum, and as mentioned, a novation is effected in order to avoid new agreements having to be drawn up between partners and with the employees. So novation is done. Circumstances leading to dissolution. What could be certain circumstances due to which there could be dissolution? So there could be fixed term, that is the fixed term partnership was there, the partnership has come to an end, so now the partnership has been dissolved. Or there could be court order also, the completion of any single venture, that is it was created for a particular venture, particular partnership, and now that venture has been done, say to create a flyover, the flyover has been done. Okay, death or bankruptcy of any one partner in case of partnership at will. Any event which makes it illegal for the partners to carry on the business, in all of these cases it will be considered that the partnership has been dissolved. There is a specific paragraph that has been given to the court, that is the court may grant an order dissolving the firm after hearing a petition from one or more of its partners seeking winding up, if on the grounds that a partner has become permanently incapable of performing on the partnership contract, permanently incapable. Okay, a partner has been guilty of conduct calculated to prejudice the carrying of the business, that is against the business. Then a partner willfully or persistently commits a breach of the partnership agreement, or otherwise so behaves that it is not reasonably practicable for the other partners to carry on. It is just an equitable also, or it is in the interest also. The business of a partnership firm can be carried only at a loss also. So should we remember these points? Please, you have to remember this. See, there could be certain scenarios which could ask that in what case court can grant the dissolution or court can order the dissolution. There might be cases you might be asked to tick the odd one out. You might be asked to tick that which one is the case. So you should ideally remember all of this. This page is very important, and that is why I am using the ACCA study up to explain this particular topic. Now consequences of dissolution. Consequences. So the assets of the firm are distributed in following order. Number 1, debts of the firm. Number 2, advances by partners beyond their fixed capital, that is only the loan that has been given to by the partners to the firm. Partners capital, and then any surplus to partners and profit sharing ratio. Okay, so this is the assets of the firm are distributed in the following order. So should we remember this order? Yes, please remember this order. Okay, Now, Limited Partnerships Act 1907. Okay, Limited Partnership Act 1907. Let's discuss about it. So, a limited partnership under the 1907 Act differs from a general partnership in that it allows one or more partners to invest in it on terms limiting the capital at risk at the amount of the investment. That is, they could only lose their investment, but there would not be any additional liability. So, sir, in general cases, if you invest 1 lakh, can you get 10 lakh liability also? Yes. But here the liability would be limited only to the amount of their capital investment. Limited partners may take no part in the day-to-day management. They lose their limited capital or limited liability only. Okay. If they do take part, then they lose their limited liability. That is, they will have the liability up to the original debt and not just to the level of their capital. Now, the firm must register details of the limited liability arrangement with the registrar of companies showing the firm's name, nature of business, names of partners and financial contribution of the limited partners. Limited partners may not generally withdraw their capital during the lifetime of the firm. They cannot withdraw their liability, capital. Can other partners withdraw? Yes, other partners could withdraw their capital also. Okay, of course, after the communication with other partners as well. Now, let's talk about Limited Liability Partnership Act 2000. Limited Liability Partnership Act 2000. Sir, we are studying 3x, right? Yes, you are studying 3x. Now, let me show you. After this, we have to discuss legal personality, liability and taxation of LLPs, incorporation of LLPs, membership of LLPs, publicity, termination of LLP, and then the syllabus would be done. That is, we are only left with the Limited Liability Partnership Act 1907. Okay, Limited Liability Partnership Act 2000. Okay, now, so sir, we have to remember 3x, right? The Partnership Act, the Limited Partnership Act, and here Limited Liability Partnership Act 2000. Okay. Now, the Limited Liability Partnership Act 2000 provides businesses with the opportunity of setting up their partnerships on a limited liability basis. That is, every partner will have what? Will have limited liability. Generally, you might have seen that when you see any of the big fours, they might be applying or they might be working under the under the legal name of LLPs. So, say ABC and LLP. Okay. ABC and Co LLP. Now, this LLP is limited liability partnership because wherever you will see that there are multiple people working, and if you say that even if one commits a mistake, everybody would have unlimited liability, then the people will not be forming the partnership firm. So, looking at that point, a new venture, a new legal form came into existence, which was called as limited liability partnership. In this, every partner has limited liability up to a certain extent. Okay. Firms of 2 or more persons are allowed to register on the terms that the members have limited liability for the firm's debts and obligations. The firm becomes a separate person from its members in the same way that a registered company is a person separate from its shareholder. That is, whatever we are going to discuss under companies, that is similarly the attributes of this. But what we should understand is why this is created. So, see, a person creates a sole proprietor and starts with the business. Okay, then once they upgrade, they find new people, they create a partnership. But now the concern is once it goes beyond certain numbers, there might be certain trust issues. There might be people who might be thinking that even if one person commits a mistake, I would be responsible. So, to save from that, limited liability partnership is there. Then if they want to go corporate, they can go for companies also, and then they can go for listed also. That is the hierarchy that they follow. Okay. So, the firm becomes a separate person. The general law of partnership does not apply to LLPs except where the LLP Act 2000 specifically provides. Okay. Now, despite their name, LLPs are in many ways closer to being limited companies than partnerships. The concept is a hybrid. That is, they are more towards acting as companies than towards partnerships. Now, legal personality, liability and taxation of LLPs. Let's discuss about it. So, first of all, like a registered company, see, it is very close to registered company. So, like a registered company, an LLP or a LLP could own assets in its own right and in its own name also, make contracts in its own name, sue and be sued in its own name, create floating charges over its assets, continue in existence despite changes in the identity of its members, and permits its members to enjoy limited liability. Let's explain. Own assets, as in they can buy the assets in their own name, make contracts in its own name, that is whatever contract they sign, they will be signing by the name of LLP only. Sue and being sued, if it is registered, sue and being sued in its own name, partners would not be liable. Create floating charges over its assets, that is fixed charges are against one asset only, floating charges as in against all assets. So, firm as a whole would be responsible to pay off certain debt. Continue in existence despite changes in the identity of its members. Say, if I leave and out of 2 partners, if I am leaving and somebody else is joining, the LLP would continue, it will not be dissolved. permits its members to enjoy limited liability. This is something that we have discussed. However, it will be taxed as a partnership only. It is not taxed as companies. So sir, which is more beneficial? That you should discuss under tax and ATX. Okay, and members will share profits in the manner of conventional partnerships rather than by payment of share dividends. That is, this one or two attributes are similar to the partnership. That is, whatever benefits they enjoy, it would be a share of profit only. It will not be kind of a dividend as happens in case of companies that we will be discussing later on. Now, incorporation of LLPs. Incorporation of LLPs. So, the first members of the LLP or their professional agents must register incorporation documents with the registrar of companies showing the signatures of two or more persons that are associated with the firm, the name of the LLP, the precise address of the registered office, the names and address of its first members, a statement of compliance signed by a member or by a solicitor. Okay, so member or solicitor or both. So, generally both. Okay. Now, the registration fee is the same as for the companies. So, should we remember these documents? Yes, you should remember this process. What you need to submit? A signature of two or more persons associated for the purpose of carrying on lawful business with a view to profit, that is the agreement. The name of the LLP, the registered office of the LLP, the registered address of the LLP, the names and addresses of its first members, that is the first subscribers, a statement of compliance that every requirement has been complied with. That statement should be signed by members as well as the solicitors. The LLP exists as an entity in its own right from the first moment of the date shown on the certificate of incorporation. Now, let's talk about membership of LLPs. Let's talk about membership of LLPs. So, number and types of members, who could be members, incoming and outgoing members, relationship between member and LLP, the relationship between members, etc. Okay. So, let's discuss about membership of LLPs. Okay. So, the LLP must have a minimum of 2 members that we have discussed, who may be human or corporate individuals also. That is, 2 corporate individuals could also form an LLP. Yes. If the number of members falls to below for more than 6 months, then LLP would be dissolved. Okay. So, members personally becomes liable with the LLP for debts. That is, if the members go below 2 for more than 6 months, then the people who are remaining, the partners who are remaining will become personally liable. The firm will not be dissolved. There is no upper limit on the number of members. That is very important. In general cases, the partnership, the normal partnership has 200 as the capping. Okay. Now, in particular, designated members. So, there are 2 designated members. Those designated members are responsible for appointing an auditor, signing the accounts, that is the overall responsibility of board of directors and the audit committee, delivering the accounts to the registrar, notifying the registrar, preparing, signing and delivering to the registrar, and acting on behalf of the limited liability partnership if it is wound up also. So, they will have all the administrative, all the BOD roles, all the board of directors roles also. Now, incoming and outgoing partners. Let's discuss about incoming and outgoing partners. So, the original subscribers to the LLP incorporation documents are its members, listed members. Other members may join later with the agreement of the existing members also. A member will lose membership when on the death or dissolution of the member, by agreement with other members, or by giving reasonable notice. Relationship between member and LLP. So, limited liability would be there. The position is similar to an unincorporated partnership that we have discussed about. Every member is an agent of the firm whose acts within actual or implied authority bind the LLP also. The LLP is liable to the same extent as the member for any wrongful acts or omission within the context of LLP's activities. Now, relationship between members. Relationship between members of the LLP, that is 2 partners. So, the LLP Act provides that the internal rights and obligations of members shall be governed by their own agreement. In default of agreement, the Limited Liability Partnership Regulation 2001 provides similar internal provisions to those under the Partnership Act 1890. Okay, let's read this again. The LLP Act provides that the internal rights and obligations of the members shall be governed by their own agreement. That is, whatever they decide, whatever bylaws they have, in default of agreement. That is, if there is no agreement for certain point, or there is no agreement as total only, the Limited Liability Partnership Regulations has been created that provides the provisions. Okay, but these are similar to Partnership Act 1890. Now, relationship between members and outsiders. So, generally there is limited liability. So, a member's liability is limited to the amount of capital introduced to the LLP. Generally, a member has no further liability for LLP matters. However, an individual member may be liable in respect of wrongful acts or omission. That is, if they have committed some negligence, if they have committed certain fraud, then they would be personally liable. Then, the court can also disqualify LLP members who are guilty of misconduct from being officers of companies or members of LLPs also in the long run. Now, let's talk about publicity. Okay, so after publicity, there is only termination of LLP and then the syllabus would be done. So, let's talk about publicity. The name, publicity as in how they are required to disclose themselves. So in the name of the LLP must end with the word limited liability partnership or the letters LLP. Now the LLP must have an official registered office like we have discussed. Okay, prepare and file accounts, provide the registrar with details of members names also, state its name in legible lettering, that is which could be read appropriately, all the limited liabilities partnerships business letters, all its notices and other publications, all bills of exchange also, so they should specifically mention its name. Show on all its business letters and order forms its place of registration, in which city, in which state they are registered, the fact that it is a limited liability partnership, and the address of its registered office also. Then finally, sir, should we remember that? Yes, you should remember that. That might be important for your examination also. Now termination of LLP, that is the last part of today's lecture. So the Limited Liability Partnership Regulations 2001 extend the rules on company winding up and insolvency to LLPs. LLPs are wound up under procedures analogous to those of registered companies, not under Partnership Act 1890 rules. That is, when it is terminated, it is wound up more like a company than a partnership firm. Under these regulations, the rules relating to the disqualification of company directors also apply to limited liability partners, that we will be discussing in chapter number 15 in the company section when we will be going for it. With this, we have completed the partnership chapter. This was all about partnership. This is a little important chapter for your examination, because generally there are certain questions that are asked from the partnerships. There could be types of partners, types of partnerships, duties towards each other, liabilities, capping, all of that, sometimes registration process also. So all of that is covered as part of your syllabus, and that could be asked in the examination also. With this, we complete this chapter. Now see you in the next chapter. Thank you so much. Hello my dear friends, hope you all are doing really well. I welcome you all to this session where we are going to cover chapter number 9 from your ACCA Law syllabus. My dear friends, this chapter is very important for you because it clearly distinguishes between the attributes of a partnership firm, of a limited liability things, and unlimited liability corporations as well. Now my dear friends, when we start this chapter, it is going to look like a very small chapter to you. That is only a 4 or 5 pager chapter to you. But let me tell you that this chapter is very important because it is going to clarify a lot of concepts that are going to be used in all other chapters as well. So now my dear friends, let's start discussing about chapter number 9, which is corporations and legal personality. Corporations and legal personality. The major, see here what you have to understand is we are going to learn about various types of corporations. So naturally what you have to understand is that you will have to learn about the similarities between them as well as the differences between them. And in this particular chapter you will also have to read between the lines. That is, if something is written, what is the actual meaning of it, what is the actual interpretation of it, that is also something that you need to cover. Now the major current company law statute is Companies Act 2006, which is generally called as CA06 as well. Okay, CA stands for Companies Act 2006, is summarized as 06. Sir, can we write CA06 in our examination also? You can write, but I would suggest not to write it. You should write Companies Act 2006 in full. Okay, so what is the relevant law? If this is asked, what is the relevant law? This is actually an MCQ. Okay, so if it is asked that what is the corporate law that is applicable for your syllabus, so Companies Act 2006 is applicable. This is UK based. Okay, now other relevant statutes are also there, like the Insolvency Act 1986 and the company's model articles regulations. So what is this model article? When there are no specific items that are created, specific laws or regulations that are created, then this would be applicable. So the Insolvency Act naturally talks about the insolvency, which governs the processes and liabilities which apply when a company winds up its business or becomes unable to pay its debts. Now my dear friends, what is the replica here in India for this? So in India we have a separate chapter under the Companies Act by the name of winding up, as well as we have IBC, which is Insolvency and Bankruptcy Code as well. Then the company's model articles regulation, which set out default provisions for company's internal constitution. That is, if no specific provision has been agreed by the company, has been created by the company, then these model articles, these are like the standard articles that are applicable if nothing has been created or nothing has been agreed by the company. Okay, now there are two principal forms of business organization in the UK: unincorporated or corporate bodies. Unincorporated means what? The sole traders and ordinary partnerships. So sir, sole traders could be like, if I say I have an institution by the name of Supreet Agrawal Classes, okay, and I am the sole owner of it, Supreet Agrawal Classes, and I am the sole owner of it, then I would be called as what? I would be called as a sole proprietor. What if one more teacher joins? okay, plus one teacher, and we create a partnership, So now it might be called as SS classes. Say the other person's name is also starting with S, so SS classes. What is a corporate body, sir? So say Supreet Agrawal Private Limited, or Supreet Agrawal Limited, or Supreet Agrawal LLP also. Supreet Agrawal LLP also is covered over here only. I hope this is clear. Now, unincorporated business, sole traders and ordinary partnerships, and here companies and LLPs, because these need to take registration. They need to follow a formal process for the purpose of incorporation. Okay. Now let's discuss about unincorporated businesses in detail. Then we will be moving forward to the discussion of corporations. When I talk about unincorporated businesses, what is important here is sole traders and unlimited liability partnerships are there. So why not limited liability? Limited liability partnerships are part of the corporations. Sole trader, what is sole trader? Sole trader is when one person is acting as the owner of the business. They have the sole rights and responsibilities of the business. So person carrying on business on their account. Okay. A sole trader's business and personal affairs are not separated. Business and personal affairs are not separated. That is, there is no separate legal entity. That is, no separate legal entity. So, sir, if company takes the loan, if my firm Supriya Work Classes takes the loan and Supriya Work Classes is not able to repay it, can my personal asset be used? Yes. If I take a loan, can the company's asset, this iPad, this laptop, could be used? Yes. Okay. Now, the business debts which cannot be paid out of business assets can be recovered out of the trader's non-business property. Non-business property as in the personal property. That is personal property. Hope this is also clear. Now, personal debt which are not met can be recovered against business assets also. That is, if there is any personal asset, if there is any personal debt which cannot be repaid by the owner of the company, then that could be paid off by selling of the business assets also, as it is sole trader, no separate legal entity is there. So what about the perpetual succession? Will perpetual succession be here? No. Why? Because once the owner dies and if the business is not legally transferred, the business comes to an end. Okay. Now, unlimited liability. So unlimited liability partnership, that is a general partnership that we studied about, a general partnership. Okay. Until and unless it is specifically clarified as a limited liability partnership, it is a general partnership. In this case, both the partners are liable for the business is liable for the share of the individual partner. So for example, if there were two partners, say A and B, okay, their personal assets were say 1 million and here 2 million. Okay, their business or say their personal liabilities are say 12 or 1.2 million and here 2.4 million. Okay, this is how it has been divided. Okay. Now my dear friends, if I ask you today that what should be the proportion of the business that they can use. So say their business asset, their share of business assets is 2 lakh or 200,000 and here it is say 400,000. Can this asset be used for their personal debt? So what is the negative balance? Negative balance is 200,000 and the negative balance is 400,000. So can this asset be sold off to pay off? Yes. Their individual business assets could be sold off to pay their individual liabilities. Their share of the business assets could be sold off to pay off their personal liabilities also. Now let's discuss. So a partnership is a relationship between two or more persons. It is a relationship. You cannot write thing. You know, one of my students wrote a partnership is a thing between. So it's not a thing, it's a relationship. Okay, a partnership is a relationship between two or more persons carrying on a business in common with a view to making a profit. So sir, first of all, relationship is a clear word here. Two or more persons should be there. Partnership cannot be formed with the purpose of one person, with the inclusion of only one person. carrying on a business, so it should be a business, and it would be called as a business only when it is conducted with the purpose of making a profit out of it. Okay, now like a sole trader, the non-business assets and income of an unlimited partner may have to be used to pay the debts of a partnership business, and the partner's share of the business may be claimed by partner's personal creditors also. This is what we have understood right here. So like a sole trader, the non-business assets, that is the personal assets and income of an unlimited partner, may have to be used to pay the debts of the partnership, that we understand, and the partner's share of the business may be claimed by the partner's personal creditors also. I hope this is clear. Do let me know if this is clear. Yes, do let me know if this is clear. Yes, do let me know if this is clear. Perfect. Now let's go for the discussion of corporations. When I discuss about the corporations, what is more important to understand here is a corporation is the legal personification in its own right of a public position, an association of individuals, a registered company or LLP. That is, it could be a corporation sole as well, such as the Crown. In UK, the Crown is called as the corporation sole, which is a public position, or an association of individuals also, like ACCA body, like a professional body, a registered company also, say Bajaj Limited. Okay, all of this example, say Bajaj or Agrawal Limited. Hope this is clear. So do we need to remember this? Yes, please remember this. Okay, but after this, whatever we study, you need to understand everything. You do not need to mug up anything. Now, a corporation exists in the eyes of law independently of the people of other corporations who own, represent or control it at any one time. That is, in case of corporation, there is a separate legal entity that is there. There is a separate legal entity that is present. Okay, this means that the owners and managers can arrange the business so that their personal assets are protected from claims by the corporation's creditors. That is, let me write, that is separate legal entity is present and personal assets cannot be used to pay businesses debts. Okay, now a corporation exists in the eyes of law independently of the people. This is something that we have discussed. Now corporations may be created by the following: by royal charter also, royal charter as in royal rules and regulations also, like the ACC body has been created like that. By private act of parliament also, say some corporations could be created. In India, ICI has been created by an act of parliament. By registration under statutory authority also, like any company could be registered under the Companies Act 2006 and they can get the corporation certificate as well. Sir, is this important to be remembered? Yes, this one is also important. Now, the syllabus mostly concerns companies registered under CA06. That is, whatever we are going to discuss about, that is majorly going to be concerned with what? The companies registered under Companies Act 2006. Okay. Now, registered companies may give their members limited or unlimited liability for the firm's debt. Sir, is it possible? We just discussed about that there would be limited liability only, right? No, but they can specifically, unless it is mentioned that it is unlimited, it is generally limited. Okay. So, unless specifically unlimited, corporations have limited liability. Corporations have limited liability structure. Okay, corporations have limited liability structure on their owners. Now, as at March 2022, there were almost 4.9 million companies on the register for England and Wales. In just England and Wales, there were 4.9 million companies. That's huge, right? Now, most companies are limited liability ventures. Why so? Because we have agreed that the biggest benefit of setting up a corporation is to get the limited liability benefit and separate legal entity benefit. Now, the liability of their members owners to contribute towards company funds and therefore towards the payment of company debts is limited to the amount they undertake to pay the company for their shares. So, this would be face value of shares. So, if say you must have understood this in accounting also, if you have agreed to pay say rupees 10 per share and you have paid only up to 8. So what could be asked? Only 2 could be asked to be repaid in case of any debt, in case of any liquidation, in case of any dilution. Okay. Now, day-to-day control of a company is exercised through its directors who may or not hold shares in it. That is, day-to-day operations is run through whom? The directors, who are having the ultimate responsibility, the strategic direction, but they can be the owners, they cannot be the owners. That is, it is possible that say Supreme classes has been set up by me, I have developed it into a corporation now, and now I am operating as the director, but after a few years I realized that I do not want to work as the director in this company and I resign, and now the company is in the hands of other directors, but the company would have perpetual succession, that it will keep on going on. Now, overall control is reserved to the members, that is shareholders, that is overall control. The biggest power of control has been given to the shareholders. That is why directors have to report on an annual basis to the shareholders, be it the financial statements, be it the audit report, be it the annual report. You might have also heard about AGM, annual general meeting, that is conducted only for the purpose of intimating the shareholders about everything. So overall control is reserved to the members, that is shareholders, who make decisions by means of passing resolutions at periodic general meetings. They have the ultimate power to appoint and remove the directors and must be consulted on major long-term decisions as well. These two lines are important. Do you need to remember it? No. But do you need to understand it? Yes. Now, the two main types of resolutions are ordinary resolution and special resolution. What is this? Ordinary resolution means normal majority. And when I talk about special resolution, it talks about 3/4 majority. So here, over 50% in favor, over 50% in favor, and here 75% in favor. But out of what? Out of the present voting, out of the total voting, out of total voting. So whatever voting has been done, if say 50% is in favor, more than 50% is in favor, say 50.50 is also covered. If that is in favor, the ordinary resolution is passed. If more than 75% has agreed, it is a special resolution. So when are these resolutions used? So for small things, say who should get this assignment, a particular contract of the company, ordinary resolution might be used for day-to-day operation. Whether we should sell off the company where we have 90% stakeholding and is generating major revenue for us. Now that is a significant portion of the business, their special resolution might be required for special businesses. Okay. Now the majority. So is this covered as part of our syllabus? When ordinary resolution would be required, when special resolution would be required? No, that is not covered as part of your syllabus. Don't worry about it. Now the majority is of those members present at the meeting and entitled to vote. That is, whenever we talk about the majority is of those present at the meeting. That is, if anybody has not attended the meeting, will that be considered as majority? No. Only those people who are present at the meeting. So say the company had 1000 shareholders, 800 attended the meeting and voted. Okay. And 500 voted yes, 300 voted no. So will it be considered as majority? Because by default it's 50% of 1000, but from the way, if we see that out of 800 present, 500 have voted yes, that is majority has been passed. Okay. Now an absentee member does not count towards the vote unless represented by a proxy. Proxy, sir, it is what? That I have the right that if I am the shareholder and I am unable to attend the meeting for some reason, I can send my proxy. So that proxy will be considered? Yes, proxy will also be considered. So if say out of this plus 100 proxy, will this still be a majority? Yes, 500 by 900 will still be a majority. Okay. Who has been duly appointed to attend and vote? Now types of companies. Let's discuss about types of companies. So there are multiple types of companies: public limited companies, private companies, then community interest companies, then unlimited company, then micro company and a small company as well. These are the companies that are very, very important. Other than that, there is holding company, there are subsidiary companies also. Okay. Now we will be discussing it one by one. Let's discuss about public limited companies. Public limited companies where the public could invest their money, right? So are permitted to make shares available to the public at large. These are permitted to make shares available to the public at large. So these generally use limited companies. Okay, means transferability of shares is allowed. Okay, free transfer of shares is allowed through stock exchanges, by advertising new issues by prospectors and by having their shares traded on the public market. So transferability is allowed. Whereas in case of private companies, these are generally called as closed joint stock companies, where transfer of share is limited. So for example, if I have a class by the name of Supreet Agrawal Classes Private Limited, now in this case I have say 4 shareholders of my family members. I will have to restrict their rights of transferring the shares, otherwise anybody could become the shareholder of Supreet Agrawal Classes, right? That is why what I'll say is, I'll say that you 4 are the members, you 4 are the shareholders, you 4 are the directors, but you do not have the right to transfer it. So that is called as private company, whose name ends with word first of all private limited, okay, instead of public limited. So limited or limited instead of public limited or PLC. These enjoy more relaxed regulation but are not permitted to make securities available. That is, here transferability is there. Here transferability is not there. Now other companies, let's talk about community interest companies. So community interest company is a relatively new company formed created by the companies audit, investigation and community enterprise. Community interest companies like the social companies, right, which works for the social welfare. So these companies are established to commit profits or apply their assets for social objectives. A CIC cannot be a charity but may be an operating company of a charity. That is, it cannot be directly created as a charity that people could donate over here and they will be working, no, but a charity could create their CIC and they could operate through that. Now an unlimited company, let's talk about unlimited company. This is something that is important because this could be asked in the examination also. What is an unlimited company? What is the nature of unlimitedness over here? So an enterprise in which the members have unlimited liability for the obligations of the enterprise. That is, whatever are the obligations of the enterprise, the members will contribute to any X amount. There is no capping on that. Therefore, if the company becomes insolvent, the members are liable for its debts on a joint and several basis. It can be formed with or without share capital. That is important. As there is less risk to third parties than dealing with a limited company, the reporting and filing requirements are minimal. Why? Because lesser risk, because people would anyways have to contribute in case of any losses. Although there are few benefits of forming such companies today, it is still used by those seeking the privacy afforded by conducting businesses through an enterprise. That is, they do not want severe guidelines on them, but they still want to enjoy the benefits of corporation. They do it. Anybody who does not want limited liability but still wants the other benefits of corporation, say the export import benefits, they operate through this company. Now a micro company, as the name suggests, it's a very small company, has a head count of less than 10 and a turnover or balance sheet does not exceed the threshold. Sir, is that threshold covered as part of syllabus? No. But do we need to remember this? 10? Yes. Head count of less than 10. Then small company, head count of less than 50. So which one is bigger, micro company or a small company? By default, the micro company is smaller and the small company is bigger, right? Okay. Now a group of company consists of a holding company also, a subsidiary company also. Holding and subsidiary means what? So if there is A Limited, it holds say 49% in B Limited, okay, and say holds 51% in say C Limited. So this would be called as holding company and this would be called as subsidiary company. That is more than 50% of ordinary shares. Sir, what is this company called? So this company is called as associate company, which has 20 to 50% of ordinary shares. But the 50, exact 50, then what? Exact 50 is associate. Even a slight increase from 50 is subsidiary. Okay. This is also important for you. Please remember this. There could be a question on whether it is a subsidiary company or a associate company. Now, the important advantages of a corporation compared with a sole trader and unincorporated partnerships include what? This question could be asked in the examination. Then what could be the benefits? Sir, why are we covering this chapter now? Because it is very important to understand this chapter before you understand partnership, before you understand the legal structure, before you understand about the capitals. Now, limited liability is there, perpetual succession is there, suing and being sued is there, and security for loans. That is, let me explain one by one. Limited liability we have already covered. Perpetual succession, company will go on even any director changes, any owner changes, any promoter changes. Suing and being sued, company can sue and being sued in its own name. That is, what happens if tomorrow there's a situation that company is being sued? Will the directors be responsible? No, unless it is an unlimited company, directors are not responsible. Company's assets, security for loan as in company's assets can be given as security to obtain loans. That is also very, very important. Hope this is clear. Now, only companies are permitted by law to create floating charges. What do we mean by fixed or floating charges? So if I talk about fixed charges, fixed means what? Against a specific asset. Against a specific asset. So say if this company is owned by me, I can say that this phone is also owned by the company. So against this phone, you can take the loan. But what if I talk about the floating charges? Then any asset of the company could be held responsible. Any asset of the company could be given as collateral. So against all or general assets. That is not against any specific asset, against any asset. Hope this is clear. Now let's talk about wheel of incorporation. What is wheel of incorporation? This is very important. Wheel as in what? This is not WHEEL. This is not VIEL. This is VEIL. When I talk about wheel of incorporation, what does it mean? You tell me. What do you think? Wheel of incorporation. What do you feel? Wheel of incorporation. See, wheel of incorporation is like a curtain. Okay. So say this is two parts. Okay. This is the wheel. This is the owner. This is the corporation, and this would be called as a V. This is like a curtain that separates the owner and the corporation. But sometimes there could be scenarios where this wheel could be lifted and the court of law and the law would say that the owner and the corporation is similar only, they do not have any differences, they are same and both are liable for each other's action. Say if any company, if I have set up any company for the purpose of committing a fraud, and it has been proved also that I have committed a fraud intentionally using that company just for the purpose that I will not be held liable because it has limited liability. But in this particular case, court of law could say that I would be held liable, as what I have done is I have given this company, or I have used this company for the purpose of fraudulent purposes, and I am using the provisions of law just to safeguard myself. So that is why corporate wheel could be lifted and I would be held liable. So let's discuss about it. Members lose their personal interest in the company's assets and affairs. That is very important disadvantage of having a corporate wheel, right? Because these are separated. So members lose their personal interest. Say if this AC belonged to me, but I have invested this in the company, now it is in the company's interest, I cannot enjoy the benefits of this AC other than the work of the company. There are tight controls on decision mechanisms and on the introduction and withdrawal of capital and profits, and a company may be liable to have an annual external audit as well. So withdrawal and introduction of capital has tight controls, and company may be liable to external audit also because of this separation. If this would have been one, whatever laws are applicable to me, that would be applicable to the business, and the business law would be applicable to me also. Accounts and other documents are open to public inspection in case of corporation because of this separation, right? Now companies pay corporation taxes, sole traders and partners are subject to the individual taxes, and their business and total income are taxed together only, simultaneously only. But if I talk about the corporation tax, my company would be paying the tax, then the money would come to me and I might also have to pay taxes on that. This may operate as an advantage or disadvantage based on the fiscal policy, that is the financial year policy. Now, members and directors can be personally liable if they personally guarantee company debts, and in certain other circumstances the wheel has been lifted, then members and liables can be liable. So corporate wheel could be lifted in certain scenarios. Hope this is clear. Hope this is clear. Yes. Now in exceptional situation that depends on the judgment, that depends on the case to case basis. There is no description of exceptional situation that has been given over here. Okay. In case of exceptional situations, the courts are prepared to lift the corporate wheel and identify the owners of the business in order that they may benefit or take responsibility from their position. That is, in certain cases, court may say that please lift the corporate wheel and consider the owner and the corporation as one, and whatever benefits they have taken out of each other, you have to restore it, you have to recover it. Now, circumstances in which the corporate veil may be lifted include, that is, in this case the owner and the corporation would be considered same, that is, in these cases the owner and corporation would be considered same. If the company was formed as a sham, that is a scam company behind which the owner wrongly tries to avoid personal liabilities, okay, if owner tries to avoid personal liabilities, then if it is in the public interest to do so, okay, for example to prevent trade undesirable or illegal purposes, where the members have assumed a duty of care for the activities of the company, then to give members rights as quasi partners. Now, what are quasi partners? To recover their investment when they leave the firm if it was run essentially as a partnership, that is, if it was run as a partnership and they are trying to get the benefits out of it, their capital out of it via different means, then it could be said that they are just working as quasi partners. Now, exceptions to the general rule of separate legal entity as per Companies Act and other legislation. Exceptions to the general rule of separate entity, that is, in this case also it is similarly applicable, same. That is, corporation would be considered same, the owner and corporation would be considered same. But sir, what is the difference between these 2 points? So this is given based on veil, this is given based on Companies Act and other legislation. Okay. Now, it is a crime for a company to fail to display its name as required by law at its place of business. That is, there is a place of business and they have failed to display their corporate name, then directors might be considered as personally liable. In default, its directors are liable with the company in criminal law. Okay. Now, an individual member may initiate action on behalf of the company against a director or other person who is in breach of duty, that is, they have conducted either breach of duty or they have acted negligently, that is, since they were relaxed that whatever liability would come to the company, that would be dealt with by the company, and therefore they acted negligently, then it would be called as that directors would be personally liable because they have deliberately acted negligently or they have done breach of duty, that is, what they were supposed to do, they have not done that particular act in good faith. Now, group of companies must prepare group accounts. The directors of parent company must prepare group accounts. What if they don't? Then they would be personally liable. If a public company trades without a statutory trading certificate, that is, there is a public company which is trading without a statutory trading license, then who would be responsible? The owners would be responsible. Therefore, the penalty, definitely the penalty would be on the company as well. But who would also be responsible? The owners would also be responsible because they have acted negligently. Now, a member or members may ask the court for relief against the companies being run in a way which is unfairly prejudicial to their or their interest. That is, if sometime, say, let me give you an example for this. Say A Limited is there, it has 3 directors, A, B and C. Okay, A has a private firm by the name of A company. Okay, there is a contract that was about to be received by A Limited, but A transferred that contract to A company. Why? Because he thought that if it is transferred to A company, he would get the direct benefit. In case of A Limited, if the contract is transferred to A Limited, 3 of them will get the benefit. So here what would happen is the director has acted prejudicial to the interest of the company. So in this particular case also, A would be personally liable for this act. So any person being run away which is unfairly prejudicial to their interest. Now, any person who is a knowing party to a company being run with the intention of defrauding creditors can be ordered to contribute to the company's assets in a winding up. That is, if you are trying to defraud, if you have created the plan that by using the company's provisions you will be defrauding the creditors, say you will sell off the assets at less than the market value just to obtain personal benefits out of it in cash. So that would also be the case of here, where court might order that you will be considered as the same person and you will have to contribute. Now the last line of the chapter, directors who continue running an ailing company, ailing as in financially distressed company, which has lot of financial obligations and which has negative net worth sometimes, at a time when they know or ought to be aware that there is no reasonable prospect of avoiding insolvent winding up. That is, the only way out of this scenario is winding up, and when they know about it and they still run, then it can be ordered to contribute its assets when it is liquidated, because you have dragged it to the level that now the company is being liquidated. You could have closed it much earlier also, and now the liability amount has gone up. With this, we have completed this chapter, which is chapter number 9, corporations and legal personality. I hope you are understanding it, and I hope you are understanding everything. Just in case if you feel that there is any question that you want to ask, please feel free to reach out to me on my WhatsApp number, on my YouTube channel, on my Instagram account, or on my Telegram channel as well. Thank you so much. Hello everybody, hope you all are doing really well. I am CA Subrita Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, today we are going to cover a very important chapter, which is the introductory chapter of the companies. Now my dear friends, we have already discussed about certain important factors from our previous chapters, but in this chapter we are going to learn everything in a little more detail, because we have already discussed about the liability section of the companies, the core differences between a company and a partnership and a LLP. But now in this particular chapter we are only going to focus on the companies, and now we are going to dive deep into the concepts related to company. So my dear friends, what is a company? Company is a body corporate, right? We have already discussed about it, about the registrations part, the core differences between the liabilities of a corporate as well as a non-corporate like partnership firms. But here we are going to discuss everything in a little more detail, and therefore I am going to use the ACCA study hub to complete this chapter so that we can cover everything. Okay, so now my dear friends, let's have a quick understanding about it, and I would really suggest that after we complete this chapter, you should also read the ACCA study hub again and solve the questions immediately for this particular chapter, because this chapter is not just an individual chapter. This will have effect over all the other chapters that we are going to cover in the later stages. Okay, so let's talk about company promoters first of all. So a person who decides to form a company and takes the necessary steps to set it up is known as promoter. So for example, if I decide to register a company by the name of ABC company, okay, and now if I take the necessary steps to set it up, I would be called as the promoter. So in case of say Reliance Industries Limited, we can say that Dhirubhai Ambani sir was the promoter. Now the term covers a multitude of activities in which a person is actively involved in forming the company, okay, instructing professional practitioners, appointing its directors, raising its finance. But so what if the owner is different and the person who is setting it up is different? So my dear friends, in this case owner would be called as the promoter, and the person who is helping the owner, now as an employee maybe, that would not be called as a promoter. Okay, now let's move forward. Let's talk about registrar of companies. What is this registrar of companies? So this is a government office which takes care of all the information related to a company. So where do we need to get ourselves registered? With the registrar of companies. Where do we need to file the annual reports? With the registrar of companies. In case of any queries, any updates, who do we need to inform? We need to inform ROC only. So this would be called as ROC in our later discussions. That is registrar of companies. I hope this is clear. Now the registrar of companies heads a government agency. Okay. Companies House, which is responsible for maintaining company records. Okay, companies formed under the Companies Act 2006 come into being when they are registered with the registrar. That is, when a company is registered with the registrar, then only it is said that it has been incorporated. Okay, now every company must periodically file information such as its annual accounts, like we discussed, with the registrar. Okay, now functions of the registrar. Sir, should we remember this? Not word by word, but you should remember the core of the functions, like to issue certificates of incorporation, like we have discussed, to be responsible for the registration, like we have discussed, to pursue companies which fail to comply with such requirements, that is, to put penalties, to put compliance actions on those companies which are not fulfilling the requirements. Then at the conclusion of winding up, to strike off the name of the company from the register, strike off as in to remove, right? Now, to provide the public with facilities for examination of file documents. So in India also you can, or in abroad also you can, in certain cases pay a little fees, and in certain cases for free also you can verify the information of a company. Specifically for public entities, everything is free of course generally, but for private limited companies you can pay a nominal amount and you can access the documents as well of a private limited company as well. Okay, now let's talk about the London Gazette. What is this London Gazette? So it is similar to the official Gazette of India that we discuss in India. Now the registrar issues public notices related to companies in per of record for England and Wales. That is, whatever notices needs to be issued by registrar, they are issued in what? They are issued in the London Gazette. That is the official document of the government. Now numerous statutory notices, including solvency notices, are required by law to be published in the relevant editions of the Gazette. So why are you mentioning confidence as medium? Because my dear friends, we are here learning, right? So I would not mark it as high, I would not mark it as low. Let's go with the medium. Okay, now that is a mandatory requirement to move forward. Now let's talk about documents delivered to the registrar. That is, what are the documents that are required to be delivered to the registrar. Let's discuss about that here. Okay. So in order to register a company, its promoters must deliver certain documents to the registrar. They may be delivered as hard copy or electronically also. But sir, can we WhatsApp them? No, electronically as in through email, through registered email, through your registered email to the registered email of the government portal. Now the documents are as follows. Memorandum of Association. So what is this Memorandum of Association? So this talks about the overall structure and the core details of a company, like what is its name, where is it registered. Then it also talks about what is the liability, whether it is unlimited, whether it is limited. Then it also talks about the assets. It also talks about the charges that have been created. It also talks about the association that a company might have. So all of that is covered in the Memorandum of Association. An application for the registration showing the proposed name of the company, the jurisdiction of its registered office, the intended postal address, like we have discussed, the address, whether the liability of the member is limited, that we have discussed, if limited, whether by shares or by guarantee, that we have discussed, whether the company is to be public or private. Now my dear friends, it's similar to what you will be understanding when you evaluate anybody for marriage. You would like to know their name, so here name. Okay, you would like to know where do they belong to, so registered office. You would like to know what is their capital, so capital clause. You would like to know that what is the liability that they carry, so that is the liability clause. Then associations also, that is covered over here. Now details of the company's shares and the rights attached to them, known as a statement of capital. This includes the number of shares of each type, that is ordinary shares, non-ordinary shares, equity shares, preference shares, the names and addresses of all the shareholders also. So when do we need to file this document? At the time of registration. So the statement of capital must also contain information about shareholders' rights attached to each type. That is, whether they have preferential right, whether they have any differential right, anything. Okay. Now, so do we need to remember this word by word? Definitely not. Don't worry about it. You just need to understand it. You should just know that what are the documents that are filed. Okay. Now, an interest statement about persons with significant control, that is, whosoever is in the significant control, say the promoters, say the directors of the company, their interest statement, that is a statement of interest, and then where they are interested, what is their interest in the company, do they own certain shares. Okay, so all of that, including individual's name, date of birth. A statement of proposed officers. Officers are just below the promoters or just below the directors. That is the first director. And the company to be a public company. Its company secretary also. What is company secretary, sir? A professional who is responsible for all the secretarial documents. That is, who takes care whether the corporate filings are being conducted as per the relevant Companies Act, and in case of any secretarial audit required, they would be the person who will be handling the secretarial audit also. Articles of Association. What is this Articles of Association? So this is the internal rules and regulations, the internal constitution of the company, how different matters would be dealt with. Similar to what we call bylaws in a partnership firm. A declaration that the formation is in compliance with the Companies Act. Who will give this declaration? The first directors, officers, promoters, as well as the practitioner who is involved. A filing fee is there. The current fee for a postal application is £40. Online applications are usually registered within 24 hours and cost is £12 only. So it would be better if you do the online registration, right? So that is very, very important. Now, streamlined registration. What is this streamlined registration? So the SBEEA 2015 required the Secretary of State to deliver a streamlined company registration process by 31st May 2017. That is, they proposed that by 2017 we should have a streamlined registration process. It should be very, very streamlined. Like we have heard that in a lot of countries there is single window registration. That is, you just have to go to one office, you just have to meet one officer and your registration will be done. The streamlined company registration service, which has been set up in collaboration with His Majesty's Revenue and Customs HMRC and Companies House, eases the burdens on new starters because the registration process is smoothened. A one-click online system supplies all information once and in a digital form to incorporate a company and register. Now, let's talk about certificate of incorporation. My dear friends, what is this? This is like the birth certificate. For a natural person, this is a birth certificate, right? But when I talk about the corporate, if you have to decide, if you have to understand that when was this corporate located, when was this corporate set up, who set it up, there is a certificate of incorporation that is there, which tells you about the age, the nature of the organization. For example, if I run an institution by the name of, say, the Land of Learners. Now the Land of Learners cannot be an institution which produces fertilizers. So that would be understood by the nature of the nature of the company that is mentioned in the certificate of incorporation. So in this case, it might be a training institution, right? So that is very, very important. If I talk about BB Virtuals, now BB Virtuals Global will generally talk about the classes only, right? This cannot produce fertilizer, so that is driven by, or that is mentioned in certificate of incorporation, that what is the company, what is the registration name, and what nature of business does it have. Now when satisfied that all the documents are in order, the registrar will issue what? A certificate of incorporation. What you should know? You should know that the registrar issues it, okay? And advertise this in the London Gazette. So advertise as in it will promote? No, it will just mention for the public knowledge, okay, that this company has been registered now. The certificate shows what? The name of the company, the unique registration number, which is also called as CIN, CIN, corporate identification number, and the date of registration as well, so that we can determine who is this particular company, when it was located, when it was registered, and what is the unique name that it has. Okay, like the social security number that we all have, the natural persons. Now, effect of the certificate of registration. This is very, very important. What is the difference between a company which does not have certificate of incorporation and the company which has certificate of incorporation? Let's discuss about it. So the issue of the certificate creates the wheel of incorporation. Wheel of incorporation. The company becomes, or the company comes into independent existence. So when we discussed in our last chapter that a company has a separate legal entity from its owners, that separate legal entity is proven by the certificate of incorporation only. I hope this is clear. Now the certificate is also conclusive evidence that the registration requirements of CA06, that is Companies Act 2006, have been properly met also. The certificate does not, however, establish the company is legal, because if the activities of the companies are illegal or contrary to public policy, registration may be cancelled as well. This is a base requirement, right? Now let's talk about some other points. So the registered status, object, name, and legal address of the company may particularly deserve some thought, so that the new company can be spared the formality of having to alter them after it has been formed. So every time you decide the nature of the company, the name of the company, the registration process of the company, you have to be very, very careful, so that you do not mess it up. You do not have to revisit it once it is registered, because that is again a different process. Now when the company start doing business, that is, can the company start doing business without having a certificate of incorporation, or when they have only applied it, they have not got it? So a company only has capacity to make contracts after it has been incorporated. Before that, they cannot enter into any contract. Transactions entered into before that might not easily be adopted by it, and the promoter might face personal liability on them, because the company was not a separate legal person till the time the certificate of incorporation has been taken. Okay. Now, so can you conduct the business? Yes. Will you be able to transfer liability onto the company? No. Now, registered status, public or private, limited or unlimited. What is this? So public companies are those companies whose shares are generally available for the public to trade. Okay, the ownership is easily transferable. I can transfer my shares in a public company to you as well very easily. But when I talk about private company, it's like a closed stock company that we have discussed. Closed stock as in the transferability of share is not there. There's a restriction on the transferability of shares. Public company issues funds or raises funds from the public, whereas whereas private company cannot do so. Right? So all of this is the difference. The name is also different. So a public company is permitted to seek funds from the general public by making a prospective offer of shares and debentures, like we have discussed. Okay, the principle underpinning the Companies Act 2006 here and the guidance of the registrar is to start small. Now, for the benefits of public status, the company must have an issued share capital with a minimum nominal value of £50,000. Nominal value. This is the face value. Okay, and of which 25% should be paid up. Now, this face value and called up capital is different, right? That you must be understanding in FA and FR. Now, out of that, minimum should be £50,000, and out of that, 25% should actually be paid up capital. Its members' liability must be limited by shares. That is, their members would be required to pay, or would be required to reimburse, or would be required to contribute up to the amount of their unpaid, up to the unpaid amount on their respective shares. Now it is subject to much tighter regulations, because public interest is involved, public money is involved, so that is why there is strict regulations also. Now when I talk about private companies, so private companies enjoy more relaxed regulation and publicity requirements than do public companies. However, they may not issue prospectus nor have their shares and debentures dealt on the public market, like we have discussed. Companies which will need working capital are mostly limited by shares. There is no minimum capital requirement, which makes this more attractive form of incorporation. So if you create, that is, if I create a private limited company today, will I have any minimum paid up share capital requirement? No. But if I open a public company, will I have some minimum requirement? Yes, 50,000 pounds nominal value. Out of that, 25% should be paid up. Now, company is limited by guarantee. What is this? It is the liability is limited up to the amount of guarantee that we have discussed, or guaranteed amount. So, limited by guarantee is more suited to companies which do not need much or any other working capital. Now, unlimited company. Unlimited liability by definition exposes the members to risk. They can be made personally liable to contribute to the company's liabilities if it becomes insolvent. Now, my dear friends, what is important here is when you study this chapter, you should also have the ACC study hub open in front of you, and you should always try to make notes for these important pointers because these are very, very relevant for you. Okay. Now, re-registration. What is this re-registration? Re-registration as in the conversion. Can a private limited company be converted into public company or what? So, a private limited by shares can re-register as a public company, and a public company can change to private also. Sir, is this allowed? Is this an important MCQ? Yes, this is allowed. No worries on that. The procedure is as follows. The change of status must be approved by a special resolution. What is a special resolution? We have already discussed 3/4 of the voting power, right? Now, the name of the company must be changed to show the appropriate ending, the as in whether it is limited or private limited or what. Now, the company must apply to register the change. That is, they should be applying to the registrar for the purpose of change. Now, the application must be supported by a copy of the resolution that you have passed, and the company's amended articles also. That is, now the bylaws have also changed for the respective purpose. If it is converting from, say, private to public, the regulations have been followed up, and if they are converting from, say, public to private, the regulations have been downsized. Now, if the registrar approves the change, a new registration or new certificate of incorporation will be issued, definitely, because the last one would be saying limited, this one would be saying private limited. Now, private to public. So there would be the requirement of minimum capital also, because in case of private there is no requirement of minimum capital, but in case of public there is a requirement of minimum capital. So, private company may only re-register as public if it has a minimum allotted share capital of $50,000, of which at least 25% has been paid. Now, the application to the registrar must, okay, there is a very important point here, plus 25% whole of any premium. That is, whatever amount we are saying, say that 25% share, that's not only the share capital, that's the amount of premium, security premium also that comes with it, that you must be studied in FA. Now, public to private, minority shareholders may object. What is this public to private? See, what happens is sometimes the public company might not have that much operation that it is rationalized for it to continue operating as a public company. So, it might decide to downsize it to the private company. So, court proceedings objecting to the resolution can be brought within 28 days following the resolution by at least 50 members or the holders of 5% or more of the issued shares. Now, this is very important. At least 50 members. It could have 1 lakh members also, but if minimum 50 members files in opposition that we do not want the company to downsize from public to private, it has to go into the court. Then the holders of at least 5% or more of the issued shares. Now, if the authorized capital is, say, 1 lakh, okay, 100,000. I'm talking about the amount, okay. At least 5% of or more of the issued shares. So, 1 lakh is the authorized. 50,000 is the issue, so it's not 5,000 that is required, it's 2,500 that is required, because 5% or more of the issued, not the total. The court has the power to confirm or cancel the resolution and may require that the dissenting minority be bought out. That is, the court can say that whether we accept the claim of the minority, or what they can suggest is that minority sell their shares to the other persons and they get out of it. Now, between limited and unlimited status. So, if the company changes from limited liability to unlimited liability or vice versa, the company must apply to the registrar again, because this is the core information, right? So, anything that involves change in memorandum has to be informed to the registrar also. What if there is a change in articles? Then it is an internal constitution. They can change it by passing either ordinary resolution or a special resolution based on the case-to-case basis, but that is not covered in our syllabus. Now, a limited liability company can become unlimited only if all the members, not any, all the members, if all the members consent that it has to become a limited liability, or it has to become a unlimited liability. A prescribed form of assent agreed to by or on behalf of all the members has to be given all the members. What is to be noted here? That is, any private company needs to be converted into the public company, that is unlimited company. That I am talking about any limited company is converted into unlimited company. Then what is there? The requirement is that every member, all members should agree to it. Okay. What if one is not agreeing? Then the provision will not be accepted. A statutory declaration by the directors has also to be filed. Now, a company which has been re-registered as limited cannot revert to unlimited status. What is this? So if there was any unlimited company, it has been converted into a limited company. Now it cannot go back to unlimited status. Is this important? So very important for your examination. And the last thing, an unlimited liability company can become limited by special resolution. That is, the vice versa is allowed. See, limited cannot become unlimited again, but an unlimited company can again become limited. Okay, by special resolution. What is this, sir? What is this? What is this? What is this? So, can I give you a trick to remember this? If somebody is very out of range, they are not a good person, okay, now they have been converted into a good person because of some reason, okay, they got converted into a good person. Now generally a bad person who has been converted into a good person by experience, by anything, they might not again go back to becoming a bad person, right? But a person who was here, limited means good person, unlimited means bad person. But an unlimited liability, that is a bad person, can become a good person again by special resolution. Okay, that is very important. That is how you can remember it. Now let's talk about the objects. So what is this object clause? So whatever I told you under memorandum, that was the name clause, registered office clause, objective clause, liability clause, capital clause, association clause. So one of that is object clause. That is for what purpose the company has been formed. So clause delimited on company's general commercial objects. So delimiting as in it limits? No. It frees? No. It just mentions delimited as in describe. Okay. Now before Companies Act 2006, very important point. Companies were required to state objects in their memorandum of association. But now, although the precision of objects could range from a simple statement, under Companies Act 2006, there is no requirement for a company to state its objective. Oh my God, sir. So that is why there you didn't tell us about the objective. Yes. See, whatever needs to be mentioned under memorandum of association, that is governed by Companies Act 2006, and it does not say that object clause is required. Earlier it was required, now it is not required unless the constitution states otherwise. That is in India, for example, if I tell you in India there is a specific requirement to mention objective clause under your MOA, but internationally there is no requirement unless it is specifically the national requirements. Okay. Now, a company in India, that means a company in India has to stick to its objectives after incorporation, but a company internationally, unless this is restricted by some national jurisdiction, they can enter into any business. Yes, that is, they can enter into any business because objective clause is not there, right? A person dealing with a company in good faith is entitled to assume that the powers of the directors to bind the company contractually are equally unrestricted. That is, whatever person is dealing with the company, they have the power to assume that directors have the power to bind the company for the transaction that they are entering into, unless there is a clear indication that they do not and they ignore it. Now, effect of objects statement. So, statement of objects in the constitution do not restrict the company's freedom to do business or to enforce rights against others, but if the company deviates from its stated objects, this may damage its good standing with members and in business dealings. That is, it is not required, but it is a good practice. Okay. Okay. Now, companies with object clause, the directors have the responsibility to work within their required authorities. That is understandable. Okay. Now, changing object statement post incorporation. Can you change the object statement post incorporation? So, statement of objective may be inserted into the articles, amended or removed later by the special resolution. Why, sir? See, I'll tell you one very special fact here. Whenever we talk about anything that is not there in memorandum of association, but it is there in articles of association, we have already discussed that it could be changed. Now, since object clause is not there in memorandum of association, so it must be mentioned under articles of association. So it could be changed by resolution. It could be a special resolution. It could be a it could be an ordinary resolution. It could be a special resolution. But in this case, since we are talking about bigger matters, that is the object, so that is why it is the special resolution. Okay. Such a resolution under does not have retrospective effect. What is this retrospective? That is, say on 1st of February the resolution has been passed, so it would be effective after 1st of February. You cannot say that since last 1 month I am changing it, say since 1st January. No, it would be effective once it is communicated, once it is registered. Only for the later stages. I hope this is clear. Now, what name should the company adopt? Now, let's discuss about what name the company should adopt. What name the company should adopt. So, it talks about the name. Very important. A lot of questions are asked from this. So, appropriate suffix is what? There's no choice about how the name may end. That is, there's no choice. You have to complete this accordingly. What we are going to discuss about. It must end with the relevant indications of members' liability. That is, whether it is limited or public limited. in full or abbreviated through limited or PLC. Okay. If the company has its registered office in Wales, it may use the Welsh language equivalents also. These words cannot be Welsh as in the London language. Now these words cannot be used elsewhere in a company name. That is at the end only. Okay. So either limited or public limited company. But so in India, we generally say limited, right? So that is why you will get confused. So if there is say A limited, it means a public company in India, but internationally it is called as a private limited company. Then sir, what is called as public limited? That is denoted by either public limited company or PLC. And this is a major change, my dear friends. A lot of Indian students make this mistake because they have a habit of understanding that anything which is ends by limited, say just limited, okay, A limited, that is a listed company, that is a public company, but that is not true internationally. Internationally, it's only limited for private and public limited company or PLC for public limited. That is a very big difference. Please note it. Okay. These words cannot be used elsewhere. That is, it has to be mentioned at the end only. Now, restrictions on choice of names. There are certain names that you cannot include in your names. So there's a wider choice over the first part of the name. However, there are restrictions, and the registrar will reject is the same as another name on the register. That is, if some company's name is same as another company's name, then it would be rejected, or it could be rejected. Is illegal or suggest that the company has been set up for criminal purposes, say A and A kidnapping services. Not a good name, right? Now, give some misleading impression about the scale or nature of the business. Uh, the only one teacher company, the best ACCA teacher company. Now this is not a good company name, right? That is very important because it might give a misleading impression as well. Names are subject to statutory and common law restrictions. That is, the laws or the national laws could restrict that what names could be used in their jurisdiction, what names could not be used. Okay, so what names are generally not allowed to be used? British, English, Welsh, Scottish, because it might result into a relation with the government or association, council, federation, because it might give that you are representing somebody. Assurance, chartered, foundation, because it talks about the objects that sometimes say I say Baby Virtuous Foundation. Now this might give an impression that it is a charitable institution when it might not be a charitable institution, right? That is very important. Now in common law, it is a tort, that is other than breach of contract, to give the impression of having a connection with another established business unless such a connection genuinely exists. So it is a offense other than breach of contract. It is a tort that you are establishing or you are displaying that you have a connection with some institution when it is not actually there. Okay. Now, business names. So a business can trade under a name other than its own name also. Such a name is known as business name or trading name. For example, if say the name of the company say BV Virtuous Private Limited, but we want to operate by the name of BV Virtuous Global. So can we do that? Yes, we just have to take the trademark and we can do that. Now, publicizing the name and other information. So the registered, publicizing does not mean advertising, it means mentioning or letting others know. So the registered company or LLP name must be clearly shown outside every place of business. So if I have said 10 places of business, should I have to mention it under every place? Yes. The company or LLP must be included on all business letters. So whatever letter I have to mention all of that there also. Now, CA06, that is Companies Act 2006, introduced particular rules for displaying the companies or LLP's details on its website also. What is required to be there on the website? Should you remember this? Not word by word, but you should be able to tick if something odd one out is asked. So the full name of the company or LLP, the registered office address of the company or LLP, the registered number of the company or LLP, the place of registration of the company or LLP, if the company or LLP is being bound up. All of that should be mentioned. Now, change of name. The new name is effective from the issue date of the new certification of incorporation. That is, when it would be said that the name has been changed, when it is mentioned in the registration or in certificate of incorporation. Okay, a company may be compelled to change its name if it is ordered by court or following an adjudication by a company named adjudicator, that is the one division of the ROC has told to change, or on the instructions of Secretary of the State also. This is something which is very important for all of you. Now, let's talk about registered office. Let's talk about what? Registered office. Okay, what is registered office, sir? The registered office is the office where company has its registered business. Okay, so if a company is to be registered with the Register of Companies for England and Wales, it must have a registered office there, fixing its domicile there for legal purposes also. The company's incorporation, so all the communication to the company would be flowed to this particular address. All the legal letters, all the legal agreements would be signed from this address only. The country of incorporation cannot be altered other than from England and Wales to Wales. That is, if you have to change the country of origin, you can only change from England and Wales to Wales, otherwise it is not allowed. Okay. Now function, the registered office is the official address of the company. This is something that we know. A public company must give official company registered address to registered office and make them available for inspection by the public also. Now a private company can choose to maintain certain information on the central register. What is central register? So to save time and cost, an option has been given to private company that instead of having all the documents saved at your registered office, what you can do is you can deposit it with the central registry, and it might be open for public as well, but it is in the control of the government. Now statutory book, the official records kept by the company relating to all legal and statutory matters, that is known as statutory books, that is books that are required by law. So say a listed company could be asked to have a statutory book related to name of or list of its shareholders, so every shareholder should be mentioned, right? Now register of person with significant control, what is this? So every person who has significant control, say more than 10% in the company, there should be a separate register of it showing all the particulars about that. But here the percentage is not 10%, in UK the percentage is 25%. Okay, so an individual who ultimately owns or controls more than 25%, ultimately as in if via they are controlling, that is A controls B and B controls into C. So let me explain. If there is A Limited, okay, Mr. A owns 10% directly, Mr. B owns 30%, and Mr. A has 100% ownership in B. So Mr. A directly owns 10%, B Limited owns 20%, so the total is 30%, and Mr. A completely owns B. So indirectly Mr. A is owning 30% in this company A Limited. So that is why it would be said that Mr. A is a significant control person, a person with a significant control. Okay, now confirmation statement. Companies are obliged to deliver annually a confirmation statement. Confirmation, every year they have to give one confirmation that confirms that certain information has been filed with the company's house. For example, annual statement, annual report, annual financial statements, notifies company's house of any relevant changes to previously filed information. Say if there is a change in registered office, they have to apply, they have to inform them. If there is a change in director, they have to inform them, all of that. Okay. Now, when may the companies start to do business? We have already discussed about that if you start to do business before getting certificate of incorporation, you might be held personally liable. So a private company can start its business as soon as it is incorporated, that is as the certificate of incorporation is received. But when I talk about a public company may set up preliminary contract but cannot start trading until it obtains the further certificate, that is the trading certificate. That is, it can enter into contractual discussions, but it cannot enter into opening its shares for public until it gets the trading certificate from the registrar. Okay, I hope this is clear. Hope this is clear. Yes, hope this is clear. Yes, hope this is clear. Any questions? Any questions? Now, application for a trading certificate. Applications for a trading certificate. So, in order to obtain a trading certificate, the company must file a statutory declaration, that is the legal declaration with the registrar, that the company has allotted shares with a nominal face value of at least £50,000 that we have discussed, or the euro equivalent. Okay, with a nominal face value, because that is what is required. That 25% of that nominal value has been paid up. That is again the requirement that we have discussed. That the amount of any preliminary expenses incurred in setting up the company is there, and the amount you have to mention that, and the and the amount paid or payable to the company's promoters for any services that has been rendered in setting up the company. That is something that you have to mention. Should you remember this? Yes. Consequences of default. What if there is any default that is there? So it is a crime for a public company to trade without a trading certificate. Both the company and its officers may be fined, and in certain jurisdictions they might be prosecuted as well. Now, if a public company defaults for 21 days or more on contracts made while trading without a section 761 certificate, that is a trading certificate, its director becomes jointly and severally liable within all the register. That is, there would be a personal liability also. Now, there is one important point here. Let's discuss about it. Okay, a company does not exist in a law before it is incorporated. Do we agree to this? Yes. If therefore cannot enter into a contract itself nor act through its promoter or any other perpetrated agent before the date of the certificate of incorporation, yes, that also we understand that it cannot deal itself or via agent also. The promoter will have personal liability on pre-incorporation contracts. That is, we have already discussed, if there is any contract that has been done before incorporation, then the promoter would be personally liable for that. Okay. Now let's talk about promoter's personal liability, and let me show you what all things are left. Then we are going to talk about promoter's benefits, and then the chapter is going to be covered. So this is very, very important for all of you. Okay. Now how do I go back here? Okay. Now promoter's personal liability. My dear friends, we have already discussed about that if there is any pre incorporation contract, then the promoter would be personally liable. So let's discuss about it. Before incorporation, the promoter might be tempted to enter into agreements to enable the company to begin business as soon as it has been formed. In most cases, the company and the other party will honor the agreement as a matter of commercial expediency, but problems can arise if one or the other chooses not to do so, and there would be a personal liability that would be on the promoter. The position is a development of law of agency and of the contractual position on privity of contract, that is the relationship which exists between contracting parties. Case law has been established that because the company was incapable of being a party to the contract when the contract was entered before incorporation, that is, it cannot enforce it unless the company has renewed or novated the agreement. That is, any party who has entered into a contract with a company before it was incorporated, the promoter would be liable, but the third party cannot force the company, cannot enforce that action against the company until and unless the company has novated the contract or ratified the contract later on. That is, say the contract was there for 3 years, every year the ratification is required. When the first year agreement was signed, the company was not incorporated, so the promoter would be held personally liable. But if I talk about the second year, when the company was incorporated, company ratified the transaction, all the officers of the company ratified the transaction. Now for second year onwards, the company would be liable for all the liabilities. Okay. Now, a person who contracts on behalf of a company before incorporation is personally liable on the contract unless there is an agreement otherwise that the company would be held liable. The promoter can therefore sue and be sued for breach of contract also unless the agreement clearly excluded the possibility of this. That is, if the promoter and the third person who is dealing with the company, they specifically agree that no personal liability would be incurred by the promoter even before the company is incorporated, then even for the transaction that has been entered before the company is incorporated, then here the promoter would not be personally liable. Okay. A promoter who sees no alternative but to make a pre-incorporation contract for some reason should consider taking steps to reduce the risk of personal liability. That is, the contract could be drafted to include a term permitting it to be assigned with the agreement of the company and the other party. The promoter's only worry then is to ensure that the company does take an assignment. That is, all the benefits are transferred to the company. Okay, if that agreement is there, that is called as assignment, and that reduces the liability of the promoter. The pre-incorporation agreement could be made in the form of an option. Then if the company fails to take an assignment or to novate the contract with the other party, the promoter is only liable for the option price, not for the full value of the whole contract. That is what you have discussed under FM and AFM, that could be covered over here. So if there is an option that has been given and there is a margin that is there, say there is a margin that if the contract is not fulfilled, this would be the penalty. So the personal liability of the promoter would be up to that amount only, not for the full value of the contract. Now, however, the best way to avoid this problem is to incorporate the company first. That is what is recommended. Okay, I hope this is clear. Now let's go for promoters benefits. That is the last topic for our today's discussion and for this particular chapter also. The need for remuneration. Promoters will get any remuneration? Is it mandatory? Let's discuss about it. Because of the pre-incorporation contract rules, the promoter cannot be certain of recovering payment for pre-incorporation expenses, because the company might be rejected, the company might take a lot of time, and might also be found liable on arrangements made on behalf of the company also. So they are not at benefit, they are at loss only. Having put time and effort into setting up the company, a promoter will expect some reward and may also want reimbursement of expenses incurred. In practice, the promoter will usually retain some, say in the business after setting up. Say they will be becoming a director, they will be becoming a controlling shareholder, and so will be able to arrange matters. If remuneration and expenses are agreed by deed after incorporation, the company is bound to honor it. That is, if it is agreed that once the company is incorporated, after that if there is an agreement that we will be paying, say Mr. A, who was the promoter of the company, who has helped the company set up, we will be paying them a sum of say £10,000. So that agreement has to be honored. Disclosure of benefits, secret profits. So a promoter stands in a position of trust, that is a fiduciary position is there, that is they might be getting some financial benefits out of this equation as well, and must act in good faith. Okay, details of promoters benefits must be given to the registrar when a public company applies for its trading certificate. So whatever benefits has been derived by the promoter, that has to be submitted with the registrar at the time of applying any of the trading certificates. Okay, now this is majorly required for public companies. Case law has established that a promoter's benefit must be fully disclosed to the board of directors and freely approved by them. If the board is in any way under the influence of a promoter, the matter should also be known and approved by the members. So what are the benefits are to be given to the promoter, that should be approved by the board of directors, and if board of directors are under influence, then it should be approved by the shareholders as well. Seems logical, right? Now if the company is to be sold on, that is the company is to be sold on, future members should also be put in picture for the purpose of deciding this. Now if the promoter takes a secret profit, what is the secret profit? An undisclosed or unapproved benefit the company can later. Now what is this? So in incorporation stage, when promoter was only there, they have signed an agreement to sell some item for say 10 pounds when it was actually to be sold for 100 pounds. Now in this case, the promoter is taking 10 pounds as a commission, as a secret profit. They are getting a bribe maybe, right? Now in this case, the company can do what? Cancel the transaction, reclaim any money or assets, that is they can reclaim that $10 also and claim damages from the promoter for the loss of 80 pounds. Now with this we have completed this chapter, and now you can go further to solve the questions of this particular chapter. This chapter was really important for you because it will form basis of all the other chapters that we are going to cover after this. So all the very best. Now we will meet for the next chapter, and I hope you will really enjoy reading all the other chapters, because we are going to learn a lot of new concepts regarding capitals, regarding loans, regarding balances, regarding transactions, regarding contracts related to the companies after this chapter. So all the very best. See you in the next class. Thank you. Hello everybody, hope you all are doing really well. Today we are going to discuss about chapter number 11, and the important part about this chapter is that this chapter is going to take further a discussion that we did in the last chapter. That is, this is going to further define certain provisions, certain laws, regulations and way of methodologies for the purpose of companies. Because when we talk about chapter number 11, it is going to cover memorandum of association, articles of association and related provisions to it. So my dear friends, you are going to enjoy learning this chapter, but the only condition is that you should listen to this lecture, you should watch this lecture till the very end. Okay, so now let's discuss about how we are going to cover this chapter number 11. So first of all, we are going to discuss about two major documents. One is memorandum of articles, memorandum of association, and second one is articles of association. And then we are going to discuss about the methods on which they operate and the any related provisions related to alteration of it. Okay, so that is a provisions, that is a requirement for today. Now my dear friends, let's discuss about each one of them. So again, this is ACCA Study Hub. I would ideally suggest that you should have ACCA Study Hub right open in front of you while studying this topic. So the memorandum of association, which we will be commonly calling as memorandum going further, and the articles of association, which we will be calling as articles going further, are the two enabling documents of the company. What do we mean by enabling documents? That is, a company cannot operate without them. Okay, now they both must satisfy requirements under CA 06, which is Companies Act 2006, that the memorandum and articles must be printed documents. That is, it should not be kept as a soft copy, it must be in printable format, and it should be kept at the registered office. Okay, second thing, sir, but registered office is not written over here, but I am telling you that. Okay, now second thing, the articles must be divided into consecutively numbered paragraphs, consecutively as in one after another sequentially. Okay, then the memorandum and articles must be signed and dated by the persons forming the company, and a witness also who must also sign. So should we remember this? Yes, this could be asked in the examination in the form of MCQs specifically. Okay, now the constitution documents take effect as contractual documents imposing obligations on every party who is signing on it and the company itself. Okay, so every member and the company itself, which we will be defining further in a further discussion. I hope this is clear. Now there is a key point that is written over here. This is a very short chapter, should take approximately 25 to 30 minutes or approximately 20 to 30 minutes to complete. Okay, but what you need to understand is that this chapter holds significant value in your examination as well. Now, a company's article of association and its members' special resolution make up to its constitution documents. Why? Because see, when I talk about the special resolutions, this is the agreement with the shareholders. But when I talk about the day-to-day operations, how day-to-day operations would be done, how the operational effects will take place, that is decided by the articles of association, which could have certain conditions which is not aligning with these special resolutions that we will be discussing further. So these two are commonly called as constitution of a company. Okay. Now, sir, together or separately? Together. When they are merged, they are called as constitution of the company. Now, let's talk about nature. What is this nature? This is nature of memorandum of association. Okay. So, first thing we will be discussing in detail about memorandum, and then we will be going into the discussion of articles, and then we will be closing our discussion. Okay. So, now, since 2006, a memorandum is simply a declaration stating that the subscribers has done three things. What? Wish to form a company, because if you have signed the memorandum, it is said that you wish to form a company. You are not forming, you wish to form. Okay, because this is a pre-document. Then agree to become members, that is, they are not just signing, they want to become members of this said company, and agree to take at least one share each, because when you are signing in the memorandum, you are taking at least one share. That is, you are saying that I am also party to this company. Okay, assuming that the company has share capital. If not, then no share capital. It must be signed by each subscriber. Is it mandatory? Yes, it is very mandatory that every subscriber to the company should sign this particular document. Okay. Now, the minimum number of subscribers at incorporation for both public and private company is 1. Minimum subscribers is 1, so that person should sign it. What if there is 7? So those 7 should sign it. Okay. Now, for companies formed before Companies Act 2006, there could be certain companies. The memorandum also contains information about the company name, objectives, potential capitalization, and the nature of members' liability for its debt. That is, these information were earlier there also. Do you need to remember this? No. Now, such old memorandum are now regarded as historical snapshot of the founder's intention to form the company. Now, for companies formed under Companies Act 2006, the information is now contained in the company's application for registration and the articles. That is, all the relevant information about the company is taken into these two documents. Now, let's talk about further details. Okay, why is it not moving further? Now, okay, now the effect of memorandum. Effect of memorandum, as in, once you submit the memorandum, what are the potential consequences, what are the potential effects of it? So, the effect of the memorandum is to form the basis of the section 33 contract between the company and all its members. That is a binding contract between a company and all its members to operate the company in accordance with the law and within the company's constitution. That is, within the law as well as the company's constitution, we are agreeing that once we sign this memorandum, we will be operating the company that way also. Okay. Plus, I'll tell you one thing, when you go for the articles of association, you will also understand one more thing, that we also have a responsibility as the first subscribers or as the subscribers to the memorandum to operate the company in the best interest of the company. That also you can write over here, that's not wrong. Okay, in the memorandum also. Hope this is clear. Now, characteristics. Characteristics of what, sir? Characteristics of articles. See, the articles compose. Sir, how you figure out that this is about articles, that was our memorandum? See, the heading changed. This is 3.1, that was 2. Okay, so the articles compose, and that is why you have to be very careful while reading the ACC study, and that is why I am taking certain chapters from here. Okay, so the articles compose the company's own regulations for how it is to be run. This is also called as the internal constitution of the company. Why internal constitution? Because here the members, the directors, the stakeholders have the power to decide how the company would be operated on a regular basis. Okay, provisions are typically included to deal with, that is, what could be the certain scenarios that an articles of association could be included in, or that could be included in articles of association. The rights of shareholders to share certificates, dividends, and notice of meetings, that we will be discussing. So, what if the act says 21 days, clear 21 days, can we increase it that we will give clear 30 days? Yes, because you are anyways complying with the provisions of the act as well as you are complying with your own provisions also. So, whatever could be the articles, they cannot contradict the act, but can they extend it? Yes. Say act requires at least 21 days notice. Can article say we give at least 30 days notice? Yes, because it is complying with the act, it is complying with the internal constitution also. The rights of the company to call for payment on the shares, that is, it talks about, the articles talks about that the company has the right to call for any of the unpaid amount on the shares from the shareholders as well. The procedure for transfer of shares, if any person wants to transfer the shares, what is the procedure for it? Sir, can there be restriction on they cannot transfer? So that could be there, but in case of private companies, not public companies, right? because in public companies the best feature is that there is transferability of shares. Now, proceedings of meetings of shareholders, general meetings and directors, that is how the meetings would be conducted, how the results would be announced. The extent of the director's power to run the company, that is how many power, what power which director has. The procedure for appointment and removal of the directors, also how shareholders would be informed, how shareholders votes would be taken. Okay, that is very important. So should we remember this? Yes. Now, word to word? No. But you should remember that what all are the contents of the articles. Now, model articles. What are these model articles, sir? See, what happens is a lot of times companies create the provisions, the internal constitution, but they might miss out on certain point. They might miss out on certain condition that might be coming up later. Say, they created the clauses from A to Z. Okay. Now, there was a new condition which was not covered in A to Z, which was neither covered in the law also. Then there comes model articles. That is, if they have not created the articles for any of the particular situation, then what could be done or what would be done, that is covered in model articles. So, model forms of articles for public and private limited companies limited by shares are contained in companies model articles regulation 2008 that we discussed about model articles. For most purposes, the public and private provisions coincide, that is, it is same for public as well as private, for most, not for all. The relevant provisions of the model will automatically apply if a company is limited by shares fails to file articles or fails to deal in its own article with matters covered by the model provision. That is, if they have not created, if the company has not created any articles, then also this will apply. And even if they have created but they fail to address any particular issue which is covered in model articles but not in their articles, then also the model articles will apply, like we discussed, right? Now, a company limited by shares may adopt all or part of the model provisions. Can they do so? Yes. At certain clauses, they can also write that whatever the model article says as the updated format, that we will be covering. Say in my institution, for example, I want to understand that how a partner will leave the firm, okay? And I do not want to frame any conclusion about it. So what I can do is, if any partner or director wants to leave the firm, the provisions that would be followed will be as per the model articles that I could write. Okay. Now, draw up its own internal regulations also. Now, the model provisions apply as the default rules like we have discussed. Okay. Now, there are certain model articles that are given also here. So, say for directors related, directors general authority, shareholders reserve power, director may delegate committees, all of that. Okay. Now, method of alteration as in how these articles could be altered. Okay, so let's discuss about it. As a general rules, the article may be freely altered by special resolution as a general rule. So for example, if something wants to be changed, say they said 30 days notice period, now they want to come back to 21 days, which is as per the Companies Act, for example. Okay, now in this particular case, they want to change from 30 days to 21 days. How they can do so? They can do so via special resolution in the general meeting of the company, in the AGM of the company, right? But what if they want that for certain provisions, say for this, for notice period, can they do so that not 75%, not just 75%, but say minimum 90% shareholding would be required? Can they do so? Yes. Okay. So, a copy of the resolution and amended articles must be filed with the registrar within 15 days after the amendment takes effect. Failure to notify the registrar is an offence. In this case, the registrar may give notice to rectify the breach within 28 days also. That is, within 15 days you have to inform the registrar. If not, then within 20 days they can also give you notice to rectify it. If the company complies with the notice, it will avoid prosecution. Otherwise, there would be a civil penalty of £200 payable to the registrar. Okay. Now, provision for entrenchment. What is this? A provision which imposes conditions or amending or repeating certain other provisions. This is what we talked about, that they can increase from 75% to 90% also. This is called as provision for entrenchment. That is, there could be certain provisions on which there would be a special condition that if you want to alter it, you have to follow not the special resolution but this particular condition, say 90%. So, a company's article may specify conditions that are stricter than a special resolution for the alteration of specified provisions of the articles. For example, the articles could restrict changes dealing with the conduct of meetings or taking the votes, or by imposing special conditions for alteration. Example, higher than 75%. Entrenching provisions can only be included in the company's articles on formation or added later if all the members of the company agree to the condition. That is, they can be there from the starting, they can be added at the end also. The entrenching provision can then only be altered by agreement of all the members of the company or by court order also. Okay, and they must be notified to the registrar in the form of a statement of compliance. Hope this is clear. See, this entrenchment provision confuses a lot of people in my experience. So what I'll suggest is you should mark it as a star mark point. That is, you should always revise it before the examination, because this is something that creates a lot of trouble in the case of many students. Okay. Now let's discuss about restrictions, case laws. So what we need to do here is we need to just read it. We just need to read the critical points that are there. For the boxes matter, I would suggest that you read it. If you face any trouble, do let me know. These are just explanatory points. Okay. So we are covering all the core content here. Restrictions, case laws. Let's read it. Any alteration to the articles must be made bona fide as in good faith, with good intention, without any malicious intention, without any bad faith. Okay, for the benefit of the company as a whole. Like we discussed, if there is any alteration, that should only be done for the purpose of company's interest, not for the personal interest of any person. Okay, now the test of being the benefit of the company as a whole does not mean that every member must benefit. This is not true. See, if any member is saying that I did not benefit from this decision, so it is not in the company's interest, that is not true. The company as a whole should be benefited. The court will ask whether the alteration benefits the individual hypothetical member and whether it is on balance good for the company as a whole, rather than looking at the subjective interest of the actual member. That is, the court, if they have to decide whether the change was in the company's interest or not, they'll have to look at it objectively. They will evaluate that whether it is in the benefit of individual hypothetical member. Now what is this? In case of Greenhalgh versus Adrian Cinemas Limited, G was a minority shareholder in the cinema company and sought to prevent the majority shareholder from selling a controlling stake. That is, this minority stakeholder was trying to stop the sale from a majority stakeholder. The articles did not permit such a transfer to a third party, but the majority shareholder had changed the articles to allow him to do so. G argued that the change was invalid, as well as being a fraud perpetrated on him. He demanded compensation. In this case, the court held the best interest of the shareholders meant the general body of shareholders. In the opinion of the majority, the individual hypothetical member would benefit from the alteration. So although detrimental to G, the alteration was valid. This is individual hypothetical member. Okay. Now let's discuss the second point, which is alterations allowing for shareholders to be expelled will be particularly difficult to defend unless the alteration is worded so that it can only operate for the company's benefit. That is, if there is any point in the articles that has been amended to allow that the members can be thrown out of the company, the shareholders can be thrown out of the company, that is generally not valid, that is generally not enforceable. But if it is proved that this exercise could only be done, this particular action could only be taken only when it is in the company's interest, then it could stand. But there is no clear indication whether it would stand or not. Okay, so with this, let's move further. Now let's discuss about other issues. But my dear friends, let me tell you that after this we have to just discuss statutory provisions, key cases, and our syllabus would be done. Okay, so just stay with me. This was a little short chapter, but a very knowledgeable chapter, I would say. Okay, now let's discuss about other issues, key cases. Alteration of the articles may have retrospective effect. What is this retrospective effect? What is this retrospective? See, whatever is given in the boxes, those are case laws. You should ideally read it once. Do not try to remember it. Do not try to remember the exact case laws, but you should ideally read it once. Okay, so other issues, key cases. Alteration of the articles may have retrospective effect. What is the meaning of a retrospective? Tell me. The meaning of retrospective is very simple. Retrospective means something that could be changed from an earlier date, say backdated, right? See, what happens is there's something called as backdated, right? See, I am signing on say 27th of February and I am signing for say 1st of February. That is backdated, but that is not legal. That is not allowed in a lot of cases, or generally it is not legal, right? But what I can say is I can sign on 27th of February only, but I can say that this is applicable from 1st of February. Whatever I am signing on 27th of February, this would be applicable from 1st of February. So whatever transactions have been done before or after 1st of February, it is applicable on all of them, not from today. That is called as retrospective. So there can be any article of association that could be changed. There could be any provision in the articles that could be changed by saying that it has a retrospective effect. Okay. Now, alteration does not relieve the company of liabilities for commitments incurred before the change. Alteration does not relieve the company of liability for commitments done before the change, as in if say 27th of March I am passing on certain alteration which is applicable say retrospective or for foregoing, but whatever liability I have incurred up to 27th of February, I'll have to stick to it. I'll have to be obligated for it. I'll have to repay it back. Okay. That is what is given over here. Now let's discuss about statutory provision. Okay, this is the second last topic, like we have discussed, statutory provisions. Statutory provisions. So the constitution documents are deemed to be contract documents. Now we have completed all the core part. Okay, we are just into the end. Let's just read it and we will be able to understand everything and finish everything. Just in case if you have any difficulties, please feel free to reach out to me. I would be happy to explain it to you. The constitution documents are deemed to be contract documents signed and sealed by the company and by all its members from time to time in their capacity as members. This rule has been interpreted by the courts as creating three sets of obligation. Number one being, it binds each member to the company. Yes. It binds company to each member. That is also true. And it binds members to one another also. So should we remember this? Please. This is frequently asked. Although the provisions of articles can be altered and therefore the terms of the constitutional contract can be varied, the articles can be enforced as among the company and the members while they are in force. Section 33 refers only to the company and its members. It follows that a member enforcing the articles against the company must do so in his capacity as a member. That is, whenever any member tries to enforce any articles against the company, they should only be doing it as a member, not as a third party. Now the company is not bound by section 33 to a member or anyone else acting in a non-membership capacity. That is, say some member was also the customer and then they are claiming, so they will not get the benefit under being a member. They will only be regarded as a customer only. This applies, for example, to directors, the company solicitor and employees. That is, unless they are members, they will not be given the membership benefits. However, if a contract arises separately from the articles, it can be enforced as a matter of ordinary contract law as well, that we have discussed the contract laws, right? Okay. Now, key cases. Each member is bound to the company as a member. Each member is bound to the company as a member. What does this mean? That whenever you are entering any company as a member, you will be bound by it. Okay. Now, the company is bound to each member as a member. This is also something that we have discussed. Articles can constitute a contract between each individual member and every other. That is, they might be responsible towards each other as well. This is something that we have already covered. Now, articles do not constitute a contract between the company and outsiders, that we have discussed, because there are certain contracts that arise from the articles, that then there are certain contracts which arise from non-articles, like contract between two members, that they will be sharing profit, they will be sharing some dividend, that is given by articles generally. But contract of purchase and sale, that is a non-article, right? So articles do not constitute a contract between a company and an outsider. That is true. The articles might contain matters which becomes terms of a contract between the company and others. That is, every sale contract must be signed by this particular person. Now, this forms a basis of how the third party contract needs to be done. Articles may be used as a evidence of the terms of contract created independently of it. For example, an employment or service contract might be created between the company and an employee or officer on terms that incorporate the relevant provisions of the articles. That is, there could be certain provisions that says that salary would be paid as per the date mentioned in the articles of association as agreed in the articles of association. With this, we have completed the entire chapter, my dear friends. I hope you have enjoyed this chapter. Now let's see you in the next chapter. Whatever your queries are, please feel free to reach out to me, and like we have completed it in exactly 21 minutes. So see you in the next chapter. Thank you so much. Hello everybody, hope you are doing really well. This is Syllabus Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, today we are going to take up one of the shortest chapter of your syllabus, but this chapter is going to matter because this is something that you have already studied, maybe in your class 11th, 12th, or if you have pursued graduation from commerce, then you might have studied this particular topic in your graduation level as well. But the important point about this particular topic is that even if it is the shortest topic, but it is one of the most significant ones. So what you should do is, you should ideally have a notepad while you attend this session so that you can note down all the important pointers as well. So my dear friends, this is chapter number 12, where we are going to talk about share capital. Now, what do we know about share capital till now? Let's discuss on that. Okay, so you might have heard of something called as equity share capital. You might have heard of something called as preference share capital, which gets preference in two things: dividend and repayment of capital at the time of winding up, right? Also, you might have somewhat discussed that there are certain types of shares which have differential rights as well, maybe changes in the terms of voting rights and so on, right? But when we talk about this particular chapter, it will have some important pointers other than these points as well. So let's complete this. It should take very less time for us to complete this chapter, but please watch this lecture till the very end to understand how we need to complete this particular chapter. Okay, so share capital, let's read it. Share capital describes funds raised by issuing shares in return for cash or other consideration. So if there is an MCQ, does share required to be issued in cash only, or there could be other considerations? So there could be other considerations as well. That is how we need to understand it each line by line, so that we do not get confused while solving the questions. Each time a company issues new shares, the amount of share capital will increase definitely. Share capital can comprise both common and preferred share, like we have discussed. Shares are units of ownership of the company. So if you go for the IFRS understanding, you might also hear this definition, which is not covered here in law, but in accounts you might hear this definition, you might listen to this definition, that equity have the residual interest. That is, after everybody's interest is taken care of, after everybody's loan repayment has been done, all the repayments have been done, then comes whatever is remaining, that belongs to the equity. So residual interest, there could be negative interest, there could be positive interest also. The shareholders collectively own the whole company. So if there is a question that who are the actual owners of the company, so you might have discussed this in your FA as well. Who are the actual owners of the company? The shareholders are the actual owners of the company. So is shareholder and stakeholders the same term? No, shareholder and stakeholder are different terms. Shareholder particularly means what? The person who is owning the share. Stakeholder is any person who is either interested in or is impacted by the company. Can creditor be called as a stakeholder? Yes. Can creditor be called as a shareholder also? No, until and unless he or she owns the shares. Now a company or a person who invests in shares and debentures in a company is therefore both a member as well as a creditor, like we have discussed. Company also may be funded by loans made by people or organizations in the form of financial institutions also. Every company must keep a register of members showing the name of each shareholder and details of the shares held. So sir, if I buy a share in say Reliance Industries Limited, will they have my information? Yes, because they'll have to maintain a register stating that who all are our shareholders along with other relevant details as well. Now let's talk about shares. This was about shareholders, but now let's talk about shares. So share is the interest of the shareholder in the company. See, here the word residual is not used because that is given by accounting standards, so it is not the language of law, and that is the difference that you need to understand while understanding different subjects. Okay, measured by a sum of money. It determines the extent of the members' investment and liability. Shares confer rights and obligations to the shareholders. Shares are personal property of the shareholders. They can be bought, sold, mortgaged, or bequeathed by the shareholder. Now, what is very important here to understand is that shares are the personal property of the shareholder. It could be transferred. However, can there be any restrictions on the transfer? Yes. In case of private company, there could be certain restrictions on the transfer as well, that you cannot transfer until unless you fulfill certain conditions. So that is also workable. Now, a fraction of a share cannot exist, but one share may be held by two or more people. That is, it should not happen that somebody owns 0.5 shares. It could happen in case of debentures. It could happen in other cases also, like mutual funds, but it should not happen in case of shares. But can one share be held by more than one person? Yes. So for example, me and my brother can jointly hold one share, but can we say that we hold 0.5 share? No, we cannot do so. Now a company may confer different rights on different classes of shares. For example, a share could be there which might have double voting rights. So if this person votes, if this shareholder votes, it would be considered twice. Say if they are voting with one share, it will be considered two votes, and I could have certain shares which have no voting rights also. Can there be a case like that? Yes. Okay. Now, terminology. Let's talk about these terminologies which are very, very important. So number one being authorized share capital. This is the maximum amount. Let's first understand this, then we will be reading it also. Authorized share capital. What do we mean by authorized share capital? This is the maximum amount of capital that could be issued by a company. So for example, if the company has the permission from the regulator to issue say $1 million, 1 million shares, okay, 1 million number of shares at the rate of say $10 face value. Now in this particular case, what would be considered as the authorized share capital? 1 million into 10 per share, that is the face value, that would be considered as authorized share capital. What is the second term? Issued share capital. Is it necessary that they will be issuing all 1 million shares now only? No. They might decide to issue say 500,000 shares as of now, and 500,000 would be on the extra end, right? So this 500,000 would be considered as issued share capital which has been issued. Called up share capital, is it important that on that $500,000 they will be calling all $10 per share? No, they might call say 5, they might not call 5. So that particular 5 that they have called would be called as called up share capital. Is it necessary that if they have called up $5 per share, the shareholders will be paying $5? No, they might pay less also, say $3. So that is called as paid up share capital. Okay, that is the term. Now let's read it. Authorized share capital. Companies incorporated before Companies Act 2006 were required to include in their constitution documents a statement of the maximum number and value of shares. Now are they required? No. This authorized share capital set a limit on the amount that could be issued, subject to increase by ordinary resolution also. This could also be increased by ordinary resolution. So should we remember this? Yes, you should remember that to increase the authorized share capital, you can just use the ordinary resolution. Now, as Companies Act 2006 replaced this with the requirement to submit an application to register the company, the concept of authorized share capital has been removed. Okay, because now you have to submit the application to the registrar. Now, issued share capital. Issued share capital is the aggregate nominal value of the share which have actually been issued. In our case, $500,000, right? This is shown in the company's financial statements as share capital. The expression, so this is also there in balance sheet, right? Now the expression also is used to describe the issued shares themselves. Now called up share capital. So shares are sometimes issued on the basis that they will be paid by installments, like first call, second call, final call, right? So when an installment becomes due, the company calls for payment. Now paid up share capital, this is something that has actually been paid by the shareholders. So paid up share capital is the amount which actually has been paid to the company by the shareholders. Okay, I hope this is clear. Now let's move to further. Now classes and types of shares. Classes and types of shares. Now what is the meaning of class here? Class rights may be conferred on particular members or group of members through the articles. That is, articles could decide that somebody who is buying this kind of share will have this extra rights, say 2 voting rights per share. Somebody could have lesser rights, say 0 voting rights per share. Okay. Now ordinary shares. Ordinary shares are the equity shares. So ordinary shares generally give the holders full voting rights. Okay. In case of preference shares, we will discuss about it. There is no limit on the size of distribution they receive, and on winding up, they participate fully in the distribution of surplus assets also. That is, they have the residual interest. But here when we talk about preference shares, so preference shares usually give holder fixed priority dividend rights. That is, once the dividend is given, it will be given to them. Now you must have understood in your FA and FR syllabus also, if you have studied FR, otherwise an FA syllabus, that there are preference shares which are cumulative, non-cumulative, all of that, right? So which accumulate from year to year if unpaid. Now my dear friends, if you have any concerns here, although I am assuming that you must have studied this in your FA syllabus, just in case if you have any concerns over here, any doubts over here, please feel free to reach out to me. I would be happy to help you here. Okay. Now they do not usually have voting rights except at meetings of preference shareholders. That is, in AGM they might not get the voting rights. Now this is point to be remembered, that they do not have voting rights in case of say AGM. They have voting rights only in case where preference shareholders, where there is a meeting of preference shareholders. Now the main difference between ordinary and preference shares can be summarized as below. And my dear friends, this is one of the most important questions from this particular chapter. So let's discuss about it. When I talk about ordinary shares, so dividends are not fixed, non-cumulative. What is the meaning of sir cumulative here? Cumulative means if it is not paid in 1 year, then when it would be paid in second year maybe, then it would be paid for 2 years together. Now what if it is not paid in second year, then in third year it would be paid for 3 years. Preference shares, fixed percentage of nominal value, okay, paid in priority over ordinary shares, usually cumulative. Usually cumulative as in unless it is otherwise agreed, these are cumulative. That is, whenever it would be paid, it will be paid for all the remaining years. Now capital growth, voting rights, usually unrestricted. That is, every shareholder gets the voting rights, every ordinary shareholder gets the voting right. And preference shares usually restricted. That is, unless otherwise agreed, they only have rights to vote at a meeting where there are preference shareholders meeting that is going on. Now capital growth, likely if the company does well, so there would be wealth growth, there would be capital growth, whereas it is fixed in case of preference shares, so it is unlikely capital growth. So they will be repaid back the amount along with the preference dividend. Now let's talk about members. So here, in general, any person including an artificial entity such as a company can be member unless forbidden by law or forbidden by the articles. That is, unless it is otherwise agreed or unless it is restricted by national laws or by articles of the company, any person including a body corporate can also become member of a company. Okay. Now treasury share. What are these treasury shares? So as a general rule, a company cannot be a member of itself other than for the short term holding of treasury share. What is this treasury shares? Did you hear of buyback shares? Did you hear of buyback shares? Company might buy back their shares also. Now in this particular case, if a company has bought back their shares, by what name it should be recorded in the balance sheet? It is not equity share capital, right? It is not general shares, it is not ordinary shares, so it is called as treasury shares. Can company hold so for a short period of time? Yes. Okay. Now the right to buy back shares and hold them in treasury used to be restricted to public companies. This right, subject to limits, is now also available to private companies. So now, can private company also have treasury shares in their stock? Yes, they can also buy back their shares and keep them as treasury shares. Okay. Now treasury shares are not shown as an asset on the balance sheet, but as a deduction in arriving at shareholders fund. So when we talk about shareholders fund, total share capital, we deduct treasury shares, and at the final column we do not disclose it. Now company investment in other companies, this is called as investments, right? So a company which holds shares in another company can appoint human representatives to attend and vote at general meetings. So for example, if company A has invested in company B, now company A cannot go directly, so company A will hire some assistant or representative to represent A limited in the meetings of B limited. Sometimes companies operate as group. One company known as the parent holds shares in other companies, which you might have discussed in FA, right? There is group company, there is holding company, there is subsidiary company also. So as a general rule, if any company, say A limited, owns more than 50% of the voting rights or shares of B limited, A limited would be said to have been the holding company and B limited would be called as a subsidiary company. If the shareholding is between 20% to 50%, exact 20% up to exact 50%, then it would be called as associate company. Okay. Now it is illegal for a subsidiary to own shares in its own parent company, otherwise there would be a circular trouble that would be created, right? Because A holds shares in B, B holds shares in A, so there would be a group consolidation issue that would happen. So that is why it is not allowed in a lot of jurisdictions. Now becoming a member, the people who sign the memorandum of association of the company become its first members, that we have discussed earlier only in the last chapter only. Every other person who agrees to become a member of the company and whose name is entered in the list of register of members is a member of the company. That is, generally who signs memorandum, they are considered as members, and after that if anybody specifically agrees, they would be considered as members of the company. Now let's talk about the voting rights. This is very important, please read line by line. Okay. The statutory model articles provide that in a general meeting, votes are first counted on a show of hands to save time, but a poll ballot could also be show of hands like this. Okay. Ballot as in the paper, right, can be demanded by the chairman or by any two members. Best practice guidance is for chairman of meetings to be cautious in taking votes on show of hands unless the outcome is overwhelmingly clear. Okay. Now my dear friends, this is very important. See, voting could be conducted through show of hands. Yes. Can it be conducted through postal ballots? Yes. Now what is more important to here is to understand here is that first of all, if it is required by whom, chairman or any of the two members, it should be in the postal ballot. But what is more important to here to understand here is that chairman should also consider that where it is not questionable, where it would not be questionable. If it is clear show of hands, it is not an issue. But if there is any discussion that is going on regarding this, so what you have to do is you have to collect the postal ballot. You should collect a postal ballot. Now on a poll, unless the articles provide otherwise, each ordinary shareholder has one vote for each share held. Can there be more? Yes, if articles provide, if there is differential right that has been given. Now let's talk about share certificates, and after this we will be talking about, after share certificates we will be talking about, let's move forward, we will be talking about transfer of shares, then restriction on transfer, then classes, then variation of class rights, then minority rights, and then we will be completing a syllabus. Okay, this is very important. Now let's talk about share certificates. Share certificates, very important. Share certificates are like share warrants, the certificates that we get that we hold this number of shares. So when a company creates new shares, it is describing as issuing shares. The director take responsibility for allotting the shares to the shareholders. The company gives the member a share certificate. Sir, is it still given? No. Generally now the demat accounts are there, right? Dematerialized accounts are there. So now physical shares is a less practice, is a less evolving practice, and now dematerialized shares are given, confirming the shareholder's name, the number and class of shares granted. The issue is recorded in the company's own records. The issue and the payment are recorded in the books of accounts, and details of the member and shareholding will be entered in the company's register of members. The certificate is prima facie evidence that the named holder is entitled to the shares. That is, if the certificate is in my name, say Supreet Agrawal owns 10 shares of Reliance Industries Limited, if that is what the share certificate says, then prima facie, unless otherwise evidence is given, prima facie it would be assumed that I am the owners of that particular share. Now transfer of shares, like we have discussed, in case of public company the transferability is allowed, is free, but in case of private companies the transferability is allowed but it could be restricted, that is you cannot transfer the share unless permission given is by other members also. So in order for a member of a company to transfer one or more shares to someone else, there must be an alteration in the company's register of members and new share certificates must be issued. If shares are transferred, the transferor retains the right to any dividend later declared for the financial year during which the shares were held. That is why you will see the calculation of ex dividend, cum dividend also when you go for FA and FR syllabus. Now what is more important to understand here is, once the share transfers are done, who will receive the dividend? The new shareholder will receive the dividend. Should you remember this? Yes. If they are transferred cum dividend, that is with dividend, the transferee acquires the right to any dividend earned but not yet paid at the time of the transfer. What is this? See, if the shares are transferred ex dividend, that is excluding dividend, the transferor retains the right to any dividend. Transferor. So did we understand wrong? Yes, the transferor. See, if it is ex dividend, transferor retains the right. Transferor, Mr. A who has transferred, they will receive the dividend. But sir, it is highly illogical, right? See, what we are saying, Mr. A has sold the shares to Mr. B. Now, if after this any dividend would be given, Mr. A will get. Yes, that is true in case of what? Ex dividend. In case of cum dividend, that is including dividend, what will happen? The new person will get the dividend because they would have already paid the price of that dividend. Since 1996, transfers on the stock exchange have used CREST, an electronic settlement system operated by CRST company, which later merged with Euroclear. The Secretary of State for Business, Innovation and Skills and the Treasury are given authority to make regulations further to develop the electronic share transactions and to facilitate electronic record keeping. Once entered on the register, a transferee becomes the legal owner of the shares. The court has power to rectify the register where a name is wrongly inserted or omitted. Now, restrictions on transfer. So let's discuss about it. Introduction. Generally, members are entitled to transfer their shares to any person. However, directors may be given power by the articles to refuse registration also. Model articles are there. The statutory model articles allow the directors to refuse to write a register, that is directors could refuse to register a new member. Modified articles. Many companies, particularly private companies, modify the model articles and insert restrictions on transfer, like we have discussed. Private companies might have restrictions on transfer. The stock exchange rules provide that a publicly listed company's articles must not give its directors power to refuse to register fully paid share. So that is why what might happen is that fully paid shares cannot be rejected in case of public companies by the directors, but in case of partly paid they could exercise this right. Okay. Now, contractual preemption right. Contractual preemption right, what is this? Right of preemption, a priority right to be offered something that is for sale before it is offered to other people. Like you might have heard of a term called rights share, right? That is whenever new shares, fresh issue might be given by the company, the existing shareholder might be given an exclusive window where it is open only for the existing shareholders and not for the public. So say Reliance Industries Limited is coming with new fresh issue. So now I as the existing shareholder might get preferential right, might get right of preemption, that now I will be asked first whether you want to opt for new shares. If yes, I would be given the right to do so. A lot of companies gives it in discount, on discount also to the existing members. The articles may require a member who wants to dispose of shares to offer them first to fellow members. This will bind members in the manner of a contract. The price may be determined by the articles or estimated as a fair price. But sir, what is the logic behind it? The logic behind it is very, very simple. The person, say I own say 1% of Reliance Industries Limited. Now they have issued fresh issue and I wanted to buy it but I could not buy it for some technical reason. Okay. Now my shareholding in the company will reduce even when I have not done anything. So that is why first of all I am giving the option, at least for the pro rata basis, that I should also subscribe to it. If I am able to subscribe to it, I would be able to maintain my particular shareholding in the company. That should be the basic logic behind it. Okay. Now, classes. Let's talk about the classes. This is one of the last few topics that we are going to discuss, because after this there is variation and then sometimes this creates a little trouble, so don't worry about it. Just the clicking issue, but it's not iPad issue. Okay, it's a study hub issue maybe, or maybe some other issue. Definitely not the iPad issue. Okay, why is this happening? Okay, now classes. Companies may create different classes of shares to be able to vary dividend payments, vary the amount of capital and control voting also. What could be this? Redeemable shares. Redeemable shares as in which are redeemed after a period of time. So issued on terms that the company may buy them back at a future date, say for 5 years, after 5 years, after 10 years. non-voting shares, that is these shares will receive the dividend but they will not get the voting rights in the meeting. So carry no rights to attend general meetings. These may be issued to employees to reward them with dividends when the company is successful, but they will not be given the rights to vote. Management shares carry extra voting rights, say 10 votes each share. These are often used to so that the original owners retain control when additional shares are issued to outside investors, just to maintain the hierarchy of control. Now variation of class rights, there could be variations, yes, like we have discussed, 10 shares, 10 votes per share. A company may wish to vary the rights attaching to a class of shares. The alteration requires the written consent of the holders of 75% of the share, that is special resolution is passed at a meeting or at a shareholders meeting. Now the variation must be notified to the registrar within 1 month of being made, and the procedure of subdividing a class of shares is an example of a reclassification of shares, and this is dealt exactly as a reclassification of shares in your accounts also. Although this may be accompanied by a variation of rights, the procedure of renaming is not a variation of class rights. For example, if you have renamed your ordinary shares as equity shares, will this be considered as a reclassification? No, but you have divided into two parts, that is one part, say out of 100 shares, now 51 will have 2 voting rights and 49 will have no voting rights. So now in this particular case we can say that there is a reclassification that has been done and would be dealt in accounting accordingly. Now minority rights, what is this? Minority shareholders who object to the variation may appeal to the court. Minority as in who does not have major shareholding, so hold between them at least 15% in nominal value of the affected shares. What is this? What is this? So even if you want to challenge this decision in court, you should have what? At least 15% in nominal value. Why so? So not paid? No, not paid up, nominal. Why so? Why so? Why 15%? So that a person who is holding say 1 share, they should not go to the court against such a big company. At least 15% should be there. So can this be owned by one person or multiple person together? Multiple person together. Did not vote in favor of the variation, they should not have voted in favor of the variation, then only they can go to court and appeal to the court within 21 days of the variation being made. So if there is any variation, say some shares, the rights of some shares has been changed, so within 21 days of their variation they can file a appeal in the court. Now the court may allow or disallow the variation or make any other order as it deems fit. With this was a very basic chapter, but there could be certain MCQs regarding this. Now with this we have completed this particular chapter. Now what we are going to do is we are going to meet in the next chapter and we are going to cover everything from detail. So from chapter number 14 to chapter number 19, I would highly recommend all of you to read it once before we start this chapter, so that you can get a good grasp over the overall concepts, because till now you were somewhere aware about these terms like shares, everything, right? But now loan capital, company directors responsibility, other company officers responsibility, CS maybe, company meetings, quorum, insolvency and administration, fraudulent and criminal behavior. Now these could be certain topics that you might not be aware about any which ways from your graduate programs or from your 11th and 12th standard knowledge. So that is why I would highly recommend that you once go through the ACCA study, once read it and then attend the lectures, so that you understand it really well. All of these are very simple chapters, very quick chapters to complete, so don't worry about it. Just give a quick read to the ACCA study and then we will be conducting these sessions. So thank you so much. See you in the next lecture. Hello everybody, hope you all are doing really well. I am CS Subrita Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, in this lecture we are going to discuss about a very important chapter, which is chapter number 13. And here we are going to talk about the capital maintenance principles and dividend policies. So my dear friends, first thing that we are going to discuss under this particular chapter is the capital maintenance. Then we are going to discuss about before issue, on issue and after issue categories of capital maintenance. Then under after issue we have to discuss about the distributable profits in the form of dividend or other distribution, then loss of capital and capital reduction also. This is the overview of this particular chapter. My dear friends, a lot of times this chapter is not directly asked in the examination, but it might frame part of some other question as well. So that is why you have to look at it from the point of view of deep understanding. Now my dear friends, let's talk about the principle first. The overall objective of company law is to protect shareholders and creditors from incompetence or misconduct by directors. That is, if director conducts any misconduct or if they are negligent or if they are not competent, then shareholders and creditors should be protected by it. Their money should be protected, right? one of the most important areas which requires a strict legislation is the maintenance of capital, that is whether capital is being maintained appropriately or not. By maintained by here means that we have to discuss about how capital is retained, how capital is utilized, how it is invested, and how it is distributed as well. So before issue, to ensure that the position of existing member is protected, that is, this is vital at each stage of the process. Before issue, to ensure that the position of existing member is protected. On issue, to ensure that the proper price is paid for the shares. And then third one, after issue, to ensure that capital once in the company is not dissipated as in reduced or unevenly distributed or misappropriated without proper authorization. Okay, now allotment. When new shares are created, this is allotment, right? After issue, there is one allotment that happens to the relevant personnel. So when new shares are created, it is the company which issues them, and its directors who allot them to holders. That is, the company issues the shares, but the shares are allotted to whom it should be distributed in what proportion, that is decided by the directors. The terms on which the company issues shares may be set out in the articles, like we have discussed in the previous chapter. Article sets out these internal proceedings. Now, companies incorporated before Companies Act 2006 were required to set in the company's constitutions an authorized maximum on the number and value of shares which the company could issue. There was authorized capital, right? Now it is not mandatory after Companies Act 2006. Now, if a public company makes a new issue by way of a public offer, it must specify the terms prominently in the listing particulars or the prospectus. That is, if a company decides to go for the issuing of any shares, which is called as IPO, initial public offering, or FPO, further public offer. Now here, all the terms of that particular issue, what is the face value, what is the premium, what is the expected dividend, a lot of these things, whether what is the differential right, is there any differential right, whether these are preference shares, equity shares, everything needs to be mentioned in listing document or the prospectus. Now, which is a famous term? Prospectus is a really famous term. So instead of listing documents, I would suggest you to use prospectus. Now, the terms of a new issue will include the following: the number and nominal value of the shares to be issued, like we have discussed, the rights attached to them, whether there is any differential right, preferential right, the consideration, price to be paid by the applicants, and the timing of the consideration, when it is required, when is the first call, when is the second call. Now, directors' authority to allot. So like we have discussed that here the directors have the authority to allot the shares, right? So directors have statutory authority to allot shares as part of employee share schemes. Directors of a private company with only one class of shares have statutory authority to allot further shares of the same class, although this right may be restricted or prohibited under the company's articles. What is this line? Directors of a private company with only one class of shares have a statutory authority to allot further shares of the same class. That is, one class can issue the shares of the same class. In all other cases, the directors need formal authority which may be granted in the articles. That is, in case of private companies, the directors can decide when to issue the new shares of the same class, not the new class but the same class. But in case of other companies like the listed companies, the public companies, what we have to do is we have to decide that directors will have to take approval from the shareholders before issuing any shares. Section 551, authority to allot is limited to a statutory maximum of 5 years but can be revoked, varied or renewed at any time by ordinary resolution. That is, generally the authority that is given for issuing of shares is for 5 years, but it could be revoked. That is, it could be cancelled, it could be extended, it could be preponed. Okay. Now, this applies even if the effect of the resolution is to vary authority given in the company's articles. That is, for company's articles also this verification could be done. What resolution is required? Resolution required is ordinary resolution, but in case of any alteration that is required in case of articles which is given by articles, a special resolution is required like always. Okay. Okay, now statutory constraints, preemption. What is the statutory constraints? Statutory constraints as in the restrictions. Preemption, like we have discussed in the last lecture, preemption means rights issue, right? Rights issue, that is, some special right is given to the existing shareholders before allotting it to the new shareholders. So the company's constitution might require that new shares to be offered first to existing shareholders. This is known as rights issue of shares. Even if the articles do not confer such a right, section 561 requires that when a company proposes to allot equity shares wholly for cash, it must first offer them to existing equity shareholder on a proportional basis. Now, my dear friends, even if it is not written in the articles, is it a statutory requirement? Yes. See, this is very important point. Even if the articles do not confer such a right, that is, even if it is not written in the articles, it is statutorily required that if any company issues any shares, then it should first be given the right to the existing shareholders to allot it, to apply for it. Okay. Now, these statutory rights issue must be offered in writing on a pro rata basis. What is this pro rata basis? That is, out of say 1000 shares of a company, one shareholder holds 100, that is 10%, and now 100 new shares are coming up. So, how many shares can this existing shareholder apply for? They can apply, or they can be allotted 10 shares, that is proportionately. Before the issue they had 10%, so now after the issue also they will be allotted maximum 10% of the new issue, okay, or no less favorable terms than they are subsequently offered to outsider. That is, whatever term that is offered to these shareholders, that should be similar to what is offered to outsiders. It could not be less. Can it be more benefits? Yes, but can it be less? No. Now, the existing shareholder have 14 days to take up or reject the offer. Can this timeline be increased also? Yes. Can this timeline be increased? Yes. Okay, 14 days is general timeline. If directors do not comply with preemption rights, the share issue is valid, but the directors must compensate the shareholders who should be offered the share for any loss suffered. That is, even if directors missed out on providing these rights issue or this particular right to the existing shareholder, will the new issue of shares, will that be valid? Yes, that would be considered as valid. That is not an issue. But what is the problem over here is that the directors would be liable to compensate any of the existing shareholders if they have missed out. Say this 10 shares that we are talking about, one shareholder who was getting right to buy 10 shares, if the directors forgot to or missed out or did not offer the rights issue to him or her, and they wanted to buy it, so they lost say $100. So that $100 should be recovered from the directors and given to this particular shareholders. That is, directors should compensate. Will the company compensate? No, directors will compensate. That is very important here. Now, circumstances in which statutory preemption rights do not apply. That is, there are certain conditions where this preemption rights, the rights issue is not applicable. The rights can be disapplied or modified by provision in the articles or by a special resolution. Via provision in the articles, can this be restricted? Yes. Via a special resolution also, can this be restricted for a particular case? Yes. For a private company with only one class of shares, the disapplication is indefinite. Otherwise, it will only apply for the duration of the authority of the directors to allot. The right to disapply in this way may itself be prohibited by the company's articles, just in case it is important. Now, the rights will not apply if the company has its own preemption provisions which are inconsistent with section 561. That is, if the company has its own articles of association for preemption rights which is not inconsistent with the company's law or Companies Act 2006 provision, then that is not applicable. Now, section 561 does not apply if the issue is of bonus shares or is not wholly for cash. So, preemption rights only apply when the shares are fully for cash. Yes, true. Okay, this is very important MCQ for you. If the shares are allotted as part of an employee share scheme, then also the preemption right does not apply. ESOPs, and in case bonus issue is there, or in case it is not fully cash paid basis shares. Okay, this is very, very important. Now, proper purposes rule. What is this proper purposes rule? I hope up to now you are very, very clear. Just in case if you are facing any trouble, please feel free to let me know. See, in case of law, understanding the concept is one thing, but you should always solve more and more questions because most of your test paper is going to be around MCQs. Okay. Now, proper purposes rule. Why I am using ACCA study? Because it is important for you to cover each and every line in an appropriate manner. Okay. Just in case if you read after this and you face any trouble, please feel free to let me know. I would be happy to assist you. I would be happy to help you over here. Now, proper purposes rule. Director's power. By case law and by virtue of section 171, which is the section 171 of the Companies Act 2006, directors must exercise their powers for the proper purposes. That is, whatever powers they are using, that should be for the proper purpose of the following of the act or the articles of the company. Now, the proper purpose of a share issue is to raise capital. That is for the purpose of raising capital efficiently. An issue for any other reason can be challenged unless the allotment is approved or subsequently ratified by ordinary resolution in good faith. So, sir, there is some term called offer for sale. What is offer for sale? When the existing shareholders are selling their stake. In that particular case, is it to raise capital? Yes, it is to raise capital to pay off. But what if the ultimate purpose of the share capital is not to raise capital, but to increase, say, authorized number of share capital or issued number of share capital to reach the maximum level? Now, in this case, you should always take ordinary resolution, because if there is any reason to issue the share capital other than to raise capital, then it should be approved via ordinary resolution in good faith. Now, what is good faith? We all understood this, that not with the malicious intention. Now, if an improper issue is not ratified as an approved by shareholders via ordinary resolution, the company can cancel the new shares or sue the directors concerned for breach of duty as well. Now, let's talk about documentation. Very, very important. Let's talk about documentation. So, when new shares are allotted, there are three areas of documentation to consider. Number one, the allottee will expect a share certificate. What is share certificate? We have discussed in the last lecture, right? What is share certificate? The company's register of members will need to be existed for the new holding. That is, if initially there were 1000 shares and now 100 new shares have been issued, so you will have to write a letter to the registrar to update it with 1100 shares now, okay? And a record will need to be made in the company's accounting records showing the new issue. That is, now the balance sheet should show that now we do not have 1000 equity shares, but we have 1100 equity shares. Now, many of the rules relating to consideration for shares are designed to ensure that shares are not issued for an inadequate capital contribution. However, there are no rules to prevent a company having inadequate capital in the first place. Now, payment for share. What is very important here is that there is this question that is very frequently asked in the examination also, which is no issue at a discount. That is, shares, can they be issued at par? That is, 10 was the face value, 10 is the issue price. Yes. Can they be issued at premium? 10 is the face value, they are issued at 20. Can it happen that 10 is the face value, $7 is the issue price? No. So, shares, I am not talking about debentures here, I am not talking about bonds here. Shares cannot be issued at a discount. Very, very important. So, there is an exception to the common law rule that consideration in a contract need not be adequate, because generally we understand in a company's law, contract act, that consideration need not be adequate. Say if I want to sell off this remote for $1, I can sell it, consideration need not be adequate. Can I sell it for free? No, that will not be considered as a valid contract. But can I sell it for $1? Yes, need not be adequate. Shares must be issued for adequate valuable consideration, cash or otherwise. That is, it could be in against property, yes. It could be against know-how, yes. It could be against furniture, tangible assets, yes. That is, the company must receive payment or the promise of it equal to the amount for which the shares are credited in the company's accounts. My dear friends, this is very important, right? So here, Contract Act and Companies Act is coinciding with each other, is contradicting with each other, because Contract Act says consideration need not be adequate, but here in Companies Act it is specifically written that if you are issuing any share, it should not be issued at a discount. Very, very important, right? Now, neither a private nor a public company may issue shares at a discount on their nominal value unless the balance remains payable, right? This is very, very important. I hope this is clear to you. Yes. Okay. Now, if shares are issued at a discount, the shareholder is liable to make up for the difference. That is, shareholder could be asked to pay $3 extra in this particular case when $10 face value has been issued for $7. Okay. Now, anyone taking shares without paying the full value plus any premium due is liable to pay the amount of the discount as unpaid share capital. Okay. With an interest of 5%. This is also very, very important. Okay. Now, also, any subsequent holder of such a share who was aware of the original underpayment will be liable to make good the shortfall. Okay, now exception for underwriting commission. So, underwriters are people who generally agrees that they guarantee the subscription of the shares. So, financiers who agree to purchase shares not taking up in response to a public offer, that is, if it is not subscribed, they will buy it, may be paid a commission from the issue proceeds provided the articles authorize it and the rate of commission does not exceed 10%. This is very, very important. Okay. Now, additional, sir, should we remember these two conditions? Yes, this is important. You should remember this condition. A lot of times underwriting questions are asked. Now, additional restrictions on public companies. So, the following rules apply only and only to the public companies. Subscriber share. What is this? The following rules only apply to public companies. What is this? Subscribers share. What is this? Signed for under the memorandum in a public company must be paid for in cash. Okay. A public company cannot accept as payment an undertaking to do work or perform services for the company in the future. Further provisions demand that whatever consideration is promised, it must be payable within 5 years. A private company planning to re-register as a public company must therefore ensure that work or services promised in exchange for shares are performed before the date of the special resolution to re-register as a public company, and any other asset promised as payment is transferred by the date of the special resolution. Now, shares issued by a public company must be paid up on allotment to the extent of 1/4 of the nominal value plus the entire premium. What is this? Shares issued by a public company must be paid upon allotment to the extent of 1/4, that is one fourth of the face value plus 100% of the premium. That should be the first installment that you should collect minimum. So $10 is the face value. So $2.5 plus, say it was issued at $20, that is $10 of premium. So total 13.5 should be received at least. Okay, so 12.5 should be received at least $10 of premium plus $2.5 1/4. Okay, unless the shares are being allotted to an employee share scheme, that is if it is part of ESOP as in what is given to the shareholder, what is given to the employees as a bonus of employment. Now any non-cash asset to be accepted as payment by a public company must be independently valued within the 6 months prior to allotment. That is, if some bank says that we want to subscribe to your share and we will be giving you, say, one piece of furniture as a consideration, so that furniture should have been valued within 6 months of allotment, within last 6 months, not from the day of allotment, but up to, say, 1st February is there, so before that 6 months. Okay, that is very, very important. Okay, okay, now sir, how did you identify that it is before that and not after that? Here there is a word called prior. Okay, prior to allotment. Now public company cannot financially assist a shareholder in paying for shares. Can public company itself give loan to a shareholder and say that you subscribe to our shares via this money? No. Breach of the above rules has the following consequences: the company and its officers are liable to a fine, and the allottee must pay any deficiency in cash with interest. My dear friends, what is the fine? What is the penalty? That is not part of our syllabus. That would depend on the national jurisdictions. That is why it is not covered here. Now share premium. What is share premium? Share premium is something that you have discussed in your FS syllabus as well. Share premium, which is collected as an extra amount over and above your face value, right? Premium. So if shares are issued under a contract whereby the allottee undertakes to pay more than the nominal value, the excess is known as share premium. The law takes the view that this extra payment should be treated with the same caution as the nominal value itself. It forms part of the creditor's buffer only. The share premium account is a capital account and is not distributable to members. It is treated as part of the paid up capital and may not be depleted, although of course the cash it represents may be converted into other assets. However, the share premium account can be reduced in restricted circumstances. That is, it could only be utilized for the purpose of write-off of the expenses or commission relating to issue of those shares, that is the floating charges, and make a bonus issue of fully paid shares. So that is, these are two uses, that is to write off the expenses or commission relating to issue and to make a bonus shares of fully paid shares. That is, bonus shares is issued only when it is fully paid. You can use the securities premium reserve. I hope this is clear. Hope this is clear. Now let's take a 2 minutes break because this is getting a little heavy. So let's take a 2 minutes break, then we will start with the further topics. Don't worry, very few topics are left, and then we will be covering this whole chapter. Thank you. Yes, so now let's get back. Let's discuss about bonus shares. What are bonus shares, my dear friends? Bonus shares, you might have heard that there are certain shares, or there is one category of shares where you do not have to make the payment, you are allotted the shares based on your existing shareholding. So say if I hold 100 shares in a company, so if they have issued say 1:1 allotment, 1:1 bonus share allotment, so what I'll get 100 more shares based on my existing 100 shareholding. So a bonus issue, also called as a scrip issue, is an issue of shares to existing shareholders by way of capitalizing profits, because it is issued by capitalizing profit, by transferring profit from your reserves or some other reserves. It causes no net change in assets. It causes no net change in assets. How? Because this is liability, equity liabilities transaction to equity liabilities, that is shares, the reserves is transferred to share capital. So it is in the liability and equity side of the balance sheet, merely redefining the proprietor's fund. For example, if share premium is converted into shares, so share premium to share capital, so it is transferred from one account of shares to the share capital, so it is capitalized. Okay, this you might have discussed in FS syllabus also. Now, return of allotment. What is this return of allotment? So directors must deliver return of allotment to the registrar within 1 month of the allotment. That is, when the allotment has happened, the directors have to submit a report to the registrar with the details, the number and nominal values of the shares allotted, the names, addresses and descriptions of the allottees. Names and addresses allowed. What is description? Say demat account number, say social security number, say in India PAN number. So the amount paid and payable on each share, everything along with the premium, along with everything. Failure to make a return does not invalidate the allotment, but those responsible will be fined. That is, what we can understand is, whatever might happen, unless the allotment has been done with fraud, the allotment will not be invalidated, but the people who are involved into that particular irregularity, I would say, those people would be fined or might be adjudicated, might be prosecuted as well in certain cases based on different provisions. Now, provisions for capital maintenance. What is this provision for capital maintenance? So, contains detailed provision for maintenance of capital after shares have been issued. Say distribution of profit. Restriction are imposed on companies' ability to pay dividends. Excessive distributions could prejudice both creditors and the members themselves. So that is why there are certain restrictions that are being placed on when you can distribute the dividend, how much you can distribute the dividend. Loss of capital. For a public company, the directors must call a general meeting if the amount of its net assets falls to 50% or less of its called up share capital. The meeting considers whether any steps should be taken. What is this? What is the amount you should remember? If the net assets as in total assets minus external liabilities, at least, right? Total assets minus external liabilities falls to 50% or less of its what? Called up share capital. Not issued, not paid up, called up share capital. Okay. Why called up, sir? Because that is the actual money that you have. Even if there was a capital which was say issued for $10, but if only 5 has been called up, so that is the amount that you have or you are expecting or you can recover from the shareholders. Now, reduction of share capital. So capital may be reduced. Capital may be reduced to extinguish members' liability on unpaid capital. Capital may be reduced to extinguish members' liabilities on unpaid capital, or to cancel paid up capital against losses. What is this? To extinguish members' liability on unpaid capital. So say if some capital was unpaid, okay, say it was $5 were paid, $5 were unpaid. So can it be adjusted against it? Yes. To cancel paid up against losses and for any other reason. Now, strict preconditions apply. A private company may, what is the precondition? That is, before doing this, these preconditions should be there. A private company may reduce its share capital by special resolution provided it is solvent and remains solvent following the reduction also. A public company may similarly reduce its share capital by special resolution, however the court must approve. So both can reduce, but in one case it should only remain solvent after the reduction, and in another case, that is public company, the court must approve it. Now, companies are not permitted to acquire their own shares, and a company cannot be a shareholder in itself, and that is why a separate category of treasury shares, a temporary category of treasury shares is created. Okay. Now, exceptions are made for tightly regulated schemes to buy back or redeem shares as well, which must then be cancelled, replaced either by a new shares or must be reissued as well. Now, financial assistance. Section 678 states that subject to strict exceptions, that is until there is a very strict exception to it, a public company cannot provide finance directly or indirectly for a person to acquire the shares in its company. Say, can a bank grant loan to another person with the purpose of buying the shares of that particular bank only? No, they cannot do so. Okay. Hope this is clear. Hope this is clear. Hope this is clear. Yes. Now treasury shares. Now let's discuss about treasury shares. This is something that we have discussed about yesterday only. Let's just read it. Treasury shares are an exception to the general rules for the maintenance of capital after shares have been issued. That is the temporary category, right? A company may buy back its shares and hold them in treasury. For a public company to qualify for the exception, the share must be listed on the stock exchange, the alternative investments market, a European economic area market, and traded on a regulated market. Is it very important for you? No. A public company must pay for the shares out of distributable profits. That is, it should not come out of the permanent capital of the company, should be formed part of the distributable profit, generally the free reserves, right? Now, to encourage wider employee share ownership, private and unlisted companies now have this right also, that shares can be bought back using small amounts of cash, and shares can be held in treasury if bought back out of distributable profits. Now, while the shares are in treasury, the company is shown as the registered owner of the shares, and the company cannot attend meetings, vote, or receive distribution for those shares. The shares are not shown as an asset on the balance sheet because it is reduced from the total equity share capital. So, total equity share capital less treasury shares, and the final amount is disclosed. This is something that we have discussed yesterday only. Now, dividends may not be paid out of capital. Dividends may. So, dividends can only be paid out of profits available for that purpose. That is, dividend is generally not paid out of capital. Dividends are only paid out of profits. Dividends cannot be paid out of share capital or share premium account, which can be used for two purposes: and unrealized revaluation of asset. Okay. So, unless say some asset was there, some say car was there, you have allotted it as say $100,000, you have valued it as say $100,000, and now it has been revalued to $120,000. So, these $20,000 is profit but unrealized profit. So, this could also not be used for the purpose of distribution of dividend. Now, profits available for that purpose. So, net realized profits determined as accumulated realized profits less accumulated realized losses. So, accumulated profits, accumulated losses, both should be realized, not unrealized. Okay. Now, the requirement that the profits and losses be looked at on an accumulated basis means that profits and losses brought and carried forward must be netted off here. Okay. Now, profits and losses, but let's see what is remaining. After profits and losses, there's a discussion on additional restrictions for public companies, then there's a discussion on other provisions, and there's a discussion of insufficient assets, public companies, conditions. It's not working, it's not moving forward, circumstances, terms, then the syllabus would be done. Hope this is clear. So, not much of the syllabus is left. Okay. I don't know why it creates trouble sometimes, and it only happens in case of iPad. It does not happen in case of any other device that we use in, and believe me, the screen is on point. Okay. So, do not doubt my screen. Yes. Oh my god, this will waste a lot of time sometimes, right? Don't worry, if required, we can also open it on laptop. Profits and losses. Okay, let's talk about it. Realized profits means the profits that has actually been generated by the company. This you must have discussed in FS syllabus also, especially under the inventory chapter. Okay, realized profits arise from transaction and events resulting in cash receipts. Unrealized profits, where the profit or loss has occurred but it has not been generated, it has not been actually received, or it has not been received in cash, it has not been generated actually by the company, like inventory revaluation, asset revaluation. Now, additional restriction for public companies. So, public company may not make a distribution if its effect would be to reduce its net assets below the aggregate of called up share capital plus undistributed reserves. Should you remember this? Yes. Let's read it again. A public company may not make a distribution of what? Of dividend if its effect would be to reduce its net assets. Net assets is what? Total assets minus external liabilities below the aggregate of called up share capital. Called up share capital. If the aggregate is below the called up share capital, it will not decide to, or it may not decide to distribute the dividend. Okay, this is very clear. Sir, other provisions. Let's read it one by one. Very important. Okay. Relevant accounts. The amount that a company is available for distribution must be determined from its most recent annual accounts. Okay. If a distribution would not be permitted according to the most recent annual accounts, the company may justify it on the basis of most recent accounts. Consequences of an excessive distribution. What if you distribute excess? So, a member who knew or had reasonable grounds for knowing that a distribution was being made in contravention of the act is liable to repay it. It could be directors, yes. Directors and auditors who are responsible for unlawful distribution may be liable to the company for breach of duty, and that is why one of the core responsibility that you will be discussing in your audit syllabus is that whenever auditor audits this distribution of dividend, they also go for maximum amount of dividend that is distributable and what the actual amount that has been distributed, and if there is any issue they have to report it. If they do not, then they will also be liable to pay back or compensate the company for that. Okay, now process of payment of dividends. So under model articles, unless something else has been agreed by the company, under model articles the process for payment of dividend is as follows. Director recommend the dividend, that is the proposed dividend that you discuss in accounting. Okay, the recommended final dividend must be approved by the ordinary shareholders or ordinary resolution in the AGM. The directors may pay interim dividends without ordinary resolution. So directors propose it, shareholders agree on it, approve it, ratify it via ordinary resolution, but can any interim dividend be paid by shareholders directly without the approval of AGM? Yes. Okay, very important points. Okay, now insufficient assets. There may not in reality be sufficient assets to cover the creditors buffer. What is this? See here, consider the following balance sheet extract. Fixed asset, fixed non-current assets is 1 million, net current assets is 2, so total net assets is 3, share capital is 7, profit and loss account is minus 4, so overall it's 3. The creditors buffer, the share capital is not represented by realizable assets because of the losses that the company has suffered, so it has not sufficient funds to distribute as well. Okay, now public companies. So the director of a public company are required to hold a general meeting of the company if the amount of the company's net assets falls. Okay, okay, the notice of the general meeting must go within 28 days of a directors becoming aware of the shortfall. Within 28 days. Should you remember this 28 days? Yes, it could be asked in the MCQs also. Now conditions, let's discuss about the conditions here. So one mathematical solution to a serious shortfall in a company's asset would be to reduce the value of the share capital to balance the equation. What is this? One mathematical solution to a serious shortfall in a company's asset would to reduce the value of its share capital to balance the equation, because the asset value has reduced, so share capital value should also be reduced. This is generally not permitted in company law, as it would be contrary to the principle of capital maintenance, because you are anyways reducing the capital. However, a company is permitted to reduce its share capital accounts provided that its articles do not prevent it. A special resolution is passed. The resolution is supported by a solvency statement and the court approves the scheme. My dear friends, here what you need to understand is this is and condition, that is both conditions should be satisfied, but this one is or, that is any one of them could be satisfied. Now solvent private company, the special resolution is supported by the solvency statement by the directors together with the revised statement of the company share capital and share premium accounts. This must be filed with the registrar within 15 days, that is whatever changes you want to do, whatever reduction you want to do, that should be submitted to the registrar within 15 days. That is something that we have earlier discussed as well. Now court approval, if the company plans to pay out buffer assets or to cancel unpaid liability on shares, the court will not approve the scheme unless creditors have an opportunity to object, that is unless creditors has been given an opportunity to object to this particular resolution, court might not approve it. Okay, so it should be approved by the shareholders first. Now circumstances, now let's discuss about the circumstances. A company may reduce its capital for any reason, not only to deal with losses. Section 641 suggests that 3 particular circumstances which might be approved. Number 1, to extinguish members' liability on share capital. This is something that we have discussed, unpaid amount, right? Now to repay capital in excess of the company's requirement. Okay, now to repay capital in excess of the company's requirement, and to cancel paid up share capital which is lost and no longer represented by assets. This is very, very important. Okay, now terms and effect of a court order. So the court can make the order on such terms as it thinks fit. It can order the directors to publish the reasons for the reduction and order the company to add the words and reduced, that is share capital and reduced, to the name for a specified period. If the nominal capital of a company falls below the authorized minimum, it must re-register as a private company. Very important point. The court order giving details of the new capital must be filed with the registrar within the specified days. No number is mentioned over here. Hope this is clear. Hope this is clear. Now with this the chapter is completed. I just hope that one thing should be clear to you. Okay, let's just discuss on that once more and then we can go for the completion as well. Why I am not getting an option to go back? Oops, let me check. No worries, I'll go to the chapter again, but that points need discussion. Okay, I was talking about this to extinguish members liability on share capital not paid up. This we have discussed, right, that if some shareholders have not paid up some amount, can this share capital reduction be adjusted against it? Yes. To repay capital in excess of the company's requirements. If a company has assets in excess of its needs, it may wish to distribute the surplus to its members. That is also allowed. And to cancel paid up share capital which is lost and no longer represented by assets. So where a company is burdened by losses which are unlikely to be made good, that cannot be recovered in future, the court can sanction them to be written off against capital. That is, capital could be used to write off these losses which are against the assets, and that asset has no future to recover. That is how we cover this particular chapter. And my dear friends, I hope you have understood this chapter really well. Now in the next chapter we are going to discuss about a whole new topic. So thank you so much. I hope you have understood it well. Just in case if you face any trouble, please feel free to let me know. Thank you so much. Hello everybody, hope you all are doing really well. I am CS Agrawal, your faculty for ACCA AA, AAA and law subjects, and today we are going to take up chapter number 14 from your law syllabus. My dear friends, let's discuss about what is this chapter. This chapter talks about the loan capital. When I talk about loan capital, so see, before understanding loan capital, let's first discuss about what could be certain sources of capital. So we have already discussed about equity as a capital, right? There could be equity. Under equity also there could be ordinary shares, there could be preferred shares also. But there comes another way of financing a company, which is loan capital, because it is not necessary that every company is a listed company, and even if it is a listed company, it can borrow funds or it can raise funds through equity every time. There are certain loan capitals which are required. Now, before we move further into discussion of this loan capital, which is a very small chapter, and you might have already discussed a lot of details about it in your 11th, 12th as well as the other chapters. So we will be able to cover it very quickly. But before I explain any of the points of this chapter, let me first ask you, what could be a possible reason that somebody takes a loan? It could be, say, they do not have the money, very basic reason. But can it happen that somebody who has enough capital, they also use the loan capital intentionally? Can it happen? Yes, it does happen. When it happens, see, please try to understand this one thing, that whenever we talk about loan as a capital, what is more important to understand here is that loan as a capital is not something that is only borrowed by people who do not have money in their account. No, it could be used by people who have sufficient money, still they want to go for loan, because they might be generating better returns wherever they are investing their loan capital. They might be generating better returns than that. Even after paying off the interest of the loan, they might be generating surplus funds, right? So that could be one reason. Now let's discuss about what could be certain terminologies that we will be discussing about it. So we will be discussing about loan capital under this chapter, then debentures, and then charges. Under that also we will be discussing about public debentures and shares, okay, then remedies of debenture holders, which is unsecured debts, secured debts, and then avoiding and invalidating charges also, like insolvency, void charges, voidable charges, etc. So let's discuss about all of them one by one. Let's first discuss about loan capital. So when I talk about loan capital, companies are usually financed by a combination of share capital and further long-term borrowings also that we know. Companies are regarded in general as having implied power to borrow in order to support their authorized activities. My dear friends, unless it has been restricted in the articles or the memorandum, every director or a board of director has the capacity, has the capability, has the powers and authority to raise loan capital, okay. Now if the director exceeds their authority, so for example, if the authority was given to borrow funds up to say $1 million and they have borrowed say $2 million, so they have exceeded the authority, they will be liable to the company for their breach of duty and to make good any consequent losses. We have already discussed about indemnity as a concept, right? So if company incurs any losses because of this decision, they will be required to compensate the company about it. Now let's discuss about point number 2, which is debenture. Now this is something that you might have discussed in your 11th class commerce as well, and this is something that is very similar to that. See, debenture is something which is called as a written acknowledgement of a debt owed by a company. So sir, it is only debt capital. Whenever we discuss about debenture, is it only debt? Yes, it is only debt. So we have already discussed about something called as redeemable debentures, irredeemable debentures, convertible debentures, non-convertible debentures, right? So all of those are parts of debentures. Irredeemable, which cannot be redeemed. Redeemable, which is redeemable at a future date, which is redeemable at an agreed future date. Convertible, which could be converted into shares also later on. Non-convertible, which might not be able to convert to share capital, right? Now there are redeemable, convertible. So debentures may be issued on terms that are redeemable, that is repayable at a certain date or in certain circumstances, or they may be irredeemable also. Convertible into shares at some later time, or they may be non-convertible also. Debenture holders can improve their priority for payment over other creditors by taking a charge. Now this is something that is covered as a separate topic in our discussion, in today's discussion only, so we will not throw much light on it here, but let me just tell you what is the meaning of charge. Say I buy this phone, okay, I have this phone, I buy this phone, and I say that I have taken a loan against it, and in the loan document it is specifically mentioned that if I am unable to pay off the loan, to repay the loan in any scenario, they can take away my phone, okay, they can take away my phone and they can sell off this phone and then they can adjust it, okay. That is one thing, that is a charge against an asset. Can it also happen that they might say that whatever is there in your balance sheet, say my car, say my home, they could also take it off if I am unable to borrow, if I am unable to repay for this loan? Yes, but these are different kind of charges. One is called as fixed charge, another one is called as floating charge. But what is more important is there could be a charge, right? Charge against asset, that in case of failure of repayment, they can take off. Now, charges. What are charges? So charges, an arrangement by which a debt is secured against a debtor's asset. In this case, I was the debtor, so the loan was secured against my particular asset, okay. So it was a phone asset, it was a mobile phone, that was the asset that we were talking about. I hope this is clear. Now, a creditor whose debt is secured by a charge has the right to look to an asset or class of asset for repayment of the debt as a matter of priority over other creditors. Can debentures do so? Yes, debentures can agree on this term, on their agreement, that if they are not being repaid, they can take a charge against certain assets, or they might have charge from the start date and they can exercise that charge. Now there is something called as fixed charge and floating charge, okay. When I talk about fixed charge, this is against a particular asset, a specific asset like the phone only. There is a floating charge also, floating charge as in general assets. So a fixed charge attaches to a specific identifiable asset, in this particular case the mobile phone. In floating charge, a floating charge is a charge which does not attach to a particular asset, but instead it gives the debenture holder the right to look to a particular category of potentially circulating asset. You might have also discussed about a term called loan against shares, right? Now when I talk about loan against shares, I have kept the loan, I have kept the shares and I have taken a loan. Is this a specific, a fixed charge or a floating charge? Tell me. So this would be called as a fixed charge because there is a specific asset against which the loan has been taken. What if the charge is there that if I do not repay, you can take 10% of my company? Now this is a floating charge because it is on the general asset, right? So about shares also there are two parts. Now floating charges can only be used by companies and LLPs, that is it cannot be used by sole proprietor or partnership firm. Why? Because their shareholding, their transactions, their financial statements are not subject to public review. They are neither legally recognized nor commercially feasible for unincorporated entities. Very, very important for you for your examination. Now, priority of charges. So, generally fixed charge is something that is given more priority than the floating charge. So, if somebody does not and is not able to pay off their repay their loan for this mobile phone, the mobile phone would be sold. If there is a fixed charge, mobile phone would be sold and first repayment would be made to the mobile phone creditor. What if there is a surplus money? Then it could be floated to other persons also. So fixed charge have priority over floating charges where there are charges of equal status over the same asset. See, it could happen that against a particular property which is of 1 CR, first loan was taken of 10 lakhs only. Now that same property could be charged back to what? To the second loan also, say again 10 lakhs. So the first in time takes priority, that is who gave the loan for the first time, the first 10 lakh creditor would get the priority over the second 10 lakh creditor, okay. But there is one exception to the second principle, that is for this principle there is a exception where a fixed charge is created over registered land. I am talking about the land only, okay. The relevant date for priority purposes is the date of registration. Date of registration of what? Date of registration of land as well as date of registration of those agreements. Now, registration of charges. All charges created by a UK registered company must be registered unless specifically excluded. Therefore, charges that are not registered are void. That is, if you have not registered any charges, they are void. So, can we take the details about the charges that are created by the company, say for a public company? Yes. If you go in India, if you go to the MCA website, which is Ministry of Corporate Affairs website, and you go for the master data, you will see certain charges details also, okay. And if you want it in little more detail, you can just pay off for minimal fees and then you can generate the report. Now the period allowed for delivery of particulars to the registrar is 21 days. The company or any other interested person in the charge may deliver the statement of particulars which will have the secured liability, the asset secured. Secured as in that asset is responsible to pay off that liability if there is any delay in repayment, or if there is any failure to repay, that particular asset would be sold and the repayment would be made. A certified copy of the instrument that evidences the creation of the charge, that is the deed that would have been signed, the original copy of that, the certified copy of that. Now negative pledge, what is this negative pledge? Should you remember this? Yes, it is asked in the examination. A contractual undertaking which prohibits or restricts the promisor from creating charges over its asset. What is this? A contractual undertaking which prohibits or restricts the promisor from creating charges over its asset. So for example, if I am the owner of this company, can I create an agreement which says that the directors cannot create a charge against the asset of this company? Yes. The registrar must be notified to include in the register when a debt for which a charge has been paid, when the charged property has been released or is no longer the company's property. So if there is any failure and the person exercises their charge, then it should be notified to the registrar also that charge has been exercised. If the charge has been cancelled, that also should be notified to MCA without saying, even if it is not written over here. Okay, I hope this is clear. Now subsequent additions or amendments to a charge, example adding a negative pledge to prohibit creation of new charges with higher priority, may also be registered. So whatever changes are there, that should be registered with the registrar. Now nature of borrowings. See, we have moved into the second section, which is nature of borrowings here. Okay, so as well as making shares available to the public by way of prospectus, a public company has the right in the same way to invite units of lending by private investors also. My dear friends, this is also called mutual fund, right? So these borrowings are known as public debentures, debenture stock, or marketable securities, where units are there, So sir, can we take 1.5 debenture? Generally yes, because it is units, right? Now the lenders might be offered the security. So it is not mutual fund, it is debenture. Now the lenders might be offered the security of a trust fund set up in their favor, a debenture trust, with a trustee holding a fixed or floating charge and maybe a share in the company. Public debentures can be dealt in and traded in the same way as shares. So sir, these are also listed on the stock market? Yes. You know, I audited one company, only preference shares were listed. Then I audited one company, although not I personally not audited, my team audited, where only debentures were listed. Okay, so if they offer attractive rates of interest or other benefits, they can attract market values in excess of their face values also. That is, the premium might also be paid on this. Hope this is clear. Any questions? Now let's discuss about the difference between shares and debentures. First difference: share is an equity capital, debenture is a borrowed capital, right? Share might not have fixed interest payments, fixed dividend payments, but debentures have fixed interest payment. Generally, repayment is not required in case of shares. When I say shares, I mean ordinary shares, but in case of debentures, the repayment might also be there. So a shareholder is a member of the company with rights to exercise control over the company through voting rights. Debentures is a creditor. A shareholder receives a dividend, a debenture holder receives interest at a fixed level. Dividends are appropriation of profits, interest is a charge against profits, which you study in FA, right? Charged against profits, that is, it has to be paid. Shares are capital and may not usually be repaid except in case of winding up, but debentures are debts and they can be repaid as per the agreement. So that is the difference. Should you remember this difference word by word? I would say word by word, point by point, you should remember this difference, frequently asked in the examination. Now unsecured debts where there is no charge created, there is no security. So an unsecured debenture holder ranks as an ordinary creditor of the company and has the usual rights in contract law if the company defaults. So they cannot sell off any particular asset and get their debts recovered, but they'll have to wait for their turn of the repayment as per the Contract Act. Creditors who are owed over £750 minimum debt have the power to petition the court for the company to be wound up. So if this is the amount, should you remember this amount? Yes. More than £750, then you can petition the court for winding up if the company defaults on payment for 21 days or more. However, an unsecured creditor has no special priority for payment in a receivership. This is very, very important. But will as a creditor rank ahead of the shareholders. So it is better than shareholders in terms of repayment rights, but not better than the secured debts. Now these are secured debts as in where there is a charge against the asset. So like any other creditor, if the company defaults on payment, a secured creditor can sue the company for breach of contract and or seek a winding up as above. The security will give the creditor priority over other creditors. Receivers, administrators and liquidators are insolvency practitioners who will be appointed to take charge of all or some of the assets of the company. Now receivers, what are receivers? Receivers are the people who take charge that they will be selling off the asset, they will be repaying the creditors. A receiver can be appointed by the holders of a fixed or floating charge. They will be vested with the responsibility to get the asset valued, to sell it off, to repay. Receivers do not automatically have management powers, although seizing the company's assets will undoubtedly have a bearing on the company's running their principal duties to the charge holders they represent. The effect of receivership can be to precipitate the company into liquidation. Now, an administrator assumes full control of the company. So, if this is an administrator, they will assume full control of the company. Can it happen? Yes. If the board fails to manage the company in an effective way, this could happen. So, an administrator assumes full control of the company, its assets and undertaking, and seeks to restructure the company's finances to improve creditors' prospects of repayment, to return the company to prosperity. Now, so receivers' responsibilities towards their hirer, which is generally the creditors. In case of administrator, the responsibility is to bounce back the company, right? Now, so statutory provisions or administrations. So, there are three purposes of administration: to rescue the company, to get a better result for the creditors as a whole, that is to increase the valuation of the asset, or to gain maximum repayment, to get maximum repayment for the creditors, and to make a distribution to the secured and preferential creditors. Now, liquidator. What is liquidator? So, liquidator is an insolvency practitioner appointed by the company or the court. See, receiver is appointed by whom? The creditors. Administrator is appointed by whom? We do not know. Administrator appointment is not mentioned in our syllabus, but liquidator is appointed by company or court. Okay, let me tell you who appoints the administrator. Again, the company law or court. Okay, now to wind up the company, to realize company's assets and to repay the creditors and have the company's existence brought to an end. That is to wind up the company. Hope this is clear. Now let's talk about insolvency. Okay, now after this is fourth section. So insolvency, void charges, then void charges, voidable floating charges, preference, transactions, and then it is done. So this is the last section of today. Okay, I hope this is the last section and you are understanding it. Now let's talk about insolvency. So if a company becomes insolvent, the liquidator or administrator will have the difficult task of sharing out a finite value for its assets. Finite value, that is the determinable value. Companies Act 2006 and the Insolvency Act 1986. So this Insolvency Act is of India or what? It is of UK. Okay, contain a number of provisions which the insolvency practitioner may have the right to ignore charges and even to recover sums already paid to creditors or others. Oh my God, this is so important. They can cancel off the charges also. Yes, even after you create a charge to secure a debt, they can cancel it, and they can also call back the money that has already been paid to the creditors if there is a creditor to whom it should have been paid. Yes, they can do so. Very powerful people. Void charges. What is this? Void charges. What is this? Any idea? Void charges. Let's discuss. Charges that are not delivered to the registrar in the relevant period allowed for delivery are void. That is, which has not been informed, are void. See, there are two words, void and voidable. Like we can read, void means that is something that has already been done. Voidable, that could become void later on, right? So on the option of one party or either of the parties. So all registrable charges must be registered with the registrar of company within 21 days of the creation of charge. This is something that we have discussed. If the charge is not duly registered, the debt to which it relates is immediately repayable. If the charge is not registered, the debt to which it relates is immediately repayable. Okay, so who should register it? The borrower should register it, otherwise it would be immediately repayable. So if somebody has given the loan and if somebody has taken the loan, who should create the charge? Somebody who has taken the loan. The charge is void against any liquidator or administrator. Therefore, in insolvency proceedings, the lender loses any priority under the charge and ranks as an ordinary unsecured creditor. That is the impact of not reporting it. Is it justified? Yes, it is very justified. This should always be the case. Now, voidable floating charge. So, floating charges may be voidable in an insolvent winding up. A floating charge is voidable by the liquidator of a company. So, there are conditions. Should you remember these conditions? Yes, please remember these conditions in which the voidable charge could be there or the charge could be voidable. The company did not receive consideration at the time the charge was created. So, you borrowed it but you did not receive the consideration and the charge was created, and insolvency proceedings begin against the company within the 12 months of creation of this charge. So, it would be voidable. If the charge holder is a director, the relevant period extends to 2 years from the date of the charge. The company's solvency at the date of the charge is irrelevant. That is, whatever was the condition, it was irrelevant. It should not just go into liquidation within 12 months from the date of creation of this charge. Let's read it full. For example, if an ailing company issues a charge to secure pre-existing debts, the charge is called by section 245, that is this section. The charge can only be saved if the company was solvent when the charge was created and did not become insolvent in consequence of it. That is, because of the charge, the company did not become insolvent. If the charge is avoided, the charge holder loses priority and ranks alongside the ordinary unsecured creditors. My dear friends, I hope you have understood it. Just in case I have gotten this feedback that sometimes the students face a little difficulty in understanding this topic, the particular voidable floating charge. Just in case you face any difficulty, please feel free to reach out to me. I would be happy to help you here. Okay, a charge is only invalidated under this provision if it was not issued for fresh consideration. So a charge issued in exchange for new funds or stock in trade will not be caught by the provision. Now preference, and after this we will just discuss about this and then the topic will come to an end. So preference, any transaction which enhances a creditor's position unfairly or improperly, that is called as a preference that has been given. This is purely the definition of the preference word, the English word, right? Any transaction which enhances a creditor's position, that uplifts the creditor's position. A preference transaction is voidable by court order at the request of the insolvency practitioner. That is, insolvency practitioner can cancel the charges, can cancel the preference that has been given via court order. Okay, if it is given when the company was insolvent and the company goes into liquidation proceedings either within 2 years of the transaction or within 6 months of the transaction, if the party is not connected. If it is connected, then 2 years. If it is not connected, then within 6 months. Okay, because the other party did not knew. If it is not related, that is why lesser time. And if they knew, then within 2 years also it is voidable, it is cancelable via insolvency professional via court order. Hope this is clear. Now the last slide for today. Transactions at an undervalue. What is this transaction at an undervalue? Undervalue transactions have been entered. So if a company disposes of assets at a gross undervalue, asset stripping, that is, you have reduced the value and then you have disposed the asset, and insolvency proceedings begin within the following 2 years, the court can order those responsible to make good any losses. So if this phone was worth say 30,000 bucks, but you sold it at 10,000 bucks, now if the insolvency proceedings starts within 2 years from this date, from the transaction date, you could be asked to repay it. The transaction will only be saved if the company acted in good faith and in reasonable belief that it was for the company's benefit only. So there should not be any malicious intention, there should be bona fide transaction. Once you complete this, you complete chapter number 14 in full. I hope you have understood it. This was a very basic chapter. Now what we will be doing is, we will be covering chapter number 15, 16, 17, 18 and 19. But let me tell you something. Chapter number 15 is about directors. So here we will be talking about what kind of directors could be there, what could be their powers. In 16 we will be discussing about other company officers like CS, right, KMPs. Company meetings and resolution, we will be discussing about various types of meetings that could be there, quorum and all. Chapter number 18 would be insolvency and administration, a little detailed manner of what we have just discussed today. And then chapter number 19 is a separate chapter which is fraudulent and criminal behavior. So we will try to complete these chapters as soon as possible, and then we will be going for the question solving sessions as well. So thank you so much. I hope you have understood it. Just in case you face any trouble, please feel free to let me know. Thank you. So very good evening everybody. Hope you all are doing really well. This is CS Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, today we are going to cover chapter number 15, which is company directors. My dear friends, this chapter is very special, very important for your examination, as well as if I talk about the intensity of this chapter, this is also going to give you a lot of knowledge which is going to be relevant for your practical life as well. Now, why do I say that? So let's first understand that what is the meaning of the directors, how we derive the term director, what is the overall responsibility of the directors and so on. Okay. So my dear friends, before we move further, when you will go to your AA syllabus, okay, you will understand about a concept called stewardship. That is, there are certain people who have been given the responsibility of stewardship. They are expected that they will be performing under stewardship. That is, they will be managing the assets that is owned by somebody else. In case of company also, we know that the company is actually owned by the shareholders, right? Directors are the representatives of the shareholders or are the employees of the company who are vested upon the responsibility of managing the day-to-day responsibilities of the company, correct? So these directors can be the shareholders also, but Generally, these directors are the employees of the company. They have the responsibility to take care of the day-to-day management of the company. That is, they are managing the company on behalf of the shareholders. That is the core of this particular chapter. So when we discuss under this chapter, we will be discussing about office of director. That is, what is the roles and responsibilities of directors. We will be discussing about certain compulsory officers. We will be discussing about directors as officers. We will be discussing about directors as agents. We will be discussing about appointment of directors. We will be discussing about service contracts and directors remuneration. We will be discussing about what happens in case of vacation of office, that is when the director leaves or is left, then remedies after removal, then directors duties, then general duties of directors, then specific statutory duties and liabilities, and that's how we will be completing this chapter. So this particular chapter is dedicated to directors, and that is why this chapter is very important for us as well, and I wanted to cover this chapter in live mode so that we can cover everything in very much detail. Now my dear friends, please I request you that you should read this chapter fully before you move further. But my strong suggestion would be, after we complete this particular chapter, you should definitely read it from ACCA Study Hub once. Okay. So company law distinguishes between the shareholders or members of a company who own it, enjoy the benefit of its profits and capital growth. The directors who run it on a current basis, that is on an ongoing basis, that is on a current basis. Okay. Now exam advice. The code is not examinable. However, it is very relevant to your future professional studies and is available at www.frc.org.uk. Okay. So the code that we talk about, what is this code? The UK Corporate Governance Code. That is not relevant for your examination as far as corporate law examination is concerned, but it is definitely relevant for your other examinations. Now let's talk about compulsory officers. So directors are compulsory company officers. That is, every company needs to have directors, and that is why you will see whether it is a listed company, unlisted company, public company, private company, every company has directors because it is a compulsory. It is compulsory to have directors in your company. Additionally, companies are required to appoint external auditors to report on the company's financial statements also. So these are called as compulsory officers. Every private company must have at least one director. Should you remember this? Yes, every private company must have at least one director. Every public company must have at least two directors. Okay, and they should have one external auditor in their company, and a public company must have a company secretary as well. So these are the compulsory officers. In case of public company, the company secretary is the company's chief administrative officer as well. Now let's talk about directors as officers. Can directors become this officer? So yes, CA06, which is Companies Act 2006, lays down number of official duties which the directors must perform. Okay, keep accounts and prepare the year-end financial statements. That is one responsibility that is given to them. Calculate and recommend any dividend. Calculate and recommend. Why not issue? Because it is to be approved by the shareholder. That is why calculate and just recommend. Then convene general meetings. It could be extraordinary general meeting. It could be annual general meeting. File the annual accounts, directors report, auditors report, and any other relevant documents to the ROC as well. So should we remember these responsibilities? Yes, you should remember these responsibilities. Now directors as agents. So let's understand this conceptually first. When I talk about directors as a position, these are working on behalf of the shareholders, right? So we have already discussed about agency as a concept, right? So we have to understand that directors are the agents of the company. That is, whatever director does, until and unless it is beyond or it is within the authority given to the director, the company is bound by it. That is, if I am the director of, say, one of my training institutions, then whatever I do, the company would be bound by it. Provided that I have acted within my authority, I have not acted beyond my authority, the company would be bound by it. Okay, so the directors are agents through whom the company acts. Like other agents, director incur no personal liability on contracts made by them on behalf of the company within the scope of their authority. What if I went beyond my authority? Say I was given the authority to sign checks up to, say, $1 million, but I issued a check for $2 million, then I would be personally liable. The company would not be liable. Okay. Now, authority of the board under statutory model articles. So the board is given their powers, authorities via company laws, other provisions in the company's articles. Sometimes if law is not made for that particular point, and any specific instructions. Now, constitution of the board. So good practices for the board to be made up of executive and non-executive directors. What do we mean by board? So the cabinet of the directors, the overall directors, when they are sitting together, that is called as board of directors. The combination of the overall directors is known as board of directors. Hope this is clear. Hope this is clear. Yes. Okay. Now, non-executive and executive directors. So executive directors, as the name suggests, they take responsibility for the execution of the day-to-day operations. So they take part in the overall day-to-day execution of the corporate objectives. But when I talk about the non-executive directors, they come once in a while and they are not part of the routine transactions. Their overall job is to guide the company towards a better corporate governance and towards management of the company. Okay. Now, managing director and chief executive officer. What? So why there's a slash and they are not separate? So you will generally see that every company either has a managing director or a CEO, or these two people are same. That is, you will never see a company where managing director is different, CEO is different for the same scope. That is, there could be a case that managing director is one, under that there are multiple CEOs for different businesses, but you will never see that there's a managing director for the overall company and there's a CEO for the overall company. As it is said that one kingdom cannot have two kings, right? So similarly, a single company cannot have two, which is managing director and CEO together. So that is why these two terms are used, at least one, only one term is used. So you will see that in America, you will majorly see that CEO term is used, right? You will never see managing director over there. In India, generally we use the term managing director. So managing director or CEO has actual implied authority for all commercial matters relating to the running of the business. This means that individuals dealing with the company can assume, unless they are on notice of any restriction, that the executive has authority to perform all those tasks which would usually be associated with a managing director. Now, how are directors appointed? Very, very important for your examination as well. The first directors, that is when the company is formed, the first directors will take appointment on the incorporation of the company by being named in the registration documents. That is, whosoever is mentioned as first directors in the registration documents, in the memorandum, in the articles, they would be called as the first directors of the company. Subsequent appointments will be made by whom? Who has the company's ownership? The shareholders. So subsequent appointments will be made in accordance with the company's constitution under the model articles. Appointment can be done by an ordinary resolution of the members. That is, ordinary resolution will be taken for the appointment of subsequent directors of the company. Okay. Okay. Now, who can be a director? So unless a person is disqualified, they can be a director. Generally, directors are individuals. Companies are prohibited from appointing corporate directors. The general rule is that directors need no special skills or qualification. That is, anybody could be a director. A minimum age of 16 years. In India, it is 18 years, but internationally, it is 16 years. No maximum age limit. In India, there's a maximum age limit of 65 years. After that, special resolutions are required. Under insolvency law, an undischarged bankrupt may not be director without the consent of the court. That is, undischarged insolvent, who has been declared as insolvent, but his liabilities has not been discharged, they cannot become director of a company unless the court permission has been given. Under the Company Directors Disqualification Act, a person may be disqualified by the court in the event of misconduct or unfitness. That is, court might decide that this person is not allowed to become director of any company. Generally, the people who are disqualified are the people who have done the corporate law related fraud in the past. Now, the company's constitution may restrict appointment or impose conditions also. That is, this person would be allowed to become a director only on this condition. Now, let's talk about the remuneration part. A formal and transparent procedure for developing policy on executive remuneration and determining director and senior management remuneration should be established. No director should be involved in deciding their own remuneration outcome. And this is the most important line. No director should be involved in deciding their own remuneration outcome. So, sir, for example, in India, we have Reliance Industries Limited. The managing director is Mukesh Ambani, sir. So he might not be deciding his own remuneration. Yes. Can any director be allowed to decide their own remuneration? No. In fact, a lot of times when the remuneration is being decided, that a specific individual has to be out of the meeting while their remuneration, while their performance review is going on, and that is why this is very, very important for all of us to understand. Hope this is clear. Hope this is clear. Hope this is clear. Please let me know. Hope this is clear. Please let me know in the chat box. I can read your chats. Okay. Okay. Hope this is clear. Yes. Now let's try to understand the remuneration point. Okay. So what is more important here is that remuneration should not be decided by the individual director for whom the remuneration is being decided. Okay, there's a ceiling also in India. There's a ceiling of say 11%. So all the directors together should not get a remuneration more than 11% of the book profit. But internationally, there's no such timeline, no such capping that has been given. Now, disclosure of service contracts. What is the service contract? Sir, I am a chartered accountant also. Okay, can this happen that I am the director of a company and the company needs say financial statement preparation services? Instead of hiring from outside, I tell them that I am also a chartered accountant. I provide the service to n number of companies. I will be happy to take up this assignment for this company also, but I will be doing a separate revenue arrangement, separate service contract, because I will be acting as a consultant along with my other team, right? I will not be acting in my individual capacity, but my firm could do this work. For that, I will be signing what? I will be signing a service contract that should be disclosed to the board, to the relevant people. So director service contract, a contract under which a director undertakes personally to perform services for the company, or the services which a director undertakes personally to perform are made available by a third party to the company. That is, the director or the representative of the directors are providing some independent service to the company. Okay, that should be disclosed. The definition applies to activities as a director or otherwise, that is in the capacity of an employee or consultant. It encompasses employment contracts, contract for services, and letters of appointment. A director's service contract must be available for inspection at the company's registered office. That is, every shareholder has the right to review this service contract as well. So is this fair? Yes, this is fair, because otherwise what might happen is everybody would be trying to take out the profits out of the company by naming their service contracts, and that is why they should be disclosed. Now, members' approval. The board will usually fix the terms of appointment of executive directors. However, if the contract is for more than 2 years, it must be approved by the ordinary resolution. That is, for all executive directors, if the contract is beyond 2 years, then it should be approved by an ordinary resolution. What if it is within 2 years? Then it could be approved by the board only. Okay. The proposed service contract must be available at the registered office for 15 days before the general meeting, and at the meeting itself it must be available. Now, voluntary vacation of office. Can director remove themselves from the office? Can director resign themselves from the office? Yes, they can resign from the office as well. A director usually holds an appointment until the term of office expires. The appointment will end sooner if the director voluntarily vacates it, or if the individual is lawfully removed. How they can be lawfully removed? Say they have been discharged, they have been disclosed as, they have been considered as insolvent, then they will be removed from their position as director. Resignation and retirement. So a director can resign at any time by giving notice to the company. Should you remember this? Yes. In public companies, all the directors retire at the first AGM of the company. They can offer themselves for reappointment. That is, at first AGM or at every AGM, the directors are retired, and then they'll have to offer themselves for reappointment. Okay. Now, annually, in public companies, 1/3 of the board retires each year at the AGM, so that over a 3-year period they will each have taken in turn, and they would have been presented themselves for reappointment. This is very, very important. So in public companies, all the directors retire at the first AGM, because first directors would be decided by the incorporation documents. So they will all be retired, and they'll have to offer themselves for reappointment, and the shareholders will decide who will continue, who will not continue. But for subsequent years, 1/3 of the directors would be called as rotational directors. That is, 1/3 would be retiring, and by this way, every 3 years, the whole director cabinet would be retiring at least once. Hope this is clear. Now, compulsory loss of office. Compulsory loss of office. What is this compulsory loss of office? Voluntary vacation of office means when director themselves are removing themselves. But compulsory loss of office, as in they'll have to compulsorily remove themselves as from the position of directors. A director's office automatically ceases on that of the director, of course, by the imposition of a disqualification order. That is, they have been disqualified, said they have been declared insolvent, on being declared bankrupt, on liquidation of the company, by a resolution of the board, by an ordinary resolution of the members. If any other provision automatically disqualifies the directors. Statutory disqualification, that is the legal disqualification, when they will be considered as legally disqualified. So a person convicted of an indictable offense relating to the promotion, formation, management, liquidation, or receivership of a company can be disqualified for up to 15 years. That is, if a director is involved in any of these activities, they will automatically be disqualified by law for 15 years to act as the director of any particular company. Okay. Now, removal by the shareholders. Regardless of anything in the company's constitution or a service contract, a director can be removed from office at any time by ordinary resolution of the members. This is also very, very important for all of us. Hope this is clear up to here. Hope this is clear up to here. Please tell me. Hope this is clear up to here. Please tell me. Yes, please confirm if this is clear up to here. Okay, okay. Yes, perfect. Now, general. A director who is removed before the expiry of a fixed term contract may have a claim for damages for breach. This is something that we have already discussed, right? Breach and damages. So this is also a contract, the contract that is happening between the director and the company. So if the director is being removed before their tenure, say they were supposed to be directors till 31st of October, but they have been removed on say 31st of August only. Now, can they claim for damages? Yes, they can file for damages. Okay, if a golden handshake is not disclosed and approved, it is voidable by the company. Okay, if the company negotiates a voluntary non-contractual payment to a director, what is this? If the company negotiates a voluntary non-contractual payment to a director, it must be disclosed to the members. What is this? This is like a severance package which is not disclosed to the company, not disclosed to the members. So if directors are offered any money which is not disclosed to the members, then it is not, then it is voidable by the company. Company can let it go. We have already discussed about void and voidable, right? Very, very important. Now, quasi partnerships. What are these quasi partnerships? Quasi partnerships. So quasi contracts are those contracts which are formed by law. Okay. So when I talk about quasi partnerships, here sometimes the director gets the power that if they are removed from the process, they might file for liquidation also. So that much power is given to the directors. Yes, sometimes that much power is given to the directors. That is, if they are not involved into the process, they might file for bankruptcy. They might file for winding up of the company, not bankruptcy, the winding up of the company. So director of a small private company who faces removal faces more than just a loss of job, being deprived of a legitimate expectation to be involved into the management of the company. In such circumstances, a director who is removed may be able to seek to have the company wound up or any shares bought back. That is, they might be required that the company should either be wound up or their shares should be bought back. Now, winding up. A shareholder of a company can petition the court to have it wound up on the grounds that it is just and equitable to do so. In one of the case laws, it was held that the removal from office of a shareholder director, that is the person who was a shareholder as well as the director of a company in a quasi partnership business, would give him grounds to seek winding up also. So can this happen in case of one person company also? It must happen in case of one person company, right? Because if I was the only director of the company and then I have been removed from the company, then the company should go for winding up, right? Now, fiduciary role. What is this fiduciary role? Fiduciary role is the financial role which has financial impact. So directors are in day-to-day control of the company. The shareholders give them access to its funds and trust them with inside information about its activities. So directors are in a fiduciary position, a position in which the company's members are obliged to put trust in them as far as finance is concerned. Now, their overall duty is therefore a general duty to act bona fide. What is bona fide? In good faith. In good faith, not with malicious intentions, for the benefit of the company as a whole. Okay. Now, directors who are legally and properly appointed are referred to as de jure directors. Duties may also be owed to the company by shadow directors. We are going to discuss it. Connected persons of the directors, we are going to discuss it. And de facto directors, we are going to discuss it after this. Okay, just after this, we are going to discuss about it. Now, what are shadow directors? What are shadow directors? What do you understand from the from this word? Shadow director. These are like sleeping partners. These are like sleeping partners. These are like sleeping partners in a partnership firm. We have discussed no sleeping partners. So similarly, there could be shadow directors who are not into the actual day-to-day business of the company, or who are actually not a director as far as the legal terms are considered, but they are acting as the director. So shadow director is a person who is not an acknowledged director of the company, but in accordance with whose wishes the board is habitually accustomed to act. The general duties of directors under Companies Act 2006 also applies to shadow directors as well. Now, connected persons. Who are these connected persons? These are the close relatives, like the close relatives. Okay. So, the connected person to a director means what? The director's parents, spouse, child, or sir, spouse or civil partner. Say they are co-living, right? Company, trust, a company in which the director alone or with others substantially controls the voting power, or a trust of which the director is a trustee or beneficiary, a business partner of the director or a connected person. These will be called as the connected person of the directors. So something that is restricted for a director, it might be restricted for the connected person also. It might happen, no, that if you remove me, I might name my brother as the next director of the company. I might be getting all the benefits again. So that way, the connected persons are also affected if if an action is being taken against the director of a company. Hope this is clear. Now, de facto directors. Now, de facto directors. So a de facto director is a person who has not been formally appointed as a director, but who performs a function which usually only would be discharged by a director. What is this? Can this happen? Yes. So in my case, I wanted to appoint one director. Okay. Now, this director was officially available to be appointed from the 1st of October, but I wanted them in my company from the 1st of September. So for this 1 month, whatever work they have done from 1st September to 30th September, they will be called as de facto director, because they are acting as the director, but they are not the actual directors. A de facto director owes the same duties to the company as a formally and properly appointed director as well. Okay. Hope this is clear. Hope this is clear. Hope this is clear. Hope this is clear. Please let me know. Hope this is clear. Please confirm me if there's any query or this is clear. Yes. Now we will take a 2 to 3 minutes break, because after this we are going to discuss about the duties of directors. One after another, we are going to discuss about a lot of duties, and once we complete this, the majority of the chapter would also get completed. So let's take a 2 to 3 minutes break. Then we will be moving further to the duties part. Okay, now let's come back. So now we are going to discuss about the fundamental duties. Okay, so now we are only left with the obligations and the duties part. Once we complete it, then our chapter will get completed. So first thing is act in accordance with the company's constitution. All of these points are being explained in detail just after this, but let's first of all understand it. A director must act in accordance with the company's constitution, that is whatever rules and regulations, whatever are the structures that is being framed inside a company, a director must follow that. Understood? Very, very understood. Promote the success of the company, that is whenever there's a choice, they should always work in the best interest of the company. They should always work in the best interest of the company. Whenever there's a choice, they should always choose the option which is in the best interest of the company. Exercise independent judgment. Exercise independent judgment, that is they should not merely rely on the data. Whatever information they get, they should also apply their internal judgment, the expert judgment, and then they should take a judgment and decision. Exercise reasonable care, that is they should not act negligently. They should be very, very careful whenever they run the business. Avoid conflict of interest. They should not get involved into any conflicting situation. For example, if the company needs some material and the material is being transferred from the company which is owned by the wife of this director and an independent party also, so they should look for the best interest of the company and not go or not be involved into any conflicting situation. Not accept benefits from third parties, that is they should not accept any bribe to favor any particular party. Declare interest in proposed transaction. For example, we discussed that if there is any interest in any of the company, any of the shares, any of the person, any of the company, then the director should disclose it to the relevant parties. So all of this. Now let's have a little detailed understanding about it. Duty to comply with constitution and use power for proper purpose, we have already discussed. So members can seek an injunction to prevent contracts being made in contravention of the company's constitution, provided the contract has not yet been made, and any contract which is not followed in these terms would be voidable. Now, the directors may have a civil liability to the company for their breach of duty and may have to compensate the company for losses incurred if they do not act in the direction given by the company or authority given by the company. Now, duty to promote the success of the company, that is they should act in the best interest of the company. So a director must act in such a way as he considers in good faith would be most likely to promote the success of the company. What if it does not? Then also it is fine, but they should be able to promote that based on the knowledge that was available back then. They took the judgment that was the best judgment for the company in their opinion. Okay. Now duty to exercise independent judgment, that is whatever information is being presented to them, they should analyze it independently and then they should take the judgment. So this duty imposes a positive obligation on directors to exercise judgment rather than merely leaving decisions to others and to do so independently. That is, they should be independently reviewing the information and then they should be taking the decision. Now, after this, let's discuss about duty to exercise reasonable care, skill and diligence. That is, they should not act negligently and they should be careful. They should take the reasonable care. They should use their best skills and they should be diligent when doing any particular task for the company. They should not be negligent. So director needs to exercise reasonable care, skill and diligence. This means the care, skill and diligence which would be exercised by a reasonably diligent person with the general knowledge, skill and experience which reasonably may be expected of a person carrying out such task would be expected from the directors also. Errors of judgment and commercial mistakes is normal and could be made by the directors as well. Now, duty to avoid conflicts of interest, that is they should avoid any situation which might create a conflict of interest. Like the example that I gave you, a director must avoid a situation in which he or she has or can have a direct or indirect interest which conflicts or may conflict with the interest of the company. In this particular case, if they select the company which is or if they select the company which is owned by the wife of the director, then they might get involved into a conflicting situation. This duty continues after the individual ceases to be a director in respect of information, contacts, assets. That is, this continues even after they ceases to be director, they stop to be a director. If not approved by the board, the general common law position is that transaction need to be approved or ratified by the ordinary resolution. That is, sometimes if they are confused whether it is a conflicting situation or not, they should take the ordinary resolution of the shareholders. Duty not to receive benefits from third parties. This is like the bribe. They should not accept the bribe. So director must not accept a benefit from a person other than the company or its representatives, associates in respect of being a director or doing or not doing something as a director. Say if some company pays you, that we pay you as a director, as an individual, we are paying you. We are not talking about the contractual terms of the company. But as an individual, it is being paid to a director that you take this 1 lakh rupees and you do not open a shop here or you do not open a showroom here. Now, if the company is doing this contract, it's fine. But if you as an individual is accepting this money without disclosing to the company and you do not take that decision, then it is a bribe. You should not accept this benefit. Then duty to declare an interest. If you are interested in any company, interested then if you are invested, if you are impacted by it, then it would have to be disclosed. Say some company is owned by your wife. If you have invested in shares of certain company and that company is coordinating or is collaborating with this particular company on which you are the director, you should disclose it to the relevant people. So the duty to declare an interest is again an extension of the duty to avoid conflicts. If a director knows or ought reasonably to know that he is directly or indirectly interested in a proposed transaction or arrangement with the company, he must declare it to the other directors as well. Now, let's talk about actions against directors. Directors may be made liable for breach of any of the foregoing duties. A member may initiate action on behalf of the companies against a director or other person who is in breach of duty, and a member or members may petition the court for relief against the company being run in a way which is unfairly prejudicial to their interest, that is, which is loss making to their interest. Okay. Now, fraudulent and wrongful trading, that is insider trading. What if director has done that? They might be asked to compensate the company for such loss and the relevant members also. There's a difference between fraudulent trading and wrongful trading. What is fraudulent trading? Any person who is a knowing party to a company being run with the intention of defrauding creditors can be ordered to contribute to the company's asset in winding up. That is called as fraudulent trading. But what is wrongful trading? Directors who continue running an ailing company at a time when they know or ought to be aware that there is no reasonable prospect of avoiding insolvent winding up can be ordered to contribute to its assets when it is liquidated. Fraudulent as in what? When you are running with the intention of defrauding the creditors. Wrongful trading is what? When you know that there's no reasonable possibility of reviving the company to a profitable situation or to avoid the insolvency, still you are running the company. So after that time, beyond that time, you will be required to you are required or you are being tagged as doing a wrongful trading, that is you are not doing trading as it is required. Now, members approval of substantial transactions, that is whenever the company enters into any substantial transactions. Now the substantial transaction depends on nationwide laws also, but whenever there's substantial transaction that is being entered into, the members approval needs to be taken. So a transfer of substantially valuable assets to or from a director, shadow director or connected person requires the prior approval of the members by ordinary resolution. A transaction involves substantial value. Here it is given if it involves at least £100,000 or 10% of the company's net asset. So if there is an acquisition of such an asset or disposal of such an asset, it needs to be approved by the shareholders via board, via ordinary resolution. And this is an excellent spot because a lot of times students mention special resolution here, which is not true. Yes. Hope this is clear. Hope this is clear. Now loans to directors. Sir, can you take loan as a director? Yes, you can take loan as a director. That is allowed, but there are certain conditions. A company cannot make a loan to a director of the company or its holding company. What is this? Cannot make loan. Cannot give a loan to the director or its holding company. Oh, okay. Guarantee the debts of a director. That is, if director has taken any debt, the company cannot guarantee it. So, sir, what you told us that company can give loans to a director is wrong. Yes, I agree. I told you wrong. A company can never give any loan to a director. Company can never give any loan to a holding company. A company cannot guarantee any loan which is taken by the directors of the company or the holding company. Provides any security in connection with the loan. So a company's car cannot be given as a security against the loan that is being taken by the director or the holding company. Oh my God, very, very important. Now, the exception to this rule is if the transaction has been approved by ordinary resolution. That is, sir, you were not wrong. The director can take loan, but it should be approved by the ordinary resolution of the members of the holding company. This is very, very important. Okay. So let us summarize. If any loan is to be taken by the directors, it can be taken only if it is approved by the shareholders of the company. Okay. If the loan is given to a holding company, it should be approved by the shareholders of our company. Yes. Plus, in case of holding company, if the loan is to be given to the holding company, it should also be approved by the members of the holding company. That is also very, very important here. Hope this is clear. If the company is a public company or a member of a group containing a public company, the prohibition on loans also includes credit transaction, that is you might not enter into any credit transaction, quasi loan where the company pays the debtor's personal debts, and transactions in favor of connected person of the debtor, that is also not allowed. Hope this is clear. Now company accounts. So directors are responsible for a company's keeping proper accounts and producing and presenting annual financial reports. That is something that we have already discussed in the earlier stage only. Directors relief from liability for breach of duty. So the company's constitution cannot give directors blanket exemption from liability for breach of duty. That is, the company's constitution can never say that directors will not be considered as responsible even if they have done breach of duty. No, that is a legal requirement that if they have done breach of duty, they'll have to compensate the company for the losses. And with this, we have properly completed this particular syllabus. Hope you have understood it. Just in case if you have any doubts, please let me know in the chat box. Hope you have understood it. Just in case if you have any doubts, please feel free to let me know in the chat box. With this, we have particularly completed this chapter. Now see you in the next chapter. Thank you so much. Hello everybody, hope you all are doing really well. This is CS Subrita Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, today I welcome you all to this session where we are going to cover chapter number 16 from your syllabus. Now this chapter is one of the shortest chapter. If you talk about the length of the chapter, this is one of the shortest chapter from your syllabus. But what I'll suggest you here is, even if this chapter is not directly asked in the descriptive part, this chapter might be asked in the MCQ part, because this chapter might not have very big provisions but definitely has a small provisions that creates a lot of value in your education, and you have to complete the understanding of this particular chapter to understand about the Companies Act 2006 in detail. So my dear friends, the name of this chapter is other company officers, and it discusses about three major headings. One is company secretary, then it talks about company accounts, and then it talks about the auditors. Now my dear friends, when I talk about company secretary, see, this chapter is very short, so it will take very less time for us to complete, but what you have to understand here is that this chapter also creates the basis for the Companies Act officers as well as the duties. So that is why this becomes little important for you. Now my dear friends, when we talk about the company secretary, we are going to discuss about the roles of company secretary, the duties of company secretary, authorities of so these are similar words only, right? Role, duties, authority. No, role means what are their responsibilities, okay? Duties, what they have to do, what they have to be bound by. Authority, what power do they have, and qualification, that is who can become a company secretary. So naturally a company secretary can become a company secretary, but who will be called as a company secretary, that is important, okay? Then company accounts. When I talk about company accounts, inside this we are going to discuss about the accounting records that a company needs to maintain, annual accounts and reports, what it means and when it needs to be furnished, small and micro companies, some special provisions for small and micro companies. Then the last heading would be of auditors. Here we are going to discuss about the compulsory officers, we are going to discuss about the appointment of auditors, the process for appointment, the eligibility, the remuneration, who will be deciding what could be the remuneration, rights and duties of the auditors. So do they have rights? Yes. Do they have duties? Yes. Termination of appointment through removal, through resignation, then auditors liability also, and whether there is any capping, that also I'll tell you in bonus, okay? So these are very important points that we are going to cover here. So let's start with the first one, which is company secretary. My dear friends, when I talk about company secretary, first of all let's discuss about, let me check it here, some error, okay, let me refresh. Okay, it's asking me to log in again. Don't worry, I'm just pausing the lecture. Yes, my dear friends, so now it has been fixed. Thank you so much for your patience. So my dear friends, we were discussing about company secretary. Now if I tell you about a company secretary, so tell me one thing, did you notice in your family as well that there are certain people who are involved into the planning, the strategic planning of the family, that what kind of decisions would be taken, where the family would go, what direction the family, what direction and values would the family follow, they take that decision, maybe grandfather, right? Grandfather and grandmother. Then there are certain people who are generally at the execution level, who follows that strategy, applies it at the ground level, right? There are certain people who does the accounting, they keep accounting of everything, that is how much money is coming in, how much money is going out. Similarly, there are certain people who takes part in the governance, right? What they do is their job is to ensure that everything is done effectively, everything is done as per the relevant laws and regulations. That is for the compliance purpose, the governance purpose, the secretarial purpose, right? So those people are called as company secretary in a company. Okay, now the role of the company secretary is to act as what? Principal administrative officer. My dear friends, if you write something else here, for example, this question is asked and you write something else here, will you get full marks? No, you will not get full marks. Why? Because certain keywords are very, very important here, like principal administrative officer of a company. Now, historically, every company was required to have a formally appointed and identified secretary, which is generally called as company secretary. Companies Act 2006 now requires this only for public companies. So, sir, here comes one MCQ. Can a private company be exempted from the appointment, from the requirement of appointment of a company secretary? Yes, they are exempted. Okay, private companies can therefore choose whether they need a company secretary, and it is quite common for small private companies not to have a company secretary at all. Very important pointer, because this is a yes and no answer, right? Now, the precise role of the company secretary will be established by the director, who will decide the roles, responsibilities, the scope of the company secretary, the directors. But the company secretary can be regarded as the principal person to whom official requests and notices may be addressed. So if ROC wants to address some notice to the company, whom they will address it to? The registered company secretary. Okay, this is very, very important. Now let's talk about the duties. My dear friends, do you need to remember these duties? Yes, you need to remember these duties, but I'll help you explain, I'll help you understand these duties better. So the law does not specify any particular duties for the secretary, but they usually include. So sir, should we learn it word by word? No, because these are the example based duties. These are not the exact duties that they need to perform. These are example based, they could be changed. Now, maintaining the company's statutory books. Statutory books does not mean financial statements also. Statutory books related to secretarial or governance related documents. Okay, so say whether annual returns have been filed or not. Not the auditing of annual financial statements, whether annual financial statements, the audited financial statements have been filed or not, whether annual returns have been filed or not, whether the particular returns have been filed or not. Filing returns with the registrar, organizing and attending members and directors meeting, organizing the meetings, attending the directors meeting. Sometimes their secretary might take the notes as well, minutes of meeting as well, maintaining minutes like we discussed, monitoring the company's compliances with all aspects of law and governance, advising the board about matters of law regulation, dealing with share transfer, if there is any share transfer that we have discussed in the previous chapters, so that documentation should also be kept taken care of by the company secretaries, signing documents as required by law. So for example, annual financial statements needs to be signed by the company secretaries also in certain jurisdictions, so they will be signing that. Okay, now in larger organizations, the company secretary will be supported by a department of assistants also. Like I told you that company secretary might not sit to take the minutes of meeting, their assistant might do. Okay, now directors of private companies opting not to have a company secretary should determine who will carry out those tasks. First of all, you have to determine whether those tasks are required or not. Okay, I hope this is clear. Now, company secretary is an officer of the company. Are they director? No. Are they owner? No. They are called as officer of the company. So, in companies like you will see a lot of times it will be written, it is applicable, this provision is applicable to directors or officers of the company. So, officers includes KMPs. One of the KMP, key managerial personnel, is the company secretary also. I hope this is clear. Okay. Now, authority, their powers. Let's talk about their authority, their powers. So, the secretary has actual implied authority to contract as an agent of the company. That is, they have the power that they can enter into a valid contract, a legal contract on behalf of the company for administrative task. Okay, if acting with an actual implied or apparent authority, the secretary will bind the firm even if the position is being abused. That is, even if they have moved beyond their powers to enter into the contract, but if it is in the normal course, then they will be binding the company if it is beyond, if it is within their authority. Okay, now the leading case, so even if they are not acting in the best interest of the company, but they are within their authority, so will that agreement be valid? Yes, that agreement, that contract will be valid. Now the leading case on the matter is Panorama Developments Limited versus Fidelis Furnishing Fabrics. Do you need to remember it? Definitely not. It's certainly entitled to sign contracts connected with the administrative side of a company's affairs. So company secretaries are authorized to sign on behalf of the company's administrative nature of works. Okay, hope this is clear. Now let's talk about the qualification, and this is the last part for the company secretary that we need to learn. So who could be company secretary? So in India, I'll tell you, there is one institute called ICSI. the Institute of Company Secretaries of India. You have to be a member of that to become company secretary. So the functions of the secretary have grown over the years as businesses have become more complex. Company secretaries in public companies must have special qualifications or experience unlike other company directors. Section 273 of Companies Act 2006 requires the secretary of a public company to be one of the following: a qualified member of any of a list of relevant professional bodies, like I told you, ICSI in India or ACCA, or the Institute of Chartered Secretaries and Administrators, ICSA. Okay, this is international organization which is a specialist body for company secretaries. A qualified solicitor or barrister, lawyer, advocate, right? A person who by virtue of holding any other position or being a member of any other body appears to the directors to be capable of discharging the function of secretary. So in certain jurisdictions, the ACC members are also allowed to act as the secretary. A public company secretary for at least 3 out of the past 5 years. A public company secretary for at least 3 out of the past 5 years. If they have done that, then they can become company secretaries. So should we remember this? Yes, this you should remember. It could be asked in the MCQ format. Okay. Now it is the duty of the directors of a public company to make sure that the secretary appears to them to have the requisite knowledge and experience to discharge the functions of secretary. That it appears to the director. It is the duty of the directors to make sure that the secretary appears to directors, to the general public, to the registrar, everybody, as someone having the requisite knowledge and experience to discharge those duties. With this, we have completed the first part, which is of company secretaries. Hope this is clear. Now let's come to the second part, accounting records. Let's talk about the accounting records. So every company must keep accounting records sufficient to show, to the extent of sufficient to show and explain the company's transaction and to disclose the company's financial position at any time. Sir, at year end? No, at any time. Okay, that is, accounting records should be maintained in such a way that at any given point of time, at any reasonable given point of time, the company could show that what transaction it has entered into, what position it is in. These records must have sufficient information to enable the directors to make sure that the accounts can be prepared in accordance with Companies Act 2006 and contain day-to-day entries of all sums of money received and expended. Okay. Now the accounting records are likely to include what? So this is not financial statements. You cannot say balance sheet. You cannot say income statement. You cannot say statement of changes in equity. You cannot say cash flow statement. See here, cash book, petty cash book, and bank statements. Then details of payments received and invoices and credit notes issued. Now, so these are generally the ledgers that we talk about, right? So yes, you have to keep that handy. Okay. Suppliers invoices and credit notes received, that is also very, very important. Okay. Then stock records and stock taking records and schedules of fixed assets also. Now breach of section 386, which is to maintain these records, is a criminal offense. The records are part of the statutory books that are to be maintained by the relevant people at the registered office. So these are those statutory books that needs to be maintained by the company secretary. Some part of it yes, some part of it no. Say you cannot expect the company secretary to maintain cash book, but you will expect them to maintain a book where all the laws and regulations and compliance reporting are done. Now let's talk about something else, which is annual accounts and reports. Let's talk about something else, which is annual accounts and reports. First of all, annual accounts and report. Who audited? Auditor audited. Who submits it to the ROC? So it is submitted to the ROC by the company secretary. Okay. Now the directors must produce accounts for the company for each financial year. Who will submit it? The company secretary. These accounts must comprise a balance sheet as at the end of the financial year and a profit and loss account also. They must give a true and fair view, what we discuss in audit. See, true and fair view is an audit word. You do not need to understand it here. Okay. The directors must also prepare a director's report for each financial year. Director's report as in their statement, director's responsibility statement. Okay. This is given by section 415. Do you need to remember the section? No. On the development, performance and position of the company and confirming that all proper communication of information has been made to the auditor. The directors of a public company must lay as in present the annual accounts and reports before the members in general meetings. So sir, all of these reports that we are talking about, the annual reports, they needs to be published, they need to be presented in the annual general meeting of the company as well. So yes, they need to be presented at the annual general meeting of the company as well. The company must file the accounts and reports with the registrar also, and I'll tell you what is not written over here. These reports are authorized by, approved by, attested by the company secretaries also. Even there's a possibility that some directors might not be attesting it, but a company secretary is always attesting it. Okay. Now, under section 463, a director is liable to compensate the company for any loss suffered as a result of any true or misleading statement in the report. So, directors are also liable, okay, if it was found misleading. Now, let's talk about a very special point here, which is regarding small and micro companies. Please read it with me. Although all limited companies must file annual accounts with Companies House every year. Companies House is like MCA here, registrar here, okay. Every year, small companies have for many years been able to file abbreviated annual accounts. These do not usually needs to be audited. Abbreviated as in these are self-prepared, self-attested. Okay, they small companies are not required to get themselves audited unless it is required by national laws. Okay, for example, in India, every limited company, every type of company needs to get their accounts audited, but in certain jurisdictions they are not required. That is called as abbreviated financial statements. A company is a small or micro entity if it meets at least two of the following criteria. Small or micro, sir, medium is not there. No, a lot of people write MSME because they use their Indian knowledge and they write MSME. That is not the right word. MSME is not the right word. You have to write a small and micro. If it meets any of the two criteria, at least two criteria, what is it? Net turnover not more than, in case of small company, 10.2 million pounds. In case of micro, 632,000 million pounds. So, sir, which one is smaller? Micro is smaller, small is here. Okay. Balance sheet total, that is the total of balance sheet, the total of assets and liabilities, or the total of assets or liabilities, not and, not more than. So, sir, what if it is exactly equal? So, it will be covered then, okay. It should not be more than, okay. So, $5.1 million and $360,000. Should you remember this? Yes, you have to remember this. Let me tell you, you have to remember this. This could be asked in the MCQs. Average number of employees not more than 50, and in case of micro, 10. So, why is this requirement there? See, when you talk about a company size, employee size is very important because you are catering to multiple families also, you are catering to the GDP also, you are catering to the average salary also. So, they have to maintain it. If you are employing say 100 plus people, you cannot call yourself a small company just because your revenue is low, okay. The minimum compulsory filing requirements are summarized as below. So, a small company has to file balance sheet, profit and loss, notes to accounts, directors report, whatever is their turnover. Auditor's report is something that is optional. Now, if I talk about micro, you only have to file the balance sheet, profit and loss requirement is not there, notes to accounts requirement is not there, director's report requirement is not there, and auditor's report requirement is not there. You can file it optionally. My dear friends, this is one of the most important slides of this particular chapter because this slide has a lot of questions into it. This slide has certain details that you might miss also, that you might mark incorrect also, like the amounts that are there. So, please take a screenshot of this slide. Please remember the word, each and every word of this particular slide, okay. Now, let's talk about compulsory officers. Now, my dear friends, the external statutory auditor is an independent third party. We have already discussed about it. Who is auditor? Auditor is the external independent party. Say, in my case, my firm is audited by say one of the big fours. Now, that big four is an external audit party. They come say once a year or every quarter. In case of limited review, they generate their report, they submit it to the shareholders, and then they go. So, the external statutory auditor is an independent third party who attests the accuracy of information provided by management to investors. An auditor cannot be an employee of the company whose accounts are subject to audit because they needs to be independent. And more of this we will be discussing in AA. And my dear friends, when you come to AA, you should definitely remember me because I would tell you that when you come to AA, you will love the audit subjects. Do not be worried about it. Do not think that you might not be able to catch up audit. It's a new subject. It's a very interesting subject, okay. So, who will be teaching it? I'll be teaching it. Don't worry about it, okay. Now, but is included as an officer of the company in several places. So, if there's a question that whether external auditors, or can external auditor be considered as officer of the company? So, yes, they can be considered as an officer of the company, but not everywhere. They could be in certain provisions. Every company must appoint an auditor except for dormant companies. What are dormant companies? Those which do not trade, which are not listed, does not mean that. Trade here means business, which are not involved into the active business, who are not getting into any significant accounting transaction. So, what if they are just paying their registration fees every year? That is not significant accounting transaction. That is not entered into trading. That is, they are not into the active business. Small and micro companies which qualify for audit exemption, they are also free from the requirement of auditing. To qualify, such companies must not be a public company and meet the small or micro size criteria. What is the criteria? What we have discussed in the last slide. Now let's talk about the appointment. So directors got appointed. A company's first auditors may be appointed by the directors anytime before the first annual general meeting of a public company and the first circulation of annual accounts to the members of a private company. That is in case of public company before the first AGM, and in case of private company before the circulation of first annual accounts, the directors have to hire one auditor, has to appoint one auditor. So what is the right word? Appointment. Okay. Directors may also appoint auditors to fill a casual vacancy during the year. What is casual vacancy? Say the auditor has died. Now this is a casual vacancy. The auditor has resigned. That is a casual vacancy. Thereafter, auditors of a public company are appointed by ordinary resolution, usually at the AGM. That is, after the first auditors, every year the auditor would be assigned or would be appointed by the general at the general meeting via ordinary resolution. That is the majority voting, and that would be done at the AGM. Okay. Now the appointment must be made within the 28 days following the circulation of the annual accounts for the next year. The auditors, so sir, it is done in advance. Yes, it is done in advance. For the next year, the AGM hires the auditor, they appoints the auditor this year. The auditor's term of office runs until the end of the meeting at which a new appointment should be made, or the next 28-day period for appointment. That is up to the time the next auditors are hired, appointed, or up to 28 days in case of private companies, the office of this director, this auditor continues. Now default appointments as in without doing anything the appointment would be done. If the directors and members of a company fail to appoint an auditor, the directors must give notice to the Secretary of State, who has power to make an appointment himself. That is, if the directors fails to make the appointment, who will write this letter? The directors must give notice to the secretary, and then the Secretary of the State would be hiring the auditor, would be appointing the auditor for this particular company. Okay. For a private company, the previous year auditors is deemed reappointed by default, just in case if you are not able to replace them, then or reappoint them, then they will be continuing their office. Okay. Or unless the company's articles provide otherwise, or there's a specific resolution that has been passed that this person should not be appointed as auditor, they will be considered as an auditor. Minority members representing 5% of a private company's total voting rights can block automatic reappointment. That is, if minimum 5% of the shareholders, in case of a private company, they do not want this auditor to be hired again, they can block that this person will not be reappointed. Okay, hope this is clear. Now let's talk about the eligibility. My dear friends, this is very, very important. Let me show you what is left after this. Eligibility, then remuneration is there. Eligibility, then remuneration. Oh, I am not able to move forward with this. Let me check. Today I think ACC Study Hub is doing some issue. Okay, no worries. No worries. Okay. See, remuneration, rights and duties, termination of appointment, and auditor's liability. So let's come to this eligibility. Okay, let's come to this eligibility. My dear friends, when I talk about eligibility, we have to talk about the qualification, we have to talk about ineligibility also, both. Qualification, that is, to be eligible for appointment, a person must be a member of a recognized supervisory body which is called as RSB. Sir, is ACCA one of the RSB? Yes. So once we qualify as an ACCA, then we become member of the ACCA body, not affiliate, member of the ACCA body. Can we also be hired as an external auditor? Yes. Okay. Now, essentially in the UK, this means being a member of either ACCA LW, okay, ICAS, ICAI and ACCA, the Association of Chartered Certified Accountants, or the Institute of Chartered Accountants in Ireland or Scotland, or in England and Wales. Okay. Ineligibility. What is the ineligibility? An employee of the company. We discussed this should be independent. So if you are an employee of the company, you cannot become the auditor. A business partner or employee of the company. That is, there's one employee. The business partner of this particular employee or the employee of this employee cannot become. Why? Because they will not be independent, right? So employee cannot become, and of this employee, whosoever is the partner or employee of this particular employee, they can also not become the auditor of the company, external auditor of the company. The rule is clearly designed to help ensure the independence of auditor. However, the following person can be auditors in law. Shareholders can be auditors? Yes. Debenture holders can be auditors? Yes. People with others financial involvement could be auditors, like the suppliers? Yes. Relatives and friends of the directors, they can also. And this is very important point. A lot of people get confused here that relatives and friends of the auditors can become the auditor or not. Yes, they can become. They should not be close relatives. They should not be immediate family members. An employee of an employee etc. of the company, although unlikely it is possible to have two jobs, one is the company's accountants and another as the employee of the audit firm. Now the above shows that the law alone is inadequate to ensure independence. You have to check whether this is independence of mind or not. See, somebody could be my best friend and they might be independent legally, but since they are my best friends, they might not be independent mentally. So what we have to feel is, what we have to evaluate is that whether the person we are about to appoint as auditors, whether they are independent in mind also, or whether they are just independent in appearance. Very, very important point. Now remuneration. The company in general meeting sets the remuneration of the auditor or determines the method by which it will be fixed. Okay. So sir, this is approved by the shareholders? Yes. Now let's talk about rights and duties. See, rights is very clear. If you are acting as an auditor, you should have access to all the books of accounts. You should have access to, you should have unrestricted access to people within the organization. You should be able to get more information if required, right? So to have access at all times to the company's books, to require from the company's officers such information and explanations as considered necessary, to receive notice of and attend general meeting also. Why sir? So that their reports cannot be misinterpreted, and if there is any question of the shareholders or the stakeholders on their report, they could ask it and they can answer it immediately. Okay. So important to remember, yes, this could be asked in the descriptive format also. Now duties: to report on the annual accounts, that is duty, to report on the annual accounts. To prepare a report which expresses an opinion on whether the accounts give a true and fair view or not. So what is the meaning of this true and fair view? See, this is something that is covered in audit, but if I have to tell you in very simple language, true and fair means whether it shows the correct particulars, correct descriptions, correct information or not, plus it is fair, that is whether this is substance over the form, whether this is following substance over the form that you have discussed in FA. Now to state any reservations on audit opinions, that is if there is any reservation that this audit opinion is only for the purpose of say banking, or it's only for the purpose of say Companies Act 2006, then that should also be mentioned. To report on other matters is specified by statute, that is law. So for example, in India there is a CARO reporting that is done. Now that is not part of your syllabus, so I am not able to explain it here, but CARO reporting is there, which is for India specific. In UK there might be some specific reporting, so to report according to that. This is again the second most important slide of the entire chapter, because this is also something that is very, very important for you. Okay, then after this, termination of appointment. So termination can arise through resignation of auditor, resignation or removal of the auditor by the members, like we have discussed. Now in case of resignation, auditor may resign their office by written notice also, delivered to the company's registered office. Do they need to submit it to the MCA or the corporate house, the company house? No. They must also attach a statement of any circumstances relevant to their resignation. That is, if they are resigning, they are themselves leaving, no? So they have to mention one statement of circumstances, that is why they are resigning. Okay, must attach. This is mandatory. If they wish, the auditors can requisition a general meeting to explain the circumstances. That is, they can require that a general meeting be held where they will be explaining the reasons. The above procedure applies both to resignation during the year and to refusal to accept reappointment at the AGM. That is, if the company's shareholders are offering you reappointment and you do not want to continue, then also you have to give this statement. Now removal by ordinary resolution, removal by members, that is members do not want you to continue, so they are removing you by ordinary resolution. So removal or replacement of an auditor before the term of office expires by ordinary resolutions of the members. Can they remove? So yes, with a special notice of 28 days given by the proposers of the resolution to the company. That is, within by giving notice of 28 days, an auditor could be removed. Okay. Now what is more important here is, the auditor has the same rights as for resignation above. That is, they can call for AGM, they can give a statement of circumstances, and a similar duty to make and deliver a statement of circumstances. Okay, now let's talk about auditors' liability. Civil liability for misleading statements and advice, and criminal liability for misleading, false or deceptive details in auditor's report. So what is the difference between these two? Let me explain. See, let's discuss it. That auditor wanted to give one information, okay, but what they have done is they have given misleading statements, but this is through negligence. They were not aware about it, that what they are giving is misleading. Okay, and second cases where they were aware about it and they still gave it. Now in case of in the first case, they will only have to face civil liability, that is, they'll have to pay the damages. But in the second case, the criminal case, what they have to do is they might be prosecuted as well. So auditors owe a duty of care to parties who they can foresee relying upon their statements. This includes a duty to the company as a whole to produce accurate reports and advice, and there could be civil claims on them. Okay, now criminal liability. So section 507, sir, do we need to remember this word by word? No. See, this is all part of the audit. So this subject is giving you a basic understanding about how audit as a subject would be. And believe me, after law, you should go for FR and AA. That should be the best combo that you should appear for if you have not appeared for FR yet. Now, Section 507 Companies Act 2006 creates a new criminal offence of recklessly or knowingly including misleading, false or deceptive details in auditor's report. A person convicted of this offence may be fined but not imprisoned. That is they may be fined but not imprisoned. No, they cannot be imprisoned. There has been much speculation in business and legal circles about how far the courts may go in convicting an auditor of having acted recklessly, but who believe they acted honestly and in good faith. This has yet to be tested in the courts. There is concern in the professional community that Section 507 may encourage auditors to adopt a defensive, risk-averse approach, relying less on professional judgment and more on a strict interpretation of the law. It remains to be seen what the effect will be. That is, as of now, despite being a criminal offence, it has been mentioned that you cannot prosecute the auditor, otherwise auditor will be very, very careful and they might not be able to make any judgments. Okay. Hope this is clear. Now, with this, we have completed this entire chapter, and now we will be meeting to complete the next few chapters after this. But I would strongly request you that you please read the ACC study up before we continue with the next chapter, because those are very, very critical. I hope you have understood this. Thank you so much. Just in case if you face any trouble, please feel free to let me know. Thank you. Hello everybody, very, very good evening. Hope you all are doing really, really well. So today we are going to cover chapter number 17 from your syllabus, which is about company meetings. Now my dear friends, this chapter becomes important for you because there are a lot of specific details that you will need to remember from this chapter. It's not a very tough chapter, it's not a very long chapter, but it is definitely one of the important chapters. And why do I say that? Because this chapter is going to tell you about company meetings, and it is also going to require that you remember a lot of concepts, and that is why it is going to be very, very important for you. Okay, now let's quickly start with the discussion today. So chapter number 17 talks about company meetings and resolutions. Somewhat we have discussed about AGM, general meetings, we have discussed about special resolutions, ordinary resolutions also, but here we will discuss all of them in detail, and we are going to take examples for all of them as well. Okay, so now let's discuss about first thing, which is communication with shareholders. My dear friends, directors, like we have previously discussed, are just the employees of the company. They are the representative of the shareholders who are bestowed upon the responsibility to run the company, right? That is true. Now what is more important to understand over here is that this particular requirement also comes up with a requirement that the directors or the people who are working on behalf of the shareholders, they should meet with the shareholders at least once a year. There could be more meetings that we will be discussing about, but at least once a year they should report that what transactions they have entered into, what is the financial condition of the company, what are the significant matters that should be made aware to the shareholders. Now that is what is the requirement of this particular heading, which is communication with shareholders. So the day-to-day management of a company is delegated to the directors. That we have discussed earlier only. The shareholders take no part in their capacity as members. However, for certain items we have discussed that shareholders approves it, right, in running it. They have no apparent authority to make commitments for the firm because that particular responsibility is being given to the directors. Now, the Companies Act recognizes this and requires that subject to private company deregulation, that is wherever it has been specifically mentioned that it is not applicable to a private company, all companies, every company should hold periodic meetings with the shareholding body, that is the general meetings that we have discussed about. The directors' stewardship of the company, stewardship as in that is they are managing the assets of the shareholders, right? Stewardship of the company and its assets should be formally reported to the shareholders for approval at annual general meeting. Now this annual general meeting is the meeting that is conducted every year at least once, right? If changes are to be made to the rights of a particular class of shareholders, they should be consulted as a group at a class meeting. What is this class meeting? Although we will discuss about each one of them in a little more detail just in this chapter only, but let me tell you, class meeting is when a particular class of shareholder has a meeting, that is called as class meeting. Okay, so we have discussed about ordinary meeting, we have discussed about a little about the AGM, we have discussed about the class meetings, and the fourth one is important long-term decisions should be made only with the approval of the members via resolutions. Now this could be an ordinary resolution, this could be a special resolution also. Okay, now in order for the company to meet its responsibilities to shareholders and stakeholders, the board should ensure effective engagement with and encourage participation from these parties. Okay, now let's discuss about annual general meeting. As the name suggests, this is conducted once a year, okay, where every kind of shareholder comes. The auditors are also required to represent themselves, the directors are also required to represent themselves, auditors should also be present, right? Now general meeting is a meeting of the shareholders as opposed to a board meeting which is only of the directors, the board of directors, right? Now a public company must and a private company may, that is, it is the mandatory requirement for a public company to hold one AGM. This chapter is very small, will not take much of the time, will be finished somewhere between 25 to 30 minutes, but what is more important is the content of it. You will need to remember all of it. Until and unless I tell you that you do not need to remember this point, you need to remember every point, okay? Now a public company must and a private company may, so it is the mandatory requirement placed on a public company, whereas when I talk about a private company, it is not the mandatory requirement, okay? Now at which the directors report on the company's performance and plans, the board should use the AGM to communicate with investors and to encourage their participation also. Now let's talk about general meetings. Let's talk about general meetings. What are general meetings? General meetings are the meetings which is not an annual general meeting but is a meeting of the shareholders. So generally general meetings, or which are also called as ordinary general meetings, are all meetings of the shareholders other than the AGM, are all meetings of the shareholders, that is these are the meetings of the shareholders but other than AGM. These may be held at any time should special circumstances arise. For example, if any director needs to be removed, if any director needs to be hired, these meetings would be conducted anytime. AGM is generally conducted once every year, okay? So is it all that is required to be known here? Yes. Now let's talk about the class meeting. Let's talk about the class meeting. So class meeting is a meeting for shareholders holding a particular class of shares, right, that we have discussed. Mostly these situations arise which affect the rights attached to a particular share. Say there's a differential voting right share that has been there, and there is some meeting only where only these differential voting rights are needs to be discussed, then a class meeting could be called upon. Now comparison, this is very important. So can this answer be asked in the descriptive format also? Yes, this answer could be asked in the descriptive format also. Now let's talk about types of meeting that is covered over here. AGM is there, general meeting is there, class meeting is there, okay? When I talk about AGM, so the frequency is first AGM within 18 months of incorporation, subsequent AGMs each calendar year. See, first AGM within 18 months of incorporation. So if the company has been incorporated on say 1st of December, the year end being December, the first AGM needs to be done within 18 months of incorporation, that is from 1st December to 18 months. So for 18 months from 1st December. So the year ending, the first year ending would be 31st December of that particular year. We do not need to conduct any AGM for that. No, you do not need to conduct any AGM for it. First AGM, 18 months is the time, okay? Now for subsequent AGMs each calendar year should have one subsequent AGM, that is for each subsequent year there should be one AGM for each calendar year, not financial year, no, calendar year, January to December. Interval between meetings must not exceed 15 months, 12 months financial year plus 3 months for holding AGM, that is after one meeting has been conducted, the next meeting should be conducted within 15 months from that particular meeting, okay? Hope this is clear, okay? Now agenda for AGM is set by the directors. It could be appointment, it could be appointment, reappointment, approval, ratification related to appointment of directors, appointment of auditors, appointment of secretarial auditors. Okay, so there was some background noise which has been fixed now. So agenda is set by the directors. It could be to appoint, like we have discussed, it could be to appoint or reappoint directors, to reappoint auditors, to do the secretarial work, to rectify the transactions. Now the notice is to be given via clear 21 days. Notice can be waived if all members with voting rights agree to a shorter notice, that is even if the notice period is say that is given is say 7 days, and if everybody who needs to vote they have agreed, then it could be a shorter one, otherwise 21 days clear notice should be given, okay? And articles could also specify longer period, that is there could be a company which says that at least 40 days of notice could be given, but articles have to mention it. Now power to call, so the board of directors under the model articles have been given the power to call the AGM. Now general meeting, so a shareholder can call AGM? No, the board of directors could call. Now let's talk about general meeting including optional AGMs of private companies. So whatever we are going to discuss now, this is applicable to general meeting, that is ordinary shareholder meeting, as well as to the AGM of private companies. For the AGM of private companies, the above rules do not apply. Now, when it is called upon, so the frequency whenever business arises which requires the consideration of the members, so there is no fixed period. Okay. Agenda. Notice of the meeting will state the purpose for which it has been called. Okay. Now, notice 41 days. Notice can be waived with the agreement of holders of 95% voting rights, not 100%. In case of AGM, there should be 100% voting rights, but here 95% voting rights could waive the requirement of notice. But sir, waive as in increase or decrease? So this is waive, complete waive, not increase or decrease the tenure. Okay. Now, in case of 90%, via 90% voting rights in private companies or 95% of total voting rights, it may be increased also. The notice period could be increased also. Now, who sets the agenda? The board of directors. The board of directors has the power to call the meeting and set the agenda also. Members holding 10% of the shares with voting rights, unless for a private company more than 12 months has elapsed since the last general meeting. What is the meaning of this? The members holding 10% of the shares could also call one ordinary general meeting or AGM. In case of private companies, they could also call it. Okay. Now, let's talk about class meeting. Okay. Let's talk about class meeting. When I talk about class meeting, so whenever business arises requiring consideration of a particular class of shareholders, then class meeting could be held. Notice of the meeting will state its purpose, so definitely the agenda would be set in the notice only. Notice is 14 days. Notice can be waived with agreement of holders of 95%. Sir, should we remember this 90%, 95%? Yes. The board of directors failing which the court will be deciding or will be doing what? Will be calling this particular meeting. Now let's talk about resolutions. When I talk about ordinary resolution is passed by simple majority. That is, say there were 100 members in the company. Okay, 80 attended the meeting. 100 members, 80 attended the meeting either directly or via proxy. Okay, 100 members were there. Either 80 attended directly or via proxy. Now there was a thing that was put to a vote. Okay, 41% voted in favor. Will this be considered as majority? Because total members were 100. So the simple majority should be 51, but in this case it would be considered as a majority because 80 members who were attending the meeting either directly or via proxy and who were eligible to vote, assuming everybody was eligible to vote, their majority would be counted. So 41 out of 80 would also be considered as majority because only 80 were there who were present and were eligible to vote. Okay. Now, simple majority, that is over 50% of vote casted by members who are present at the meeting either in person or by proxy and entitled to vote. So should I remember this entitled to vote? Yes, this is very important. So if there is any member who is not entitled to vote, will that be considered? No. Now, records must be kept for at least 10 years. 10 years from the date of resolution. Only copies of a specified ordinary resolution needs to be filed with the registrar within 15 days from the date of the resolution. What are these particular things? So for purchase of own shares, that is for the purchase of own share, the buyback share, you need to file with the registrar and written resolutions of private companies. Now, when I talk about the notice, same notice as for meeting, which is 14 days or 21 days, whatever we have discussed in the last part. Means 28 days from proposer to company and 14 days from company to members. This was very, very important. Hope this is clear. Now let's talk about special resolution. This is a special resolution that is minimum 75% share. Okay. So sir, exactly 75. See, let's read the previous language also. What is given over here? Over 50%, that is more than 50%. 50.01 would also do. Okay, but here when I talk about this, it talks about not less than 75%. Not less than 75%, that is 75.01 would also do. The language is different but the meaning is same. Okay, not less than 75, that is not equal to 75. Okay, not less than 75. Not less than 75 as in if it is equal to, then also it would work, but they are more than 50%. So exact 50 would not count in ordinary resolution, but exact 75 would count in a special resolution because it is not less than 75%. It includes 75. Okay, again the same parameter, whosoever has voted. Now records must be kept for at least 10 years. Same notice as meeting. Okay, now written resolutions about private companies. Let's talk about this. Okay, so anything which might be done by resolution in general meeting or class meeting may be done by written resolution with only two exceptions. That is, there are two exceptions that could not be used for this type of resolution. Removal of a director could not be done. Okay, and removal of an auditor could not be done. Basically, removal of a particular person will not be able to be done. Okay. via written resolution. So what is this written resolution? See, generally when we talk about written resolution, this is required in case of private companies. In case of private companies, written resolutions are there. Okay. So the members of a private company can pass either type of resolution by means of written resolution. Instead of a physical meeting, decisions are taken by way of correspondence, either in hard copy or soft copy electronically. So can they make a decision in the electronic format also? That is, everybody would sign it, everybody would attach their DSC to it. Yes, they can do it. What is DSC? Digital signature. Now let's talk about the role of the chair. Who is chair? Role of the chairman. The board of directors will have one chairman, so we are talking about the role of that particular person in these meetings. So the meeting will usually be chaired by the chairperson of the board of directors, although any member can act as chair. So any member of the board of directors could act as the chairman. Yes, they can do so if it is allowed. Now it is the chair's task to, do you need to remember this? Yes, you need to remember these 3 points. Conduct the meeting in accordance with the agenda. That is, whatever was the agenda that was set, the chairman has the responsibility, the task to exactly do what? To exactly conduct the meeting according to that agenda. There should not be any point that has been moving out of the agenda. Even if there is, they have to deal with it accordingly, that whether the agenda has been taken care of or not, and whether a separate meeting is required for a different agenda. Preserve order. What is preserve order? That is, everything should be conducted in a true and fair manner and as required by laws and regulation. Now make sure that the meeting follows the law and the company's constitution. That is, whatever has been agreed in the articles or memorandum of the company, that should be followed in the meeting. That is the responsibility of the chairman. Chairman should act bona fide, that is without malicious intentions. Now let's talk about something called as taking votes. Okay, taking votes. So the chair has a duty to allow expression of all points of view before a vote is taken. That is, before anything is put to vote, all points of view, all possibilities should be taken care of. And who has this responsibility? The chairman has this responsibility. Sir, why are you figuring out, why are you stressing out this particular point in a little more detail? Why? Because a lot of my students have done this mistake earlier, that they have written board of directors has this responsibility. No, the chairman has this responsibility. Since it is not written in the last slide, a lot of people makes this mistake. Okay. Now, a poll may be demanded by the chair. Okay, poll as in the voting. Number 2, a member or members as specified in the articles not exceeding 5, or a member or members holding at least 10% of the voting rights. They can ask for the voting. Okay, they can ask for the poll. Now chair's casting vote. What is this? So in companies incorporated before Companies Act 2006, that is before, it was common for the articles to give the chair a casting vote on any ordinary resolution where the vote was split exactly 50-50. That is, if there was a tie, the chairman would also be able to vote and their vote would be considered as the decision maker. Okay. Now the right is not included in post Companies Act 2006 amendment. So it has been amended. Now it is not allowed for any company which has been incorporated after Companies Act 2006. Now let's talk about modified votes. Voting rights may be modified by the terms of the articles or the share issue or preferential. So this voting rights could be, we have already discussed about, there could be preferential rights, there could be no voting rights, there could be differential voting rights also. Now let's talk about proxy votes. What is this proxy vote? So for example, if there is a meeting of a company called say RIL, okay, and I do not want to visit over there, but I want to send somebody from my team to attend the meeting and vote on my behalf. Can I do so? Yes, via proxy vote. So a proxy is an agent appointed to attend and vote in place of a member, like we have discussed. A proxy has the same right to demand a poll as the member. So if tomorrow say 10 people are demanding the poll and I am the 11th one and I am acting on behalf of somebody as a proxy, can they say so that since you are a proxy you cannot demand the vote? No, I have all the rights to demand the vote also. Okay. Okay, now what if my proxy is attending and then I come also? Okay, say I am in the same city, I also go to attend the meeting. Now the proxy's rights would be cancelled. I would be allowed to attend the meeting. My voting would be considered, not the proxy's voting. Okay, quorum. What is this quorum? This is a little new word, right? What is quorum? See, tell me one thing. If you are deciding a life partner, okay, say there are 10 members in your family, you are deciding a life partner. Two were present, you married in front of them. Is the other family members obligated to accept this marriage? Maybe not, right? Why? Because as per your say family tradition, at least the majority vote should be in your favor. So out of 10 other family members, at least 6 should agree that this person is right for your family, and then you should get married. For example, let's assume that is your constitution. Okay, that is the constitution, that is the articles of your company or your family. Now tell me, Were the minimum numbers were present? No, there were only 2. Required were 6. So this particular concept is called as quorum, the minimum number. Okay. So the minimum number of persons who must be present to conduct a meeting. So say 100 members were there. Minimum quorum is 10 members. If 10 members are not there, meeting would not be conducted. Now please tell me one thing. If there were only 9 members present, will that meeting be valid? No. So meeting would have to be cancelled or adjourned to a next day. The quorum is specified in the articles. So it is always mentioned in the articles of a company, be it a private company or a public company, what is the quorum that is required to conduct a meeting. Okay. Now for a one-person company, the quorum is that particular member only. Okay. If the quorum is not satisfied, that is, say 9 members were present, so the meeting will be adjourned. Adjourned as in postponed. It will be reconvened at the same time and place 1 calendar week later. That is, from this Monday, it would be postponed. It would be adjourned to the next Monday, same time, same place. Okay. Now, right to requisition a general meeting. Right to requisition a general meeting, that is, right to require that a general meeting be conducted. So a general meeting may be requisitioned by holders of 5% of the voting capital, 5% of the paid up voting capital, 5% of what? Not voting rights, paid up voting capital. So whatever are the voting capital that is there, voting paid up capital, 5% of it. The requisition also can include the text of a resolution to be put to the meeting. The requisition may be in hard copy or in electronic format also, that is, you can share the hard copy or the electronic requirement to conduct a general meeting. The directors must give notice of meeting within 21 days of the requisition, not 21 days notice. The notice must be given within 21 days of the requisition. When you require, within 21 days that, and then 21 days of clear notice. The meeting must be held within 28 days of the notice of the meeting. Okay. Now, right to request resolutions. What is this? That a resolution should be passed for this. An ordinary resolution or a special resolution should be passed for this. So, in a case of a public company, at least 5% of the voting rights can ask for a resolution. So any member with 5% of the voting rights or a group of 100 members representing 10,000 pounds of voting capital. Voting capital as in the capital that is held by people who have voting rights. This will be put to the members at the next AGM. The request can be in hard copy as well as electronic format. Now, written resolution in a private company. We have discussed written resolution. So the percentage that may require a written resolution to be held is 5% unless a lower percentage is specified in the articles of the company. Now, resolution to remove a director. This is very important. We have discussed remove a director, remove an auditor is very special, right? So unless the company's articles provide otherwise, a member must satisfy Companies Act 2006 requirement to demand a resolution to remove a director from the office. And let me tell you, this requirement is also similar for the removal of the auditor also. One person cannot say that. There are different requirements that should be covered. Now, my dear friends, requisition of circulars. What is this? So the same proportion of members as previously stated can requisition a circular of not more than 1000 words to be circulated in the same manner as the notice of meeting. That is, if there is any particular requirement for which a circular should be required, it should be given by those minimum number of members that we have discussed earlier. Now, the requisition must be signed by the person requisition it, deposited at the registered office at least 1 week before the meeting, and accompanied by sufficient cost. So if there is any circular that should be there, say they want a particular circular of a particular thing, so they should require it at least 1 week before the meeting. They should bear the cost of that also, and then it is the company's responsibility to refer to that circular and to issue it. Now, my dear friends, with this we have completed this chapter. But now for this particular chapter, I would like to tell you first, before closing this video, that this chapter requires a good reading of the ACCA Study Hub. Like we have discussed, you should read the ACCA Study Hub by yourself once. If you face any trouble, please feel free to let me know. For this particular chapter, I would also guide you that you should solve the ACCA Study Hub questions immediately after completing this chapter, because this chapter has that particular data which can confuse you. 50%, 90%, 95%, right? 10%, 21 days, 28 days. So you should create a summary of that particular chapter, and you should appear for the MCQs also. Just in case you face any trouble, please feel free to reach out to me either on WhatsApp or on the app. Thank you so much. Thank you. Hello. Hope you all are doing really well. This is CS Agrawal, your faculty for ACCA AA, AAA and law subjects. And my dear friends, today I bring to all of you a very special and important chapter for your examination, which is related to a wholly new concept that you might not even have heard of. In fact, there's a chance that you might have heard of it, but today you are going to get a detailed understanding of this particular concept. And what is this concept? This concept is insolvency. Now, in general English terms, whenever we say the word insolvency, what comes to our mind? We say somebody who is bankrupt, or the process through which the assets are realized and the liabilities are paid off. Now, these are generally the understanding of the word insolvency. But my dear friends, today we are going to discuss how actually this insolvency proceeding works, what are other alternatives to insolvency, what ultimately is meant by winding up of a company, what are other measures that are being taken care of. And my dear friends, this chapter is really important from your examination point of view as well. So I would request you that even if it is a very small chapter, please stay with me till the very end of the video so that we can understand everything in one go only. Now my dear friends, let's discuss about what we are going to discuss here. So we are going to discuss about the insolvency proceedings first, then we are going to discuss something about administration, which is part of the insolvency proceedings only, and then finally we are going to discuss about the winding up as a concept. Now let's first go to the terminology understanding. So when I say insolvency proceedings, what do we mean by it? The process of realizing the assets and paying off the liability. It's a very small chapter, we will be able to cover it within 20 to 30 minutes only. Now, any proceedings under the Insolvency Act 1986. So should we remember this particular year 1986? Yes, it is very important for you to remember this particular year, because this might be asked in your examination as well, including receivership, administration and liquidation. What is receivership? Receiver is the person who takes the responsibility of selling of the asset and paying off the liability. Administration, sometimes what happens is, instead of just winding up a company, the insolvency professional tries to revamp it via new strategies. Sometimes the board is dismissed and a new strategy is placed to revamp the company and make it profitable again. That is called as administration. We will be learning about it in detail. And then liquidation, that is finally death of the company, which is winding up also. So winding up or liquidation is same or different? It's same. Okay. Now, whether or not the company can pay its debts. Okay. Now, so if the company is able to pay its debts, that time also it could be put into administration or insolvency or winding up. Yes, we will be learning about it in a little more detail now. Insolvency proceedings may be brought against a company because it will not pay its debts, not because it cannot. What is the meaning of this line? And it is mentioned under a key point. So what is meant by this line? See, please try to understand this one thing very carefully. Whenever I say that a company will not pay its debts, it has nothing to do with the solvency status of the company. Sometimes the intention of the companies might not be to repay the debt, right? So that is why insolvency proceedings are started when the company is expected not to pay its debts, not when it cannot pay its debts. Okay. Now, the syllabus is concerned with two specific insolvency processes. One is administration and another one is winding up, like we have discussed. What is administration? Administration, like we have discussed, is a process which is carried out with a view to salvaging all or part of an ailing company. That is the company that is being hurt, the company which is facing losses. What is it? Carried with a view to salvaging, that is saving, revamping all or part of an ailing company. Okay, and if that is not practicable, then winding up or administration could be done with the court order or the company, its creditors or its floating charges creditors. Okay. Now, on the direction of court order or its particular shareholders, members and directors. Now let's discuss about insolvency practitioners. Who are these people? These are the people who are vested upon the responsibilities of carrying out the insolvency proceedings. So administration, orders and liquidation must be managed by qualified insolvency practitioners. Sir, in India also, can we become insolvency practitioners after qualifying as CA or ACCA? Yes, you can be. However, there are certain examinations, certain experience requirement that you have. Based on my understanding, you should have at least 10 years of practicing experience after qualifying as a CA, and then you might have to appear for certain examination also from IBBI. Okay. Now, but generally these are licensed by qualified insolvency professionals are there, and these are licensed by the relevant statutory bodies. So is ACCA one of those bodies? Yes, ACCA is also one of that bodies. Now let's discuss about priority of creditors. What do we mean by it? See, if the company has saved $100,000, okay, $100,000 is the amount that the company has sold off all of its assets and they have realized it. Now they have to pay it. Okay, so what should be the order? Because there would be 4 or 5 people who might be in the line, right? there could be secured creditors, there could be unsecured creditors, there could be government dues, there could be some unsecured creditors, there could be employees, there could be shareholders, all of that could be there. Under shareholders also preference shareholders could also be there, right? So what should be the criteria, what should be the order in which it should be repaid? Number one, fixed charge holders. We have already discussed about fixed charge holders, right? Those would be the people who would be paid first. That is what we have to consider, that we have to pay the fixed charge holders who have charge over a particular asset for a particular debt. They will be paid off first. Then cost of the insolvency procedure. So this insolvency profession would also be charging certain fees. They might also be sending letters that would also involve certain fees, certain costs that would be paid after that. So fixed creditor, fixed charge creditor would be paid even before these costs. Yes. By default, it goes without saying that if the money is not enough to pay all of them, it would be paid in this sequence only. Now preferential debts which have preferential rights, that would be paid, but subject to a maximum claim per employee of £800, okay, plus any unpaid holiday pay. Okay. Now HMRC. What is HMRC? What is HMRC? So this is the taxation of UK, right? His Majesty's taxation, like value added taxes or debts that relate to pay as you earn income tax, employee national insurance contribution. So these are part of His Majesty's taxes. All of those are paid after that. Then floating charge holders. Now they do not have charge over a specific asset, they have charge over all of the assets or a particular category of assets. So they would be paid. But there is one important point, created before September 2003. So if it's something is created after September 2003, they will not be paid here? No. They will be paid after one more point, which is the prescribed part, where the company's remaining asset exceed £10,000. Funds will be ring fenced at this level towards the payment of unsecured creditors. That is, here unsecured creditors would be paid. The sum set aside will be 50% of the first 10,000 of company assets and 20% thereafter. So if say £15,000 is left, so out of the first 10,000, 50% would be taken, that is 5,000, and for remaining 5,000, out of 15, 10 has been done. Now out of remaining 5,000, 20% would be taken, that is 1,000 more. So total 6,000 would be set aside to repay the unsecured creditors. And after that, floating charge holders that has been created after that, which is not covered in point 5 above, that would be considered. And then the remaining unsecured creditors, and finally there would come the day when members would be paid. So what about preferential holders? So when we come to member, first preferential holders would be paid, and then finally equity shareholders would be paid. My dear friends, my only suggestion would be, do you need to remember the sequence first? Yes, you need to remember the sequence. Do you need to remember the calculations here? Yes. So do you need to solve questions here? Yes, we will also be solving questions. But my first suggestion would be, you should write this sequence in a particular order, and you should try to rewrite it at least once a day for next 2 to 3 days, so that you remember it exactly. Okay. Now, if there are insufficient assets to pay a class of creditors in full, the repayments to the creditors of that class are reduced proportionally. The classes below them receive nothing, that we have discussed. Now, position of the directors. So once the insolvency professional takes over, generally the directors' powers are dismissed. They cannot take any decision. So when a company becomes insolvent, the administrator or liquidator will not merely deal with the settlement of debts, but also will scrutinize the way in which the business was managed. So that this condition has come up, and if there is a negligence found, then directors might also be, that corporate lift might also be lifted, corporate wheel might also be lifted, and directors might be paid to or be asked to contribute to this particular loss. So if undervalued or preferential transactions are found, undervalued as in if the transaction that has been incurred by the directors, they are undervalued, that is they have entered into less than the amount they should have been entered into, or preferential treatment has been given to certain, say, related parties or any of the parties, then the directors may be liable to contribute to the company's assets also. They might also be charged with the charges of wrongful trading or insider trading or fraudulent trading also. And the report may recommend the disqualification of directors, that is they might not be able to act as directors for further companies, for any of the companies, for some number of years. Hope this is clear. Any questions? Now let's discuss about administration. Now when I talk about administration, this is exactly when the board of directors are dismissed and the resolution professional, the insolvency professional, is trying to revamp the company. Now they might be revamping it by freezing the liabilities. We are not saying that we will not be paying it. We might just freeze it for some number of time so that the company can revamp, generate profits, and then repay all of its debts. So administration offers an alternative to liquidation. It was introduced under IA, Insolvency Act 86, to give companies in difficulty an opportunity to find a means to survival, and the scope of the procedure was widened by EA02. In administration proceedings, the liability of the company are frozen while investigation and restructurings are carried out with the aim of returning the business in whole or in part to viability. That is, they are trying to make the business viable again. Hope this is clear. Hope this is clear. Now, the process can be started by what? A court order, or the company, its directors or floating charge creditors could also implement this process without a court order. Okay. Now, administration has the effect of freezing the pre-administration debts of the company during the course of the process. That is, pre-administration debt will be frozen. They might not be paid for some number of time, some years of time, some duration of time. No resolution or court order can be made to wind up the company during this process. That is, while the resolution process is going on, there could not be any court order, any resolution that could say that the company would be wound up. No security can be enforced against the company without the leave of the court. That is, until and unless the court has specifically instructed the fixed or floating charge gets on hold, that cannot be enforced. Okay, the administrator's proposals might include the following. That is, they might suggest selling off part of the undertaking, not full undertaking. Why? Because winding up is not an option. Then restructuring the company's capital, that is, they might decide to take some more amount of loan, or they might want to repay the loan first or repay the equity first. Overhauling the management and reporting structure, that is, they can change, they can modify the reporting structure, the organizational structure that is in play. Okay. Now, pre-pack administration. What is this? In recent years, it has become common for companies in difficulty to make pre-appointment plans, lining up potential buyers for the business, not the company, which the administrator can then finalize speedily. That is, before this process starts, what a lot of companies might do is they might come up with options that who might be able to take their business, not the whole company, because it is a part of administration, the company cannot be wound up, but one part. Say there are 5 units, so 1 unit is being given to somebody else for a profit, and they have pre-decided that they will be taking it. Often the insolvency practitioner, the directors and the bank will have obtained valuations, agreed a sales price, and drafted contracts to enable the business to be sold immediately after appointment. Now, if the business is to be sold to a connected party, say the directors, the assets needs to be independently valued to ensure that they are not undervalued, because if that is not the case, then a lot of directors might do what? They might undervalue the original company. They might willingly transfer this original company into debts, into a condition where administration might be an option, and then they might buy it and transfer the ownership into their names. Now let's talk about the administration procedures here. Okay, let's talk a basic about administration procedures. So how's the process started? Application to court by directors or creditors or the company, or out of court by company, directors or floating charge creditors can make an out of court application also. Now, when is the process permitted? So for court appointed, the court must be satisfied that the company is unable to pay its debts, and the order may achieve the survival of the company, the approval of creditors of a course of action to clear debts, and a better realization of assets. Do you need to remember this word by word? Definitely not. It's just to improve the company's operation and to make the company viable again. But when I talk about voluntary out of court administration or appointment, then the reasons could be the company has not been in administration in the preceding 12 months, the company cannot or is likely to become unable to pay its debts, the company is not in liquidation, and the company is not subject to pending liquidation or administration application, and that is why we are making this application, so that the company could be revamped, the company could be relived. Okay, now what does the administration do? In both voluntary proceedings and in proceedings under court order, the administration takes place the role of directors, like we have discussed. The board of directors gets dismissed and the administrator takes the role. They try to revamp the company by freezing the current liabilities, and they try to revamp it and make the company viable again, the whole company or could be part of the company. But you need to remember this, what they have the power to do, what to carry on the business. The administrator has the power to carry on the business, to deal with or dispose of assets of the company. Can they buy also? Yes. Now, to borrow money and grant security, to action legal proceedings, and to employ and dismiss employees. Okay, so they may hire new employees, they may dismiss also. Now let's come to one of the most important points and one of the last points of this chapter, which is winding up. So is this chapter that small? Yes, but it is divided into major portions, right? So that is why it looks small, but it has a lot of volume. Now winding up. So winding up is the process by which life of a company is brought to an end. It may be started by a court order or a special resolution of the members. Here this is very important. For winding up, you need a special resolution. It cannot be done on the application of shareholders or directors or company. No, it has to be done by the special resolution of the members or a court order. This is one of the important points that you need to remember. Now the court appoints a liquidator to take charge of and realize the company's assets, that is to take under consideration and sell off and realize the money of the company's assets, to settle a list of creditors, to pay creditors in the statutory order, and to effect the resolution of the company. The liquidator is treated as an officer of the company for liability purposes. The mechanism for commencing compulsory and voluntary winding up are summarized on the following pages, and we will be discussing about it now. My dear friends, after we discuss the compulsory winding up and the voluntary winding up and case law winding up, the syllabus would be completed for this particular chapter. What's not going back? Yeah, let's discuss about compulsory winding up now. Okay, who can petition the court for compulsory winding up? It has to be done, the winding up has to be done by special resolution or court order, but somebody can petition the court, right? That is applied to the court. So one could be creditors, another one could be members, the company or department for business and trade, that is the governmental body, they can apply. So should we remember this? Yes, you should remember this. Who is not covered over here? Who is not covered over here? Shareholders, right? So they shareholders, but they are covered in the form of members. Now members have passed a special resolution to see compulsory winding up, then it could be applied. A public company has fewer than 2 members for more than 6 months, or ceases trading for more than 12 months, or fails to commence trading within 12 months of incorporation, they could also be thrown into winding up. Okay, a company fails to obtain a trading certificate within 1 year of incorporation, that we have discussed in one of the chapters, then also it might be thrown into winding up. A company is unable to pay its debts, then also it might be thrown into winding up, just equitable to wind up the company. If in the court's eyes it is just an equitable to wind up the company, then also they can do that. Now effect. Date of liquidation is deemed to be the date when the petition was presented to the court. So date of liquidation would be what? The date when it was applied. Okay. Directors' powers are transferred to the official receiver, the court appointed receiver, like we have discussed. Company seizes new business, that is they cannot enter into new business. So new line of business or new business? New business, they cannot sign any new contracts. Floating charges crystallizes as in floating charge holders can exercise their powers. Employees are automatically dismissed but may be re-employed until completion of the winding up, and entitled to damages for breach of contract also if there is any breach of contract. Liquidator is appointed and a statement of affairs is produced which contains details of the assets, debts, liabilities, names, address of the creditors, etc., and assets are realized. Then when I talk about voluntary winding up, now this is done by members, okay, because this is not driven by court, this is driven by members. Sometimes members might feel that this company holds no value, it should not be continued and we should just sell it off or we should just close it. So usually comes by special resolution, like we have discussed. The directors make a declaration of solvency in the 5 weeks before the resolution to include a statement of the company's assets and liabilities. That is, directors have to show that the company is solvent. We are not winding up because we do not have assets, we do not have solvency, we are winding up because we voluntarily want to wind up. A declaration that in their opinion the company will be able to pay its debts in the next 12 months, so nobody is going to get at loss, and within next 12 months we will be able to pay all of our liabilities. What if they are not able to repay? What if through their financials it is looking that they might not be able to repay? Then they will not be able to go into the voluntary liquidation. Okay, a copy of the declaration is delivered to the registrar within 15 days of the special resolution. Members appoint a liquidator. Who appoints a liquidator? Members appoint a liquidator. In compulsory winding up, it was written that a liquidator is appointed. Who appoints it? Generally the court appoints it. Okay, official assignee. Now if the liquidator believes the company cannot pay its debts in compliance with the declaration, a creditors meeting is held and procedure follows that of a creditors voluntary liquidation. Assets are called in and realized by the liquidator, debts are cleared. Now creditors voluntary winding up. So commenced by special resolution, members nominate a liquidator. Here also no declaration of solvency is given because this is driven by members, this is driven by creditors, so no solvency statement needs to be given. Okay, now deemed under SBEEA, creditors are deemed to consent with the actions of the liquidator unless they request a meeting. A meeting can be requested by 10% in value, 10% of creditors, or 10 creditors. That you have to remember, that who can call off the meeting. This is called as COC, Committee of Creditors. Okay, could be done by 10% of value, that is if total value of creditors is say 1 million, so $100,000, a creditor holding $100,000 can ask for the meeting. 10% of creditors, say 1000 creditors are there, so 100 creditors, or in general 10 creditors could also ask for it. Now the creditors also have the option to nominate a liquidator. Members and creditor appoint representatives to a liquidation committee. Assets are called in and realized by the liquidator. Only same procedure, no difference. Now case law on winding up. Let's just have a quick reading of this particular statement. Now the most common grounds for compulsory winding up of companies are that the company is insolvent and that it is just and equitable to wind up the company. That is the common reason. What is and is not just and equitable is not strictly defined, so it is depending on the judgment. Now nevertheless, winding up has been awarded as the last resort in cases of, that is generally winding up is considered as the last resort in cases of the failure of the company's stated main objective, deadlock in the management of a company, and the breakdown of a quasi partnership. Also this is considered as a last resort. And with this we have completed our whole chapter within 20 minutes like we have discussed, and I hope you have understood it. Requesting you to read the ACCA study hub, solve the questions, and do let me know if you face any queries. Thank you so much. Hello everybody, hope you all are doing really well. This is Syllabus Agrawal, your faculty for ACCA AA, AAA and law subjects, and today is a very special day because today we are going to complete chapter number 19, which also happens to be the last chapter of your entire law global syllabus. My dear friends, this chapter is very important because it talks about a very important concept, which is fraud and criminal behavior. So inside this we are going to discuss about certain criminal offenses. We are going to discuss something about bribe related laws. We are also going to discuss about insider trading. We are also going to discuss about market abuse. Then we are going to discuss about money laundering, and as a final topic we are going to discuss about the tax evasion also. And once we complete all of that, our chapter will get completed. My dear friends, this chapter might not be very relevant when it comes to remembering the information, but what you will have to see is you will have to remember the concepts behind creation of such a concept. So for example, you might not be required to remember the exact flow of the insider trading, but you might be required to understand the value of insider trading laws, how the laws are created, what the laws are trying to speak. So we are going to learn the concept here more than the data. Okay, now my dear friends, let's discuss about this particular chapter. So when I talk about the criminal offenses, there are a lot of offenses which have been described as the criminal offenses. Now company legislation contains a number of instances which constitutes a criminal offense. One of such, so sir, this entire slide had that only? Yes. Now one of such thing is Bribery Act 2010. When I say Bribery Act, what do I mean by it? So this is not how to commit bribery charges, okay? This is related to how to stop bribery or what actions would be taken when a bribery charge is committed, when a bribery offense is committed. Now, bribery and corruption undermine the rule of law and economic development under BA10. BA10 as in Bribery Act 2010. It is a criminal offense for a person or organization. It is applicable to person as well as organization, including a company, to seek, take, offer or give a bribe. See what is important here, what all things are covered. To seek, that is when they want, when they seek that they should get some bribe. To take, even if somebody else is giving and they are accepting it. To offer from their end, and to give a bribe in a relevant function or activity. Now any function of a public nature, when this bribe becomes a criminal offense, when it is in the nature of, when there is any function in the nature of public nature. Then any activity connected with a business. So if you are doing a business and you are giving bribe for any of the thing which benefits your business, that is also a criminal offense. Any activity performed in the course of a person's employment. So if you are into employment and you are, say, paying for your promotion, so that is also a bribe. And any activity performed by or on behalf of a body of persons, all of this is considered as criminal activity. Now something that you need to remember, this act covers what? This act covers bribery committed in the UK and outside the UK as well. But sir, this act is belonging to UK, right? So how it can cover the bribery committed, the bribery offences committed outside UK? So only by specific persons. A person who is a British national, even if they commit a bribery offence in the another country, even when it is not an offence in another country, then also they might be charged for bribery charges. Then a British resident, then a national of a British overseas territory. There are certain territories which have been defined as the British territory, and a UK corporation, UK based corporation. But this does not cover bribery committed outside UK by two people. So what if these two people commit bribery inside UK? Then it will be considered an offence? Yes, that would be considered as an offence. But here, if these two people commit the offence outside UK, it will not be covered. Whose two people? The foreign subsidiary company of a UK corporation. That is, UK has a company UK's company which has a foreign subsidiary. If that commits outside UK, that will not be considered under this act. And a foreign company or partnership, if it commits outside UK, then also it will not be considered. What if there is a UK based company and they have committed bribery outside UK? It will be charged under this act. Okay, hope this is clear. Now, bribery offences under Bribery Act 2010. So, bribing another person, that is also called as a bribery. Being bribed or seeking a bribe, like we have discussed, that is also an offence. Bribing a foreign public official, even if it is committed outside UK, yes, that would also be considered as a bribe. Even if that country does not consider it as a bribe, UK government and UK laws consider it as a bribe and they punish you. Organizational failure to prevent bribery, that is, even if you have failed to prevent bribery, then also you might be charged, the organization might be charged. The act covers monetary and non-monetary bribes as well. So, for example, if you have gifted a car, it's a non-monetary, still it will be considered. The act covers all bribes, however small. The act does not apply to genuine hospitality that is reasonable and proportionate. For example, I had a guest, so I went to the station or the airport to pick them up. Now, when I went to pick them up, this is a normal hospitality. This could not be considered as a bribe in kind, right? Now, bribing another person, being bribed, bribing foreign officials and failing to prevent bribery, all of them has been defined here. You can read it from your end because we have already discussed about it. But there is one very important point which is associated. A person is associated with a commercial organization if he performs services for the organization or on its behalf. Okay, this is very, very important. So, even if you have bribed an associated person, it would be considered as a bribe only. That is why this definition is defined. Now, guiding principles in preventing bribery. There are certain guiding principles that helps you to prevent bribery. So, the guidance from the Secretary of State gives 6 guiding principles. Number 1 is proportionate. Number 1 nature of principle is proportionate procedure. What is the expectation? Anti-bribery procedure should be proportionate to the risk faced and to the nature, scale and complexity of business activities. A small organization would require different procedures from a large multinational organization. So, what is considered as a bribe should depend on the nature, size and objective of the organization as well. Now, top level commitment. Second principle is top level commitment. What it says? Top level management should be committed to prevent bribery. Management should foster an organizational structure in which bribery is unacceptable. What if it is proven that the top level management has not taken any efforts to stop bribery? Then it would be considered as that top level management should be punished. Now, risk assessment. Management should assess the nature and extent of the organization's exposure to risk of bribery and they should consider the relevant risk and create the relevant controls also. Due diligence. Due diligence procedure should be applied in respect of persons who perform services for the organization or on its behalf in order to minimize bribery risk. That is, there should be a system of control, there should be a system of monitoring in the organization, especially for the persons who are performing the work on the organization behalf. It could be directors also, to ensure that they are not committing any bribery offences. Now, communication. Bribery prevention policies and procedures which are proportionate to the risk faced should be embedded and understood throughout the organization. It should be communicated actively to all members of the organization. Then monitoring review, there should be a continuous system of monitoring. Should you remember this? I would not suggest it. Okay, what you can do is you can somewhat remember what all are the guiding principles, but definitely not the inside information. And even if you don't remember the guiding principle, I am fine with it because I have never seen a question on that. Now, deferred prosecution agreements. What is this? This is like out of court settlement. This is like out of court settlement. The out of court settlement you have heard of, no? What happens is sometimes somebody is committing a bribe. Okay, they have been convicted, they have been prosecuted, and now the prosecutor has an option, or prosecutor wants that they should be free from every criminal charges against a responsibility of, say, paying fine, taking care of the community. These punishments should be given to them, but they should be free from criminal offences. If prosecutor is of that opinion, then prosecutor can offer it. Now, deferred prosecution agreement, an agreement between a designated prosecutor and an entity that the prosecutor is considering prosecuting, that is the accused, for an alleged offence. So, it is an agreement between the prosecutor and the alleged offender. Now, this particular agreement says that this offender would be released from criminal charges, but they'll have to abide by certain conditions of this agreement. It could be to pay fine, to take care of a committee and so on. A DPA as in deferred prosecution agreement, is a discretionary tool. That it is not mandatory that prosecutor has to offer it. No, it is discretionary tool created by the act to provide a way of responding to alleged criminal conduct. Sometimes what happens is, even if the highest punishment is given to the offender, no benefit would be passed on to the victims. So to ensure the victims are protected, sometimes prosecutor could offer it. Now it is only available to companies, partnership and unincorporated organizations. Okay, it is not available to individuals. No. Now, so should we remember this? Yes, this is something that you should remember. Please note it down. Now it can be entered into in respect of fraud, bribery and similar economic offences. So it cannot be offered in case of criminal offences, right? It could only be offered in case of fraud, bribery or other civil or economic offences. Now it is only available at the invitation of the prosecution, that is an entity cannot propose it. Now if an entity charged with a criminal offence reaches an agreement with the prosecutor, the prosecution proceedings are automatically suspended because anyways the agreement has been entered into. A DPA does not allow an entity to escape the financial consequences, that is they might be required as a condition to compensate victims, to donate money to a charity and to pay a financial penalty to the prosecutor as well with reasonable cost. That is very, very important. Now we are moving towards a new heading. This was all about bribery. Now let's come to a different point of view, different understanding, which is Criminal Justice Act 1993. Criminal Justice Act 1993. Okay. So what does it talk about? It talks about insider trading. What is insider trading, sir? So say if I am working at a company, it's a listed company, I know a lot of unpublished price sensitive information. Unpublished price sensitive information, that is what I believe is that I have certain information. If I use it to my benefit, say if I know that company is going to publish great results and the share price is going to go up, and I use that information to buy the shares, to park the shares on either on my name or on my relative's name or my close friend's name. Now when the information is released, the share price go up, I sell it off, I make a good money. Now this is called as insider trading. This is not allowed. Okay. Generally, whosoever is convicted of an insider trading offense, they can only use it as a defense that they did not know that this was not published, or they did not know that they will be able to generate profit, or they might be able to reduce their losses because of those information. That are the only defenses that is available. Now let's read it. Insider dealing. Using insider information to gain advantage when dealing in securities. Insider dealing is a prime example of the abuse by directors or others of their position of trust and confidentiality. The law prohibiting insider trading is contained in Part 5 of the Criminal Justice Act 1993. This deals with the offense of insider trading, defenses of insider trading, that is what you could use as a defense, relevant securities, penalties and prosecution, and territorial scope of the offense. So what do we mean by relevant securities? That is trading in which securities could be covered under insider trading, penalties and prosecution, what could be imposed as a penalty, and territorial scope of the offense, as in under what jurisdiction it could be imposed. Okay. Now, so say if somebody sitting in UK has done insider trading on an Indian company, can that be covered? That is also covered under the territorial defense. Now, terminologies. Inside information. What is considered as inside information? I told you, price sensitive. Unpublished price sensitive information is called as inside information. So inside information means price sensitive information relating to the issuer of securities. Securities, price affected shares or debentures in a company, that is whosoever or whichever securities has price affected behavior because of this information, that is called as security. Price affected securities whose price would change significantly because of this information. Okay, then dealing, acquiring or disposing of relevant securities. So only acquiring should be considered, no disposing also. If you are sure that the results are negative and the share price would go down and you have sold it off, you have avoided the loss. No, even if you have not made the gain, you have avoided the loss. That is also considered as using inside information. Now insiders, people who know they have inside information from an inside source. So sir, only employees? No, anybody. Say my friend works at a company and they have given me information, I would also be considered as insider trader. It could be director, employee, shareholder, professional advisors, those who obtain the information directly or indirectly from one of the above. So if I obtain information from one of my friends, that would also make me insider trading and the offender under the insider trading laws. Hope that it's clear. Now offense. The prosecution must prove, the prosecution as in the public prosecutor we are talking about, the person who is prosecuting should prove that the insider dealt in the price affected securities, encourage someone else to deal in them. Say my friend has not dealt in them directly, he or she has encouraged me to do that, disclose the information and enable it to be used by a person dealing in them. Now encouragement is an offense if the individual encouraging another knew or had reasonable cause to believe that the dealing would take place regardless of whether or not the person encouraged, how the encouragement is given, and whether any dealing took place. Now this is not very important for you. Now let's talk about penalties and consequences. So the maximum penalties under the act are currently 10 years jail. So 10 years jail, insider trading 10 years jail, yes, 10 years jail, or an unlimited fine. Unlimited, see in India if I talk about, the prices or the fine could go say twice, thrice of the profit make. But in UK it's unlimited fine, unlimited. It could be any amount that is decided by the court or the relevant parties. Now the share dealings remain valid. It would be too difficult and complex to unravel them. That is, whatever share transfer has been done, that would still be valid. No reversal on that. But the fines would be unlimited. There could be 10 years of jail as well. That's huge punishment. Now defenses. What could be defenses? We have already discussed. He did not expect to make a profit for himself or avoid a loss. He had reasonable grounds to believe that the information had already been made public. He was going to deal in the securities anyway without the information, or in disclosing the information he did not expect any person to act on it, or to deal, or the dealing to result in a profit or to avoid a loss. So this is one slide that you should remember, and I hope you have understood it as well, and what could be the possible defenses for insider trading. This is not just important for examination but for real life also. So sir, are you promoting that we should enter into dealing insider trading or enter into insider trading transaction? No, my dear friends. But just in case if you are ever accused of it, you should know your defenses also. That is why I am telling you that you should remember it always. Okay, very important. Now regime. What is this regime? What is this regime? So this is market abuse regime. The market abuse regime, which talks about misuse of information in the market. So there's one special authority, Financial Services Authority, okay, which has been created under Financial Services and Markets Act 2000. This is created Financial Services Authority, and what it does, it talks about market abuse via when misuse of information happens in the market, when misleading statements and impressions are made in the market, or when market distortion happens. So for example, if somebody has not made use of the information and made profits or avoided a loss, but they have given certain information which has distorted the market. Say I have spread a rumor which has reduced the market price of a share to a great extent. I might not be charged under insider trading offenses, but I might definitely be charged under market abuse offenses, market abuse regime. Now types of behavior: misuse of information, misleading statements and impression, market distortion. Let's read one by one. Misuse of information. Misuse of information involves making improper use of information that the other investors would regard as significant in advance to that information being announced to the market as a whole. Insider dealing can be dealt with as market abuse as an alternative to using the Criminal Justice Act. That is, it is similar to insider dealing, only when the information is not published, you have used that information. The provision protects investment markets that rely on the timely provision of information to all market participants. Now misleading statements and impressions. So misleading statements and impression involves making information available that is likely to give a false or misleading impression about the supply or demand or price or value of an investment. An example is a share buyer posting untrue messages on the internet to drive the share price higher and then selling at a profit. So say if I have 1 lakh shares of say Reliance Industries Limited, and I say that Reliance Industries Limited is entering into a huge collaboration with the government of India, and my only intention of disclosing this information, which I am not sure of, is to make good profits in the shares because I want to sell it, then that would be called as misleading statements and impression. Then market distortion. Distortion is improper conduct which manipulates the marketplace to the detriment of investors, that is which ultimately is harmful for the investors as a whole. So interference with the normal process of supply and demand of shares, say I have hacked the system, okay. Improper interference with the price of shares, say I have by default entered into an algorithm and manipulated the prices of the shares. Now market abuse and share financing scheme in public companies. The regulation of market abuse overlaps with section 678 of Companies Act 2006, which prohibits a public company from directly or indirectly financing of a person's share acquisition. We have already discussed it under chapter 13 also, that a company cannot finance anybody's transaction of buying into a share transaction or entering into a share transaction, especially of their own shares. So that is something also called as market abuse. Now let's talk about one of the last topics, which is terminology. Okay, after this only tax evasion is left. When I talk about terminology related to money laundering, so this is something that we generally cover in AAA syllabus as well, but let me tell you what is money laundering. Money laundering is either knowingly or unknowingly you are being party to, okay, you are holding, you are transferring, you are dealing in, you are acquiring, or you are participating in any transaction or conversion of money generated from illegitimate source into conversion into legitimate source in the form of clean money, that is called as money laundering. So exchanging criminally obtained money or other assets for clean money, that is conversion of black money or illegitimate money into a legitimate source of money with no obvious links to their criminal origins. When we go to AAA, we will also be discussing about stages of it, like placement, layering, integration. Okay, it also covers money, however, come by, which is used to fund terrorism. So terrorist financing is also covered into here. Money laundering is covered by the Criminal Justice Act 1993 and other legislation. The term money laundering is widely defined to include possessing, in any way dealing with, or concealing. Possessing as in if you are holding it, even if you do not own it but you are just keeping it, that is also a money laundering offense. In any way dealing with, you are just converting it, still you will be considered as a money laundering offender. Concealing, you are hiding, or the proceeds of any crime. Now it also includes an attempt or conspiracy or incitement to commit such an offense, that is you are just promoting the idea of committing such an offense, that would also make you a money laundering offender. Criminal property includes what? The proceeds of tax evasion, the tax theft that you have done, the money that you have stolen from the government or you have hidden from the government to avoid the taxes, that is called tax evasion. A benefit obtained through bribery or corruption, it could be any money. Now let's talk about legislation. So relevant legislation includes the Criminal Justice Act 1993. Should you remember this? Yes, my dear friends, I would request you that you remember these acts. The Proceeds of Crime Act 2002, which is also called as POCA. The Prevention of Terrorism Act 2005, which is also called as TACT, and the Money Laundering Regulations 2017. Now, Money Laundering Regulation 2017 talks about certain special features. Let's discuss about them one by one. The Money Laundering, Terrorist Financing and Transfer of Funds Information on the Payer Regulations 2017 implement the 4th EU Money Laundering Directive in the UK. This is 4th edition of it. The regulations play a crucial role in safeguarding the UK financial system from organized criminals and terrorists. See, it does not talk about protecting from unorganized sectors, but at least organized sectors should be reduced. Now, relevant persons, that is the persons to whom the regulation apply to credit and financial institutions. So some banks also, yes. When we go to EEE, we will discuss about a concept called KYC and CDD, which is know your client and customer due diligence, that is applicable to financial institutions. Auditors, insolvency practitioners and tax and financial advisors, that they are sometimes required to report it and they are allowed to avoid tipping off. Then legal professionals and estate agents also. Now, those who are not already regulated by the Financial Services Authority or by a recognized professional body must satisfy a fit and proper test that they are not involved into any of such transactions. Okay. How it could be managed? It could be managed by risk management practices, internal controls, customer due diligence, like we have, like I've told you about. So whomsoever you are entering into a transaction with, you should check their background. You should keep the records for transaction. You should keep it for at least 5 years from the date of transaction, and you should also keep the records of the verification of the particular customer from the up to the 5 years from the last date of transaction or from the date of the end of the relationship. Okay. Now reliance and record keeping, very important for at least for 5 years. See, then monitoring and management of compliance and internal communication, that is whatever communication has happened, you should always keep a record of it. You should always verify it. You know, at one of the times I was making one of the payments to outside India party via my card. The bank that I was dealing with, they hold the transaction, they just held the transaction, they just called me up just to ensure that whether the transaction that I was entering into, which was a very unusual transaction, whether that was authorized. When I confirmed that it was authorized, then only they proceeded with the transaction. Okay. Now please go through it, please read it, and do let me know if you face any issues. Now let's talk about offenses. So there are 3 main categories of offenses: laundering, that is exactly being involved into the conversion; failure to report also, that is you were aware but you failed to report; and tipping off, that is you were nowhere involved but you just tipped them off, that you know the government is trying or government is coming for you, government is knowing that, or government knows that you are a money launderer and they are trying to prosecute you. Now this is also called as tipping off. Now the offense of making a reckless statement in the context of money laundering which is false or misleading can also result in 2 years of imprisonment. Now there are processes, there are 3 stages like we have discussed: placement, layering and integration. Placement, when the money first enters the financial system. So say the cash has entered the financial system, it has been deposited into the bank. Layering, that it has been divided into multiple layers to avoid the original source, to avoid finding the original source. And integration, it has been plugged back into the economy in the form of legitimate money, say via IPO, everybody is invested back into the company. Okay. The proceeds of tax evasion can be laundered in the same way as those from drug trafficking also. Now failure to report, so there is suspicious activity reporting, SAR, that is there. Okay, SAR, suspicious activity reporting, that needs to be done. whomsoever. Every company has one MLRO also, which is money laundering reporting officer, and there should be a system of suspicious activity reporting also. So if anybody, be it outside the company or inside the company, they are suspecting any money laundering transaction, they should be able to submit a report to the MLRO, who will further investigate it and report it to the relevant authorities also. Failure to report includes failure to appoint a money laundering reporting officer, MLRO, like we have said, failure to implement internal proceedings or procedures to comply with the legislation. Say there was one training required, there was one reporting required, you have failed to do that, and failure to report any knowledge or suspicion, like we have discussed. Then there's tipping off. What is this? Tipping off is just informing. So the offense of tipping off occurs when an MLRO or an individual makes a disclosure which is likely to prejudice an investigation. That is, there was an investigation, you have harmfully affected that investigation. This does not prevent businesses and individuals discussing with clients and advising on issues regarding prevention of money laundering. That is, if you are, as a professional, you are discussing these issues, you will not be considered as tipping off. Now, penalties. Offences may be tried in a magistrate's court or in a crown court depending on severity. On conviction, offences are punishable by imprisonment, maximum terms from 6 months to 14 years, and an unlimited fine also. So, unlimited fine, should we remember it? Yes. Should we remember the tenure also? Yes, you should remember the tenure also. 6 months to 14 years is the part. Okay. Hope this is clear. Now, defenses, very important. General defenses. The defendant properly reported the matter to NCA or the business's MLRO. Okay. Now, the defendant intended but failed to report, make a report to NCA or the MLRO. Reasonable excuse would include the fear of physical violence also, that they would have harmed us physically, or the defendant required laundered asset for adequate consideration and in good faith. Legal privilege. Legal privilege can provide a defense for professional legal advisors. It only applies when information is received in privileged circumstances. Say there is attorney-client privilege. The client has come to you and informed you that they have entered into a money laundering transaction, but since you are an advocate, this information is protected by attorney-client privilege and you cannot disclose it. Is not communicated to or by the lawyer with the intention of furthering a criminal purpose. So for that, to avoid a criminal purpose, they have not reported it, then it could be a defense. Okay. Hope this is clear. And what could be general defenses that we already reported, or we thought that it is not required to be reported, or it is not a money laundering offense. Now, Economic Crime and Corporate Transparency Act 2023. What is this Economic Crime and Corporate Transparency Act 2023? So according to the UK government, fraud accounts for more than 40% of the crime. In the Economic Crime and Corporate Transparency Act 2023 has introduced a new failure to prevent a fraud offense. That is, if you are aware about the fraud and you have failed to report it, then here you will be considered as an offender under failure to prevent a fraud offense. To hold organization to account if they profit from fraud committed by their employees, that is, if employees has committed the fraud and the organization has been benefited and they fail to report it, they will be charged under this. To improve fraud prevention and protect victims of the fraud, to strengthen existing powers to fine and prosecute organizations. Now, failure to prevent fraud offences could be fraud by false representation, fraud by failing to disclose information, fraud by abuse of position, say director has abused their position, obtaining service dishonestly, or participation, obtaining services dishonestly as in by bribing, maybe participation in a fraudulent business, false statements by company directors, false accounting, all of that is covered over here. But there are certain key points that are covered. Let's discuss about it. So money laundering offences are not included because relevant organizations are already required by law to have anti-money laundering procedures in place and be regulated by the Financial Conduct Authority as well. Now, relevant bodies, a body, corporate or a partnership, wherever incorporated or formed. A body, corporate or a partnership, not the individual. A relevant body which is a large organization is guilty of an offence if during a financial year an associated person commits a fraud offence with the intention to benefit either the organization itself or any person to whom the organization provides services on behalf of the organization. Now, my dear friends, this is something that we have already covered. Only one information is very important here, which is a relevant body is a large organization if it is satisfied, if it satisfied two or more of the following condition, that is, either it has a turnover of more than 36 million pounds, or balance sheet total is more than 18 million pounds, or number of employees is more than 250. One key point also here, which is the relevant body is not guilty of an offence if it was or was intended to be victim of the fraud offence. That is, they will not be charged as guilty, they will not be considered as guilty if they were themselves a victim of the fraud. Okay. Now, let's discuss about Criminal Finances Act 2017. Let's discuss about them. Now let's talk about the last heading, last part of this particular chapter, which is Criminal Finances Act 2017. My dear friends, this particular act talks about tax evasion, and it talks about majorly from a point of view that if you have failed to prevent, please remember the words, failed to prevent the tax evasion, then you might be considered as an offender. Okay, with this particular theme in your mind, please understand this particular concept. So the Criminal Finances Act 2017 has created new corporate offences for failure to prevent the facilitation of UK or overseas tax evasion. So first thing, is only UK tax evasion covered? No. Is only foreign tax evasion covered? No. Both are covered. Okay. CFA 2017 imposes a strict liability on an organization whose employees are found to have facilitated tax evasion. That is, the organization would be prosecuted, would be penalized if its employees have found that they have facilitated tax evasion. It could be UK tax evasion, it could be foreign tax evasion. Creates new measure aimed at tackling money laundering and corruption. Then facilitates the recovery of proceeds of crime. Now this is repetition of information, that is why I am just reading. Provides authorities with new investigative and recovery powers. Now let's talk about new corporate offences. So CFA 2017 introduced two new corporate criminal offences. Number one is failure to prevent the facilitation of domestic UK tax evasion and failure to prevent the facilitation of foreign tax evasion, or both of them are covered. Only a relevant body, that is a body, corporate or partnership, can commit these offences. So sir, individual will not be charged? No, individual will not be charged under this particular act. They could be charged under the other relevant laws in the UK. Now the offences therefore apply to companies, partnerships and not for profit organization only. A person, individual or body corporate is associated with the relevant body if they perform services for on behalf of the relevant body, and they might also be considered as an offender. Now for an organization to be convicted of either offence, prosecutors must prove three stages. That is, for an organization to be convicted of either of these offences, they should be able to prove these three stages. Number one being criminal tax evasion by a taxpayer. So there is a tax evasion. Criminal facilitation of the tax evasion involving deliberate and dishonest behavior by the associated person, and that the organization failed to prevent the associated person from committing the offence. Now let's try to understand this. Criminal tax evasion by the individual person, the taxpayer. So there has been a tax evasion. Criminal facilitation of the tax evasion involving deliberate and dishonest behavior by an associate person, that is an employee, agent or other person on the organization behalf. So they have facilitated the tax evasion, the other party, the employees of the organization. And third, that the organization failed to prevent it. That is, there is a person who has actually done the tax evasion, there is an organization whose employees have facilitated it, second point, and third point is that the organization failed the procedure or lacked the procedure to prevent this from happening, from this facilitation, like the procedure to prevent this facilitation from happening, then the organization would be considered as prosecuted under this. Now reasonable prevention defense, that is the defense part, right? The defense of having in place reasonable prevention procedure must show that the organization carefully considered and applied bespoke prevention procedure in a risk based and proportionate way. For example, terms of employment contracts include agreement not to facilitate tax evasion, that should be there. Providing training to associated person on how to identify tax evasion and other financial crimes, that could be their defense, that we have trained these people. And establishing whistleblower procedures, that is there should be a proper working procedure for whenever they face any of this issue, they should be able to report it to the relevant person immediately within their organization. With this, we have completed this entire chapter, and I hope you have understood everything, but I would highly recommend you to please go through it, please read it once more, and if you face any trouble in any of the points, please feel free to reach out to me. And my dear friends, it is very important for us to understand this, that law is that one particular subject where we can explain the concept, but you will have to read it once more, you will have to solve plenty of questions, and I will also solve a lot of questions with you. But you need to understand this one thing, that until and unless you do not solve the questions yourself and ask the queries, you will not be able to take the right question, right answer here in this particular subject. So my dear friends, I wish you all the very best for your law preparation. If you are facing any trouble, please feel free to let me know. Thank you so much.